Okay, let's start. Chapter number the Constitution of India. This law is all about the Constitution of India. As we know, Constitution is the basic law which provides the political structure of our country. Correct, right? This is the law through which all other laws derives their powers. Constitution of India is the supreme law. What law? Which provides the basic structure of our country or basic structure of political system in a country. Having constitution is different from having the constitutionalism. What is constitutionalism? When the constitution is followed in the true spirit, it is called as what? Constitutionalism. In India, what is superior? Is it the parliament superior or the president superior or the constitution is superior? Because we are a rule-based country. What based country? Rule-based country. Broad framework of constitution, there are how many articles? 395 articles. How many parts? 20. How many schedules? 8 schedules. At present, because there are many amendments to the Constitution of India, present there are how many articles? 470 articles. How many parts? How many schedules? 12 schedules. Out of these, we don't have all the parts. Majorly, we have part 3 of the Constitution of India, which deals with the fundamental rights. What rights? Let's discuss. Preamble of Constitution of India. Based on this, there are less chances that they'll ask questions in the examination, which you should know. Preamble of Constitution of India. What is the preamble of Constitution of India? It just says, we the people of India solemnly resolve with great affirmations, we are resolved to constitute our India into what? Sovereign, socialist, secular, democratic republic. This is the type of India we want. The word secular was not there in the preamble of Constitution of India. That was added by the constitutional amendment. Clear? So we want India to be sovereign, means we are not under the control of any external powers. Then we want India to be secular, socialist and secular and democratic, as well as the republic. We have 2 governments, right? One at the state level as well as the central level. To secure all its citizens, what we want to secure? Justice, liberty, equality, and promote the fraternity among all the citizens of India. Correct, right? We want to promote what? Justice. What justice? Social justice, economic justice, as well as the political justice. Next one, liberty of thought, expressions, belief, faith, and worship. You can worship anybody. You can worship in the idols. You can worship whatever you believe. Correct, right? So belief is different from the faith. Faith is different. Belief is different. You have the freedom of both. See, belief is still logical. Faith is illogical. Agree with this? Faith is illogical, right? Is it possible to prove your faith? Somebody have a faith in something, correct, right? For example, you believe in God. You believe in what? God. Belief has some logic. For example, you can believe that you are in Goa now. Even though it sounds impractical, but it's still possible. But faith, some people have faith in God, right? Is it possible to prove God here and is it, have anybody seen the God? No. That is called as faith. So you have freedom of both. You can believe in God, you may not believe in God. You may be you can worship God or you may not worship the God. You have the freedom of all these things. Constitution of India assures the freedom as well as the equality, as well as the what? So we the people of India solemnly resolves to constitute India into a sovereign, socialist, secular, democratic republic and to secure all its citizens justice, liberty, equality and promote the fraternity among the citizens of India. And the Constitution of India came into force on what date? 26 November 1949. On that date, Constitution was adopted. But it came into force on what date? 26th of January 1950. And we celebrate that day as what day? Republic Day. Basic information, but the chances are very less. The last question based on the preamble of Constitution of India. Let's go to the concept of structure of Indian Constitution. Structure of what? This is the part which says what type of political system we have in India. Do we have federal system or unitary system? So Indian Constitution is basically what? Federal. With certain what features? Unitary features. Whenever they ask question about structure of Indian Constitution, you should also mention the case law called as Kesavananda Bharati vs. State of Kerala. Very good. So Constitution of India is basically federal, but with what features? Certain unitary features. You guys give me an example for the best example for unitary system of Constitution. UK. US has federal system, correct, right? Pure form of federal system, and UK has the unitary system. What system? We have derived the features from both the system of constitution. That is why Indian constitution is basically federal with certain what features? Unitary features. Very good. Next one. Majority of judges. In which case law? Keshavanandavarti versus State of Kerala. Hence the Indian constitution is basically what? Federal. Basically with certain what features? Unitary feature. Federal system has the following essential characteristics. If they ask, what are the characteristics of federal system or why Indian constitution is considered as federal? First one, dual government. What government? You should remember all these points. Federal system has these features and our Indian constitution satisfy all these conditions. What is the first condition? We have dual government, one at the center, one at the what? State. Second one, distribution of power. Is there any distribution of power? We have Schedule 7 to the Constitution of India, which has three lists: Union list, State list, concurrent list. There is a clear distribution of power, and this concept was there in the before independence itself. We had a Government of India Act. Which act? British enacted Government of India Act 1935. In that act itself, there was a clear distribution of power between the state and the center. And we implemented that concept even in the Constitution of India. So, there is a clear distribution of power in the federal system of government. Even in the USA, there is a clear distribution of power, right? Yes or no? Each state has different laws in USA. Citizenship also different in USA. One state citizenship is different from what? Other state citizenship. But we have a different concepts in that is a peculiar features of our federal system. Clear? What is the first feature of federal system? Dual government. Do we have dual government? That is why it is federal. Second one, it's a distribution of powers. Yes, there is a distribution of power. Next one, supremacy of constitution. Do we have supremacy of constitution? Because what is superior here? Constitution is superior, not the any other laws. Next one, independence of judiciary. Do we have independent judiciary? Yes or no? So Supreme Court and High Courts functions independently. That is what called as rule of law. What of law? A.D. Dicey has given the concept of rule of law, administrative law, where law is superior. What is superior? Law is superior. And there is a clear separation of power. Even though that concept is changing now, when in the Constitution of India, there is a separation of power. What is separation of power? We have three organs: legislature, executive, judiciary. And there is a clear distribution of power between them. Legislature makes the law. Executive enforces the law. Judiciary interprets the law. One organ cannot interfere with the other organ. Right? Independence of judiciary. Fifth one is what? Do we have written constitution? Yes. Last one, rigid procedure. Is there any fixed procedure to be followed for the purpose of amendment of Constitution of India? Yes. Article 368. Which article? Provides the procedure to be followed for the amendment to the Constitution of India. Recently, the Modi government has introduced an amendment bill in the parliament to bring reservations and delimitations, but that bill has not been passed because there was no required majority. There is a fixed procedure for amendment to the Constitution of India. Is our political system, our constitution, satisfy all these six conditions? That is why our constitution is basically what? Federal. With certain what features? Unitary features. Can you guys repeat the points, please? See, when you do the revision, you will not please read these points. You only read what? These main points. So you don't need a short notes. If you guys want short notes, I will provide the short notes. I have a short notes. But instead of referring to multiple materials, just stick to this material along with the question bank. And for revision purpose, just go to the what? Headlines. The headings of each concepts. Clear? So what is the first feature? Second one. Third one, supremacy of constitution. Fourth one, independent judiciary. Fifth one, written constitution. And sixth one, rigid procedure. We satisfy all these conditions. That is why the political system of our country is basically federal with certain what feature? Unitary feature. This was held even in which case law? Keshavanandavarti versus State of Kerala, with the majority of the judges. Next one. Peculiar features of Indian federalisms. Why it is considered as peculiar or why it is different from the US federalisms. First one is what? Mode of formation. Mode of what? So in case of USA, the federation was formed by an agreement. And the state can leave that union by waging a war against the union. Because this federation was formed in USA, the federation was formed by an agreement between the state and the center. If any state want to go out of that federation, they just have to what? Wage a war against that and they can go out of that union. But there is no such concepts in case of what? India. Once you are a part of Indian Union, even Parliament cannot remove you from the union. There is only a power to annex a state, but not to remove a state. In the constitution, there is no power or there is no provisions for what? Removing a state from the union. But you can annex a state to the union. There is a difference in way the federalism is formed in case of USA and in India. So in case of USA, how it was formed? Agreement between the independent and sovereign state. But in India, federation was formed by creating a autonomous states through one constitution similar to what model? Canadian model. India was originally unitary and highly centralized state, correct, right? Because we are under the control of who? British. And the concept of federalism was introduced for the first time in which act? Government of India Act. Which act? Which year? 1935. Next one. Position of state in the federations. So in typical federation, that is nothing but US federalism, every state has a what? Sovereign before joining the federations. In India, state were not sovereign before the constitution came into force. Correct, right? As a result, more powers are given to the union, including the what power? Residuary powers. But in case of USA, the residuary powers are with whom? State. In USA, state. In India, center. What is residuary powers? Anything which is not covered in this list is called as what? Residuary powers. We have a union list. On union list, who can make laws? Center. A state list? Concurrent list? Anything which is not covered in the union list or the state list or the concurrent list, on that matter, who can make law? Center. In India, center can make law. In the USA, there is the one more difference between the Indian federalism and the US federalisms. Correct. Next one, third one is one of the important features: citizenship. In India, we have only one citizenship throughout India, but in USA there is a what citizenship? Dual citizenship. Next one, residuary parts. What parts? What is residuary parts? Not covered in the list. Who has the residuary powers in India? Center. In the USA, state. This last para is very important. Constitution of India is neither purely federal nor purely unitary. It's a combination of both based on the principle that despite federalism, national interest must prevail. Most important. If they ask question, they use this kind of words. Despite federalism, we know that there is a clear distribution of power. State is separate, center is separate. But in the interest of the nation, the union can take over the power of a state in case of emergency. That is why it is neither pure federalism nor pure unitary system. It's a combination of both, but it's basically federal. Clear? So, based on the principle that despite federalism, national interest must prevail and governance should operate under the supremacy of law rather than what? Autocratic power. Means nobody has no individual is superior in the Constitution of India. Clear? So, based on this, what type of questions might come in the examinations? Can we read the question, please? What is the first question? Is federal in character with certain unitary feature. Comment. You just write the features of federalisms. Second one, examine how far the essentials of federal polity is incorporated in Indian Constitution. Fourth one, Constitution of India establishes federation with strong centralizing tendency. Discuss. You can write answer for this. To what extent does the Indian Constitution different from system of other countries? So you should write the peculiar features of Indian federalisms. What are the peculiar features of Indian federalism? Mode of formation, position of the state, and citizenship and residuary powers. That's it. So these are type of questions which were asked in the previous examination. Chances are very less that they ask questions based on this concept. Most of the questions comes based on the fundamental rights. And also this distribution of powers, Schedule 7 of the Constitution of India. And next one. Let's go to the next concept. Fundamental rights. What rights? Fundamental rights. Which part of the Constitution of India deals with fundamental right? Part 3. Which part? Part 3, Article 12 to Article 36 deals with the fundamental rights. What rights? Let's start. Fundamental rights, Part 3 of the Constitution of India, Article 12. Article 12 defines the word what? State. What do you mean by state? Include government. State includes what? Government and Parliament of India. Second one, government of state, legislature of the each state. Next one, all local and other authorities within the territory of India or under the control of government of India. That is what called as state. You know what is state? Government and Parliament of India, government and legislatures of each states, all local and other authorities within the territory of India under the control of government of India. We have discussed all these concepts in detail with multiple examples in the class. Correct, right? But again, we will just go through the example. You guys tell me, is electricity board is a state? Yes. Come under which point? Is it a government? Is it a government? Is it a, I'll ask questions. Is it a government? Is it a parliament? Is it a state? Sorry, is it a state government? Is it a legislature of the state? Is it a local authority? Is it a local authority? No. Is it a other authority? It is other authorities. What do you mean by local authorities? Nothing but this panchayat, district board, then port trust, all these called as what? Local authorities. This electricity board come under the concept of what? Other authority, and that is the one of the most disputed area in the Constitution of India. The concept of other authorities. What are considered as other authorities? Any institution or any body corporate in which government has a deep and pervasive control, or if an institution is an agency of the government. You know what is agency concept, right? What do you mean by agent? The one who acts on behalf of the other or represents the other in a dealing with which party? Third party. If you are representing me and you are nothing but I am only acting through you, right? So that is why even that agent is considered as what? State, for the purpose of fundamental rights. So if an institution is an instrumentality of the government or agency of the government, that instrumentality is also considered as what? State. And our fundamental rights are available against the state. Are we clear with this? Electricity board. What board? It's a state. No. Electricity board, is it a state? Yes. Because it comes under the what? Local authority. Government has a deep and powers. Sorry, other authorities. Because it comes under the what? Government has the deep and pervasive control. Next one, electricity board. It is state. Yes. And who has the judicial review? The High Court and Supreme Court has a judicial review power under Article 226. High Court under Article 226 and Supreme Court under Article 32 of the Constitution of India. Judicial review is one of the fundamental or basic structure of our Indian constitutions. Correct, right? Yes or no? Yes. Next one. Universities. Our universities are considered state because there is a deep and pervasive control by the state government. The governments. Next one. President. President is a state? Yes or no? Next one. Is income tax department is a state? Yes. International airport authority, is it a state? Yes. Why? Because it is the agency of the government. What of the government? It is a local authority. That is why even the airport authority of India is considered as what? State. Next one. Decide whether an institution is an instrumentality or agency of the government, because we know that if an institution is an instrumentality or agency of the government, it is considered as what? State. Now, how to decide whether an institution is an instrumentality or agency of the government? There are 6-point test. How many point test? And these 6-point test was given in which case law? Ajay Asia versus Khalid Mujib case law. Mark it important. Mark it important. If they ask questions based on Article 12, based on this concept, they'll ask questions. How to decide whether an institution is an instrumentality or agency of the state? What is the first condition? Entire share capital. What capital? Is held by who? Government. If entire share capital is held by the government, we can assume that it is an instrumentality of the what? State. Second one, government provides almost what funding? entire funding. Third one, monopoly status is conferred by the state. We have the DRDO, which is monopoly status is there, correct, right? If an institution is enjoying the monopoly status, we can presume that, or we can come to a conclusion that it is a instrumentality of the state, hence it is also considered as the state. Fourth one, deep and pervasive state control, means government take most of the decisions or major decisions, it is considered as state. Next one, functions of what importance? And the last one, government department is transferred to the corporations. If department of the government is transferred to the institution, it is considered as the state. Clear? What are the tests to be satisfied? What is the first one? You should write all the 6 points 1, 2, 3, 4, 5, 6. Based on these 6 points, you will decide whether it is a state or not, whether it is the instrumentality of the government or not. See, simple. A authority is considered as other authority if it is a instrumentality or agency of the government. How to decide whether an authority is an instrumentality or agency of the government? Based on how many points? It is not like all 6 points to be satisfied. You have to decide based on case to case basis. And these are not conclusive points. There can be other criteria also which court can take into consideration for the purpose of decisions. Clear? So what are the conditions given in the Ajay Asia versus Khalid Mujib case law? What is the first one? Entire share capital, entire funding, deep and pervasive control, monopoly status, department of the government is transferred to the institution, or the functions are of what importance? Public importance. IRCTC. Have you heard about IRCTC? What is IRCTC? Is it a state? Because government is having what control? Deep and pervasive control. Is CSIR is a state? What is CSIR? Indian Institute of Chemical Biology. Is it a state? Why? Why? Because there is a deep and pervasive financial, functional and administrative control of the government. Is BCCI is a state? BCCI. Why? Because it is government is not having deep and pervasive control. Does government give funding to BCCI? Do government make decisions of BCCI? Do government have any representative in the board of BCCI? So is it performing functions of public importance? Is it performing the functions of public importance? No. That is why BCCI is not a state. If BCCI is a state, then you can enforce your fundamental rights against the BCCI. Clear? Next one. NCERT. Is NCERT is a state? Based on this, you can ask practical question in the examination. Stock exchanges? No. NSE and BSE. Are they state? No. But are they enjoying monopoly status? Yes. M6 is having monopoly status. BSE and NSE there is having what? 0. Next one. Air Force School. Is it a state? Air Force School is not a state because government is not having the deep and pervasive control. Institute for Plasma Research. Is it a state? Yes. Because receives full funding from the Department of what? Atomic Energy. Because it is receiving the full funding from the government, it is considered as what? State. Where is it a state? Is ICAI, ICSI, is it a state? No, it is not a state because government is not having deep and pervasive control. Government is not giving funding. Government is only established it by through a law in the parliament. Next one, Air India. Is Air India is a state? Yes, 100%. Stake is with whom? With the government. So based on this, there are chances that they'll ask practical question in the examination. Any question they ask, your answers depends upon 2 points. First one, definition of state. Second one, this Ajay Asia versus Khalid Mujib case law. Those 6 points you should write in the examinations. Can you guys repeat those 6 points? Entire share capital, entire funding, monopoly status, deep and pervasive control, public functions are of public important and department of the government is transferred to the institutions. Are you clear with this? Based on this, what type of question might come in the examinations? There are 2 questions which were asked in the previous examination. What is the first question? Explain the test laid down by the Supreme Court of India for determining whether an entity is an instrumentality or agency of the state. What do you write for this? Ajay Asia versus Khalid Mujib case laws points. Next one. What do you understand by the expression state under part 3 of the Constitution of India? Explain the help. Explain with the help of a decided case law on this point. Can you guys write this case name Ajay Asya versus Khalid Mujib case law? Done with this. So there are asked only two type of questions. Now there are chances of asking practical questions. For the practical questions, we have discussed many examples. IRCTC, BCCI, all these are not considered as IRCTC is a state, but not the BCCI. Done with this. Next one. Justifiability of fundamental rights, Article 13, one of the important concepts based on which they'll ask questions in the examinations. There are three doctrines under this. What are the three doctrines? Doctrine of severability, doctrine of eclipse, and doctrine of waiver. Last one is not so important. What is the first two are important? Doctrine of severability and doctrine of eclipse. And before that, Article 13 provides definition of law. Article 13 clause 1 deals with existing law. Article 13 clause 2 deals with future laws. Article 13 clause 3 deals with and Article 13 clause 4 is an amendment to the Constitution of India, Article 13, which provides that nothing contained in this article shall apply to which laws? Constitutional Amendment Act. Which act? So Constitutional Amendment Act is not a law. Not a what? Law for the purpose of Article 13. So if a Constitutional Amendment Act takes away or abridges the fundamental right, is that law valid? No. See, any law which takes away or abridges the fundamental right, to that extent, the law is void as per Article 13 clause 2. Article 13 clause 2 provides that state shall not make any law which takes away or abridges what right? Fundamental right. And any law which takes away or abridges the fundamental right, to such extent it is what? Void. Now what do you mean by law? Law means act, rules, regulations, bylaws, ordinances, even to some extent customs are also considered as law. So now what do you mean by any law? If Parliament makes a law which takes away or abridges the fundamental right, will that law be also considered as invalid? In Parliament bring a Constitutional Amendment Act, take away fundamental right. For example, we had a right to property. Right to what? It is a fundamental right. But that has been removed. Yeah, Parliament has a right. So, a Constitutional Amendment Act to take away or abridge the fundamental right, will that law be considered as invalid? The answer is no. That is why Article 13 clause 4 is there, which says that law means all the laws except Constitutional Amendment. So if Parliament makes a law to take away or abridge the fundamental right, that law is valid provided it does not alter the basic structure of our Indian Constitution. Golaknath case, correct, right? And after that, Keshavananda Bharati versus State of Kerala case, correct, right? Article 13 clause 1 deals with what? Article 13 clause 1 covers the doctrine of severability. Yes. So not doctrine of severability, doctrine of eclipse. Existing laws, right? Yes. Any existing laws, to the extent they are become inconsistent with the provisions of Constitution of India, they'll be in what? Eclipse. They'll be in dormant status. Yes. Once that inconsistency is removed by amendment to the Constitution of India, they will be revived again. This is called as concept of eclipse. Clear? Article 13.1, 13.2, 13.3 and 13.4. What's Article 13.1 deals with what laws? Pre-constitutional laws are void to the extent to which they are inconsistent with the what right? Fundamental right. Article 13 clause 2 relates to future laws, that is laws made after the commencement of the Constitution. After the Constitution came into force, state is prohibited from making any law that takes away or abridges what rights? Fundamental. What is take away? Complete removal. What is abridges? Reduces the effect of that fundamental right. Next one. Any law made in contravention of this provision shall be void to the extent of such contravention. Definition of law. What is the law includes? Rules, regulation, notification, custom, usage having in the territory of India the force of law. I have explained each and every word in detail in the class. I will not explain it again. I explained what is the meaning of the ordinance, order, bylaws, rules, regulations, notification. What is the difference between rules and regulations? Who makes the rules? Executive. Who makes the regulations? Regulatory bodies. When SEBI make regulation, we call it as what? Regulation. SEBI regulation, not SEBI rules. When RBI makes law, it is called as what regulation? RBI regulation, not RBI rules. Here, we have discussed all these things. Even customs are considered as law. That is why this custom of not allowing the women to Shabarimala temple was challenged in the court. And it is still going on in the Supreme Court now. Yes or no? Next one. To nullify the effect of Golaknath case, where in the Golaknath case, the judges held that law includes even which act? Constitutional Amendment Act. So if that is true, then Parliament cannot change any part of the fundamental right. So to nullify that effect, the Parliament got an amendment to Article 13 saying that nothing in this article shall apply to any amendment to the Constitution. Amendment made to the Constitution under which article? 360A. Means the definition of law does not cover the Constitutional Amendment Act. Which act? Because if the definition of law covers even the Constitutional Amendment Act, then Constitutional Amendment Act itself is void. If Constitutional Amendment Act is void, there is the question of amendment to the fundamental rights. So to balance both, what court has done? Court has got a principle of basic structure. What structure? So Parliament has the power to alter any part of the Constitution of India, including the fundamental right, except what structure? Basic structure. Judicial review, federalism, distribution of powers, then equality. All these are what structure? Basic structure of our Constitution that cannot be altered. Clear? So this is Article 13. Article what? 13.1, 13.2, 13.3 and 13.4. Article 13 deals with what? Justifiability of what rights? Fundamental right. Article 13 gives teeth to the fundamental rights. And a law is declared as void by the court. Under which article? 13. If a law is made by the Parliament or any, let's say, state, if a law is made by a state which is inconsistent or against the fundamental right, who will declare them as void? Court. Who has a judicial review power? Which court? High Court and Supreme Court. Under which article High Court has a judicial review power? Article 226. Under which article Supreme Court has judicial review power? Article 32. So if any law, if it is inconsistent with the fundamental right, we can approach whom? High Court or? High Court or? And High Court and Supreme Court has the power to declare a law as invalid. As per which article? 13. Because 13.1 says existing law inconsistent, void. 13 clause 2 says state shall not make any law which takes away or abridges what right? Fundamental right. If they make such law, they are void to the extent they are inconsistent with the fundamental right. Are we clear with this? Next, this case law is important. Based on this case law, there can be a practical question in the examination. CBI versus RR Kishore case law. What's the case there? I hope all these things are there in your material. It's there in your material, right? See what happened in this case law. Simple. There was a law made by the Parliament. There was a law made by the Parliament which required the consent of an authority to arrest a person if he is a government servant. A law was made where the CBI required permission of certain authority to arrest a person. To arrest what? That law has been made. So, if CBI want to arrest any government officials, what officials? They need permission of certain authority as per the new law. What CBI has done, They have arrested a person without approval of an authority. As per this law, is the arrest valid or not valid? Why not valid? Because they didn't take the approval. During this time, what happened? The law itself was challenged in the court, saying that this law is against Article 14 of the Constitution of India. Because all are equal before the law. But now you are saying to arrest this person with approval of who? Authorities. They challenge it under Article 14 of Constitution of India, and court declared that it is unconstitutional and hence it is void. Are you guys clear with this? Now the law has been declared as what? Void. Now the question is it void from the date of order of the court, or is it void from the date of enactment itself? Now the question is this arrest valid or not valid? Is this arrest valid or not valid? Why it is valid? Because that law which was requiring the approval itself was declared as what? Void. It is void from the beginning itself. So hence the arrest is what? Valid. That is what held in which case law? CBI versus RR Kishore case law. Now you guys need only 1 minute to read this and understand it. Just go through it please. First one, Supreme Court held that once the law is declared as what? It is considered to be void ab initio. What is void ab initio? It is treated as if it never existed. The court emphasized that if a law is found to be violative of Part 3 of the Constitution, it is deemed to be stillborn, means it is not came to existence, unenforceable, and not existence in accordance with Article 13, Clause 2 of Constitution of India. In line with Subramanian Swamy case, the court declared that Section number 6A of TSP Act would be treated as not in force from its insertion date itself. Section 6A required prior approval of central government before the CBI could initiate inquiry or investigation against a senior public servant. Accused officers challenged the CBI actions on the ground that no prior approval under section number 6A was taken. Court held that section 6A itself never existed in law, so the accused cannot rely on its invalidate arrest. Why? Because that section number itself was declared as what? Unconstitutional and void. Based on this, they can ask practical question in the examinations. Are we clear with this? So once a law is declared as unconstitutional, it is considered as stillborn and it is void from the beginning itself. The next one. Doctrines. What is the first doctrine? Doctrine of severability. So now just now we discussed, we had a law called as DSP Act, correct, right? DSP Act. Out of these, only one section number was against the fundamental right. But the question is the entire law considered as what, or only that section number? That is what called as doctrine of severability. It is not the entire law which is considered as void. It is only that part which is inconsistent against the fundamental right is considered as what? Void. And if it is possible to separate, possible to what? And if that after separations, the remaining part can still give an effect to the object of the law, it is considered as valid. That is what called as doctrine of severability. Doctrine of what? What does it say? Law is void. What is void? Is the entire law is what? Only the part of the law is void. The extent of its inconsistency or contravention with what right? Fundamental right. Under Article 13 of the Constitution, it is not the entire law that becomes invalid if it violates a fundamental right. Only portion of the law which is inconsistent. You should use this word called as inconsistent and contravention. Only that part of the law which is inconsistent with what right? Is considered as what? Void. While the remaining valid portion continues to operate. This principle is called as doctrine of severability. But however, to apply the concept of doctrine of severability, the important point is that after separation, the remaining part should still be able to give effect to the what? Object of the law or purpose of the law. If 90% of the law is inconsistent, what is the use of keeping remaining 10%? That is not considered as valid. So the doctrine of severability is applicable only when after separation the remaining part can still give effect to the what? Object of the law. What of the law? Object of the law. This para is important. The courts have clarified that to apply this doctrine, the invalid part, which part? Must be severable from the valid part. After removing the invalid portion, the remaining part of the law must be capable of functioning independently and give effect to the intention of the legislature. What of the legislature? Intention of the legislature. That is what considers what? Doctrine of severability. Doctrine of. Now you guys tell me what you guys write in the examination if they ask question about doctrine of severability. Very good. The law is void only to the extent it is inconsistent or contravention of the fundamental right. This is also called as doctrine of what? Severability. As per Article 13 clause 1 of 13 clause 1, right? Article 13 of the Constitution of India, it is not the entire law which is void, it is only that part of law which is inconsistent with the fundamental right is void. And the remaining part which is valid will continues to offer it. However, to apply this doctrine, the remaining part, after separation, the remaining part should be able to give effect to the purpose of the law or object of the law. Clear? And for this, we have this case law. What is the case there? AK Gopalan versus State of Madras. If you remember, you can write this case law. Otherwise, you can ignore this case law. Done. Next one, doctrine of eclipse. Doctrine of what? Is it applicable to Article 13 clause 1 or Article 13 clause 2? Only for the existing laws. What laws? In the existing law, that is the law which was in existence before the commencement of Constitution of India becomes inconsistent with the fundamental right, then it becomes what? Dormant. It stays inactive. Once that inconsistency is removed by amendment to the what? Constitution of India, then that provisions are revived again. This is called as doctrine of eclipse. Doctrine of. First point, what you will write? Applying to what laws? Pre-constitutional laws. Under Article 13, an existing law that is inconsistent with the fundamental right does not become dead altogether. Such laws become inoperative. You should remember this word called as inoperative. Only from the date of commencement of the Constitution and only to the extent of inconsistency. Not the entire law again. It becomes inoperative only to the extent of what? Inconsistency. The law is said to be eclipsed or dormant as it remains on the statute book but cannot be enforced. If the constitutional prohibition is later removed by amendment, the eclipsed portion of the law revives automatically. This principle is known as what? Doctrine of eclipse. This para is most important. What is the last para? If the constitutional prohibition or inconsistency is later removed, later what? The eclipsed portion of the law revives automatically. This principle is known as what? Doctrine of. Understood? If the prohibition of constitution or inconsistency of the constitution is removed, then the eclipsed portion is revived automatically. This principle is called as what? Doctrine of eclipse. And this doctrine is applicable for which laws? Existing laws. And the existing law, to the extent they become inconsistent with the fundamental right after the commencement of Constitution of India, they become dormant and inoperative. And once that inconsistency is removed by amendment to the Constitution of India, then they will revive automatically. For example, before the commencement of Constitution of India, there was monopolies given to the transportation business. There was a monopoly in what business? Transportation business in favor of the state. And as per Article 19 of the Constitution of India, freedom of what? Trade. So this law which was creating monopoly becomes what? Eclipsed. because it is inconsistent with what right? Fundamental right. But later what government did, they brought amendment to the Article 19 itself to allow the state to create what? Monopoly in its favor, in the interest of who? Public. Now that law is revived automatically. This principle is called as what? Doctrine of eclipse. Doctrine of. Next one. Same case law is there. You guys can go to the case law later. We have discussed all this case law in detail in the class. Next one, doctrine of what? Can a person waive the fundamental right? Yes. But in the recent judgment, the court have held that a person cannot give up his fundamental rights. What rights? Fundamental right. The doctrine of waiver is based on the idea that a person is the best judge of his own interest and may choose to waive the enjoyment of certain rights conferred on him by the state. For a valid waiver, the person must have full knowledge of the right and the waiver must be voluntary. Position under the Indian Constitution, in India, fundamental rights cannot be waived. The courts have consistently held that fundamental rights are guaranteed not only for individual benefit but also for the public policy and constitutional governance. Thus, it is not open to citizens to waive any fundamental right guaranteed by the Constitution. As per Indian Constitution, you cannot waive the fundamental right. Based on this, what type of question they asked in the examinations? Please look at the question. What is the first question? Can you guys write the doctrine of severability? Next one. Any law. Consistent with fundamental. It is not necessary to stop. It's only a part. This concept is called as what? Doctrine of severability. That is what we just discussed. That next one. Based on question number 2 is there. This question was asked in the recent examination, that is December 2025. Read the question, everybody. Is it severed means what? Separated. Is it possible to separate? Possible or not possible? Section number 8 and section number? Which one is valid? 8 is valid. What does 8 says? Promotion of awareness programs for communal harmony in the school. Is it valid? Yes. Which one is invalid? The public conducting of public meetings without prior. It's a violation of which article? Article 19(1). C, correct. Article 19(1). C, freedom of association, assemble peaceably without any arms. Correct, right? So now here, 2 section numbers are there. One is against the fundamental right, and is it possible to separate it? Yes. So which part is valid? Other part is valid. This is called as doctrine of severability. How to write the answer for this? Can you guys read the answers as well, please? According to Article 13, Clause 2 of the Constitution of India, this principle is called as doctrine of severability. At that point, when you write to apply this principle, the remaining part should be able to serve the purpose for which the law has been made. then only we can apply this doctrine of severability principles. In view of the above discussion, it can be said that we can also write the word called as in the view of above provision or as per the above provisions, in the light of the above provision, it can be concluded that, or it can be said that, or it can be answered that the section number 5 of the Social Harmony Act, which imposes a blanket restrictions on the public meeting, can said to be what? As it is violation of what right? Fundamental right, and can be severed. What is severed? Removed. And the rest of the act may continue to operate validly. Isko exam should be like this. It has some meaning, right? They must ask these kind of examinations from now onwards. Not only for this chapter, for every chapter, they must ask this kind of questions where students use their brain and answers the questions in the examination instead of asking explain doctrine of eclipse, doctrine of severability. It's of no use. This checks the conceptual clarity of the student, right? Yes or no? Clear with this? And this type of question they asked in the previous examinations. Don't complain that examination is difficult. Prepare for it, because situation is like that. You should use your brain. You should have that interpretation skill, problem solving skills. That is what sells in the market. Just having information here is of no use. Correct, right? You must have the problem solving skills. That is why you get paid in the market. Correct now? So that is why don't complain, prepare for the examination. Next one, discuss doctrine of eclipse under what? Constitution of what? India. Can you write about doctrine of eclipse? Yes or no? Next one, is it applicable to post constitutional laws or pre-constitutional laws? So we are able to solve this question also. Next one, we will start with our fundamental rights. What rights? Ready. Let's start. Right to equality. Which article? So Article 14 says state shall not deny. Simple. It's the obligation upon whom? State. State shall not deny to any person. Is it citizen of India or only any person? It means citizen or not a citizen of it doesn't matter. The state shall not deny to any person equality before the law and equal protection of the law. Which concept is derived from UK Constitution? Equality before the law. All are equal before the law, irrespective of their caste, irrespective of their creed, irrespective of their financial position. Correct, right? And equal protection of law is most positive approach. What approach? And it is derived from which constitution? US Constitution. So equal protection of the law allows classification. Yes. Because we can treat two peoples as equal only if they are equal. Treating equals as equal is called as equality. Treating unequals as equal is not equality, it's a discrimination. And to bring everyone to equal status, there should be what? There should be a classification, there should be some special measures, special provisions in favor of. That is why we have a concept called as classification. Article 14 prohibits class legislation but allows classification. And to be a valid classification, there are two conditions must be satisfied. What is the first one? There are two conditions to be satisfied for the purpose of a valid classification. Remember, the first thing is there should be intelligible differentia. There should be intelligent reasons for that classification. And the second condition is that there should be a rational nexus. A reasonable nexus, a connection between the classification made and the object to be achieved. If you make any random classification, arbitrary classification, is it valid or not valid? Not valid. Keep this in mind. Arbitrariness and equality are both are enemies. If there is an arbitrariness, there is no equality. Agree with this? If you favor somebody arbitrarily without any basics, without any intelligent reasons for that, it is considered as violation of Article 14. Just now we discussed that provision, right? Did they had any intelligible reasons for requiring approval of the central government to initiate investigation against the senior officers? No. That is why that law was considered to be invalid. Are you guys getting it? So in the Article 14, there are three important concepts. First one is what you should remember the definition of Article 14. It says state shall not deny. Who shall not deny? Mhm. Mhm. What? Unequal protection of the, which one is derived from US Constitution? Which one is derived from UK Constitution? Equality before the law. Which one is positive approach? Which one is negative approach? Equality before the law. Clear with this, everybody? So it is one of the basic feature of Constitution of India, the basic structure of Constitution of India. Can it be taken away by the Parliament? Is it possible for the Parliament to take it away? No. Legislative classification, based on this, they ask questions in the examination. If there is a question, the question will be based on this legislative classifications. What do you mean by classification, sir? The doctrine of classification gives meaning and substance to the guarantee of equal protection of the laws by allowing to separate person similarly situated from those who are not. That is why we have the classification of SC and ST, scheduled caste and scheduled tribes. Are they same or different? There is a classification, right? What is the classification? Scheduled caste is different, scheduled tribe is different. Yes, sir. Next. Uh, you should not treat everyone as equal. You should treat everyone as equals. That is, unequals as equal. It is called as discriminating. You should treat the one who are similarly situated as equal. This concept is called as what? This concept is called as equality. For the purpose of achieving the equal protection of the law, there can be a legislative classification. What classification? There should not be a class legislation. You cannot make a law for a separate class of people. But you can make what classification? Legislative classification. For what reasons? Equal protection of law. What protection of law? The rules with respect to permissible classification as evolved in various decisions have been summarized by the Supreme Court in Ram Krishna Dalmia versus Justice Tendulkar case. Sachin Tendulkar. Justice Tendulkar. What is the first one? Article 14 prohibits, but not the forbids the classification. It forbids class legislation, but not the classification. Second one, permissible classification must satisfy how many conditions? What are two conditions? It must be founded on an intelligible which differentia, which distinguishes the persons or the things that are together from the others left out of the group. For example, we have scheduled caste, scheduled tribes, and general category. These are groups, right? And they are based on certain intelligible reasons, based on their caste and based on their scheduled tribes are because they are into tribal areas, right? Shillong, people who are from Shillong are considered scheduled tribes, STs. Yeah, Shillong is a scheduled, it's a tribal area. Shillong. Shillong is famous for this flower. Which flower? Costliest flower. Huh? Not one of the costliest flower. People say Brahma Kamala in Bangalore. Orchids. Orchids and cherry. That's also famous in Shillong. Yeah. Okay. Anyway, 20 days, 20 days of examination. Article 4, hey, concentrate guys. We have to cover many things, as I said. No wasting of time. Article 14 forbids class legislation, but not a classification. Permissible classification, that is for how many conditions? There are two conditions. What is the first one? What are the conditions to be satisfied for permissible classification? What is the first one? Intelligible differentia. Second one, the differentia must have a relationship between the what? Objects sought to be achieved by the statute in question. So there should be a connection, the rational nexus between the object to be achieved and as well as the classification made. See, first one. The classification should be based on the intelligible reason. Second one, there should be a rational nexus between the classification made and the object sought to be achieved by the law. Only when these two conditions are satisfied, that classification is valid. This classification can also be a single person classification. Even a single person can be considered different from the other persons. Right, right. We had discussed one person law, Charanjit Lal case law, where a law was made for one single person. Valid or not valid? Valid. Why? Because he was in a different situation from the others. Clear with this? Let's start. The classification may be followed on the different basis, namely geographical areas, according to the objects or occupations or the like nature. The classification can be either based on the what? Geographical areas, or according to the objects or occupations or the like nature. In permissible classification, mathematical nicety and perfect equality are not required. It is not possible to have a 100% perfections in classifications. Correct, right? However, non-identity of treatment is enough for the purpose of classification. Even a single individual can be considered as what? A class by himself on the account of some special circumstances or reasons applicable to him and not applicable to the others. I have discussed this case law called as Charanjit Lal Chowdhury versus Union of India case law, if you guys remember. That spinning and waving company, they were employees, it was about to close. Because it was about to close, government took over the control by a law. He challenged that law, saying that his law is against the fundamental right, but court held that you are different from the others, that is why it is valid. Correct, right? Next one, there is always a presumption in favor of constitutionality of any enactment, and the burden is upon whom attacks it. So whoever say it is unconstitutional, he has to provide evidence to the court of laws. Are you guys clear with Article 14? What does Article 14 says? Repeat, what does Article 14 says? Right to equality. It says state shall not deny. Shall not deny? Deny what? Equality before the law, equal protection of law to any person. To any persons. Correct, right? Then you also write two more points with respect to the Article 14. Then you shift to the classification. Legislative classification. Article 14 forbids class legislation, but not the classification. For the purpose of achieving equal protection of the law, there can be a classification subject to how many conditions? Two conditions. Conditions. What is the first one? Intelligible differentia. Second one, rational nexus between the classifications and objects sought to be achieved. And there is no requirement of mathematical nicety for the purpose of Article 14 of the Constitution of India. Are we clear with this, everybody? Yes or no? Now, there are certain case laws. Let us discuss whether a law made only for one company violates equality. The situation is different. If the one company is different from the other companies, can the classification valid or not valid? Even single person can be considered a separate class. What class? Subject to how many conditions? Next one. With special codes without guidelines violate equality? Yes. There should be a proper guidelines. If you are establishing a special code without proper guidelines, is it valid or not valid? This is again comes under the administrative law. See, special courts are administrative authorities. They come under the executives, tribunals. Yes or no? Any delegation of power which is unguided, uncontrolled, without any principles, is it valid or not valid? Not valid. It is a violation of fundamental right. Article 14. We discussed this, the judicial review of administrative discretion or executive functions. See, if I say government, if state makes a law saying that state has the power to refer certain cases to this special court, is this provision clear or ambiguous? If I say you are a state government, you can refer certain cases to whom? Special court. Means I am giving, the law is giving discretionary power to whom? State, the government, executive, without any control. There is no guidance, there is no proper provisions here. This always lead to abuse of power, right? Yes. That is why it is against the what? Fundamental right. Which are fundamental right? Article 14. Now the government can discriminate among whom? Different people. So any establishment of special court without proper guidelines is considered as void because it is against the what right? Fundamental right. What right? Next one. Whether special courts for disturbed areas are valid? What is disturbed areas? Special areas. Like there are some disturbances, floods. Whether are not valid? Valid. Degree holders were promoted, while diploma holders were not. Is it valid? Yes, valid. Valid classification. Are they same or different? Is the classification valid? Yes, valid. Classification can be made based on education as well to achieve certain purpose. Yes or no? Next one. SC/ST employees were promoted even if they had not passed departmental test. Unlike general category employees. Is it valid? Yes, because they are separate categories. Next one. Passport was impounded without giving reasons or hearing. The provision which gives the power to police officer to impound the passport without proper reasons. Valid or not valid? Not valid. Against Article 19 of the Constitution of India. Next one. Hair roasters were terminated on the pregnancy while male staff were not. There was a policy that if the girl is conceived, she'll be terminated from the employment. Is it valid or void? Because it is against the right to equality. When woman is removed, why not boy? And pregnancy is not a incapacity. Pregnancy is not a what is it? It's not a disability. It's against the article what? 40. This was held in which case law? Air India versus Nargis Mirza case law. One of the celebrated case laws in Indian history, the Constitution of India. Next one, horse racing was treated as gambling when other skill-based games were not. Is it unconstitutional? Yes. Muslim husbands could divorce unilaterally. Wives had no such right. Is it constitutional or unconstitutional? Triple talaq was held to be unconstitutional. One of the famous case law, Shaira Banu case law, where the court held that triple talaq is unconstitutional. It violates the what? Article 14 of the Constitution of India. Yes or no? Now there is a classification. This classification is not valid. Next one. Law punished only men for adultery. What's adultery? It's a tree climbed by the adults. No. Law punished only men for Law punished only men for the adultery means having an affair after you are married. So men was punished, but women were not punished. But later the government struck down this section number saying that if you are punishing, punish both. Otherwise, don't punish. It's against the equality. Correct, right? Am I saying anything wrong? This is consensual same-sex relationships were decriminalized. Are they not criminalized? Decriminalized. Earlier it was a crime, but now it is no more a crime. No, it is no more a crime. But marriage is not identified. It is not it legalized. Means you cannot get married and get claim the marriage status, but however, restricted, so you can live together. It is not a crime. Investigation against superior officer required special permission. Is it valid or not valid? We discussed just now. We discussed now because it is a classification without proper reasons. Next one, loan waiver applied to small farmers but not to the large farmers. Is it valid? There's a separate specific reasons for this classification, right? Farmer. But small farmer, I'm waiving the loan. Large farmers are not waiving the loan. Is it classification valid or not valid? Is it a violation of Article 14 or not a violation of Article 14? Why? Because there is a proper reasons for the classification. Yes or no? Next one. Reservation extended to what classes? Backward classes. Valid or not valid? Valid. Prisoners segregated based on caste-based occupation rules. Not valid. Next one. Question was whether state can further classify scheduled castes to ensure that most backward among them actually receives the benefit. Yes, among SC itself there can be further classification based on their income status or other status. These are the recent case laws based on which they can ask practical questions in the examination. These are not there in your material, only few case laws are there, but based on this, they can ask practical questions in the examinations. Based on this, what type of question they've asked in the examinations? There are around 4 questions. I want everyone to read these 4 questions fast. Can you guys answer this question? Next one. What is the scope of but does not forbid to write Article 14? You also write the important points of justice. What Tendulkar? Tendulkar. Which Tendulkar? Justice Tendulkar. Okay. Discuss the rules with respect to permissible classification as evolved in various decisions and have summarized by the Supreme Court in Ramakrishna Dalmia versus Justice Tendulkar. The 6 points are there, right? You should write those 6 points. Just now we discussed now. It forbids classification, sorry, forbids class legislation, but not the classification. Condition to be satisfied. No mathematical nicety is required. It can be based on a geographical area or based on qualifications, all these things. Next one. Article 14 of the Constitution of India does not rule out classification for the purpose of legislation. What it requires is valid classification for the same. Explain. Can you write those extensions and write these answers? If you remember, you can write the case laws also. At least Hostess case law, adultery case law, decriminalize, Sharavanu case law. No. Next one. Can there be a law for single person? Yes, we have discussed all this. Article 14 is done. Article 15, one of the important article based on which they can ask practical questions in the examination. You guys tell me what does Article 15 says. Article 15 prohibits state from against any citizens on grounds only of what? What are the 5 grounds? Religion. Either all of them or any of them. So if the question is based on only these 5 grounds, it is not allowed. Not allowed. However, if addition to any of these 5 prohibited grounds, there exists some other valid and reasonable basis of differentiation, such discrimination is constitutionally permissible. For example, let's say certain jobs are reserved for the men only. Is it a violation of Article 15? For example, working in the mining areas, the result only men is allowed. Is it a discrimination? No, not a discrimination. Why? Because there are some other factors taken into consideration under the purpose of that job. Clear? So Article 15 prohibit the state from what? Discriminating against who? Citizen on the grounds only on citizens. If they are non-citizens, there can be discriminations. Based on what? Religion, race, caste, sex, place of birth, or any of them. Article 15 prohibits discrimination based on how many grounds? 5 grounds. Example, employing only males in heavy industries or mining activities, or hair hosters job reserved for the women. Most of the hair hosters jobs are reserved for the women only, right? Because it requires that patience. Women tend to have the patience. For me, when I hear this word patience, correct, right? Yes or no? Next one, guys. 20 days. Let's start. Next one. Article 15, clause 2. Don't have time. Article 15, clause 2. What is Article 15, clause 2 says? No citizen shall be subjected to any disability, restriction, or condition. What is disability? You can't do that. What is restriction? For you, for her, no restriction. For you, there are restrictions if you want to get access to the shop. Next one, condition. What is conditions? Are restrictions and conditions both same or different? What are the difference? What is the difference?
Conditions convictions be when you're allowing something, but like you are
Subject to few.
boundaries.
Yeah, restrictions is like random. Like you need permission for doing the restriction. You need if you need permissions for doing something, we can say it's restriction. If you're supposed to satisfy something to do that, it is called as what? Condition. Can we say this?
Condition applies to all restrictions applies to some kind.
That can also be taken like restrictions are like I uh, uh, I restrict you from doing this thing. They say right, this area is restricted, restricted areas, restricted entries. Correct, right? So keep these three words in your mind. No citizen shall be subjected to any disability, restrictions, or condition with respect to access to the shops, public restaurants, hotels, places of public entertainment. What is the first one? A girl go to a shop. She buy nice dress. Then she go to the restaurant to have a dinner. Then they go to the movie to get entertainment. In all these places, she is facing what? Restrictions, disability, or conditions. Allowed or not allowed? No citizen shall be subject to any disability, restriction, or a condition with regard to the what? Access to the shop, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing arts, roads, and places of public resort maintained wholly or partially out of state funds are dedicated to the use of general public. Last 2 points are important. Either it is maintained wholly or partially out of state funds or dedicated to the use of whom? General public. She goes to a shop, but that person says, "Ma'am, because of your this trust, I will not sell this trust to you." She got disappointed. Then she go to the hotel to have a dinner. Sorry, restaurants to have a dinner. In that restaurant, that person is saying, "We will not serve food to you because of this cost." Then she go to hotel to rest for some time. And the person says, "Ma'am, we will not give room to you because of your this reason." Then she goes to a movie to get some entertainment. And the person says, "Ma'am, you're not allowed inside this because you're of this religion." Is it a violation of Article 15 Clause 2?
Yes.
Because Article 15 Clause 2 says no citizen shall be subjected to what? Disability, restriction, or condition with respect to access to the first shops, then and first shop, then restaurant, then hotel stay, then now you guys remember because of this girl example. Next one, correct, no, first she goes to shop. She does shopping, a nice dress. You can imagine, I know what's your imagination is now. You will be like that, suddenly that nice dress will pop up, right? Fancy wala. I didn't give the boys example. Why? Because boys होता है इसमें like we don't have any fancy things to buy. कुछ भी चलता है. Correct, right? Anyway. Marathon. Next one. 15-2 is done. What is 15-1? Five rounds. No citizen shall, the state shall not discriminate among any citizens based on how many grounds? 5 rounds. No citizen shall be subjected to disability, restrictions, or condition with regard to access to shops, public restaurant, hotels, entertainment, or the use of wells, tanks, or bathing guards, roads, or places of public resort maintained wholly or partially out of the state funds or dedicated to the use of general public. Are there any exceptions? What is the first one? Article 15 Clause 3, state can make what provision? Special provision for who? Women and children. This is also called as positive discrimination. It is allowed. That is why we have special reservations in metros. Separate one section is for ladies. Correct, right? Okay, next one. Children's, there is a special provisions for the favor in the favor of children's as well. Correct, right? They provide this midday meal, egg, milk, and all these for the kids. Why? Because they were like, see, the reasons there is a special provisions in the favor of women. Why? Because the women were harassed over a period of time in the history of human development. Correct, right? That is why there are special provisions to eradicate those differences and in the societies. That is why, in case if you register a property in the name of woman, there is a concession in the stamp duty. You cannot challenge it. Why? Because it is not a discrimination. It's a positive discrimination. What discrimination? Positive discrimination. Allowed. Article 15(4) empowers the state to make a special provision for the whom? Advancement of socially and educationally backward classes of citizens. You should remember whatever we discuss in the class in today's class itself. Okay, focus everybody. Focus. What is the first one? Article 15 clause 1 is done. What is 15 clause 1? Prohibit state from making discriminations based on 5 Article 15 clause 2 provides the state shall not, no citizen shall be subjected to any disability, restriction or condition with respect to access to the shops, restaurants, last or wells, tanks, or public routes which are resorts which are maintained wholly or partially out of the state funds or which are open to the public. Next one, Article 15 clause 3, state can make special provisions in favor of women and children. For example, we have the examples like Maternity Benefit Act 1961, which gives benefit only to whom? Women, if she is conceived, not to the men. Oh, she get a paid leave. Do men get paid leave? No, men don't get paid leave. Who gets the paid leave? Women. Next one. Do we have National Commission for Women? Do we have National Commission for Women? Yes. For every minute thing they come up and they make this. Recently, this some song controversy happened, right? They take actions because. Yeah. Do we have National Commission for Men? Do we have national commissions for men? No, there is no national commissions for men. Is it a discrimination? Not a discrimination. Positive discrimination. Not allowed? Allowed. Next one, Article 15 clause 4. Article 15 clause 4. 15 clause 4. Um, let's start. Article 15 clause 4 should read along with me. Start. Sand mein padhai karenge. Done? Ready? Yes. Let's start. Article 15 clause 4 empowers the state to make special provision for the advancement of socially and educationally backward classes of citizens. Socially as well as educationally backward. Third one, so second one, and the third one, scheduled tribe. First one is socially and educationally backward. Third one, SC. Fourth one, who can make special provision? State for the advancement of socially and educationally backward classes, scheduled caste and scheduled tribe. Article 15 clause 4. 15 clause 5 was inserted by the 93rd Amendment Act. Who can make special provision? State for the advancement of socially, educationally backward classes of citizens or scheduled caste and scheduled tribes in the matters with respect to admission to educational institution. This provision, Article 15 clause 5 was introduced to give a reservations in the educational institutions. Clear? Why? Because again, positive discriminations, equal protection of the laws. Because if you see, most of the educated were general category people. When the constitution came into force, at the time, most of the educated persons were from the upper categories like Brahmins and other categories of people. So there was inequality. Inequality was there, right? How to bring that equality? By removing the word inequality. To remove this inequality by giving certain special provisions for the one who is treated unequal. That is why there are reservations. But at present, The problem is that even the one who is not deserving those reservations are getting that reservations. That is where the problem is happening. Because, for example, if you are from north countries, for example, let's say you are from, let's say your father was, uh, let's say a person was from SC category or ST category. He got government job because there is a reservation. He earned so much of money. Now he is in the creamy layer, but his son is still enjoying the concept of what? Reservations. That is where the problem is happening. When these reservations were introduced, they were not bad. That was actually needed for the purpose of what? Removing the inequality. Problem is now there are certain class. It's not like they have achieved 100% equality. Still there are differences. There are still some category of the people who are below the poverty line. But the problem is that there are some people who are not eligible for this benefit, but they are getting the benefit. And there are some other category of people who are eligible for this benefit, but they are not getting the benefits. So these reservations are not bad. Reservations are not wrong.
But the main thing for this reservation was that ICSTs were like financially backward compared to general category.
Social and educationally backward for the purpose of reservations in educational sectors.
But what if they're like financially very stable than a general category as well, and they're financially able to pay the fees for the admission of the education
That
institution?
is where the problem is arising now. Now, there are some people in the same category who are competent enough to pay. Among SC itself, there are few people who are already crossed that creamy layer, like they are in the creamy layer now. Means they have achieved financial independence and they are doing well. But even they are claiming the benefit. That has to be removed. But that there should be a political will for removing that. Like we have to bring an amendment to the constitutions and they should do some classification among the SC itself. It's happening, but it is not happening in the center, like in the larger extent. Every state should do it now. Instead, it's a political will. If politics, the one who comes to the power, if they have the political will, they can change it. Otherwise, it will not happen. Okay. Anyway, let's discuss our 15 class 4 is done.
Yes.
15, what is 15 class 5?
Special
Provisions for the advancement of what? Social and educationally backward classes. SC, ST with respect to what? Educational institution. Keep this in mind. All educational institutions, including private educational institutions, but other than minority educational institutions. There can't be any reservations in the minority educational institution. You go to Christ College, no reservations because it is a minority educational institution. Jain College, minority educational institutions. So government does not have the power to give reservation in what institutions? Minority educational institutions. Are we clear with this? Next one. Article 15 clause 6 is one of the achievement of the Modi government. They brought this amendment to the Constitution of India in which year? 2019. Which year? Which gives reservation to the economically weaker section, EWS. They introduce a separate clause called as what? Economically weaker section, irrespective of your religion, irrespective of your caste. Correct, right? Can you read this provision, please? Empower the state to make special provision for the advancement of economically weaker sections of citizens other than those covered under Article 15 clause 4 and 15 clause 5 and special provisions in the matters with respect to admission to educational institution including private educational institution whether aided or unaided by the state other than minority educational institutions. Are you guys clear with Article 15? What is Article 15.1? No discrimination. 5 crores. What is 15.2? No disability restrictions and condition. 15.3, 15.4, 15.5, 15.6 are what? Exception. 15.3 women and child. 15.4 scheduled caste and scheduled tribe and economically and socially and economically, socially and educationally weaker section. 15.5, 15.6 for educational institutions. Same category but educational institutions. Are we clear with this? Let us go to the case laws, please. Let's read issue. What is the first case? Don't read the case name, just read the issue. Caste are a religion-based seats in the state educational institution. Valid or not valid? Not valid. Admissions cannot be denied on a prohibited grounds like caste or religion, etc. Non-domicile student charge capitation fees. Local exam. Is it discrimination on the place of birth? No, it is allowed. If you are from different state, they charge extra fees, right?
Yeah.
Is it allowed or not allowed? Why what is the reason behind this? Otherwise, yeah, only state students. Otherwise, what they will do, they will admit those students only, and there will not be any seat for the local students. Correct, right? Next one. But these things are not applicable for the minority educational institutions. Next one. Reservation for the backward classes. Creamy layer. Is it allowed or not allowed? Creamy layer exclusions evolved for OBCs to target the real backwardness. In OBC, we have OBC category, right? Other backward classes, but once your income crosses 12 lakh, I guess, you are considered as creamy layer. You will not come under OBC category. Even if you are, they introduce this concept only for OBC, not for SC and ST. In OBC, now I'm in a creamy layer. I am in a creamy layer. I'll not get any benefits of the government. I'll not get any ration in the ration shop. Because even though you are OBC, OBC covers what? Lingaites also considered as OBC now, right? And Lingaites are considered. No, mind Jain is Jain is not a caste, it is a religion, right?
Yeah.
They are Hindus, but they are considered as Hindus because the definition of Hindu is always inclusive in nature, not exclusive in nature. But that's religion. So in OBC includes this Gauda and Lingayat. Marwad is I don't know. I'm not expert in these classifications. I think array SC is different, ST is different, OBC is different, general category is different. General, all Brahmins come under what? General category. In that, there are certain categories also, like Lingayats is there, then some other category, some other peoples are there based on something. So many castes are there. So they come under OBC. In OBC, there's a concept called as creamy layer. Means once your income crosses certain limit, you will not be eligible for what? Benefits. They have done this in only for OBC, not for the SC and ST. So allowed or not allowed? Allowed. You guys can go to the absence of law to prevent sexual harassment at workplace. Now we have this POSH Act, prevention of sexual harassment of women at the workplace. Not only for women, even for the men also. Asking a colleague for a coffee for once is not a sexual harassment, but asking her again and again is a sexual harassment. Be careful when you ask your colleague for a coffee. If you ask her once, not a sexual harassment. If you ask her twice, sexual harassment. And passing comment on her personal life is also sexual harassment. Getting next one. This one, can we read this case law, please? Women barred from makeup artist membership work. Discrimination only on based on sex. Is it valid or not valid? Not valid. Article 15 clause 1. Makeup artist. ನಾಟಕ ಎಲ್ಲ ಮಾಡ್ತಾರಲ್ಲ ಆ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಶಿಪ್ ನ ಅಲೋ ಮಾಡಿರಲಿಲ್ಲ. Is it a discrimination? Yes. Based on what? The gender. Protective law restricting women's employment in the bars. Is it valid or not valid? Not valid. Even though it is protective in nature, but not protective in nature, it's a discrimination in nature. If you want to give protection, employ some officials and give protection to them and let them employ. What state government did, they banned the employment of women in bars, saying that it is for the protection of women. In the name of protection of women, you are discriminating the women. Yes, sir. So instead of that, what do? You bring a measures to improve the safety of the woman instead of prohibiting them from employment in the bars. Discrimination. See, these case laws will give an idea of what is discriminations for you guys. And to be honest, if you have this material, you don't need CSR for explanations for this. No, you need. Next one. SCBC and Maratha reservation breaching 50% ceiling and constitutional framework that struck down the Maratha reservations law, which exceeding how much? 50%. If you give more than 50% reservation, what about the other categories of people? Yes or no? English medium schools denied admission to students whose mother tongue was not English. Huh? Mandatory registration of transgender persons or self-reliance was declared what? Unconstitutional. Declared as what? It was requiring registration. It's also one of the gender, right?
Yes.
So if you discriminate based on the gender when it is not required for the registration is not required for the other category of people, why only for this category? But recently, I think it has been passed. The law has been passed which mandate the registration of these transgenders. Why they have? Because they have given a separate reasons for that. They want to bring welfare measures for these categories of people. One who is eligible. That is the reason they have assigned it. So it's a debatable issue, but it has been passed in the parliament. Court held that it is not unconstitutional. Anyway, Article 15 is done.
Yes.
If there's question in the exam, what you guys will write? Article 15. State shall not discriminate based on how many laws? Next, no citizen shall be subjected to disability. Next one, 15.3, 15.4, 15.5, 15.6. What is 15.3? Women and child. 15.4, socially and educationally backward. 15.5, 15.6, educational institution, including private educational institutions, aided or unaided, other than private educational institution. 16, equality of opportunity in the public employment. Let's start. Article 16 clause 2 guarantees equality of opportunities to whom? Is it equality of employment or opportunity? To whom? All citizens in the matters with respect to employment or appointment to any office under the state. If you remember here, employment or appointments to any office under the state. It also covers even the promotions as well. So there should be an equality of opportunity to all. It is not equality of employment, equality of opportunities to whom? All citizens with respect to employment or the appointments to any officer under the state. And Article 16 clause 2 prohibit discriminations against any citizens in the matters of employment on the grounds of what? Religion, race, caste, sex, descent, place of birth or residence. Exceptions are most important. Based on exceptions, they can ask questions in the examinations. Let's start. First one, 16 clause 3.
Yes.
16 clause 3 exceptions. Can a parliament Article 16 clause 3, 16 clause 4, 4A, 4B, 5, 6 are the exception to Article 16. Concentrate everybody. Parliament may by law prescribe residence within the state or UT as an essential qualification. What qualification? For certain class of employment or appointment under the government of the state or UT under any local or other authority within it. Who can require a condition? Parliament. Only who can make law? Parliament may by law prescribe residence. Underline the word residence. So here there is a discrimination which is happening based on residence. Is this allowed or not allowed? Allowed. Under which article? 16 clause 3. And this law can be made only by whom? Parliament. Parliament may by law prescribe residence within the state or a UT as an essential qualification for the employment in certain class of employment or appointment under the government of the state or UT or any local or other authority within it. For example, if you want to be employed in Jammu and Kashmir, you should be residing in Jammu and Kashmir. Is this law valid or not valid? Valid. Only Parliament can make this law, not the state government. Is it a discrimination based on place of residence? Yes. But is it allowed or not allowed? Allowed. Under which article? 15 clause or 16 clause 3. Are you guys getting it? What does article 16 clause 1 says? Guarantees equal opportunity of or appointment to any office under the state. Article 16 clause 2 prohibits discrimination against any citizen in the matters of public employment on the grounds of religion, race, caste, sex, descent, or the place of birth or residence. Exception, I hope you guys are clear with Article 16 clause 3. Parliament who by law prescribes that having residence in a state or a union territory as an essential conditions for certain class of employment or appointments to the state government or the union territory, UT government or the local or other authority. Is it valid or not valid? Valid. Next one, Article 16 clause 4. Provisions may be made for reservations for appointment or post in favor of whom? Backward class of citizens, which is in the opinion of the state is not adequately represented in the services under the state. Most important, this point is most important. There can be reservations. What can be there? Appointments at the post in favor of whom? Backward class of citizens. Is it? In the opinion of the state is not adequately represented in the services under the state. See, there is a commission called as Mandal Commission. What commission? There was a Mandal Commission report. As per that report, most of the government jobs were held by upper category of people. Means the backward classes of citizens were not adequately represented in the service of the state. So to remove that inequality, this Article 16 clause 4 or 16 clause 4 allows the state to make what provision? Special provisions or reservations. ಅರ್ಥ ಆಗ್ತಾ ಇದೆಯಾ? So reservation means Article 16 clause 4. What is it? Reservation means what? Article 16 clause 4. So Article 16 clause 4 allows the state to make what? Reservations in the appointments or the post in favor of whom? Backward class of citizens who in the opinion of the state are not adequately represented in the service under the state. Are we clear with this? Yes or no? 16.4a and 16.4b are amendment most important. Based on this, they can ask questions in the examination. Article 16.4a. Continue. State may provide reservation in the promotion with consequential seniority. Underline the word consequential seniority means what? Without actual consideration of the actual seniority. Means what? Let's say you are working in the office for 10 years. There is one SC category person who is working for only 1 year. And this post is reserved for the SC category. Who gets the promotion? SC category persons gets the promotions. That is called as consequential seniority. What seniority? Consequential seniority. This can be done in respect of any class or classes of post under the service of the state. Such reservation is permissible only when the state is satisfied that SC and STs are not adequately represented in the services. See, this reservation in promotions. Underline the word reservation in promotions. This Article 16.4a was introduced. Why? Because in Champakarajan Dole case, Supreme Court held that reservation in employment allowed, but not in the promotions. To nullify the effect of decision of the court, Parliament got amendment called as Article 16.4a, which allows the Parliament or the state to make a law to give reservations even in the what? Promotion. That's with what seniority? Consequential seniority. Which article? 16.4a. Allows what? Reservation in promotion. Reservation which article? 16.4. Reservation in promotion. And there is one more called as carry forward rule. What rule? Any unfilled vacancies in a year should be carried forward to be filled in the next year, and for the next year those carry forward vacancies should be treated as separate from the other vacancies for the purpose of this 50% limit. What limit? What court has done? The court held that reservation is allowed or reservation is permissible subject to what limit? 50% limit. For this 50% limit, you should not count what? Backlog vacancies. You should treat them as separate. For example, let's say this year, if out of 10 jobs, 50% is for SC categories. Means how many are reserved? 5 reserves. But we could fill only 2 vacancies. How many left? 3. We can carry forward this to which year? So next year, again, 10. 10 means how much? 50%. 5. It is not 13 or 50%. Whatever the unfilled vacancies were, they should be carried forward to which year? Next year. And they shall be treated as what? Separate. That is what called as carry forward rule. What rule? 16.4b. 16.5 is what? A law shall not be considered as invalid. See, what is Article 16.2 says? What is Article 16.2 says? Based on what? Religion, caste, sex, place of birth, or residence. But 16.3, 16.4, 16.5, 16.6 are all what? Exception. Now 16.5 says, देखो भाई, if there is a law which requires a person to be a particular religion for an employment to a particular institution, is not invalid. If it is a religious institution. What institution? Religious institution. For example, if in case of temples, only Hindus are allowed to be appointed as a priest, even though the temple is managed by the state. Is it a violation of Article 16.2? No, it is allowed. Its law shall not be deemed to be invalid merely because it requires that a person holding an office connected with the affairs of a religious or denominational institutions or being member of its governing body must belong to that particular religion or denominations. If a law requires a person to be a particular religion for the appointment to any particular institutions, religious institutions or denomination, ಯಾವುದೋ ಒಂದು ಮಠಕ್ಕೆ ಯಾರನ್ನೋ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಬೇಕು. If it says the person should be a Hindu, is that law valid or not valid? Valid. Under which article? 16.5. And last one, 16.6. Again, it is the contribution of Modi government. These 6 are always the contributions of Modi government, which provides reservations in the employment to which category of people? Economically weaker section, but that should not go beyond how much? 10%. Both the cases it is 10% limit. Are we clear with this? Which article? 16.1 is what? Equality of opportunity. Not employment, public employment and public post. Second one, 16.3 based on residence allowed. 16.4 reservation for backward classes. 16.4a promotion. 16.4b carry forward. 16.5 religious denominations, religion. 16.6 EWS reservations. Now, based on this, what type of questions were asked in the examination? Article 15, I want everyone to read the questions. I will not read. You guys will read. I'll take some read. A certain membership rules which excluded people from certain racial backgrounds, including Nepals. Beside the validity of such rules, these rules are not valid or valid. Is these rules valid or not valid? Excuse me. Sorry. Thank you. See here, they're excluding the employment of certain persons in a club based on their racial background. Is it a violation of right to equality? Yes or no? If that club is of state, if it's a private club, no. If it is a public club, then it is considered as violation of it's a discrimination as well as violation of Article 14. If they ask question like this, how to write the answers? Can we read the answer, please? Article 15 clause 15 prohibits the state from discriminating against any citizens on the ground only of religion, race, caste, sex, place of birth, or any other. Further, no citizen shall be subjected to any disability. We have discussed all these things already. Exception. State can make special provisions for the women and children. Next one, state can make special provisions for the advancement of. Next one, state can make special provisions for the advancement of socially and again educational institutions, and the last one economically weaker section of the society. You write all these provisions. Next one, equality of opportunity in the matters of public employment. Question number one. However, can you write Article 16.4, 16.4a and 16.4b? Akshay was denied public employment. Is it a violation of his fundamental right? Why? Because there cannot be any discriminations based on the place of birth with respect to. That is only when the parliament makes a law requiring the residence as an essential conditions for the employment to a particular post in the government or the union territory. Done. Next one. Now we should start with important article 19 to 22 based on which they generally ask questions in the examinations. Let's start, guys. साथ में पढ़ाई करेंगे. We are reading together. Done. Let's start. Article. Everybody, article 19 to 22. Law with respect to what? Right to freedom. Article 19(1) of the Constitution guarantees to citizens how many freedoms? What are the 6 freedoms? Sa, M, R, P. Hello? What is S? Speech. What is A? Assemble. Then association. Next one. Free movement and residence and practice. It is Article 19B, not C. Sa, MRP. What is S? Speech. What is A? Assemble peaceably without any arms. Third one, associations or unions. Movement, recite, and practice. This article 19F is repeat, means remote. Practice any profession or to carry any occupation or trade or business. Can there be reasonable restrictions on this fundamental right? This part is most important based on which they'll ask questions in the examination. Listen, everybody. Listen. Are the freedom under Article 19 absolute or can there be reasonable restriction? The Constitution permits restrictions on these freedom only if the following conditions are satisfied. You must remember this condition. First one, the restrictions can be imposed by law and not purely by executive order. Means there has to be a law which allows the government to put restriction. Second condition, the restriction must be reasonable. Third condition, the restriction must be imposed for achieving one or more object specified in the respective clauses of the Article 19. If you see, 19(1)A itself provides the grounds on which there can be a restriction. To achieve certain object, there can be a restrictions on the freedoms. Correct, right? For example, freedom of speech and expression. To prevent defamation, there can be restriction. Yes or no? And those restrictions can be placed only by what? Law. and that law must be reasonable, and that law should be able to achieve the object of Article 19(1) to 19(6). Then only those restrictions are valid. What is the first restriction? What is the first condition?
Should be imposed by law.
Imposed by what?
Law.
Law, not by executive order. That must be reasonable. And the third one, it should be imposed for achieving one or more objects specified in the respective clauses of Article 19. You must remember these points. Then next one, what are conditions to be satisfied to check whether the law is reasonable or unreasonable? What is the first one? Objective of the restriction. Second one, nature, extent and urgency of the events sought to be dealt with, that is the problem to be solved. How far the restriction is in proportion to the evil in question, duration of the restriction and the conditions prevailing at the time when the law was framed. For example, let's say during COVID, the freedom of movement was restricted.
Yes.
That was restricted under the existing law. We had this NDPS Act, not NDPS Act, Natural Disaster Preventions Act, something is there. Under that law, they imposed restrictions on the freedom of movement. Is it valid or not valid? Valid. So if they ask questions in the examinations, can there be a reasonable restrictions on the freedoms? The answer is yes or no. Yes. Subject to how many conditions? 3 conditions. The restriction can be imposed only by way of law, not by executive orders. Second one, it should be reasonable. And the third one, to achieve the object specified in the respective clauses. Done. Next one, procedural as well as what? And substantiveness. Reasonable restrictions implies that limitation must be fair, proportionate and non-arbitrary. The court considers both substantive reasonableness as well as the what? Procedural reasonableness. मतलब क्या होता है सर? See, listen. For example, arrest of a person. Is it a violation of fundamental right? In general. Forget about exception. If police arrest a person, is it a violation of any fundamental right?
Yes.
Which one? Freedom of movement. More important, liberty. Personal liberty. What liberty? But is there any law which allows the police to arrest a person?
Yes.
Means there is a law. For example, we have the BNSS, which allows the police to curtail this freedom. Correct, right? Is it a reasonable restriction? Yes. Now, when the court check the reasonableness, we check the substantive reasonableness as well as the what? Procedural reasonableness. Think. Means what, sir? Means the law which allows the police officer to interfere with your fundamental right should be reasonable. You can challenge BNSS itself, saying that if it is allowing the police to arrest without proper guidelines, or police can, if that law is arbitrary nature, that law itself can be challenged. It is substantive law. What law? And we also have the procedural formalities. So now BNSS allows the police officer to arrest. Reasonable restriction. At the same time, when the police officer exercises that power, that should also be as per the what? Law. Which is called as procedural reasonableness. Means the procedure to be followed while interfering with the fundamental right. You should inform him the grounds of arrest. You should produce him before the magistrate within how many hours? 24 hours. Even those things has to be complied. If it is not complied, it is considered as what? Violation of fundamental right. The court will check both substantive reasonableness as well as what reasonableness? Procedural reasonableness. Both has to be reasonable. Are we clear with this? Next one. Substantive reasonableness. Can you guys read this? 2 paras.
The court
Restriction to see whether it has a rational nexus with the object sought to be achieved. Procedural reasonableness. The court also examines procedures prescribed for enforcing the restriction. The procedure must be just, fair, and reasonable and should contain adequate safeguard against the misuse of powers. Reasonableness is judged objectively from the point of view of the general public and not from the standpoint of affected individual. Example, freedom of movement during the COVID-19. I hope you guys got an idea of what is the difference between procedural level reasonableness as well as the substantive reasonableness. Both has to be reasonable. What is substantive reasonableness? The nature and extent of restriction imposed by the law must be what? Reasonableness. And while putting that restriction, there has to be a check and balance. Check and what? Balance. That is why there is provisions are there, right? In CRPC, which says that once the police arrest, the police officer should produce a person before whom? Magistrate within how many hours? 24 hours. Is not procedural reasonableness. So now you tell me which what Article 19 says? Freedom. It guarantees what? Freedom. How many freedoms? Subject to reasonable restriction. Now, when can we say restrictions are reasonable? Subject to how many conditions? Three. What is the first condition? A restriction must be imposed by law, not by executive order. Second one, it should be reasonable. Third one, one or more object specified in that respective clauses. And the reasonableness must be what? Substantive reasonableness as well as the procedural reasonable. They'll ask these complicated questions if they want to make examination difficult in the difficult. Okay. Next one, 19(1)(a). What is 19(1)(a)? Freedom of speech and what? Expression. What does it say? Means right to express one's convictions and opinions freely by word of writing, printing, pictures, or any other mode. Freedom of speech, regarded by most philosophers as a what liberty? Fundamental liberty, includes the right to freely express one's opinion without interference and without fear of punishment or retaliations. Correct, right? Anybody can express their opinion subject to reasonable restriction. They can criticize. You can pass any comments. Yes or no? Subject to what restriction? Reasonable restriction. Courts have held that this right include freedom of what? Press, right to publish one's opinion, right to circulation, propagation of one's ideas, freedom of peaceful demonstration, dramatic performance, and cinematography. Means you can say whatever you want through cinema, but subject to reasonable restriction. Kerala story, freedom of speech, subject to reasonable restriction. What is the reasonable restriction? Censorship. They can do censor, right? Yes. But censorship is not applicable for press. These Vijay movies now, Jananayagan, they challenge this in the court by filing a writ petition saying that it is a violation of fundamental freedom of speech. Clear? So, freedom of speech under Article 19(1)(a) is one of the important fundamental right. It provides that it gives a right to the persons to express one's convictions and opinions freely by what? Word of mouth, writing, printing, pictures, or any other mode. It also includes freedom of what? Press. Reasonable restrictions, important. Based on this, they can ask questions in the examination. What are the reasonable restrictions can be imposed? What is the first one, everybody? Everyone should read sovereignty and integrity of example, speech promoting a rebellion against the government. If I give a speech in the class saying that let's revolt against the government, violation of, is it a, and if police comes and arrest me, can I say it's a fundamental right? No. My fundamental right to give a speech subject to reasonable restriction, but in the interest of sovereignty and what? Integrity of India. Is there any law which allows the police officers to arrest a person if he is giving a hate speech? No. Do we now have laws in India where police officer can arrest a person if he is giving a speech which is promoting a rebel against the government? Yes. Is that law valid or not valid? Because is that restriction reasonable or unreasonable? Why it is reasonable? First of all, the restriction is imposed based on what? Law. To achieve one of the purpose of Article 19(1)(a). Because what is the purpose here? Sovereignty and integrity of India. Second one, security of what? State. Next one, public order. What order? To maintain public order. They can arrest or they can prevent you from publishing it. For example, Peace TV is banned in India. There was a channel called as Peace TV, and there was a person called as Zakir Hussain. No, no, no. He's still alive, but he's in some other country, I guess. Not this guy used to give a speech in about Quran and about religious practices. They used to say Earth is flat, but not. And they used to give a hate speech against other religions, and the channel is banned now. So is it violation of fundamental right? No. Is it allowed or not allowed? Allowed. The restriction is allowed. Reasonable restriction. Next one, next one. Friend relationship with who? Foreign state. Now, what if a person is publishing articles in his Instagram page against Trump, abusive statements? Can that be taken down? Can that be restricted? Yes. Next one, decency or morality. That is why in Instagram you're not supposed to put certain post. Understood? Next one, contempt of court. What is contempt of court? Defaming the judges or defaming the court. You can criticize there can be a constructive criticism of decisions of the court, but not the contempt of court. Contempt of court is one of the reasonable restriction. Next one, defamation. Next one is what? Defamation is one of the reasonable restriction, and incitement to an offense. What is incitement? Encouraging to commit the criminal offenses. Based on these grounds, there can be a reasonable restriction. What if I say, let's burn the other community people? That violence is going on in Manipur, right? There can be, that is why they ban this. See, all these are interconnected. Like disconnecting this internet disconnection. That's one of the part of freedom of speech, right? I can express my opinion only when I have an internet connection. If that itself is taken, it is a violation of what right? A fundamental right. And if it is done because of this reason, it is valid. Are we clear with this, everybody? Which one? Next one. Issues. Can we read the issues, please? First one. Criticizing government policy. Is it a violation of fundamental right? Yes, it is a violation of fundamental right. If Indira Gandhi bans a magazine which criticizes the government for its bad policies, is it a violation of fundamental right? Yes. I have a freedom to criticize the government, but not defamation. Defamation is different, criticism is different. You can criticize even the judges also. Correct, right? Next one. State monopoly over electronic media on denial of access to telecasting. Is it considered as a violation of fundamental right? Yes. If there is only monopoly of the state and if they don't allow any private individuals to participate, how will we express our freedom of speech? Next one. Newspaper price and page restriction affecting circulations. Government put a restriction saying that you should not go beyond these many pages. Is it a violation of Article 19(1)(a)? How is it a violation? You're putting restrictions on the freedom of speech. Freedom of speech and expression includes even the word. Right, freedom of press. Next one. Fourth one. Is it allowed? Yes, allowed. It is not considered as a restriction. Next one. Is it a fundamental right? Yes. Speech is based on information. That is why we have a law called as right to information. Next one. Commercials advertisement. Yes. That is also allowed. Means you can also give advertisement in the newspapers as well as in the TV channels. Next one. Students compelled to sing the national anthem against religious belief. No. It's a violation of fundamental right. Right to speech also include right to remain silent. Next one. Whether citizens can freely fly the national flag. One of the interesting case law, before Naveen Jindal case law, only government officers was allowed to hoist the national flag. But after this judgment in the Naveen Jindal case law, he claimed that freedom of speech and expression includes even rights to see the people express their express towards express their feelings towards the national flag in a different way, right? So in this case, what happened? Naveen Jindal, they hosted a national flag on their private building. It was an offense at that time because only the government buildings and officers were allowed to hoist the national flag. He challenged this order or challenged this law, saying it is a violation of Article 19(1)(a) because according to him, the way of he expressing his love towards the nation is by hosting the what? National flag. From that day, it is allowed to hoist the what? National flag. That is why we have celebrating this Har Ghar Tiranga. Every day, 15th of August, we celebrate it. Hoisting the national flag, right? Earlier, it was not allowed. After this judgment, it is allowed. Clear with this, everybody? Students sought an anticipatory bail for allegedly defamatory or parody social media posts. Is freedom of speech includes defamatory statements? Government denied the anticipatory bail in this case because why they denied the anticipatory bail? Because freedom of speech is subject to what restrictions? Reasonable restrictions. What restriction? Now, what questions were asked based on this? Everybody read this question. Hello. Read everybody. Stand. Can this order, will this order sustain or not sustain? Is it a violation of Article 19(1)(a) of the Constitution of India? He has the freedom of speech and expression, either by words or by writing or by pictures or any other form. Correct, right? Just because he has published a defamatory matters once, it doesn't mean he will publish the same again. So this order of the government, is it valid or not valid? Not valid. How to present the answer for this? Read the answer. Right to express one's convictions and opinions freely. We are discussing this point now. Writing. He want to express his opinion by what? Writing. Right to circulation and propagation of one's ideas. Demonstration, dramatic. Continue. What is the conclusion for this answer? Sorry, conclusion for the question. So you can say in the light of above provision, the restrictions is not valid and it can be challenged in the court. That is what you are supposed to write. Done. Next question. Freedom of assembly. We have discussed these questions already, I guess. Anyway, we'll discuss. Article 19(1)(b) of the Constitution guarantees to whom? All citizens. See, doesn't matter how much provisions you remember about Article 19, at least you remember these 3 points so that you can write in the examinations. What is the 19(1)(a) says? Right to express. Well, opinion and convictions, either by way of what? Mouth, writing, printing, pictures, or any other mode. This includes freedom of press. And subject to what restriction? Reasonable restriction. At least you should remember 4 to 5 points of this reasonable restriction. Done. Next one. Freedom of assembly. Let's start. Article 19(1)(b). Continue. Guarantees to whom? All citizens the right to assemble peaceably and without any arms. Further, the state is empowered to impose reasonable restriction on this right in the interest of what? Or in the public order. What order? Public order. So, Article 19(1)(a) and 19(1)(b) is interconnected. A politician can give a speech only when the people assemble. If assembly is itself is prohibited, how will he give a speech? Nowadays we have social media where we can put or we can express our opinions to the social media. But in those days, when the constitution came into force, there were no social media. The only mode was radio channels. Correct, right? That is why Article 19(1)(b) allows the citizens to assemble peaceably with any arms, not carry any weapons. So which article? 19(1)(b). Is it absolute or can there be reasonable restriction? What is the first one? Sovereignty and integrity of India are the public order. What order? What if there is a communal violence? During that time, they can restrict the assembly of the people. Correct, right? Can you guys read the importance of freedom of assembly and its connection with Article 19(1)(a)? Read. First, one views before it is closely connected with the freedom of speech and expression under Article 19(1)(a). In a democratic system, this right is vital as a free speech itself. Freedom of assembly is a core feature of democratic governance. Public meetings serve the purpose of educating the public and shaping the opinion on religious, social and economic and political issues. Thus, right to assembly has a close and inseparable with the right to speech under Article 19(1)(a). They may ask this question in the examination. What is the importance of freedom of assembly and its connection with Article 19(1)(a)? Then let's read the question. What is the question they asked based on this? Question number 1. Everyone should read. Sat on Dharna near Jantar Mantar in New Delhi, and later on this led to a traffic jam. The government had imposed a ban on demonstrations near. The organization filed a petition in the High Court against the ban, pleading infringement of their fundamental right of freedom. Will the petition be admitted? Will it be admitted or not be admitted? Why not be admitted? It is disturbing what order? Public order. Is it a reasonable restriction? Can there be reasonable restriction? How to present the answers for this? Did everybody answer? Article 19(1)(b) gives the right to citizens to assemble peaceably and without arms. However, apart from the fact that assembly must be peaceful and without arms, the state is also authorized to impose on this right in the interest of sovereignty and integrity of India. As facts given in the case, stage processions, demonstrations, and agitation before the secretary. This caused what jam? Traffic jam, as the and the state can definitely impose ban on such demonstration. As the ban on demonstration is valid, the petition will get rejected by the. This question was asked in one of the previous examinations. Done with this, Article 19(1)(b). What is 19(1)(c)? Freedom of what? Association. This a right to hold meetings and to take out what? Possession without any arms. Further, this right to form association or unions enabling individuals to associate with others who hold similar ideas, beliefs, or objectives. Again, we have political parties, we have various associations. Correct now? Political parties are also association. You have the freedom to form association subject to reasonable restriction. What is the first reasonable restriction? Sovereignty and integrity of India. There are a few Muslim organizations which are banned recently because of this, after this DJ Halli and KG Halli incident. They banned one police station only, right? Some Muslim organization, they are banned because they were involved in activities which are against the sovereignty and integrity of India. You have a right to form an association, but subject to reasonable restriction that it should not be against the what? Sovereignty and integrity of India. And also what order? Public order or morality. This is one more interesting fact. See, they can ask practical questions based on this. I will give an example. You guys should tell me what will happen in this case. Listen. Can you start association? For lawful purpose? You need registration from the government for starting an association. You apply for registration, but government is not giving registration. Can you go to the court? Claim it is a violation of your fundamental right? Because you have a freedom to form an association. But what if you are forming a terrorist association? Police comes and arrests you. Can you claim it as a violation of your fundamental right? No. What if, let's say, a person is a graduate, is a software engineer, he is jobless fellow, is not having any job in the market. Now what he does, he start an association of his friends. He form a WhatsApp group, association of friends, not association of friends. He and few friends forms an WhatsApp group. In that group, anyone can become a member of that group by paying some subscription money. In that group, what they will do, they will arrange, not okay, they will arrange girls from different places. They are running highly sophisticated, organized prostitution. Police caught them, arrested them. Now they are in jail. When they say they were exercising their fundamental right of association, they formed an association, right? Is it against the public morality? Can that be? Is it a reasonable restriction? Yes. We can form an association. Only for what purpose? Lawful power. If it is against the sovereignty and integrity of India or public order or against the morality, can it be challenged? Yes, it can be challenged. Are we clear with this? And right to form an association also include right not to form a what? Association. Nobody can force you to be a part of an association. If somebody forces you to be a part of association, can you challenge that? Yes or no? If they say, for example, to take admission in Yeshas, you should be a part of an association. Can you challenge that? Yes. If let's say you got a job in the government office, they compel you to be an member of a trade union. Can that be challenged? Can it be challenged? Yes. It's a violation of what right? Fundamental right. Based on this, they asked question in the previous examination. Let's read the provision. Read. Can you guys read this? Explain the freedom of association under the Constitution of India. What reasonable restrictions have been imposed on the freedom under Article 19 of the Constitution of India? Are we clear with Article 19(1)(c)? Can you guys write the answer if they ask question about Article 19(1)(c)? Everybody? Yes or no? We will discuss two more articles, then I'll give a break. Done? Let's start. 19(1)(d). Do you have freedom of movement? Yes or no? 19(1)(d). Let's start. Freedom of Article 19(1)(d) guarantees to all citizens right to move freely throughout the world, territory of India. Only for citizens, not for the foreigners. Next one. This right ensures free internal movement from one place to another within India and essential to the national unity and individual liberty. However, this right does not include right to travel where the state may impose reasonable restriction in the interest of public protection of the what? Interest of scheduled tribe. During COVID-19, there were restrictions, right?
Yes.
Under which category? Interest of what public? General public. Have you heard about this externment and internment laws? Externment means ಗಡಿಪಾರ್ ಮಾಡೋದು. Have you heard about ಗಡಿಪಾರ್? Let's say, are some area. Let's say, you are the notorious criminal, the rowdy of that area. Kirti is the notorious gang leader of Jainagar. She is creating a lot of issues in Jainagar and she is planning to disturb the elections, upcoming elections. Now what police does? Police extern her from Jainagar. They say you should not come to what? Jainagar till the elections get over. Now Kirti says, I know Constitution of India, and she files a writ petition saying that sir, it is a violation of my fundamental right to movement. I can move anywhere. I can go to Jainagar, I can go to Bharati Nagar, I can go to whatever the Nagar I want. Is this contention correct or wrong? Wrong. Because you are a notorious criminal. Are you guys getting the concept? Externment means removing. Internment means what? Confined into a particular area. They can say you should stay only in Jainagar, not anywhere else. That is called as internment. What is externment? Not in Jainagar. You do whatever you want in other areas. Clear with this? Based on this, they can ask questions in the examinations. Can you read this, please? A law. What about remaining use of the material? Right, read. A law providing for external. The restriction is reasonable and it falls general public are protecting the interest of what tribes? Scheduled tribes. There are tribal areas where you're not allowed, right? In Andaman and Nicobar, there are a few areas which is not allowed for the public. Reasonable restrictions. Are we clear with this? Examples: imposing wearing helmet by a drivers of two-wheelers. Is it a reasonable restriction?
Yes.
मर जाओगे. That is why wear what? Helmet. Restrictions and the movement in what area? Prohibited area. Reasonable restriction in the interest of public. Next one. Wearing mask. Wearing seat belt. Reasonable restriction. What restriction? Are we clear with this? Freedom of movement. Last one. 19(1)(e) before we take a break. Freedom of residence. Can you reside in any part of India? Is movement and residence both same or different? One is with respect to liberty of movement and second one is what? Stay. Can a Tamil Nadu person stay in Karnataka? A Karnataka person stay in Tamil Nadu? You have freedom of what? Movement throughout the territory of India. The right is substantially overlap with the right to move freely under Article 19(1)(d), but while Clause D concerns movement, it focuses on the permanent or temporary residence and settlement. The purpose of this freedom is to move what? Remove the internal barriers. It promotes national integration and unity. Which article promotes the national integration and unity? 19.1 E. Freedom of what? Residence. Can there be reasonable restriction?
Yes.
In the interest of what? General public or for the protection of interest of scheduled tribes. Area based restrictions. Can we read this please? Yes or no? So these are the important freedoms. Now, before we go to the next articles, I'll ask you questions to you guys. You answers. Then we'll go to the next article after we take a short break. Okay. Now listen. G. ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆ ಇಲ್ಲಿ ರಾಂಗ್ ಇದೆ happens sometimes it happens I'm also a human being I make mistakes please correct it in the material ಆಲ್ರೆಡಿ ಮಾಡಿದೀರಾ ಅಂದ್ರೆ ನಾನು ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೆ ಅಂತ ಅರ್ಥ ಇನ್ನು ನಾನು ಅಪ್ಡೇಷನ್ಸ್ ಮಾಡಿಲ್ಲ ಮಾಡ್ತೇನೆ ಟೇಕ್ ಸಮ್ ಟೈಮ್ ಓಕೆ listen everybody we have discussed article 14 is done what is 14 what's article 15 prohibition of discrimination I will give practical scenario you should tell me which article you will apply for this okay government creating reservations in the employment towards SC and ST is it a discrimination or a discrimination allowed or not allowed under which article 16 clause 4 16 clause who can make state can make special provisions for the reservations in the post or employment towards whom backward classes who are not adequately represented in the services of the state. That can a person form an association to do charitable activities? Can there be restrictions on that? If government put restrictions, general restriction, valid or not valid? But for the interest of integrity and sovereignty of India, public order, yes. And one more is there, public morality. Are reservations legally justifiable or justifiable? Is it a violation of Article 14 of Constitution of India? Why no? It's a reasonable classification. What classification? And what is reasonable classification? Based on how many conditions? 2. What is the first one? Intelligible differentia and rational nexus between intelligible differentia and object to be achieved. Is panchayat a state? It come under which point? First one, second one. Local. Is university is a state? It come under which other? How do you decide whether other authorities is state or not? If it is an instrumentality or agency of the state. And how many conditions are there? 6 conditions. How many conditions? Are we clear with this, everybody? Let's see, is there any question based on Article 19.1? C of the D, E, G. G we have many questions based on Article 19.1G that we will discuss. That is freedom of profession, trade, occupation and business. You guys need break? Okay, take. Let's start. Freedom of residence is done, right? We have the freedom to reside and settle in any part of the territory of India, subject to reasonable restriction. That is in the interest of general public and the interest of scheduled tribes. Next one, Article 19(1)(e), one of the important article based on which there can be questions in the examinations. Freedom of profession, trade, occupations, and business. Every citizen of India has a right to practice any profession or to carry any occupations, the trade or business. Correct, right? It includes trade, professions, business, as well as the occupations. What do you mean by trade? Buying and selling, commerce work, especially skilled work, is considered as trade. Business is more comprehensive than trade. It has no rigid definition. It must be determined case to case basis, applying the common sense. And profession includes any occupation requiring the intellectual skill, often coupled with manual skill. CACS law, all these are considered as the professions. See, Article 19(1) is G says all citizens of India has a right to practice any professions, trade, occupations, or business, subject to the reasonable restriction. What are the first reasonable restrictions? First one, in the interest of public. Correct, right? You're not supposed to start a Gudka business in a residential area. Correct, right? It is prohibited. That's the reasonable restrictions in the interest of public interest. Second one, professional technical qualification. Only a person who is graduate of MBBS can practice the medicine.
Yeah.
Reasonable restrictions. And the last one is state monopoly. There are few business or trade in which state can create monopoly in its own favor, and it can restrict any other person from carrying those activities. Correct, right? So state has the power to create monopoly in its own favor. It is a reasonable restrictions. What are the three reasonable restrictions in the freedom of trade, profession, occupations, or business? Public interest, technical qualification, and state monopoly. The state monopoly is an important provisions. The state may carry on any trade, business, industry, or service either completely or partially excluding private citizens. This legitimates state monopolies in the public interest. For example, defense industry, state has a monopoly. Correct, right? There are defense atomic energy. Only state can do it, not the private individuals. Is it reasonable restriction? Yes. So there are three reasonable restrictions on the freedom of trade, profession, occupation. What is the first one? Public interest. Second one, technical qualifications, and the third one is state monopoly. Case law, I will discuss with Chintaman Rao versus State of MP, where the law prohibited manufacturing of DDs during the agricultural season. The court held that this blanket ban of manufacturing of DDs is considered to be violation of fundamental right. Why? Because there were old age women who are depending upon these activities. So if you ban completely, it is considered as violation of Article 19(1)(g). So we have discussed various case laws. We have run the various case laws. What is the first one? Whether liquor trade is protected under Article 19(1)(g? No, it is not a fundamental right. Trading in liquor is not a what right? Fundamental right. Next one, because liquor trade is rest extra commercial, means it is outside the normal commerce. Not, you cannot claim it as a fundamental right. Next one, whether regulation of admission process and fees in private professional colleges violates the professional freedom? No. See, restrictions are different from regulations. If a law regulates the admissions process in the educational institutions, is it considered as violation of Article 19(1)(g? No. Next one, whether the state can exclude the private players and create a monopoly in manufacturing high security vehicle number plates. This is one of the recent introduction, HSRP number plates. Is it a violation of fundamental right? No, because it is the what interest? Public interest. Reasonable restrictions. Otherwise, everybody has the right to manufacture the number plates. But in this case, now the water rule saying that only state can do it. You have to put the number plates, and only the state authorized players can issue the number plates. Is it a violation of fundamental right? No, it's a what restriction? Reasonable interest. Reasonable restriction in the interest of what? Public. Next one, whether state regulations of app-based taxi services violates the business freedom? No. Any regulation does not violate the what? Freedom. Temporary suspension of professional activity during COVID-19. Is it considered as a violation of fundamental right? No. In the interest of public. Reasonable restriction. Whether street hawkers have right to carry on trade on the public streets? No. Why no? Again, in the interest of who? Public. Street hawkers means what? That Tamilnadu, they are doing the business. So if police comes and snatch their equipments, is it considered as violation of the fundamental right? No. You have a freedom of criminal business, profession or occupation subject to what restriction? Reasonable restriction. And one of the reasonable restriction is that public interest. What interest? COVID-19 public interest. This traffic public interest. Public interest, technical qualifications, state monopoly. What monopoly? State monopoly. Remember these three keywords. What is the first restriction? Public interest. Second one, technical or professional qualification. The third one is what? State monopoly. I want everyone to participate. As I said, by the time I finish this chapter, you should be having 15 to 20 marks in your pocket. We should be solving the questions of previous examination as well. Are you guys getting it? Yes or no? Let's cover all the topics. Next one, guys. Article 19(1)(g) is done. What is Article 19(1)(g)? Freedom of trade, professions, occupations, and business. Is it free?
Yes.
Subject to what restriction? Reasonable restriction. How many are there? Three reasonable restriction. HSRP is one of the best example for writing this reasonable restriction. Next one, protection in respect of conviction of offences. One of the favorite topic of ICSI. 20, 21, 22 are the favorite topics of ICSI. Protection in respect of what? Conviction of offences. For criminal cases. What cases? Offense means what case? Criminal case. Correct it? Yes or no? There are three protections. How many protection? Three protection. What is the first protection? Protection against ex post facto loss. Second one, protection against double jeopardy. And the third one is protection against self-incrimination. Based on these three topics, that generally ask questions in the examinations, especially the practical questions. What is the first one? Protection against what? Means no person shall be convicted. What is convicted? Punished. Any offense except for the violation of law in force at the time of commission of the act. What is the provision says? No person shall be convicted of any offense except for the violation of law which was in force at the time of commission of the offense. So if you want to convict a person for any offense, you can convict him only for the violation of the law which was in existence at the time of commission of that act. And again, he shall not be subjected to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offense. It's not only for the conviction of offense, it's also for the what? Penalty. Clear with this? That is what called as protection against the ex post facto loss. Ex post facto, after something has happened, you cannot increase it. And this provision is applicable only for substantive law. What do? Procedural laws can have a retrospective effect. But substantive laws always has what effect? Prospective effect. Because procedural laws does not confer any right upon the persons. They only provide the procedures to enforce your right. That is why substantive law cannot have retrospective effect and procedural law may have what effect? Retrospective effect. What effect? So what do you write in the examination if they ask question about Article 20 Clause 1, protection against ex post facto loss? You should say no person shall be convicted. For what? That's question you answer, okay? Who
No.
can be
Convicted.
for any offense. What offense? Other than violation of which was in existence at the time of commission of the act, not subjected to any penalty other than what might have been inflicted at the time of commission of the offense. Both penalty as well as the convictions. Both you should write in the examinations. Are you clear this? A law which reduces the severity of punishment or this, the rigorous of criminal law is not hit by what? Article 20 clause 1. You can reduce the penalty or reduce the imprisonment period, but if not increase it retrospectively. Can they reduce it?
Yes.
Can they increase it? No. So, what is the important exception to this? Beneficial or mitigating loss. Underline the word beneficial or mitigating loss can be applied retrospectively. Meaning of ex post facto law means a law which makes an act of an offense after it was committed or enhances the punishment retrospectively. That is what called as ex post facto law. Is it allowed or prohibited? Are ex post facto laws are allowed or prohibited? Prohibited. Under which article? Article 20 clause 1. Can procedural laws be ex post facto?
Yes.
Substantive law? No. Procedural law? Yes. Next one. Exclusion of procedural law. Exclusion of what laws? procedural laws are not within the purview of Article 20 Clause 1. Why? Because Article 20 Clause 1 is applicable only for what laws? Substantive law. Only substantive law creates a right, not the procedural laws. Now you guys tell me, if there is an amendment to the CRPC, not CRPC, BNS, can it have retrospective effect? What is BNSS? Suraksha Sanhita. Is it substantive law, procedural law? Can it have retrospective effect?
Yes.
Can BNS have retrospective effect? Why no? This is substantive law. Or law? And what is protected under Article 20 Clause 1 is what law? Substantive law. Not the word laws, procedural laws. Are we clear with this, everybody? Next one. Article 20 Clause 2 deals with what? Protection against double jeopardy. Simple, simple. Listen, everybody. No person shall be prosecuted, punished twice. Offense, same offense. I'm using the two words here: prosecuted and punished. 3B. What is prosecution? Trial, which happens before the court. Prosecution and punished. If prosecution happened, if he was not punished, he can be again prosecuted and punished. But once he is prosecuted and punished, he cannot be tried for the same offense and punished. In this, that is Article 20 Clause 2. No person shall be prosecuted and punished for an offense more than once. Can he be prosecuted and punished for a different offense?
Yes.
For example, let's say somebody kidnaps CSR from the Yeshas Academy. Then they torture him. Then they kill him. No matter how many offenses here. One offense or two offenses. First of all, kidnap. Can he be punished?
Yes.
Murder. Can he be punished? Are the same offense or different offense? We have discussed this concurrent punishments. The court can say either it will run concurrently or it can run separately. We have discussed this in some chapter. Which chapter? BNSS, is it? Or the punishment may run either concurrently or it can run separately. In case of BNSS only, limit on the punishment. Maximum imprisonment can be granted. Maximum 20 years, is it? Shall escape how many years? 20 years for total offences. Correct? Right? We'll discuss all those things. Are they clear for protection of double jeopardy? Double jeopardy. No person shall be prosecuted and punished how many times?
Twice.
For what offense? Same one. Now here it is and. What does and means? Both. If he is prosecuted but not punished, can he be tried again? Yes. The person must have been prosecuted and must have been punished for what offense? Same offense. If the person is prosecuted but not punished, can he be tried again? Yes. See, acquittal is different, conviction is different. Once he is convicted, you cannot convict him again for the same offense. But if he was acquitted, can he be tried again? Yes. And punished? Yes. Article 20 Clause 2. We have discussed all these case laws in the class. Next one. Protection against self-incrimination. Based on this, they asked many questions in the previous examination. No person, mark it important, no person accused of any offense shall be compelled to be a witness against himself. Most important. In 3 words here. Person. Second one is what? Accused of any offense. Accused of what? Should be accused of an offense. Again, offense is not wrong, criminal wrong. What wrong? Shall be compelled. Means he was compelled. What do you mean by compelled? First, to be a witness against himself. Means to give a witness against himself. There are 3 important terms here. Can you guys read the entire one, please? Please. Note. First thing is what? Accused of an offense. First condition. Second condition? Compelled. He was forced to give a witness. Third one? Against himself. That is called as self-incrimination. Now, what if I force you to give an evidence against her? Not a self-incrimination. What if you give an evidence voluntarily? Self-incriminations. What if you give an information other than in a situation where you are not accused of an offense, not a self-incrimination? 3 conditions. The first condition, accused of an offense, compelled to be a witness, and the witness is against yourself. That is what called as self-incrimination. It is a violation of Article 20 Clause 3 as well as personal liberty. What liberty? Personal liberty. Can we read this again one more time, please? No person accused of any offense shall be compelled to be a witness against himself. Essential condition was the first one, accused of an offense. Second one, must be a compulsion to be a witness, and such compulsion should result in his giving evidence against himself. So if the person was not accused when he made a statement, or the statement was not made as a witness and was made by him without compulsion and does not result as what statement against him, then the protection available under this provision does not extend to such person or to such statement. I hope you guys are clear with this. There are how many conditions to satisfy? Three conditions. What is the first one? Accused of an offense, forced to be a witness, and witness against what? Himself. Against himself. Next one, case law. Selvi versus state of Chandigarh. Selvi versus state of Karnataka. Important case law. In this protection is applicable not only for the accused person but also to the suspect under investigation or witness who are reasonably apprehend that their answers may expose them to one liability, criminal liability, either in the same case or in one case, different case. Correct, right? Next one. Techniques such as narco analysis, polygraphy test, brain mapping, when conducted without consent, violates Article 20, Clause 3 and personal liberty. What liberty? The interesting case is the see. If can police officer compel you to give a password?
No.
Then it also considers what incrimination? Self-incrimination. Police officer cannot force you to give a password, but they can take your thumb impression or they can take your retina scan. That is not a violation of Article 20, Clause 3. Only when something is so stored inside, and if you compel to give it involuntarily, it is considered as what? Violation of Article 20, Clause 3. Narco test analysis. Narco analysis is considered as violation of which article? 20 Clause 3. It's a self-incrimination. Correct, right? Because they're doing it without your consent. Yes or no? Article 20, Clause 3. Article 20 deals with protection against conviction for certain offences. What is 20 Clause 1? Double jeopardy. What double jeopardy? Protection against exposed factor loss. Everybody must answer. Protection against what? Exposed factor loss. 20 Clause 2. Double jeopardy. 20 Clause 3. How many conditions? What is the first one? Accused of an offense. Second one? Compelled to be a witness. And the third one? Against himself. Are they clear with this? Now, based on these, there were questions asked in the previous examination. First, let us understand Article 91G. Let's read the question. What question was asked based on Article 91G, everybody? Article 91G of the Constitution of India provides that all citizens shall have the right to practice any profession or occupation, trade or business. Explain. Subject to how many restriction? Three restrictions. Public interest, technical and professional qualifications, and the third one is monopolist. Next one. The government of Madhya Pradesh. Sorry.
The government of Bangladesh
It is similar to the case law. Manufacturing of BDs was prohibited. It was held to be unconstitutional. Why? Because it's a random blanket ban on manufacturing of BD. Violates the what? Fundamental right. Was the law made by a state to create monopoly rights in favor of a person to carry on any business affect the freedom of trade? Yes, but however, it is an exception to Article 91G. Can state create monopoly? Can state create monopoly in its own favor or to any person in the interest of public? Yes. Allowed. Can we read Article 20 Clause 1, please? Which are accused of an offense of dacoity, which year? At the time, how many years of imprisonment? 10 years. In 2016, during his trial, a law was passed which made dacoity punishable with a life imprisonment. Now tell me, what is the punishment for it? 10 years or life imprisonment? Because of which law? Exposed factual loss principle. Article 20, Clause 1. Yes or no?
Yes.
Can you write answers for this?
Yes.
Double jeopardy. What do you mean by double jeopardy? Can you write the answers for this? No person shall be convicted, shall prosecuted and punished twice for the same acts. Conditions: he was been prosecuted and also what? Punished. If he was prosecuted but not punished, then he can be tried again. Clear? Next one. Protection against self-incrimination. Can we read this case law? They asked this question based on this. They asked question in December 2024 for 5 weeks. What is the question? Everybody read the question. Let me see who can answer this question. The investigating authorities want to conduct narco analysis test without his consent to obtain the evidence. Mahindra advocate argues that the use of this state violates the fundamental right with reference to Sindhi versus Karnataka state discussed as to whether the use of narco-analysis test on Mahindra without his consent constitute a violation of his fundamental right. Yes or no? Yes. How many conditions? Three. Accused of an offense? Compared to be a witness and the witness engaged himself. Satisfy all three conditions, then it is not allowed. Violation of Article 20, Clause 3. Yes or no? So next one, protection of life and personal liberty. Article 21, one of the most important article in the Constitution of India. So no person shall be deprived. What is deprived? Take away his life or personal liberty except according to the procedures established by law. What is the provision says? No person shall be different about life or personal liberty. Let's say, listen, everybody, listen, everybody. A girl want to get aborted. She got pregnant. Now she thinks she don't want that kid. She want to terminate her pregnancy. Can she do it?
Yes.
Within medical practitioners' approval.
She is like, no, it is my life, right to life. I can live in whatever the form I want. She's conceived. There is already a baby inside her tummy. Fetus is already formed. Baby also has a what? Right to life. No person shall be deprived of right to life or liberty except as per the what? Procedure established by law. It doesn't mean you cannot kill somebody. You can't kill. We have death punishment where you will be killed only as per what? Procedure established by law. There are two words here. There are two words here. Life and personal liberty. One, citizenship, not only Indian citizens, every citizen, no person shall be deprived of life and personal liberty except as per the what? Procedure established by law. What established by law? You need to follow the procedure established by law. Now, what do you mean by procedure established by law? Means there should be a valid law and that valid law should be followed properly. For example, police arresting you. It is a intervention of personal liberty. Means it allowed? See, when the police comes and arrests you, they are curtailing your liberty, right? Only if it is as per the what? Procedure established by law. Understood, everybody? Article 1, 20. What does it say?
Protection of the life and personal
Protection of life and what liberty? Personal liberty. What does the provision says? No person shall be deprived of life and personal liberty except procedure established by law. Is there any situation where a person's life can be deprived? Is there any situation where a person can be killed? Only as per the what? Procedure established by law. I want to die. Can I die? I want to die peacefully. Can I die? Is it a violation of fundamental right? Yes. No person can die without what? As per the procedure established by law. So have you heard about passive euthanasia?
Yes.
That is happens only as per the what? Procedure established by law. That's a violation of what right? Fundamental right. What right? Do you have a right to speech? Do you have a right to remain silent? Do you have a right to life?
Yes.
Do you have a right to die?
No.
No. Next one. Life and liberty are different. I hope you guys are clear with this. Life means to live. Liberty means freedom. Freedom of movement without any barriers. Now tell me, if your liberty is curtailed, which petition you can file? Which writ petition you can file? Habeas corpus. Which corpus? Habeas corpus. If somebody's liberty is curtailed, what is the writ petition you can file? Habeas corpus. What is habeas corpus? To have the body. Yes. If your parents lock you inside the home and they are not allowing you to go outside because you are planning to go away, not go away. Run away, it seems. Hey, no. A boy wants to run away and boy is locked inside the room and his personal liberty is curtailed. Can you file a petition? Why no? Yes. You are a major.
You said boy, sir.
Even boy has a freedom of liberty, right?
No, but boy sounded very minor, sir.
Boy is a minor. Okay. So men. Okay.
But DNR, when somebody is in like coma
Hmm.
and they not allowed to resuscitate, like bringing them back to life by CPR. Recently, one case happened. Yeah, one case.
Because see, there is a concept. There are medical terms, okay, where this percent of brain is dead, non-functioning. Only they can take away the life. There are technical terms. Like one of the case where a girl was ravished, like she was raped and she was in a coma because of an incident. She was suffering for many years. Finally, they granted her the euthanasia, means the mercy killing. So there are techniques. It's very sensitive issues. What if the person want to live? I am in coma, but I don't want to die. Well, how can you decide I want to die? It's a very sensitive topic. That is why it is no more. It's the court is allowing the euthanasia only in the exceptional cases. And see a developing concept. Only in few cases they have granted these permissions because nobody can. I have a guys understanding. Even for a child which is not born yet, it also has the freedom of life. Sorry, right to life and liberty. Getting it? It's a debatable topic. Anyways, I hope you guys clear right to life and personal liberty cannot be defined in exceptional cases cannot be deprived.
Yes.
Subject to what? Procedure established by law. Now, what do you mean by procedure established by law? There are three conditions. How many conditions? What are three conditions? Keep underlining. Firstly, there must be what? Law justifying the interference with person's life or personal liberty. Do we have law for abortion? Everybody, do we have law for abortion? Second one. Secondly, the law should be what law? Valid law. There should be constitutionally valid law. Third one. Thirdly, the procedures laid down by the law should have been strictly followed. For abortion, there is a permission of two medical practitioners. Only with their permission, the pregnancy can be terminated. Are you guys getting it? Yes or no? So, only as per the procedure established by the law, you can deprive the life and liberty of a person. Now, what do you mean by procedure established by law? There are three conditions. What are three conditions? First, there should be a law which allows interference with his life and personal liberty, and that law must be constitutionally valid, and the procedures given in that law must be strictly followed. One more example I will give. Can a police officer arrest another person? Can a police officer arrest a person if he is accused of an offense? Subject to law allowing him to do so, there should be a law. We have BNSS, and the law must be constitutionally valid. And third one, whatever the conditions prescribed by the BNSS must be strictly followed. It should be informed about his grounds of arrest. It should be produced before the magistrate within how many hours? 24 hours. If not produced, you can get a bail, and it can be you can file a writ of habeas corpus. Otherwise, getting it. These are important article based on which they can ask question in the examination. If they ask any question about Article 21, what happened in the examination? No. Repeat everybody, what is the answer you write? No person shall be deprived of his life and personal liberty except as procedure established by law. What do you mean by procedure established by law? First condition, second condition, third condition. What is the first condition? There must be a law justifying the interference with the life and liberty. Second, should be constitutionally valid. And third one, procedure laid down by the law should have been strictly. In this Sutendra Kumar Anti versus Central Bureau of Investigation, because there were many arrests with the police officers without proper justification, they had given some guidelines based in the which case law? Satendra Kumar Antil case law. In this case, they provided the police must strictly follow what? Arrest guidelines. Any violation should be reported to whether courts to the senior authorities. Failure to follow article section number 41 and 41A entitles the accused to bail as a matter of right. What are right? Recently, Darshan got a bail in the High Court. High Court granted a bail based on a condition that he was not informed the grounds of arrest. Because there was a procedural lapse. What lapse? And when the case went to Supreme Court cancelled the bail saying that they cannot go only based on the what? Procedures. When there is a understanding, when there is a facts which are evident that he might be the one who has on that offense, you cannot grant a what? Bail. They reverse the bail in the Supreme Court. But in general, if the procedures are not followed and there is no prima facie case, you can get a bail as a matter of right. Bail as a what? What was held in which case law? Second anti case law. Arrest is not mandatory at a cognizance stage if the accused is cooperating during the what? Investigation. If he is cooperating, what is not mandatory? Arrest. In case of non-cognizable offences, what is not mandatory? Arrest is not mandatory. At trials, completing half of the maximum sentence must be released unless in the exceptional reasons exist. Where after there, but he already served half of the imprisonment in the jail. He should be what? Released. These are the key points given in the Satyendra Kumar Antil versus CBI case law for the personal liberty and life of a person. And you guys are clear with this. Now next one. Examples. Quickly go to the example. What is the first one? Fair, reasonable procedure? No. Why no? Is it a violation of which right? Life or liberty? Take an answer, life or liberty? How much correct liberty? Because to fly abroad, you need what? Passport. Without passport, you cannot have the liberty, right? So confiscating passport is considered as a curtailment of liberty, and that can be done only as per the what? Procedure established by law. How many conditions? 3 conditions. Yes or? Next one. Next one. Whether police regulations permitting violates personal liberty under Article 21? Yes. Police cannot visit the houses of the criminals and whenever they want. The law was struck down stating that it is violation of which article? 21. Whether state actions collecting personal data violates the fundamental right? Yes. Right to privacy declared as a fundamental right. Privacy integral to dignity, autonomy, and liberty. The state cannot collect the what data? Private data. What data? Private data. Yes or no? Now, for example, if you let's say if you want to join an academy, they put a restrict condition saying that please mention how many girlfriends you had in past. Is it a violation of your fundamental right?
Yes.
Why? Personal matter, right to privacy. Yes or no? And this one more case was there that nothing. Next one. Whether solitary confinement, hey, marathon, not a detailed discussion, sir. Let's start. Whether solitary first of all, I'm discussing in detail only. So let's finish it first. Whether solitary confinement and inhuman treatment of the prison crews violate Article 21? Yes. What is solitary confinement? Have you heard about solitary confinement? Where you put it in a separate cell alone. Yeah, no mirror, nothing, and you just put it in a one cell alone. It's mental torture, right? It is a inhuman condition. आप मर जाओगे, आप पागल हो जाओगे. Imagine being stuck at one place where you can't talk to anybody. You stay alone in a dark room. It is a very inhuman situation. It's a violation of what? Right to life. Next one. Whether next one. With absence of legal framework for passive euthanasia and leading will violates the Article 21. Yes. So that's why the law has been made. Compulsory narco analysis test. Is it a violation of fundamental right? Yes.
Yes.
You cannot do narco analysis test to a person without his consent. Whether use of loudspeakers, firecrackers beyond permissible limits violates Article 21.
Yes.
Which article? 21. Which part? Liberty or life? How liberty is violated if somebody is using firecrackers? Life. What if he's a heart patient and he will die, right? And right to sleep is a part of right to life. If you don't sleep for a few days, what you will do? You will die. Right to sleep is a fundamental right. Right to sleep is a fundamental right. Agree with this? Peaceful sleep. That is why you're not supposed to play loudspeakers at midnight, right?
Yes.
Yes or no? Next one. When unmarried women can access abortion, when whether reproductive autonomy is Protected under the Article 21.
Yeah.
You have a right to choose to reproduce or not. At the same time, once the baby is formed, the baby has a fundamental right. They cannot choose. You choose it before you conceive it. I hope you guys are understanding. Okay, next one. Once the baby is formed, you cannot terminate the pregnancy. After how many weeks? 20 to 24 weeks up 9 सकता 24 weeks अब तो not allowed at all. 20 to 24 weeks it is allowed subject to medical certification by the searches. There is certain provisions. It is a violation of fundamental right. Yes, next one. When Supreme Court proceedings involving constitutional questions of public importance should be live streamed for public viewing. Yes. Live telecasting of Supreme Court cases which are of public importance held to be part of fundamental right. Article 21. That is why you can see the court proceedings in the YouTube channels. Correct, right? It was held to be fundamental right. This is one of the important case law based on which there can be question in the upcoming examination because it's a recent case study where the court held that live telecasting of cases happening in the court which are of public importance are held to be part of right to life. Life. Article what? 20? 21. What is Article 21? Right to life and personal. What are in the examination if there is question about it? No person shall be deprived of life and personal liberty except procedure established by law. How many conditions we discuss? What are the conditions? There should be a law justifying the interference. Law must be constitutionally valid and the procedure must be strictly followed. And we also discussed the example. Based on Article 21, they asked two questions. Let's read two questions. One question is there. Read. Surendra Kumar Angie versus Central Bureau of Investigation. The points what they are given. General questions they are given. Like if police are not followed, you can get a bail. And if you already served half of the imprisonment, you can also get a. You should be released. All these points you can write. Next one, Article 21A. Right to. Right to. State shall provide. Who shall provide? What? Free and compulsory education. Underline the word free and compulsory education to all children. You know how many years of age? 6 to 14 years. How many years are? Yes or no? Next one. How? You know how many years of age? 16 to 16 to 14 or 6 to 14? Right to Children Free and Compulsory Education Act, RTA Act, which represents the consequential legislation and this is which article 21A means that every child has a right to full-time elementary education of satisfactory and equitable equality in formal school which satisfies certain essential norms and standards. Free and compulsory education. What education?
Free and compulsory education.
Are we clear with this, everybody? So what is to what age?
6 years.
Is it a fundamental right?
Yeah.
It's a part of right to life, Article 21. And next one, protection against arrest and detention. This is one more important article based on which they generally ask questions in the examinations. Protection against arrest and detention. Article 21 permits deprivation of life and personal liberty as per the procedure established by the law. And Article 22 provides the protection. It says that Article 22 does not apply uniformly to all person. It classifies the individuals into how many categories? 3 categories. What is the first one? Alien enemies. Who are alien enemies? When there is a war between the two countries, the opposite citizens are considered as what? Alien enemies. They don't have any of these protections. Second one, person arrested or detained under which law? Preventive detention law. We don't have any protection of this Article 22. Other they have no protections. For the purpose of Article 22, we are classifying the persons into how many categories? 3 categories. No protection. Second one? No protections. Other persons, they don't have a protection. What protections they have? There are 3 protections. What is the first one? Right to be informed of grounds of offense. Second one, right to legal counsel. And the third one, right to produce before the magistrate. He should be produced. He should be informed of the grounds of arrest, which enables the arrestee to understand the accusation and seek the legal remedy. Right to legal counsel, he has a right to consult the legal practitioner of his choice, and right to produce before the arrested person must be produced before the nearest magistrate within how many hours of arrest? 24 hours of arrest, excluding the what time? Travel time. What time? Remember this. And the last one, right to be produced before the magistrate is going to discuss kiya tha within how many hours? 20 hours. 24 hours. Then I ask question based on preventive detention. What detention? Sorry, what detention? It's preventive detention. Detaining a person before he commits an offense.
Can we give the consequence in some package?
So it's like you're not done an offense. To prevent you from doing an offense, we arrest you or we detain you. That is what called as preventive detention. What detention? See, in case of normal arrest, you have done an offense, police will arrest you. In case of preventive detention, the police detains you from preventing you from committing an offense. Have you heard in case of when we did in 2019, when BJP government updated Article 370 of Constitution of India, they put Umar Abdullah, Mehbooba Mufti in house arrest. That was about detention, preventive detention. What detention? Did you do any offense at that time? No. To prevent them from committing the offense, they detain them. That is called as preventive detention. In case if a person is detained for preventing to committing from an offense, Article 22 is not applicable to him. But there are certain extra provisions for that. What is the provisions? First of all, what is preventive detention?
It's not to punish a person.
What is preventive detention, everybody? Detention of a person without any trial. Everybody, what is preventive detention? Without any trial. The objective is not to punish a person for having done the offense, but to prevent him from doing it. So what to make law? Who can make law for preventive detention? Who has the power? As well as the state. Who can make law on the for defense, foreign affairs, and security of India? Parliament. Who can make law for security of the state, maintenance of public order, maintenance of supplies and services essential to the community? Parliament and state. Who can make the law? Parliament and state. Safeguard against preventive detention. Maximum period of detention. No person shall be detained for more than how many months? 3 months. Unless such detention beyond 3 months is advised by the advisory board. What board? And this advisory board should consist of persons who are eligible to be a judge or the person who have been the judge of the High Court. A person can be detained for more than how many months? How many months? Only if it was recommended by a advisory board, which consists of person who is eligible to be a judge of which court? High Court. No. And who set the maximum period of detention? Parliament. Rights of detainee. What is detainee? The one who has been detained. Authority ordering preventive detention must communicate the grounds of detention to the detainee as soon as possible so that the detainee is aware of the basis of his detention. Offer the earliest opportunity to the detainee to make representation against the what? Detention order. What order? Detention order. Means they can also seek the court. They can approach the court for the purpose of assessing these detentions. Clear? What is the protection available for preventive detention? He can detain only for how many months?
3 months.
Beyond 3 months, it requires whose approval? Advisory board should recommend it. Only can detain him how many months? 3 months. And first of all, tell me who can make law for preventive detention? Parliament and state. Parliament and what? State. Can you give the example, please? Case. What is the case name? Farooq Abdullah versus State of Jammu and Kashmir. In this case, who was detained? Under which law? Jammu and Kashmir Public Safety Act. Which year? 1978. His reason, his public speeches and political influence could disturb the what order? Public order, unrest or violence in the Kashmir. Are you clear with this? Article 1, 20? Article 1, 22. Next one, 23 and 24 is what? Rights against exploitation. Last two articles of fundamental right. Prohibit traffic in what beings?
Human beings.
Which article prohibits trafficking in human beings? And also what labor? Child labor. What labor? Sorry. Child labor is 24. Forced labor is what? Article 23. What's trafficking in human beings? Selling of human beings. Article 23 Constitutions imposes complete prohibition on the trafficking in human beings as well as beggary and other similar forms of what labor? Forced labor. Forced labor. What is forced labor? Forced labor means when you are forced to work against your will, or you are forced to work without payment, or forced to work with payment against your will. All these are considered as what? Forced labor. Another prohibited. What you will write in the examination if they ask question about trafficking in human beings and forced labor? Constitution imposes a complete prohibition on trafficking human beings, beggar, other similar forms of forced labor. Unlike many other fundamental rights, this right is enforceable against private individuals as well. Beggar means what? Involuntary work without any payment. Article 24 prohibition of what employment? Employment of the children. Article 24 prohibits the employment of children below the age of how many years? Claiming factory or mine. After 14 years, he can be employed. Here, and Supreme Court has issued detailed guidelines as to child labor, in which case now MC Mehta was State of Tamil Nadu. State of with these, we are done with major fundamental rights. Article 20, Article 14 to Article 24. 24. Can you guys notice Article 12? Definition of state. Article 30. Justifiability of fundamental rights. Article 14. Right to equality before the right equal protection of equality before the law and equal protection of law. What's 50? Prohibition of discrimination. 60. Equal opportunity in the public employment. 17 and 18 is there in your syllabus. And 17 is prohibition of untouchability. 18 is abolition of title. 19. Right to freedom. 19(1)(a), 19(1)(b), 19(1)(c), 19(1)(d), 19(1)(e), 19(1)(f) is not the 19(1)(g). Then Article 20, protection against conviction for offences. 21, life and liberty. 22, protection against arrest and detention. 21A, right to education. 22, protection against arrest and detention. 23, right against exploitation and trafficking in what? Human beings. 24, abolition of prohibition of employment of children. It's all. Next one, constitutional what? Remedies. This we will cover in the petitions. If any, listen everybody, I'll give a brief of this article. Do you have any remedy in case of violation of fundamental rights? Whom do you can approach in case of violation of your fundamental rights? High Court and Supreme Court. High Court, you can approach High Court under which article? Article 226. You can approach the Supreme Court as per which article? To what petition? Writ petition. Article 32 itself is a fundamental right. Judicial review is the basic structure of Constitution of India. It is based on the principle EB just UB remedial. Where there is a right, there should be what? Remedy. You have a fundamental right. In case of violation of fundamental right, you can approach High Court or Supreme Court. High Court under which article? 226. And Supreme Court under which article? Article 32. Through various writ petition, we have writ of habeas corpus, mandamus, certiorari, prohibition, and cure warrant. These are the writ petitions you can file it in the High Court and Supreme Court for the purpose of enforcement of what rights? Fundamental right. What right? Fundamental right. Are you clear with this, everybody? 33, 34, 35 are supplementary provision. What 33 says? Only who can abrogate or remove the fundamental right? Only Parliament, not the state. Parliament is the only one who has the power to remove the what? Fundamental rights. What is? And Parliament has the right to restrict or abrogate the fundamental right to the members of what forces? Armed forces, parliamentary forces, police forces, as well as the analogous forces. For example, Army officers, do they have right to freedom of movement? No. They need permission of the officers before they leave the camps. Yes or no? Next one. Article 34 is what? Deals with indemnity for the acts done within the what law? Operation of martial law. What's martial law? Military rule. What law? In Indian history, they never imposed the military rule in India. But this Article 34 says during military rule, if any person suffers the damages, who should compensate? State should compensate. Next one, Article 35 provides that where the Constitution expressly authorizes the Parliament to make a law restricting or giving effect to fundamental rights, only who can do it? But only who can do it? Parliament can do it. No other persons can do it. These are the fundamental rights. What rights? Fundamental rights. Are we clear with this, everybody? You guys tell me what are the topic we have discussed since morning in today's sessions. Tell me what is the first one? Clear one. Next one. Structure of the Indian Constitution. Next one.
Features of it.
Structure of Indian Constitution. Then 30, then 14, then 15, 16, 17 is not there. 19, 19.1a, 19.1b, 19.1c, 19.1d, 19.1e, 19.1f is not there, 19.1g. Then 20, 20 only 3 articles brother. 20 subclause 1, 20 subclause 2, 20 subclause 3. What is 20 subclause 1? Exports factor loss. 20 clause subclause 2? Double jeopardy. 20 subclause 3? Self-incrimination. 21 right to life and personal liberty. And 21A right to education. 22 protection against arrest and detention. 23 right against exploitations and prohibition of the beggary and all the system. And 24 prohibition of child labor. See 24 and 14. 4 is there, right? Who is prohibited from employment? Child of how many years? 14 years. Article is what? 24. Then we also discussed Article 33, 34 and 35. Which article allows you to approach Supreme Court for remedies? Article what? 32. Article what? 32. Next one, next one, next one. Amendability of fundamental right. Tell me, are fundamental rights are amendable or amendable? Because the law includes all the laws except Constitutional Amendment Act. But however, can Parliament amend the basic structure of the Constitution of India? This concept of basic structure was invented in which case law? Keshavananda Bharati versus State of Kerala. Have you heard about Indira Gandhi versus Raj Narayan case law? Where one of the important case law, Raj Narayan, he challenged the election of Indira Gandhi in the Supreme Court by filing writ of what? Quo warrant law. Because our election was rigged, there was corruption in the election. And Supreme Court disqualified her. To nullify this, what Indira Gandhi did, they brought amendment to the Constitution of India itself, stating that Supreme Court does not have a judicial review power of election of the public representative, election of the members. Supreme Court nullified that amendment stating that judicial review is the what structure? Basic structure of Indian Constitution. So Parliament has the power to amend any part of the Constitution of India except what structure? Basic structure. Clear with this? Now, Parliament has the power to alter any part of Constitution of India? Parliament has the power to alter any part of Constitution of India except what structure? Basic structure. An example of basic structure? Supremacy of Constitution, welfare of the state, principles of equality, nature of polity, judicial review, free and fair elections, secular character of Constitution, independence of judiciary, federal character. In law, whatever we have discussed based on this, are there any question? Right to education, write a short word on the what? Can you write in the examination if they ask question?
Yes.
Write to what? Protection against arrest and detention. Can you read the question, please? Reach. Can you write about prevent detention? Yes or no? Next one. Other safeguards provided under Article 22 for prevent detention as well as for the normal detention, arrest, monitoring, and provisions in it. Next one. Right against exploitation briefly describe the fundamental rights against exploitation under the Constitution of India. Can you write this? Next one. Remedy 33, 34, 35, no questions were asked till now. Amendability of fundamental right, no questions were asked. Next, we have 36 to 51, DPSP. What is DPSP? Directive principles of what policy? State policy. Are they mandatory in nature? No, but they guide the state in making the policies. Making the what? Policies. These principles are aimed at achieving the social, economic, and political justice. Underline the one, what justice? Social, economic, and political justice. Major discussion is they can ask questions based on difference between fundamental rights and directive principles of state policy. What policies? Directive principles of what policy? State policy. What is the first one? Enforceable. Which one is enforceable? Which one is not enforceable? Mode of operation, which operates without any legislation. Which one requires legislations? ABS. Effect in the absence of law. And fundamental right be enforced without any existence of law. Can you claim fundamental right? Even if there is no law to protect it. Yes. But for enforcement of directive principles of state law, there has to be a what? Law made by the states. Correct later. Next one. Legislative power. Um, Fundamental right restrict the legislative and what power? Executive power. Directive principles do not confer or take away what power? Legislative power. What power? It's just a guidelines to the state to make the law for achieving the social, economic, and political justice. Next one, judicial review. Which are subject to judicial review? Which are subject to judicial review? Fundamental right. But DPSPs are not subject to what here? Judicial review. Third's power to enforce. Third can compel the state to implement fundamental right, but not the what policies, directive principles are state policy. Yes or no? And you guys tell me if there is a conflict between fundamental rights and DPSP, which one is valid? What rights? The court looked into the strict rule and held that directive principles cannot override what rights? Fundamental rights. In case of conflict, they ask questions based on this, a practical question. In case of conflict between the fundamental rights and the directive principles of state policy, what is given effect? What rights are fundamental rights. And we have important directive principles of state policy. You guys can go to the important directive principles of what policy? State policy. Let's see it together. Tell me what is the first one. Who should maintain social order? Also the welfare of the people. Next one, principles of what justice? We have this right, equal right to livelihood for men and women, fair distribution of material resources for common good, no concentration of wealth causing harm to society, free legal aid, village panchayats, their right to work and education and assistance, human conditions of work at the working places, living wage and cottage industries, workers' participation in the management, that is trade unions, then uniform civil code. In Uttarakhand, we have uniform civil code, right? Uttarakhand, not in UP, there is no uniform civil code. Uttarakhand, we have a uniform civil code for marriage and for divorce. Goa, I think they implemented uniform civil code. Goa and Uttarakhand, two states. Next one, easy only. Why only these two states have these uniform civil code? It's not mandatory because divorce just ಇದೆ ಅಲ್ಲ ಅಂತಂದ್ರೆ it is a state. It is not mandatory. It is the state who has to implement it by making a what? Law. Next one, welfare of weaker section, public health and prohibition, agriculture and animal husbandry. Uh, See, cow slaughter is prohibited in UP and Bihar. It's one of the directive principles of state policy to protect the certain indigenous breeds of cows. When there is laws made by the certain states. So these are the DPSPs. This is the what? DPSPs. In the exam, they can ask questions based on difference between fundamental rights and DPSPs. Let's see what questions were asked based on DPSP. Can we read the question, please? What is the first question?
It's all right. I'm saying. Yeah. Is it BBS?
Let's start. What is the question? Is it correct? Are DPSPs are subsidiary to the fundamental right? Yes. Because in case of conflict, what prevails? Fundamental rights. If they ask this kind of question, what the guys will write in the examination? Can we read the answer also? DPSP shall not be requires to be implemented by legislature. The directives per se do not confer upon or take away any legislative power from the appropriate legislature. The courts are not competent to compel a government to carry out any directives or to make any law for that purpose. In case of conflict between the FR and DPSP, fundamental right would prevail over the directive principle. Between the directive principles and fundamental rights to give absolute primacy to one over the other would disturb this balance. Both can coexist harmoniously. In this, we can say that the statement is correct. These are supposed to present the answer for this. Differentiate between DPSP and fundamental right. As I said, important one. Can you guys write in the examination if they ask questions about difference between DPSP and fundamental right? Yes. Next one, fundamental duties. What duties? Have you heard about fundamental duties? Yes or no? So fundamental duties were not part of Constitution of India. They were introduced by the amendment to the Constitution of India based on which committee report? Sardar Swaraj Singh Committee report. What are the fundamental duties? What is the first one?
To abide by conduct and
Everyone should read. You have the material, right? Then read on. Covered by the Constitution and respect the ideas, institution, national flag and national anthem. That's your duty. Next one. Cherish and follow the global ideas that unify India's freedom struggle. Uphold and protect the sovereignty, unity and integrity of India. Wherever called upon to do so. For example, in future, if there is a war, if the government asks you to fight for India, you should be ready for that. Next one, promote harmony and spirit of common brotherhood instead of creating communal violence or disturbances. Next one, value and preserve the rich heritage of India's composite culture. To protect and improve the natural environment. Compassion for what creatures? Living creatures, animals. Next one, develop a scientific temper. That's your fundamental duty. Develop what temper? Second one, humanism and spirit of inquiry and reform. See, this is your fundamental duty. You should have a spirit of inquiry to learn and to reform, to change. You have forgotten your fundamental duty. Next one. Safeguard what property? Public quality and observe what? Violence. Avoid violence. Strive towards excellence and provide opportunities for education to one's child or a wall between how many years of age? That is your duty to provide opportunity of educations. These are the fundamental duties. Based on Article 123, they ask questions in the previous examination. Article 123 and Article 213 deals with what? Ordinance making power. What power? Who has the ordinance making power? President and governor. When they can make ordinance making power? Or when they can make ordinances? When the houses are not in session. Both houses or any one of the houses? Both the houses, if they're even if one of the houses not in session, President can make the promulgate the ordinances. Why? Because to make you need both the houses. Can president promulgate the ordinance on its own without the advice of council of ministers? Can president promulgate ordinance on his own? No. President should always act as per the whose advisor, council of ministers, cabinet advice. Yes or no? Based on this, they asked question in the previous exam. And this ordinance is valid for how many weeks? 6 weeks. Once the parliament comes into session, from that date, it is valid for how many weeks? 6 weeks. It has to be ratified within 6 weeks. If not, the law will lapse. Clear? How to present the answers? See, president has how many powers? First, what are the parts? Administrative power, military power, legislative power. What is the military power? Who is the supreme commander of the army? Everybody should answer. Who is the supreme commander of the army? Who can declare the war? And the advice of who? Who is the head of the council of minister? Who is the head of the council of minister?
Chairman.
She's recalling 104 of Companies Act. Chairman. Who is chairman? Huh? Shit on the chairman. The one who takes the chair and conduct the meetings of the meetings. Not shit, is it? Not shit. Exactly. Concentrate. Everybody listen. President has three powers. The first one, guys, administrative power. Second one, military power. Third one, legislative. Because he is the one who summons the parliament sessions, correct, right? And he also has the right to dissolve the parliament if there is a majority, correct, right? Next one, ordinance making power, most important. Based on this, they ask questions in the examination. Let us go point by point. Remember the point. What is the first one? President can issue what? Ordinance when urgent action is needed. Underline the word urgent action is needed. And the parliament cannot make a law immediately. So when president can promulgate ordinances, what is the first situation? When what is needed? Urgent action is needed and parliament cannot make law immediately. Available only when what is not in session? Both the houses of the parliament is not in session. That is, even if one of the house is not in session, the right is available. Next one, such ordinance making power has to be exercised by presidents on the advice of a council of ministers. Next point, such ordinance shall be laid before the houses of the parliament. Such ordinance shall cease to operate, means end to operate on the expiry of how many weeks?
6 weeks.
On a resolution as disapproving it are passed by both houses upon passing of the second of those resolutions. When two houses of the parliament assembles on a different date, the period of 6 weeks to be reckoned from the what date? Later of the 2 dates. See, from the date when both the houses are in session, from date, it has to be approved within how many weeks? 6 weeks. How many weeks?
6 weeks.
Last one. Such ordinance may be withdrawn by who? Resolution. At one time, any time. Governor also has legislative power as well as executive power, except what? Military power. Governor, correct, right? Who appoints the governor? Who appoints the governor? President appoints the governor. Can governor also promulgate ordinances on the advice of who? Council of Ministers of the state. Most important, these three I have already discussed in the class. There are three situations where ordinance by the president requires the permission of the ordinance by the governor requires permission of who? President. What is the first one? Permission would have required the previous sanction of the president. Means if a normal law was made in the state legislation, it would require the approval of president. For example, any law putting restrictions on the freedom of trade with the state requires approval of a president. So if that law is made through ordinance, even that ordinance requires approval of a president. Second one, the governor would have required to reserve such bill for the president consideration. If he feels that that bill can be reserved for the consideration of the president, it has to be reserved. And the last one, a state law with the same provision would have been invalid without whose consent? President consent. I have given examples for all the three. You guys can go through it. Next one. These are the provisions with respect to what? Ordinances. Were there any questions in the previous examinations? Read everybody. List out what notice? Article 123, they asked question December 2025 for how many marks? How many marks? Read the question. Parliament is not in session. Both houses are prorogued. Therefore, due to the urgency, the President promulgates an ordinance on a subject of national importance, discussed in detail, referring to the ordinance making power of the President under the Constitution of India. Can you guys write the answer if they ask this question? Can President promulgate ordinances on the advice of Council of Ministers? Is that law valid? For how many weeks? From what date? Assembly of Parliament. Up to how many weeks? 6 weeks. Next one. What is the next concept? Most important part of our Article 245 to 255 deals with what? Legislative power of the Union and State. First one, territorial distribution. The legislative powers can be classified into two categories. Territorial distribution of power. Second one is what? Subject matter distribution of power. Repeat. Which article to which article deals with distribution of power? 245 to 55. In case of territorial distribution of power, tell me who can make law for the entire territory of India? Who can make a law for the Parliament? For the state? For the state, who can make law? For a UD, who makes law? For the law made by the Parliament. See, simple. Listen, everybody. Who has the power to make a law for the entire nation? Who has the power to make a law for the state? Are the laws made by one state have effect in the other state? Are there any exception? Territorial nexus, remember? RMD, Bombay case law. Yes or no?
Yes.
Tell me, if law is made by Parliament and if that law is having an effect outside India, is that law valid or not valid? Is it valid or not valid? Can a person challenge that law saying that Parliament does not have the power to make a law which is having effect outside India? Why not? Why not?
Some things that have jurisdiction outside India.
So you mean to say Parliament has the power to make a law which is having effect outside India?
Yes. Yes. There are some cases.
Can Parliament make a law having effect outside India? It can make a law to punish a person who is outside India. Yes or no? But is it practically possible? But still, is the law valid? Practical impossibility is not the question here. Parliament has the power to make law for the what? The entire territory of India, even outside India. For example, we have BNS. BNS what has what jurisdiction? Extraterritorial jurisdiction. Trump arrested that fellow. Who's that fellow? Venezuela president. Because he was doing the drug trafficking. That is the justification he has given. So, law made by USA has effect in what? Other country as well. That is called as extraterritorial jurisdiction. Are you guys getting it? So, Distribution of power. Well, first of all, what? Distribution of power. Two classification. Territorial distribution of power, subject matter distribution of power. Territorial distribution of power. We have the union, we have the state, and union territories. To the entire union, the entire nation, who can make law? The state who can make law? Can one state make a law for other state? Generally, no. Are there any exception? Only when there is a what nexus? Rational nexus, territorial nexus. Can we read this provisions, please? Let's start. Parliament. Fast we will read. Let's start. Parliament being a what body? Can make law for the what? Whole of India. Parliament may also make laws for what approach? Extraterritorial operation. Such laws are valid or not valid? Are they valid or not valid? Valid. Next one. In H. Wadia versus Income Tax of Commissioner, it was held that courts cannot question the validity of a law on the ground of what territoriality. Court observed that issues like violation of internal law, international law, non-recognition by the foreign courts, difficulty in enforcement are policy matters and not legal grounds of what? Invalidity. Means the law made by the parliament can have what approach? What extent? Extraterritorial applicability. Yes or no? Second one. UT. Who makes law for UT? Who is the supreme law making body in India? Make law for the whole of India. Can you have an extraterritorial operation? We have the BNS, which has what? Jurisdiction. Extraterritorial jurisdiction. UT is administered by the central executive. Every UT is administered by who? President through an administrator appointed by him, who is called as empowers parliament to create local legislatures or council of ministers for certain union territories. So if there is a local legislatures on certain matters, who makes the law? Local legislator makes the law. For example, Delhi. Delhi is a what? Union territory. They also have local legislature. There is no example. Parliament therefore enjoys the plenary legislative power. What is plenary? Widest power. Plenary power. Doctrine of plenary power means what? Widest powers over Union territories, subject only to special constitutional provisions. Example: Metro Railway Act 2002, enacted by the Parliament to regulate metro rail operations in the national capital regions, only limited to one. Delhi. See, metro is a state subject. State is the one who makes the law. But in case of Delhi, who made the law? Parliament. Because Delhi is a what? Delhi is a what? Union territory. State legislatures, who makes the law for the state? State. Then, however, state have a extraterritorial approach. Yes, only when there is one nexus, territorial nexus. One nexus. This was explained in which case law? Wiley versus RMDC case law. According to Supreme Court, two conditions must be satisfied for the validity of the such law. The connection between the state and the subject matter must be real and not illusory, and the liability imposed by the law must be related to the connections. Remember, I discussed this case law. They were publishing magazines in Karnataka, that is Mysore, but they were circulated where in Bombay. So they made a law to tax production of that magazines. Is it valid or not valid? Valid. Why? Because there is a what nexus? Territorial nexus. What nexus? Next one is most important. Subject matter distribution of power. Which article to which article deals with distribution of powers? Everybody 245 to 255. Yes or no? What is the first one? What is the first one? Parliament. Second one? State. Parliament makes law for the what? Territory of India. Can it have extraterritorial applicability? All these things we have discussed. Next one, subject matter distribution of power. I discussed all this introduction, USA, Australia, Canada, India, all these things we have covered detailed in the class. I will not cover it in the marathon revision. Next one, distribution of subject matter legislation. We have how many list? What are the list? Union list, state list, concurrent. On union list, who can make law? State list, concurrent list. I will give the key important points in this. Concentrate. As I said, based on this, they generally ask questions in the previous examination. One questions for sure will come in the examination based on this topic. Concentrate. We have how many lists? What are the lists? Union list, state list, concurrent list. So, union list consists of subject on which only who can make law? Parliament has the exclusive power to make the laws. These subjects are considered as what importance? National importance and require uniformity of policy across the country. So, what matters are there in the union list? The matters which are of national importance and requires uniformity of policies throughout the nation. Those type of matters are there in the union list. For example, defense, companies act, income tax, all these are in what list? Union list. And the matters which are in the union list, who can make law? Parliament alone can make the law. Then we have a state list. What list? These subjects are typically the local or regional interest. National interest, which is matters which are of national interest. That in which list?
Union list.
The local interest or regional interest. They're in which list? State list. For example, public order, state list. Gambling, state list. Agriculture, state list. Industries, state list.
Alcohol.
Alcohol, state list. Police, state list. Otherwise, because these are all regional matters, regional interest. Right? And who can make law on the regional, state list? State. Next comes concurrent list. What list? Important. Concurrent list on a subject in which both parliament and state legislatures has the power to make laws. Concurrent list includes subjects which are of local in nature but requires uniformity at what level? National level across more than state. Example of concurrent list subject includes criminal law, marriage and divorce, transfer of property, contracts, etc. Both parliament and the state can legislate on the same subject in the concurrent list. What list? See, the matters which are in concurrent list are of local importance, but still they require uniformity at what level? National level. Got it? Yes or no? How many lists are there? Everybody should answer. How many lists are there? What are the lists? Matters of national importance are in which list? Matters which are of local interest? Matters which are of local interest but requires uniformity in what list? GST in what list? It was in which list? VAT was in which list? VAT. It was removed from that and added in which list? Through Constitutional Amendment Act. Because they wanted uniformity throughout the nation. Understood? Next one. In case of conflict, it's a बहुत important. This part is most important based on which they can ask practical question in the examinations. Tell me, in concurrent list, everybody, what list? Adi, in case of concurrent list, who can make law?
Both state and center.
Both state and center can make the laws. Now, what if there is a conflict between the two laws? Which law will prevail? The law made by the parliament will prevail. But however, if a law was made by the state with approval of the parliament, then the parliament allows the state to override the laws of what? Parliament. Correct, right? This is one of the exceptional situation. Concentrate everybody. In case of repugnancy, that is conflict between what? Parliament law and the same concurrently subject, parliament law will prevail and the state law become void to the extent of inconsistency. Are there any exceptions? Yes. What is the exception? Is reversed for the consideration of the president and receives the president assent, then such state law will prevail within that state. So it is not the parliament, it is the president. Underline the word. It should be reserved for the consideration of the president and receives the president assent. Whose assent? Then such state law will prevail within the state even if it conflicts with the what law? Parliamentary law. However, parliament retains the ultimate control. It can override the state law at any time by enacting this law, new law. It may amend or repeal the state law, thereby removing this effect. See, generally, if there is a conflict between the central law, between the laws made by the state and the parliament on the matters which are in the concurrent list, which law will prevail? Parliament law made by the parliament. However, if a law was made by the state and it has received the assent of the president, then the state law will prevail. However, parliament can change it to what law? New law or amendment to the existing state laws. Clear with this? Last one, residuary power. What law? Any matters which are not covered in any of these three lists. Who has the power to make law?
The second
Parliament has the power to make the laws. Yes or no? Yes. Next one. This topic is most important. This topic is what? Most important. Listen everybody. We're discussing which concept? Distribution of. Which article to which article? 245 to? First classification. Territorial distribution of power. Bolu? Second topic. Subject matter distribution of power. Which schedule? 7 schedule. Which schedule? How many lists? What are three lists? Evening list who can make law? List who can make law? Concurrent list? If there is inconsistency, which law will prevail? Can there be an exceptional situation where the of a clear with this? Now, on state list who can make law? Can parliament make law? Generally no. Are there any exceptions? Most important topic for the examination purpose, they can ask question based on this. In what cases parliament can make law on the matter which are in what list? State list. What list? What is the first one? What interest? Solve by. We should not spend more than 5 minutes for this. I will help you guys. If you guys get any doubts, I will help you guys. Let's start. What is the first one? When parliament can make law in the national interest.
Only when there are.
Read. Parliament can make a law on the state list subject only when the Rajya Sabha has a resolution necessary or expedient in the national interest. Whose interest? Who has to make a request? Rajya Sabha. The resolution must be passed by what? Not less than how much? 2/3 of the members of present are voting. The resolution remains in force for up to how many years? And can be extended again for 1 year at a time by what resolution? Fresh resolution. A law under Article 249 does not end immediately when the resolution ends. It automatically stops after how many months? 6 months from the date of resolution ceases. It means, see, generally who can make law on the state list? Is there any exceptional situation where parliament can make a law on the state list? In whose interest? That who should request? With how many members approval? Present and this resolution passed is valid for how many years?
1 year.
Means the law made by parliament valid for how many years? 1 year. Plus 6 months. Once the resolution ceases to have an effect, the law will be valid for extra how many months? 6 months. On the expiry of 6 months, what comes to an end? Law comes to an end. Law made by who? Can that resolution be extended? So how many? Then fresh resolution. For the session, keep on passing resolution, the law will be valid. Understood? First exception. Second exception is what? During proclamation of emergency. President's rules. Emergency. So during emergency, Parliament can make laws on any state list subject for the whole or any part of India. Such laws automatically stops after how many months? From the date of emergency ceases. After how many months? 6 months. Next one, breakdown of constitutional machinery in the state. That is president rule. Whose rule? If the president is satisfied that the state cannot be governed according to the constitution, president rule may be proclaimed under Article 356, and president proclaims president rule as per whose advice? Governor's advice. Next one, after that, under Article 357, legislative power of the state can be exercised by who?
Parliament.
Because it is under whose control now? President controls. Next one, on the request of how many states? 2 or more states. 2 or more states can make a request to whom? Parliament. On one request, who can make the law? Parliament can make the law. Correct, right? And any other state can also join by adopting it, by passing a resolutions. Once Parliament makes such law, only Parliament can amend it, repeal it, and also And the state that requested adopted it cannot change it on their own. Only who can do it? Parliament. Last one, to enforce what agreement? International agreement. That is treaty, agreement, convention with other countries, decision of international conference, associations or body. There can be a law made by the parliament. On what list? State list. You tell me, what are the exceptional cases in which parliament can make law and the state list matters? National interest, proclamation of emergency, controversial material and nothing but precedent rules. Fourth one, and the fifth one, to enforce the international agreements. More important, based on this, they ask questions many times in the previous examinations. Then next one, interpretation of legislative list. What list? Legislative list. One more important topics based on which they generally ask questions. Mark it important activity. What is the first one? Plenary parts. What parts? What is plenary part? Widest meaning to be given for every legislative list. Correct, right? Power to make include, power to amend it, power to make it effective retrospectively as well as what? Prospectively. So, when a legislative power is granted in any of the legislative list, without any limitation, it must be interpreted as what? As widely as possible. See, listen. The doctrine of plenary powers. Repeat everybody. Doctrine of provides that whenever a legislative power is granted, what is granted? On any subject without any limitation, it must be interpreted as widely as possible. It is what called as plenary power. I want everyone to repeat. What is plenary power?
When a legislative power
As widely as possible. That is what called as doctrine of plenary power, which says you should interpret a legislative power as widely as what? Possible. Power should be given full and effective meaning, but without making any other constitutional entry useless or negatory. The doctrine of plenary power says you should have the widest possible meaning. But that doesn't mean you will make other provision negatory or invalid. That is why we have this concept of and substance. Getting it? For example, industry. If you say industry, you should say industry means everything. But that doesn't mean you will make other provision negatory. You cannot include anything which is specifically mentioned in the other entries. So, doctrine of plenary powers provides that when a legislative power is granted to any of the authorities, it has to be given what meaning? Widest possible meaning. Widest possible meaning. And the power should be given full and effective meaning, but without making the other constitutional entry useless or negatory. The constitution must be interpreted liberally. Until and the word should be interpreted liberally, and especially when it refers to legislative powers. A general word used in a legislative entry includes what? Ancillary matters as well as the subsidiary matters that are reasonably connected with the main subject. What subject? What's ancillary? Supporting. What is subsidiary? For example, let's say you want to start a company for manufacturing of mobile phones. What are the ancillary matters to manufacture the mobile phone? Establishing industries, buying raw materials, opening showrooms. Opening showroom is a secondary matter. To sell a mobile phone. Procuring raw materials, hiring employees, hiring distributors. These are all what matters? Ancillary matters. Are you guys getting it? So, a power to make law. If whenever a legislative word is used in the legislative entry, it includes all ancillary matters as well as all what matters? Subsidiary matters that are reasonably connected with the what? Main subject. What subject? Therefore, a legislature empowered over a subject can make a law, can enact prospective as well as retrospective laws, can also legislate on the matter which are incidental as well as ancillary to that particular subject. These are the concept of plenary parts. If you ask question in the examination, what you will write in the examination about doctrine of plenary parts. What is doctrine of plenary parts? It provides the when a legislative has been granted with the power to legislate, it has to be given the what? Widest possible meaning. Clear? And the power to legislate include the power to legislate on the ancillary matters as well as the subsidiary matters. And that power should be given full and effective meaning without making other matter in the other entries negatory or invalid. Should be given the widest possible scope. That is what called as what? Plenary powers. And this power to make law includes power to make law retrospectively, prospectively, and to make law on the ancillary matters as well as the subsidiary matters. Should quote these points in the examinations. Done. Next one, harmonious construction. Most important article, sorry, doctrine. What's harmonious construction?
Without
When there is a conflict between the two entries,
without
two entries of the same list or two entries of the different list. Interpretation should be done in such a way that the conflict is avoided and effect is given to both the entries. And for this purpose, the scope of an entry can be restricted. Can be what? Restricted to give an effect to the other entry. It is what called as harmonious construction. Should always try to avoid the what? Conflict between the two entries. Can we read this please?
Doctrine of harmonious construction means that different entities
Avoid the conflict. It is presumed that Constitution does not intend to create conflict between the entries in the Union State and concurrent list. When two entries in two different lists appears to overlap or conflict, court must try to reconcile them, and correct the approach is to interpret both the entries such a way that effect is given to each. For achieving the harmony, the scope of one entry may be reasonably restricted so that other entry can also operate. Thus, harmonious constructions ensures the balanced distribution of legislative power and preserves the constitutional scheme of federalism. We have discussed this already, correct? Right? Have I solved these questions? Examples explain Madhigna,
Yes, sir.
industry and gas works.
Yes, sir.
Have I discussed this? Discussion Madhigna. Next one. The unsubstance rules. This also I have discussed, I guess. What's fifth and substance rule?
consider the core of the law is judged by its true nature and not by its incidental effect.
If the pith and substance of a law lies within the legislative competence of the legislator, but it is incidentally touching upon the matter which are outside the scope of legislative matter, that law is valid. But if the pith and substance itself is outside the scope of legislative competence of the legislature, is that law valid or not valid? Not valid. While deciding whether a law is within the legislative competence of the legislator, what you will take into consideration? The pith and substance of that law, not its incidental effect. There may be a law which lies where the pith and substance of the law is within the legislative competence of the legislature, but however it is incidental touching upon the matter which are outside the scope of the legislator, then that law cannot be declared as invalid. That is what called as what? Pith and what? Substance. Law is judged. What is judged? By its true nature and real purpose, not by its what effect? Incidental effect. What effect? Remember I gave an example of tree. The tree is within the compound of a person. Instantly goes to other person's house. The tree belongs to the one who's where it is situated, right? And he said, no. Next one. If a law substantially falls, under the word substantially falls within the legislative competence of legislature, but does not become invalid merely because it incidentally touches subject in the another list. In a federal constitution, overlapping of legislative subject is inevitable. There's a concept of overlapping, right? Alright, so no, we have discussed this case law, this Rajasthan health broadcasting banning of loudspeakers after certain time was based on health, not broadcasting. On the broadcasting matters, who can make law? On the broadcasting matters, who can make law? Center, Parliament. On the health matters, who can make law? State. Here the law was made banning using of loudspeakers after certain time. Here the law was made to not to regulate broadcasting. Here the law was made to regulate the what? Health of the public. So the law was within the legislative competence of a state, even though it is incidentally touching the what? The matter which is outside the scope of the state legislatures. Hence, it is valid because what is to be checked? The core, the pith and substance. What needs to be checked? Pith and substance. Colorable legislation. Have you heard about colorable legislation? Where legislature apparently acts within its powers, but its substance does not something which is not permitted to do. It is against the fit and substance rule. Where the law made by the legislatures looks like it is within the powers, but actually it is what? Outside the power. It is called as colorable legislation. Is that law letter not valid? Not valid. Constitution does not allow transgression of what is transgression? Assuming the power which is not given to you, it is called as transgression of power, whether that directly or indirectly. A law is called colorable when it is disguised in constitutional form, but its real object to achieve an outcome which is beyond the legislature's competence. It's based on the principle. What is the principle? What cannot be done directly cannot be done indirectly. This doctrine is opposite to the rule of with the substance. Correct, right? Colorable legislation strike down a law that is fraud on the constitution. Actually, the word fraud on the constitutions. Remember this, we have discussed a case law where what case law we have discussed for this? Government was not allowed to acquire the property without payment of compensation. So what they have done? They made a law where they acquire, they take over the property and they promise to repay the rent due on that property. So essentially, they're not giving any compensation to the owner because they're just returning whatever was due to him. They're not paying any compensations. So is that law valid or not valid? Not valid. Because you are trying to make a colorable legislations. These are the four doctrines. Any one doctrines can come in the examinations. What are the four doctrines we have? Plenary part. Second one, third one, and fourth one, colorable legislations. Are we clear with this? Next one, Article 301 to 307, judiciary, and then we are done with Aste. So it's already fast. Let's start. Next one. What is the next one? Freedom of trade, commerce, and intercourse. Is it required to be free? Is it required to be free? What is required to be free? Freedom of trade, commerce, and intercourse should be free throughout the what? Territory of India. Territory of what now? Can there be restrictions? Can there be a restrictions on the freedom of trade or commerce or intercourse? No. Subject to Article 302 to 307. Listen everybody. Trade, commerce or intercourse throughout the what? Territory of India. Shall be what? guarantees free flow of trade, commerce, and intercourse throughout the India. Applies to interstate as well as the intrastate trade. Does not extend to foreign trade. Correct? Right? This freedom is only for the what trade? Internal as well as the trade between the state as well as the outside the state, but not outside India. Are there any restrictions be imposed on freedom of trade? Can there be a restrictions on the freedom of trade, commerce, or intercourse? Intercourse means the free movement of goods from one state to another state. Can there be restriction? Yes, under Article 302 to 307. Other than Article 302 to 307, the trade, commerce, and intercourse throughout the territory of India should be free. Now, this restriction on the freedom of trade, intercourse, or commerce should be what? Free. But if the restriction is not immediate restriction, like indirect restrictions, for example, uh, power outage. If there is no power, is it possible to do trade or commerce? To carry out the manufacturing activity, is it possible or not possible? But that is not a restriction on the fundamental right. That is not a direct restriction. Are you guys getting it? If government put a restriction saying that you should not manufacture something, what is restriction? And Article 301, because it's a direct restriction. So Article 301 deals only with what restriction? Direct restriction, not the indirect restrictions. Clear? So example, in this case, Supreme Court held that only those laws which directly and immediately restrict or impede the trade, commerce, or intercourse fall within the Article 301. Thus, regulatory laws like licensing, what laws? Electricity times, radio regulations do not violate Article 301 merely because they incidentally affect the trade. Only the direct and immediate effect. The laws having direct and immediate effect are covered under Article 301. Exception, do we have any exception to this? Yes, what is the first one? We can make no. Parliament may impose what restriction? Everybody what restriction? On trade, commerce, and intercourse. In whose interest? Public interest. No preference or discrimination between state. So when the parliament put reasonable restriction, they should not give any preference to what? One state over the another. Are there any exception? Yes, in case of what? Scarcity of goods in any part of India. If there are shortage of onions in one state, the parliament can give preference to which state? One state over the other state, even in case of water supply. Next one, power of state legislature. Power of what?
State legislature.
Now let's see, listen. Can during, for example, now there was a shortage of gas. Correct, right? And Parliament has put a restrictions on the Reliance industry, saying that we should convert all your facilities to what? Manufacturing of gas instead of petroleum product. Is it a restrictions on the freedom of trade? Yes. Is it allowed? In whose interest? Public interest. Because gas is an essential commodity. Correct, right? I have a freedom of trade. Government cannot put restrictions. As per Article 302, my fundamental right. This is one of the right available to me. But again, Article 302, 303, 304, 305, and 307 gives the power to the Parliament to put what? Restrictions. Correct, right? 301, who can make the restrictions? Parliament. In whose interest? But the Parliament should not give discrimination between the state, except in case of what? Scarcity of goods. Of state legislator, state can also impose non-discriminatory taxes on the goods imported from the other state, involves reasonable restriction in whose interest? Public interest. That is why alcohol is taxable.
Yes.
If it is not taxed in Karnataka, if you bring something from outside India, Karnataka, it is not taxable. If something is taxed in Karnataka and you are bringing something from other state, is it taxable or not taxable? Taxable. They can impose that restriction. That is, impose tax also restriction, right? Allowed or not allowed? Allowed. Are you guys clear with this? Karnataka levies tax on liquor imported from what? Goa. Only if liquor produced in Karnataka is what? Taxed at the same rate. What's the logic behind this? If you don't tax it, what people will do? They import from what? Goa itself. And nobody manufactures in Karnataka. Is it a restriction? Yes. What restriction? Reasonable restriction. Next one, saving existing laws. Pre-constitutional laws remain valid unless what? President directs otherwise. State monopoly laws, law creating state monopoly are immune from challenging under which article? 301. They are valid. Right? Now, most important one, based on this, they can ask questions in the examinations. State monopoly and freedom of trade. Can a state create monopoly in its own favor?
Yes.
Yes or no? There are exception to which article? 301 as well as 19 clause 1 G. After the Constitutional First Amendment Act, state can create monopoly in its own favor, but the state need to justify such monopoly as reasonable before the courts. Who can create monopoly?
State.
Last few topics. Who can create monopoly?
State.
In whose favor? Its own favor. But state has to prove that monopoly is what? Reasonable. What are the conditions for that reasonableness? Listen, everybody. Article freedom under Article 19(1)(g) does not prevent the state from carrying any trade, business, industry, or service either directly or through a state-owned or state-controlled corporation to the complete or partial exclusion of citizens. What are the provisions is? Article 19(1)(g). What is Article 19(1)(g)? Freedom of trade, profession, and occupation. But that article does not prevent the state from carrying any trade, business, industry, or service directly or through whom? State-owned or state-controlled corporation to complete or partial exclusion of the citizens. Thus, citizens cannot claim a fundamental right to compete with the state in such monopolized business. For example, atomic energy. This is what most important, judicial scrutiny of monopoly laws. You tell me, if Parliament makes a law to create monopoly in its own favor, to exclude citizens from carrying the same business, can that law be challenged? Yes, because even that law should satisfy the reasonableness.
Yes, sir.
Now, what if Chief Minister of Karnataka, Siddaramaiah, because he wants to give benefits to a private organization, he creates monopoly where indirect benefit is going to private individuals. Is that law allowed or not allowed? Not allowed. A monopoly created should always give the benefit to the state. So even a law conferring monopoly to the state must satisfy the what? Reasonable test. What test? Reasonable test. Based on this, the last question in the examinations, court examines which provisions are essentials for creating and operating the what? State monopoly. There is a law. In that law, there are 10 provisions. How many provisions? All 10 provisions are not valid. Only those provisions which are essential, only essential to create monopoly and operate monopoly, only they are valid. Rest of them are not valid. My question is, listen everybody. Can state create monopoly?
Yes.
a law creating monopoly in favor of state, is it valid or not valid? Is it a violation of Article 19(1)(g)? Yes, but still is it valid? Because it is an exception. But even that law creating monopoly should satisfy the reasonable test. Yes or no? No. When the court examines the law, it examines the provisions which are essentials for creating and operating the state monopoly, and only those provisions which are basic, essential, and integral to the monopoly are protected under Article 19(6) Clause 2. Provisions that are subsidiary, incidental, collateral do not automatically enjoy the what? Protection of Article 19(6) Clause 2. Only those provisions which are what? Basic, essential, and integral to the monopoly are protected. Are not protected. Yes or no? See, listen. Let's say government want to, you are producing the tendu leaves. What is tendu leaves? They use it for tobacco. Huh? What is this leaf? Kendu, Kendu, leaves. Kendu leaves. I think it is kind of tobacco leaves. What happened? Listen, state made a law saying that only state authorized persons can buy the Kendu leaves because it is of no, it's a kind of hazardous goods. They wanted to create a monopoly in purchase. If you grow Kendu leaves, you can only sell it to who? Authorized dealers or officers appointed by the state. That provision is valid. And the government also put one more rule saying that they should sell only at a price fixed by this authorized dealer. Is that required to create monopoly? No. Article 301 6 authorizes the parliament, sorry, 19 US 6 2 authorizes the state to create monopoly, correct? But only those provisions which are essential to create monopoly are protected, not everything. You tell me, fixing the price, is it essential for creating monopoly?
So in this case, yes, I guess, because it might be exploited.
Who will exploit it?
State.
So if state fixes the price, it means they're exploiting. Law allows you to what? Create monopoly. In the name of monopoly, you cannot regulate the price, right? You want, see, what is the object of the law here? You want to acquire all the Kendu leaves. Correct, right? Why? Because you don't want it to go to the hands of some other person. Correct, right? For that purpose, you can say, you can put a restriction saying that only you can buy it. That is essential. At what price you should buy it is not essential, right? That provision is not valid. Yes or no? If you say you should sell only at 100 rupees, how is it valid? Is it essential for the purpose of creating monopoly? No. So only the provisions which are basic, which are essential, and which are integral to create monopoly are protected, not any other matters. This was in which case law? This was in which case law? Akadashi Pradhan versus State of Orissa. State of what? Orissa. Next one. We have the concept of judiciary. In judiciary, what is the highest court?
Supreme Court.
Under Supreme Court, under High Court, and we have Civil Court, Criminal Court. Criminal Court, we have Executive Magistrate as well as the Judicial Magistrate. All these things we have discussed in the BNSS, and we also have the special tribunals. What tribunals? Writ jurisdiction. Have I discussed about writ jurisdiction?
Yeah.
Who has the writ jurisdiction?
Supreme Court.
Supreme Court as well as under which article High Court has writ jurisdiction? Under which article has High Court has jurisdiction? 32. What are the writ? Very good. I was just checking whether you guys have attentive or not. Listen. Supreme Court, 32. High Court.
26.
What are the types of writ you can find? Habeas corpus, mandamus, prohibition, quo warranto, and certiorari. What is the first one? Habeas corpus. What is habeas corpus? To have a body. It is an effective bulwark of personal liberty. So whenever a liberty of a person is curtailed, you can go for file what? Writ of habeas corpus. Issued to a person who is illegally or wrongfully detained. Court issues rule Nissi calling upon retaining authority to show cause why the writ should not be issued and explain the grounds of detention. The detaining authority must produce the detained person before the court. If no legal justification exists, the person is released immediately. Disobedience of this amount to what? Contempt of court. Contempt of what? Court. Writ of mandamus we command. This is issued when a authority have an obligation, especially public authority, and if they fails to comply the obligations, then court can issue a writ of mandamus. Writ of what? Issued by whom? Issued by whom, everybody? Against who? Government, corporation, inferior court or tribunal. When an authority fails to perform the public duty or refuses to exercise the jurisdiction vested in it, the purpose of this writ is to compel the performance of what duty? Public duty, and it commands any activities. The writ is not issued if the authority has discretion or if there is any effective alternate remedy available. Correct, right? इसको हमने discuss किया था in case of listen. We have discussed this in Limitation Act. Limitation and writ. Last topic of Limitation Act. In case of breach of contract. Breach of what?
Contract.
With the government. You can file a civil case. What case? Correct, right? When the civil cases can be filed, you cannot file a writ of mandamus. Now, to file a civil case, what is the limitation period? 3 years. But there is no limitation for filing a writ of mandamus. So what people used to do, after 3 years, they used to file a what? Writ of. But court applying the analogy of this limitation act, they used to not, they may not allow the repetition. After how many years? 3 years. Because for filing writ, there is no what period? Limitation period. Yes or no? There is a connection between writ as well as the Limitation Act. We have this concept in the Limitation Act. We will discuss one more of that. Next one. What is prohibition? Prohibit whom? Inferior court from exceeding their what? Jurisdiction. The purpose is to prevent assumption of jurisdiction, means claiming a jurisdiction is not with the court. It is issued when it acts without jurisdiction or excess of jurisdiction. It violates any law or procedures. It is issued only against the judicial or quasi-judicial authorities. Certiorari, what is certiorari? To quash an order which is not available against any body having legal authorities determining the rights of subject or having a duty to act judicially. It is issued when the authority acts without jurisdiction or in excess of jurisdiction, in violation of principles of natural justice, or commit any wrong apparent on the face of the record. In all these cases, what is issued? Writ of. What is certiorari? To quash. Last one, quo warranto, means by what authority? If somebody claims to a public office without legal justification, who can be charged by filing petition? Writ of. Writ of what? Quo warrant. It is issued when the officer is public, substantive, and treated by a statute or constitution held without any authority. The writ is available against illegal appointment in the public office. This was issued in case of Indira Gandhi case law. Indira Gandhi case. Delegated legislation. Have you heard about delegated legislation? What is delegated legislations? It's a supreme law making body in India. Can it delegate its power to the executive. It is called as what? Delegated legislation. What legislation? Why there should be delegation of power? Because time of there's a limit of time of legislature because parliament meets only how many times in a year? 3 times in a year. Next one, need for some weapon for coping with situation created by the emergency and to meet the changing circumstances. There should be what legislation? Delegated legislation. Classification of subordinate legislation. What is the first one? When the executive make the law within the powers conferred to them, it is called as what legislation? Executive legislation. What is the second one? When the judiciary makes the law, it is called as what? Judicial legislation. Priya, next one, municipal legislation. What legislation? When the municipal authorities makes the law, it is called as what legislation? Municipal legislation. Nothing but this BBMT. Next one, autonomous legislation. Educational institutions makes the laws. And last one, colonial legislation, but we don't have colonial legislation now because we are not under the control of any authorities. Principle applicable for delegated legislation. Based on this, they can ask questions in the exam. These are everything. Who can make law? Who is the supreme law making body in India? Can they delegate the principal law making power? Can parliament say, executive, you make all the laws? They cannot delegate the entire power of making. They can only delegate what? Part of it. And this delegation of power should be based on certain principles. Any delegation of power which is uncontrolled, unguided, is it valid or not valid? Not valid. Yes or no? Only what can be delegated? Only no. We cannot delegate essential legislative power. Have you seen in companies that in many places there is a word called as prescribed? That means they're delegating the power to executive. Are they delegating unguided power or guided power? That is why there is a limitations also. They say as prescribed, which shall not exceed this much. Because they cannot give the uncontrolled power. That is the principle of delegated legislation. In determining the validity of delegation, courts may rely on the preamble as well as the provisions of the Act. Whether the delegation intra-virus, ultra-virus must be decided in each case by applying the what? Set up judicial test. Separation of powers, we will discuss this in the what is separation of powers? There is a clear distribution of power between the legislature, executive, judiciary. But however, in the modern political system, it is not possible to maintain the absolute separations where the functions of one organ is performed by which organ? Other organs. For example, who makes the law? But nowadays, even who makes the law? Executives. Who perform the judicial functions? Judiciary. But nowadays, even the executive discharge the what functions? Judicial functions. Next one, law making process. What process? Law making process. Simple one. What is bill? Everybody, what is bill? Draft legislative proposal which must pass through various stages before it becomes an act of parliament. It is what called as bill. Draft legislative proposal. Which should pass through various stages before it becomes a law. There are various stages. What is the first stage? First reading. What reading? First reading. Read everybody first reading. When it's introduced, Lok Sabha. What is bill? Draft legislative proposal. Clear? It has to go through what stages? Various stages. First reading. What happens in first reading? Lok Sabha, Rajya Sabha. Not required to be in both Lok Sabha itself. It can be even from where? Rajya Sabha. But it has to be passed in one houses? Both houses. Next one, introduced by who? Private bill, private member. Next one. It's leave of the house, permission of the house. So introduce the bill. Next one. The leave here, permission is granted. The bill is introduced at this stage. It's called as what? First reading. If opposed, the speaker may allow the brief explanations or full discussion when legislative competence is questioned. Leave to introduce a finance bill or appropriation bill is put directly to the voter. Publication in the official gazette. After introduction, the bill is published in the what gazette? With the speaker's permission, the bill may be published even before the what? Introduction. With whose permission? Speaker. But publication is mandatory before it's put for voting. Next one. After introduction, presiding officer may refer the bill to what committee? Standing committee. And committee submit is what? Report. The committee report has a persuasive value. What's persuasive value? They can take it to consideration, but not mandatory. Second reading. What is second reading? In this stage, what happens? General discussions on the bill as a whole, focusing on its what? Principles and policies. Second stage. What is second stage? Clause by clause consideration, where amendments may be proposed and voted upon. Third reading. The member in charge moves that bill be passed. Debate is confined to arguments for or against the bill. Ordinary bill passed by simple majority. Constitutional amendment bill, most important, it requires majority of total membership and 2/3 of the members present and voting. If the house has membership of 500, out of that, what is the majority? 250. What is 2/3? No. Majority in total membership. Out of 500, 251 must be present. Out of this persons present, how much should vote? 2/3 of the members present are voting. Both should be satisfied. First thing is majority in membership. Second thing is 2/3 of the members present and voting. Both conditions must be satisfied for what amendment? Constitutional amendment. In other houses, then it goes to which house? Other house, Rajya Sabha. And if the bill is not passed, there can be a joint sitting. What is joint sitting? Where both houses members comes together and vote. And then it requires assent of a president. And with these, we are done with the Constitution of India. Right, India? Constitution of India. Now concentrate for the next 10 minutes. I want everyone to focus. Try to answer. But this only you get to know whether you are on the right track or not. Concentrate. Read the question first one. Can you answer this question? You can make a law for the entire UT state legislation. And have extra can it be applicable to other state? Yes. Only when there is an electoral nexus. What is the case law for this? Bombay versus RIDC case law. Subject matter distribution of power. Explain the distribution of subject matter of legislation. There are how many lists? Union list, state list, conference list. In case of inconsistency or in case of contradiction, which law will apply? In case of concurrent list, which law will prevail? Parliament's law. Are there any exceptions?
Yes.
Okay. Under the Indian Constitution, Parliament is empowered to make law even on the subject mentioned in the state list. Discuss the power of Parliament to make law on the state list. Exception. What is the first one? National interest, proclamation of emergency, breakdown of constitutional machinery on the request of two or more states to enforce the international agreement. Here, interpretation of legislative list, explain the doctrine of plenary powers. Pith and substance rule. Have I discussed pith and substance? If the pith and substance of a law falls within the legislative competence of a legislature, but however it incidentally touches upon the matter which are outside the legislative competence, the law is not considered to be invalid. It is valid. Correct, right? Because the main pith and substance falls within the what competence? Legislative competence. Have I discussed this Rajasthan case law? Rajasthan case law.
Yes.
Broadcasting and public health. We have discussed this case laws in class also. Harmonious construction. Write a short note on harmonious construction. Conflict with the two different legislative lists are entries in the same list. Next one, tolerable legislation.
Yes. Yes.
Explain various principles behind interpretation of legislative list. Doctrines. How many doctrines are there? 4. What are the 4 doctrines? Plenary powers, pith and substance, harmonious construction, tolerable legislation. Does the law made by state to create monopoly rights in favor of a person to carry on any business affect the freedom of trade? Yes, but however, is it valid or not valid? Valid because who can create monopoly? State. The creation of monopoly rights in favor of any person. Am I writing the exam? You guys are writing the exam. Then read. Ah, that one. Second one. First one is already done. Second one. Can state create monopoly in itself? Yes, we have discussed what is the situation where it can create monopoly. Judicial structure of India is well equipped to deal with every kind of cases. Comment, we have the structure, Supreme Court, High Court, and all these things. Writ jurisdiction, explain the writ jurisdiction of Supreme Court and High Court. Habeas corpus, can you guys read the questions based on habeas corpus? Read. Writ of habeas corpus is a bulwark of personal liberty. Justify this statement in the light of provisions in the Constitution of India. Raj has been wrongfully detained in custody by Yogesh, a police officer. What remedies available to Raj's family in such a case under the Constitution? Discuss. This question was asked in June 2025, 5 marks. What is the importance of habeas corpus? It means to have the body. It's an effective bulwark of what liberty? Personal liberty. It is issued to a person who was illegally confined or detained. Correct, right? How it is issued? Court issues a rule receipt to be produced before the court, and if he has been detained without lawful justification, will be released immediately. Not complying with the order of this court, it is considered as what? Contempt of court. Correct, right? Next one. Writ of mandamus. Short note and one. Writ of mandamus. See, based on writ, if you observe the tendency, they're generally asking one questions out of any of these writ. Correct, right? December 2024. Read the writ. Sorry, case. Mr. Attorney, the Municipal Corporation of Indore has a legal obligation to provide clean drinking water to residents of Madhya Pradesh Municipal Corporation Act 1956. However, for the last 6 months, residents of the Ward 12 have been complaining about the lack of clean drinking water supply. Despite repeated complaints to the municipal authorities, no action has been taken to these issues. Raj decides to take legal action. He wants to file writ petition in the Madhya Pradesh High Court to complain. What type of writ petition can file with the High Court in these cases? What writ petition he can file? Writ of mandamus. Clear? Can he file a case? Can he file this writ in the he should also write, see, writ of mandamus is not available against the president and governor.
Yes.
We can also ask question based on these minute points. Getting it? Next one, writ of prohibition. Short note on writ of prohibition. They not ask question based on this. There are chances that they can ask question based on writ of prohibition in the upcoming examinations. Writ of certiorari, they not asked questions based on this. They can ask question in the upcoming exam. What is certiorari? The quash. When it is issued, when authority act without jurisdiction, nexus of jurisdiction, and violation of what principle? Natural principles of justice, or commit any error which is apparent on the face of the decisions. Next, what is quo warranto? Under what authority? And delegated legislation, there is one question. Separation of powers. Explain the concept of what? Separation of powers. Law making process. Can you explain law making process? Yes. Now we will discuss the case study questions. What questions? Case study questions. Everyone must read it. Let me see how many of you can answer it. Read.
Miss, I can say order for actually the booty.
The moment you read the case law, you should always the information should flash. First one is what export patent law. Second one is what arresting and detention and arrest protection against arrest and detention. Within 24 they should produce, they're not produced. Next, continue. Self-impression of bias happening. It is self-incrimination. Not allowed. Next one. Arguing that it did not require his consent as they were launched, it requires. Next one. Sanjay was suffering from Syria. Now, why sample not allowed? Thumb impression they can take. Thumb impression and voice sample also they can take. Samples they can take. But whatever stored in brain cannot be taken. Voice samples they can take. Continue. Sanjay was suffering from severe asthma while in the custody. He collapsed finally before being taken to a hospital. Based on the above questions, answer the following question. This was asked in December 2025 examinations for 10 marks.
Whether opening of sentence.
Here's the question number one. Whether opening of Sanjay's room is in the home. Which fundamental right? Article 20 clause 1. Protection against ex post facto loss. Next one. Was compelling Sanjay to password narco resistance? Next one. Sanjay was detained. Does it amount to violation of Article 22? Sanjay was denied emergency medical services while in custody. Discuss whether this is a violation of which article? Crime के guideline. Life मर जाए हाँ 21 सब तो होता है ना they can put written of ABS calls. Yes or no? See the answers. Exposed factor law. Then does it violate thumb impression and voice samples? No. Within how many hours? 24 hours. No person shall be deprived. Can he approach High Court? Can they approach High Court? Which writ? Writ of habeas corpus. Writ of what? Next question. Very good. Distribution of power is an essential. So this distribution of power concept was there in which law itself? Government of India Act itself, 1935. Present constitution adopt the method followed by the Government of India Act and divided powers between union state and pre-list. Union list, state list and concurrent list. So remaining I can go through it. Okay, let's read the question. It is almost universal rule in all the constitutions where distribution of legislative power is divided that it is concurrently filled in the central law limits if it conflicts with the state law. However, our constitution recognizes an exception to this general or equal. Explain. What is the answer for this? Consent of the CSR. President of Parliament. President. If there is a law made by the state on a subject matter which is in the concurrent list in conflict with the law made by the parliament, the law made by the parliament will prevail. However, if the law is made by the state with the consent of president, the law made by the state will prevail. However, the parliament by making a new law or by amendment can nullify the effect of the state laws. Understood? We have discussed this. Question number 2. What is the case law for this territorial nexus? What is the case law? Bombay versus RLDC. Can you guys write next verse? On a particular item included in the state list, the state of Haryana, Rajasthan requested the parliament to make a law for them on the particular subject. Can the parliament make a law on this matter? Exceptions when who can make on parliament on the request of only state to one state. Once the law is made by parliament, only parliament can change it, modify it or anything. Next one. Can you guys write the answer for this? The entries in the two legislative list are the matters in the two different legislative lists should be interpreted in such a way that the conflict should be avoided and effect is given to both the entries or both the list. For the purpose of this, the scope of one entry can be restricted to give an effect to the other entry. That is called as what? Harmonious construction. Next one. Discuss the principle. Okay. If it is necessary or expedient in the national interest that Parliament should make a law on a matter enumerated in the state list, can Parliament do so? At the request of who? Rajya Sabha. With how much authority? Two-thirds of the members present today. Are you guys able to answer the question? Simple, say simple. This question was asked in June 2025 for how many marks? 10 marks. Then here this question. Okay, you can read it at home, but read the questions. Rajasthan government passed the act. In this contention, correct or wrong? Wrong. Pith and substance is within. What's the pith and substance here? Health, not the broadcasting. That is why this law is valid or not valid? Valid. What is the rule applicable here? Pith and substance. Explain the term judicial review. Who has the power of judicial review? Supreme Court and what court? High Court. Under Article 32, Supreme Court. Under 26, High Court. Judicial review examining the constitutional validity of the law and dictating it as void if it is unconstitutional. Next one. What do you understand by meaning? A broad proposal of legislation which required to go through certain stages to become a law. It is called as what? Procedure wise, what are types of bill? You don't have the types of bill in your syllabus. It is shifted to CSET level. Okay. We have this in the, there are some amendments, right? Array, this marathon is already available in the YouTube. I have introduced this because the notes has been changed. And one more thing is there are a few amendments. There are certain topics are removed. इसीलिए and procedure, what does mean by the word law under Article 30? What do you mean by law?
Law.
Act, rules, regulation, bylaws, ordinances, customs, and also usages. Are we clear with this? These are the questions. By this, we can observe the trend that there will be 10 marks questions out of this chapter for sure. But if you see here, this is one prediction now. Most of the in the past, in the 2025 December, question was based on which topic they ask questions? Fundamental rights. Before that, they ask question based on distribution of legislative powers. Few topics are left here. What are topics left? DPSP, then fundamental duties, then also the starting point, this justifiability of fundamental rights. And they have not covered this Article 14, Article 15, and Article 16. Article 14 and Article 15 and Article 16 is not covered. So there may be a chances of practical question based on Article 14, 15 and 16. Trust me, these 10 marks questions are the easiest way to score in the examinations. Question only answer ಇರುತ್ತೆ ನಿಮ್ಗೆ ಗೊತ್ತಿರಬೇಕು ಯಾವ ಕ್ವಶನ್ ಅಂತ ಅಷ್ಟೇ. Getting it? Yes or no? With these, we are done with which chapter? Constitution of India, which has weightage of how much? 10. Not 10 marks, sir. 10 marks, one question. Plus, we have one more questions of 5 marks, right? 15 to 20 marks. But don't go with this prediction. Sometimes they will not ask even a single question also. 5 marks question to they'll ask. 5 to 10 marks. We can keep it. That so first everybody, if you want to pass, you must solve this question bank. Keep it in mind. If you don't solve this question bank and if you go to the examinations, then at least don't know what you guys do. You must solve all the questions of this question bank because मैंने मेहनत किया है. No, because you want to pass. If you want to pass, you should solve all these questions. Get an idea what type of questions will come from each topic. I have included all the recent examinations questions even for the topic. So, the Indian Contract Act, which year? 1872. This chapter is all about, present everybody. This chapter is all about contract. And this covers both general principles as well as the special contract. Section 1 to 75 deals with general principles of contract. Section 124 to 238 deals with special contracts. Remember these topics, listen everyone. Remember the topics of the Indian Contract Act 1872. Listen, section 1 to 75 deals with what principles? General principles of contract. Section number 1 to 75. In these, you have this topic IOC, CFL, VP, what is the acronym? IOC, CFL, VP. This is the acronym. Remember the provisions of general principles of contract. What principles of contract? General principles of contract. Now, what is I, sir? Introduction. Here we discuss how the contracts are formed. Then O means what? Offer at acceptance. Offer and what? Acceptance. C means what? Consideration. Again, C means what? competent to contract, and capacity to contract. F means what? Free consent. L means what? Lawful object and consideration. And V means what? Void agreements. There are few agreements which are declared as void by the law itself. P means what? Performance of the contract. What of the contract? Performance of the contract by the parties. D means discharge of contract, and B means a breach of contract. So a contract at the general principle starts with introduction and ends with what? Remedy for the breach of contract. Can you guys repeat the acronym, please? IOC. CFL, VP, DP. I gave a hint. Remember this acronym as well. Indian Oil Corporation want to distribute what like CFL line to the village people, and further they applied the law to Dana Bank. Which one? Repeat. Indian Oil Corporation. What is IOC? They want to distribute what like CFL lines. And for the loan, for whom they want to distribute CFL lines to the village people. And for the loan, they apply to which bank? Dana Bank. Which bank? So Indian Oil Corporation, CFL lines to the village people. And for loan, they apply to which bank? Dana Bank. So what is our introduction? O, offer and acceptance. C, consideration. Again, C, capacity to contract or competent to contract. F, free consent. L, lawful object and consideration. D, void agreements. C, performance. And D, discharge of contract. Starts with introduction, ends with discharge of contract. B, breach of contract. Correct, ma'am. And D, discharge of contract. Yeah. And also along with that, we have a contract of indemnity, contract of guarantee, contract of pledge, and we also have a contract of bailment and contract of pledge. And one more contract is there, that is contract of agency. Contract of what? Agency. Clear with this? Yes or no? Let us start one by one. So 1 to 75 provides what principles of contract? General principles of contract. Correct, right? So outside this, uh, we have 1 to 75 is there, 76 to 123 is not there, then 124 to 238 is there, and 239 to 266 is not there because they were dealing with partnership and these provisions were written and a separate law was made. What was made? A separate law was made called as the Indian Partnership Act 1932. Now, formation of contract. We know that every contract starts with what? Offer. Starts with what? Offer. Offer plus acceptance becomes what? Promise. Promise plus consideration becomes what? Agreement. Agreement which is enforceable by law becomes what? Contract. Our entire discussions deals with this equation itself. Clear? So what is the first step, everybody? Proposal. Proposal. Proposal plus acceptance. Promise. What is the first step in a contract? Proposal plus acceptance becomes what? Promise. Promise plus consideration. Agreement. Agreement plus enforceable by law. Contract. And there are few conditions to be satisfied for enforceability of an agreement. What are the few conditions? Fish can laugh at night. Remember? Fish can laugh at night. FC. Fish can laugh at what time? Night time. So what is F? Free consent. What is C? Competent to contract. What is that? Lawful object and consideration. And what is that? Not expressly declared as what. If these four conditions are satisfied, the agreement is enforceable by law and the agreement becomes contract. Otherwise, the agreement is not enforceable by law. Only if the agreement is enforceable by law, the court will enforce the rights and obligation of the parties to the contract. Are you guys clear with this? What is the first step in a contract, everybody? Offer. Offer plus acceptance. Union, offer plus acceptance, promise. Promise plus consideration, agreement. Agreement plus enforceable by law, contract. How many conditions are there? Four conditions. What are the four conditions? Free consent, competent to contract, lawful object, and not expressly declared as void. Our entire general principles of contract revolves around this equation itself. Clear with this? Next one. Definitions I will discuss whenever they are required. Definition of proposal, definition of acceptance, promise, consideration, agreement, reciprocal promises, void agreements, contract, voidable contract, and void contract. Now, I'll just give a brief of all these definitions. Listen, everybody. Can you guys repeat the equation for me, please? What is the equation? Offer plus acceptance becomes what? Promise. Promise plus consideration, agreement. Agreement plus enforceable by law becomes contract. What is the first one? Offer. So what is offers are simple. When one person, how many person? Keep this in mind. Every contract requires how many persons? Two persons. Out of that, one person express his willingness to do. When one person signifies his willingness to do or abstain from doing something with the intent to obtain the assent of the other person, is said to make an offer. When can we say Keshav is said to make an offer? Keshav is said to make an offer to Pradyumna when he expresses his willingness to do or abstain from doing what? Something with the intent to obtain whose consent? Pradyumna's consent. It's what called as what? Offer. Now Keshav is called as the offerer and Pradyumna is called as what? Offeree. Who made an offer here? Keshav. Pradyumna. Did he make an offer just to inform him or to get his consent? That is what called as offer. Just giving information is not an offer. You should have an intention to obtain the assent of which party? Other party. So when they ask question about offer, your answer must have the word called as intention to obtain the assent of which party? Other party. Who expressed the willingness here? One person. When one person signifies what? Willingness to do. Are what to do? Willingness to do. Positive or negative? Positive. Or abstain from doing something. What is abstain from doing something? Not to do something. When one person say I will do something or I will not do something, if you give a consent, it is called as what? Offer. Offer can be positive as well as negative. To do something or abstain from doing something. That's what called as offer. The one who makes an offer is called as what? Offerer. Other person is called as what? Offering. Are we clear with this, everybody? Now, what is acceptance? A person to whom the offer is made signifies his assent. What do you mean by assent? Approval. It is called as the acceptance. Now, Krishna made an offer to Pradyumna. When Pradyumna says yes, it is considered as acceptance. And what is promise? An accepted offer becomes a promise. Who made an offer? Keshav to Pradyumna. And when Pradyumna says yes, it becomes a promise. In that situation, there will be reciprocal promises. What promises? Promise for a promise. He made a promise to sell the goods and he made a promise to make the payment. There are two promises here. Promise for a promise is considered as what? Reciprocal promises. What promises? So now, first of all, tell me, what is a promise? An accepted offer becomes what? Promise. And what is an offer? One person signifies his willingness to do abstain from doing something. Why? With the intent to obtain the asset. He said to make an offer. One who makes the offer is called as an offer, other person is called as offer. An accepted offer becomes what? Promise. Becomes what? Promise. Next. Every promise will and a set of promise having consideration to each other, it becomes an agreement. It becomes what? A promise is not valid unless it has a consideration. A promise must have a consideration. If I make a promise, if there is no consideration for this promise, it is not legally enforceable by law. Every promise or set of promise, but set of promise, more than one promise, must have consideration. Must have what? A promise without consideration is not enforceable by law. So every promise or a set of promise must have a consideration to become an agreement. Become a what? Now the question is, what is consideration, sir? What is consideration?
Something in it.
Something in return. Simple. See, I am not the desire of the promiser, promisee, or any other person.
That's not something I want to.
Very good. You guys remember?
Such
Abstinence or a promise is called as consideration for the promise. Listen, everybody. When at the desire of promise, desire of either the promisee or any other person has done or abstained from doing, does or abstains from doing, promises to do or abstain from doing such an act or abstinence is called as the, or promise is called as the consideration. So consideration can be past, present as well as the future. Done means past. Does means future. Promises to do something. Does means present. Promises to do is what? Future. And consideration can be past as well as present as well as future. Consideration can be positive as well as negative. What is positive? To do something. What is negative? Abstain from doing something. But that should happen as per whose desire? Promises desire. Whose desire?
Promises desire.
Tell me if I make a promise. Is it valid or not valid?
not valid.
If there is a consideration,
Valid.
who should give consideration? Who should give consideration?
Promise. Promise.
At whose desire? promisor desire. Who should give consideration? But whose desire? Promisor desire. Can it be positive? Yes. Negative? Yes. From something?
Yes.
Abstain from doing something? Past?
Yes.
Present? Future? Past? Who can give? Not any other person. I don't care who gives. You give as per desire, promises desire. Either you give it or someone else can give it on behalf of you. We have the Chennai versus Ramaya case law for this, where you already gave a consideration on behalf of Chennai. Valid or not valid? Valid. But it should be as per whose desire, promises desire. If I make a promise to sell this water bottle, either you should pay or someone else should pay. How much? As per whose desire. I should pay how much ever I ask, not how much ever you want to pay. That is what called as consideration for me. If you do something voluntarily, is it a consideration for me? Because consideration must always happen as per whose desire, promise or desire. But can be from who? Or any other person on behalf of the promisee. But as per whose desire? Can it be past? Present? Future? Positive? Negative? That is what called as consideration. What is consideration? And the desire of promisor, promisee or any other person. Thus are abstained from doing, thus are abstained from doing, promises to do, or abstain doing something. Such an act, or an abstinence, or a promise is called as consideration. Clear? And every promise and a set of promise having consideration for each other, it is called as what? Agreement. Called as what? And every agreement which are enforceable by law becomes one contract. And how many conditions for enforceability? Four. What are the four conditions? Free consent, lawful object, comprehensive contract, and not expressly declared as void. And what is a contract? Every agreement which are enforceable by law is called as what? Contract. It is really called as what? Contract. And there are how many conditions? Four conditions. How many conditions? Now listen everybody. Otherwise clear with these four conditions: free consent, competent to contract, lawful written consideration, not expressly declared as well, becomes a contract. Becomes what? Contract. Clear with this? Now what is a contract? Agreement enforceable by law. Right? Agreement is called as what? Contract. Agreement not enforceable by law. Void agreement. What agreement? Means it is void from the beginning itself. Then comes void contract. What contract? Void. A contract which ceases to be enforceable by law because void when it ceases to be enforceable. Matlab that contract is valid in the beginning, but due to certain unforeseen cases, natural calamities, or supervening impossibility, if the contract becomes impossible to perform, it is considered as what contract? Void contract. What contract? Void. Void agreement is different, void contracts are different. Which one is void from the beginning itself? Void agreement. What agreement? Void agreement. Which one is void after the contract is made? Void contract. If it ceases to be enforceable by law, void contract. If it is not enforceable by law, void agreement. Are we clear with this? Yes or no? I will give examples. I should tell you whether it is void agreement or void contract. बोलेगा आप लोग agreement with minor. Void agreement. Agreement. I made an agreement today to teach law, but something happened to me and I'm not able to teach it. Void contract. This Syrian war, I had a contract with Iran to not Iran with Saudi Arabia to purchase the oil, but because of the war, that the highway is not highway, waterway is blocked. Now, is it supervening impossibility? Yes. The contract is valid or void? Void contract or void agreement? Is it not enforceable by law? Ceases to be enforceable by law. What the difference? Next, there is one more contract called as voidable contract. What contract? This a contract becomes voidable in three cases. The first situation is when the consent of a party is not free. The contract becomes what? Voidable. Contract becomes what? For example, let's say if I take your consent by fraud or by coercion or by undue influence, it is called as what contract? Voidable contract. Means you have a right to cancel it. If you remain valid, silent, it becomes valid. But if you cancel it, it becomes what? Void contract. What contract? A contract which is enforceable only at the option of how many party? One party, but not at the option of which party? Other party. It is called as voidable contract. I think the situation, you guys should tell me what will happen in this case. A girl has taken the consent of a boy. She's saying that she's not married. She was not married, but she is actually a widow. She got married earlier, and the husband died within 1 hour of getting married. So she did not Papa, yeah, it happens. She did not disclose this information to the boy and she took the consent of the boy to get married to him. Boy got married to her and later he discovered that she was already married. Now tell me, is this contract valid or voidable or void contract? What contract? For exception to cancel it. Can you remain it? Then it becomes enforceable by law. Now tell me, if husband don't want to live with her, can you go to the court and cancel the contract? Can wife do that? Can husband do that? Now, what if he chooses to continue with her? Can he continue with her? Is the contract valid? So these options are with whom? Only the boy. That's why it's called as what contract? Wider contract. Term. But once he accepts that contract becomes one contract, valid contract. Then we can enforce it, both the party can enforce it. Let's say he wanted to live with her, they got a baby. After having a baby, he wanted to leave the other baby. He want to get divorced. Can he get divorced? Can he get divorced? Can he get a divorce? Why yes? No. Hey, so here, like he he had a what? Correct. He had a quick car. Contract is valid contract. What contract? Valid contract. Now, if he is not ready to live with her now, he wants to cancel the contract. Can he cancel? No. Can wife file a case against him to live with her? Can she compel him to live with her? Yes. इसको बोलते हैं conjugal right. What are conjugal right? The purpose of getting married to is to live together. Correct, right? If anybody is not living together, you can file a case against them in the court. Ask the court to compel him to live with you. It's a right.
Yes.
Marriage is a contract.
Yes. He fight any other.
हाँ, reason तो फाइल कर सकता है. What reason you can give? You cannot give a reason of. You should give a valid reason.
First,
And you have to provide in the contract law that you is abusing her. You must have evidence to prove it. You cannot just say she's abusing you. And first of all, even court takes the
yeah.
statement that wife is abusing, the side is otherwise. So it's very difficult to put it in a court of law. But I agree with your point. However, if they mutually want to learn it, they can. It's very difficult to maintain your accent. Very good. अंदर से आना चाहिए. Marathon, oh my God. What is on? White contract. What contract? What is wide open contract, guys? It's a contract which is enforceable at option of how many parties? One party. But not at the option of which party? Other party. It is considered as what contract? Wide open contract. Clear with this, everybody? Now we will discuss about the other project. That's it. Section number 10. Based on this, there can be a theory question. Very important theory question they can ask. They can ask one of the essential element of a valid contract. What contract? Valid contract. I will forward it immediately today. I will send it today itself. Don't worry. Let's start. Huh? Session number 10 provides. See, what's a contract? Agreement enforceable by law. Well, agreement which is enforceable by law is called as contract. But how many conditions satisfy for enforceability? Four conditions. What are the four conditions? In consent, competent to contract, lawful object of consideration, law expressly declared as what? Mark it important for theory question. What question? Theory question. You can write down somewhere that it is important for theory question. Okay, I will only write here. I will write it and share it to you guys. Okay, so this one is a theory question. What question? Theory question. There can be a chances of theory question. I'll write PQ and PQ. PQ means theory question. Okay, PQ means practical question. Now tell me, if they ask all agreements are contract, but all contracts are agreement, but all agreements are not contract. Comment me should say all agreements are contract, provided if they are made with what consent? Free consent by a person who is competent to contract for lawful object and consideration, which is not expressly declared as what. Understood, everybody? Along with these, there are a few more conditions to set. What is the first one? Consensus added up. What is consensus added up? Meeting of mind. Both of the party should agree to the what thing? Same thing. In what sense? Same sense. First essential. Second one, there should be intention to create what relationship? Legal relationship. Are intended to have the what? Legal consequences. For this, you have this case law called as Balfour versus Balfour case law. Domestic agreement. In case of domestic agreement, there is no intention to create what relationship? Legal relationship. What relationship? Legal relationship. Are you clear with this? What is the first essential? Consensus. Consensus and second one, intention to create what relationship? Legal relationship. Second one, third one, consideration. What consideration? Lawful consideration. Fourth one, parties to the contract are legally capable of contracting, and there should be a genuine consent. What consent? Nothing but there should be a free consent between the parties to the contract. Next one, the object and consideration of the contract is legal and not opposed to what policy? Public policy. Object must be legal. And next one, the terms of the contract are certain. If it is uncertain, the agreement is not enforceable by law. The meaning of the contract must be certain, should be clear. For example, if I agree to sell oil, should mention what type of oil, how many liters of oil, at what price, all these terms must be specified. And the last essential is that agreement should be capable of being what? Performed. If an agreement is incapable of being performed, the agreement is void. For example, if I promise to run 1,000 kilometers per hour, how many kilometers per hour? 1,000 kilometers per hour. Is that agreement valid or not valid? Not valid. Why it's not valid? Possible to perform, impossible to perform, impossible to perform. Understood? Can you guys write if there's theory question based on this? Yes or no? What type of theory question they can ask? They can ask what are the essential elements of what contract? Valid contract. Can you guys tell section number 10? Section number 10 says all agreements are contract if they are made with what consent? Free consent by a person competent to contract for lawful object and consideration, which is not expressly declared as void. And further, there are how many conditions? First one, consensus added up, intention to create what relationship? Legal relationship, should be not consideration, capable of contracting, genuine consent, legal and not opposed to public policy, terms are certain, and agreement is capable of being performed. It is not impossible to be performed. Next one more question. Based on offer, they can ask this theory question again. What question? Theory question. Types of offer. They can ask what are types of offer, whether they can be theory question or practical question. What is the first one? Particular offer. Specific offer. What offer? What specific offer, sir? An offer made to an identified person. What person? Everybody must repeat when I ask the question so that you guys remember it in the class itself. Yes or no? Uh, let's start. That's our offer. No? Specific offer. What offer? Offer made to identified person or a specific person. It is called as what offer? Specific offer. Next one, general offer. What offer? Any offer made to public at large. You know? Public at large is considered as what offer? General offer. A general offer can be accepted by anyone by performing the conditions of the offer. For example, these tickets are on such examples of what offer? General offer. Ticket purchase for entrance into places of amusement, ticket issued by railways, bus companies, clockroom tickets, many other contracts without the printed document contains the numerous terms of many of which parties receiving the ticket or document is ignorant. These are also called as special conditions. What conditions? When you purchase a ಹಲೋ ಸರ್ ಇದು ಬ್ಯಾಟ್ರಿ ಬೇಕಿತ್ತು ಸರ್ ಬ್ಯಾಟ್ರಿ ಕಳಿಸ್ತಾರೆ ಇದನ್ನು ಚಾರ್ಜ್ ಆಗ್ತಿಲ್ಲ ಬ್ಯಾಟ್ರಿ Let's continue. Let's continue. Okay, next one. Listen, everybody. Okay, next one. What is general offer? Offer made to the public at large is considered as what offer? General offer. What offer? Who can accept general offer? Anyone by performing the conditions of the offer. Even see in the agreement. If an offer contains special conditions, what conditions? So that even if you don't read them, are you bound by it or not bound by it? Bound by it. Because you're presumed to have read that. For example, when you buy a railway ticket or the flight ticket, behind that there will be some terms and conditions. Are you bound by the terms and conditions? Yes. Even if you have not read them, however, there should be reasonable conditions. What condition? Reasonable conditions. Now you guys tell me types of offer. What is the first type of offer? Specific offer. General. Second one, general offer. Third one, cross offer. When the parties exchange the theoretical offer. What offer? Without knowing about each other's offer, it is called as what offer? Cross offer. For example, you are in. This is not possible nowadays, but it is possible. It was possible when the offer was made by post. Let's say you are in Mumbai. I am in Bangalore. I make an offer by letter. You also make an offer by letter. Similar offers. I also make an offer, you also make an offer. You get my offer, I get your offer, which are same offer. It is considered as what offer? Cross offer. Both are offers itself. Either I should accept your offer or you should accept what? My offer to become a valid contract. Are you clear with this? What is cross offer? Exchange of identical offers. Bro. It is called as cross offer. Next one, open, continuing, and standing offer is what most important. If an offer is allowed to remain open for a specific period of time for its acceptance, it is considered as what offer? Standing offer or open offer or continuous offer. If I say I will keep this offer open for 1 year, it's considered as what offer? Standing offer. And during this 1 year period, you can accept the offer more than how many times? More than how many times? So one time. It is considered as what offer? Standing offer. What offer? Standing offer. Yes or no? We have this example. Can you see the example, please? Where P tender to supply the goods to up to certain amount and over a certain period, yes, order did not come up to the amount expected and B sued for the breach of contract and each order was made was a separate contract and B was bound to fulfill orders made, but there was no obligation on the end to make any what order on. Correct, right? Yes or no? I keep an offer open for a particular period of time. You can place the order and accept my offer. And every time you place an order, it is considered as what contract? Separate contract. A contract? I want to accept my offer. No. But once you accept, it becomes what? Obligation to supply goods. Is it same contract, different contract? And every time you place the acceptance, it is considered as what contract? Different contract. Are you clear with this? One more example, here tender was put to obtain a raw coffee beans by a company. The coffee beans were required to provide and as and when the order is placed. The tender was awarded to the partnership firm. The firm, there was no concluded contract. Contract will be concluded on placing the what? Placing the what? Correct, right? Because tender itself is an offer. And only when you accept it by placing the order, it is considered as an acceptance. Next one is counter offer. What offer? This counter offer, when the offeree changes the terms of the offer, it is considered as what offer? Counter offer. What offer? For example, let's say I offer to sell at 100 rupees, but you say I will buy at 50 rupees. It is considered as what offer? Counter offer. What offer? When the offeree changes the terms of the offer and gives acceptance, it is considered as what offer? Counter offer. What offer? In case of counter offer, which offer will lapse? Original offer will lapse. Which offer will lapse? Original offer. Based on this, they asked question in the previous examinations. In case of counter offer, you know what offer? Which offer will lapse? We might offer to sell this at 100 rupees. The moment you say 50 rupees, it is considered as only to counter offer. In case of counter offer, which offer will lapse? Original offer will lapse. Let me accept your offer and reject your offer. Are you guys clear with this? What is counter offer? When the offeree agrees to accept the offer subject to conditions of modification in the original offer, it is considered as one offer counter offer. Are we clear with this? Next one, contract by post. Contract by what? Post. The rules of contract by post. Till fifth one, it is types of offer. Tell me what are types of offer. They can ask any question based on this. What is the one type of offer? Specific offer, general offer, permanent offer. What is specific offer? Offer made to a specific person. It is considered as what offer? Specific offer. Public at large, general offer. Same offers are subject to conditions and modification. Counter offer. What specific level of time? One offer. Standing offer. One offer. Clear types of offer. Next we have contract permanence post. Listen everybody. Communication of acceptance. Communication of what? Acceptance. ये थोड़ा confusing concept है, but still listen everybody. Listen. Now when communication of offer is complete, listen. If I make an offer today, you're present at the same place. When the offer is complete, I make an offer saying that I want to sell this water bottle. When it is complete, immediately. In this case, you get to know about the offer immediately, right? Because we both are present at what same in the same place. What place? Same place. If I make an offer by telephone, when the offer is complete, immediately. But if I make an offer by post, when letter reaches to whom, to the offering. That is when you get to know about the offer, right? It's a no. So keep this in mind. An offer is complete when it comes to knowledge. Offer is knowledge. Who is knowledge? But however, in case of contract by post, when the acceptance is given by post, what is given by post? If the acceptance is given by post, the acceptance is complete against the proposal. What is proposal? The one who makes the offer. When the letter of acceptance put into the course of transmission. There is a presumption in case of acceptance by post. Even though I'm not aware about it, still I'm bound by your acceptance. I cannot cancel my offer once you post what letter of acceptance. Are you guys getting it? But can you cancel your acceptance? Yes. Till it reaches to whom? Reaches to whom? Offer. We have discussed this in detail in the class. Yes or no? Yes. Next one. Can offer be revoked? Before who gives acceptance? An offer can be revoked before the acceptance is complete for who? Offerer. Once acceptance is complete for the offerer, he cannot cancel his offer. Tell me, if I make an offer by post, letter is in transmission, can I cancel offer today? Tomorrow? Once you receive the offer, you can cancel it. You can cancel the offer till what is complete? Acceptance is complete. When the acceptance is complete, when you post it, till that time, can I cancel my offer? Everybody is on. An offer can be cancelled till who gives the acceptance? Offer he gives the acceptance. Who gives the acceptance? Our acceptance is complete for who? Complete for the offer. And we know that if acceptance is given by post, acceptance is complete when it is posted. When it is what? Posted. Are we clear with this, everybody? Yes or no? Next one. Contract over telephone. Is it possible to make contracts over telephone? Possible or not possible? Possible. Yes or no? But all the parties should hear the offer and acceptance clearly. Then only what is concluded? Contract is concluded. Communication of offer may be expressed or implied. Expressed or what? By words expressed. Other than words, implied. When a coolie comes and pick a luggage, it is considered as what offer? Implied offer. What offer? You can add this one more topic for the purpose of your types of offer. You guys tell what are the types of offer? What is the first one? Specific offer, general offer, and counter offer. See this Cargill versus Cargill is more company versus and one more case law is there. Harbhajan law versus Harcharan law case law. In case of Cargill versus Cargill is more company limited case law is for what? General offer. What offer? In case of general offer, who can accept the offer? Anyone can accept the offer. Now, we can accept the offer by performing the conditions of the offer. There is no requirement of communicating the acceptance by words. By what? Words. For example, if I say, if anyone consume this water bottle and if they die, I will pay them 1 lakh rupees. How can I accept this offer? Now, if I say if anyone consume this medicine called a smoke ball and if they get affected by influenza, I will pay them 1 lakh rupees. A lady bought the smoke ball, that is medicine, she consumed it, but since she got affected with the influenza, can she claim compensation here? Yes. I made an offer and she gave acceptance by what? Performing the conditions of the offer. What was the conditions of the offer? She should consume the smoke ball. Yes or no? What was happened in which case law? Carlin versus Carbonic smoke ball complemented case law. Then we have Harbhajan law versus Haricharan law. What happened in this case law? Your boy was missing. You made an offer to pay 1 lakh rupees to anyone who finds the missing ball. Is one of If anyone finds the missing boy, he will pay the finder reward of how much? 1 lakh. A person found the boy without being aware about the offer. Can he claim the compensation? No. It is always communication first. You should be aware about the offer when you find the what? Missing boy. Yes or no? An acceptance of an offer and ignorance of the offer is not considered as an acceptance. If you alarm Shukla also it is there. If you're not aware about the offer and if you accept the offer as an acceptance, what are you not valid? Not valid. An acceptance of an offer and ignorance of an offer is not a valid acceptance. There should be communication of offer first. Yes or no? Usko pata nahi tha there was an offer. He simply found the boy. Then he got to know about the offer. His acceptance will be not valid. Not valid. First offer, then acceptance. Are we clear with this, everybody? Next one. Offer and invitation to offer. Are they both same or different? Offer and invitation to offer is both same or different. See, out of offer and invitation to offer, invitation to offer is not a final expression of willingness. When a person communicates the terms on which he is willing to negotiate, willing to what? It is considered as what? Invitation to offer. Bolo? When a person communicates the terms on which he is willing to negotiate, it is considered as what? Invitation to offer. But when a person expresses the final terms, it is considered as what? Offer. Considered as what? Offer. But yes or no? Auction notice. What notice? What notice? Is it offer or invitation to offer? Keshav. Auction notice is what? Tender notice. Tender notice. Invitation to offer. Bidding at auction. Offer. Auction notice. Bidding. Tender notice. Imanchi and tenders given. Offer. And advertisement in the newspaper. Invitation to offer. Then prospectus. Display of goods. Invitation to offer. That machine, vending machine. Invitation to offer. What offer? Invitation to offer. You can accept. You can. You put a coin and you make an offer to buy it. It may accept it or it may what? Reject it. When you enter into a contract. Yes or no? Metro. It's an implied contract. What contract? Implied contract. Unless clear with this. Now display of interest rate at the bank. Invitation to offer. Are you clear with this? Yes or no? Now tell me, listen everybody. I'll make an announcement to sell this what Yeshas Academy. I make an announcement. How if you come to the academy? Then I cancel the auction. Can you file a case against me? Yes or no? Why no? Because it was a state invitation to offer. Unless you make an offer, I accept it. There is a question of contract between us. Yes or no? Offer is different. Invitation to offer is different. Acceptance of which one create legal obligations? Offer, but not the invitation to offer. Next one, Harvey versus basic case law. What is Harvey versus basic case law? This what happened? The communication of price. What? On which a person is willing to negotiate, it is not considered as offer, it is considered as what? Invitation to offer. If somebody come and ask me, sir, will you sell me water bottle? What is the lowest price? I say lowest price is 100 rupees. Is it an offer or invitation to offer? Invitation to offer. I'm just giving the information. Giving information is considered as what? Invitation to offer. Quotation is what? Invitation to offer. Menu card, price tag, display of goods, advertisement in the newspaper, quotations, menu card, all these are considered as what? Invitation to offer. So only when the invitation is accepted, it becomes what? Offer. Yes or no? And acceptance and offer creates what? Legal obligation. They can ask a practical question based on this. One more theory question. One important theory question. They can ask theory question like lapse of offer. When the offer lapses. What lapses? Offer lapses. ಇದು ಮೇಲೆ ಒಂದು questions ಕೇಳ್ಬೋದು. Based on offer, there are two possibilities. Either they can ask types of offer or they can ask what? Lapse of offer. And based on this invitation to offer, they can ask practical questions. Clear with this? What is the first situation when the offer lapse? If the offer is not accepted within what time? Specified time. What time? After this lapse of time, what comes to an end? Offer comes to an end. Second one is what? Not. If it is not accepted in the what mode? Prescribed mode. What mode? मैंने बोला था you should accept the offer by depositing the cash. But again, sometimes by telephone, not valid. If I say telephone, telephone. If I say WhatsApp, WhatsApp. If I say email, email. If the offer is not accepted in the prescribed mode, what will lapse? Offer will lapse. But what will lapse? Next one, the offer rejects. Who rejects? Offer rejects the offer. What comes to an end? Offer comes to an end. Fourth one, and the offerer or offeree dies before the what? Acceptance. Oh God, Shantam Papam. What comes to an end? Offer comes to an end. And next one, the acceptor fails to fulfill the condition precedent. What precedent? मैंने बोला था I can accept this offer after fulfilling this condition. आपको CA पास करना पड़ेगा और CS का पास करना पड़ेगा और कुछ तो कुछ करना पड़ेगा. You can accept this offer only after get married, but you accept this offer without without getting married. Is the acceptance valid or not valid? Not valid. मैंने एक offer दिया. I gave an offer to you. The offer बढ़ गई. ಏನಂತ? I will send the goods to you, provided you should clear the examination in first attempt. But if you not make it happen, then what happens? Offer again lapse. But yes or no? Next one, offer he makes counter offer. Offer he makes what offer? In case of counter offer, which offer will lapse? Original offer lapse. This is the cases in which what lapses? Offer lapses. What is the first one? Specified time, more prescribed, rejects, dies, condition precedent or acceptance, uncounted. What are it? In all these cases, what lapses? Offer lapses. Theory question is possible out of this topic. Are we clear with this, everybody? Next one, acceptance. We are done with offer. Offer is done? Yes. Sorry, Bolo, offer is done. What is offer? When one person signifies his willingness to do or abstain from doing what? Anything with the intent to obtain the certain which person, other person is said to make an offer. One who makes the offer is called as what? Offerer. Other person is called as what? Offeree. Now what is acceptance? When the person to whom the offer is made signifies his what? Acceptance. It is called as what? Acceptance. Rules of acceptance are pretty concentrated, everybody. Acceptance may be what? Expressed or what? Implied. By words, it is considered as what of acceptance? Expressed one. Other than words? If you take an offer to give 1 lakh rupees to anyone who finds the missing boy, and if you find the missing boy, it is considered as what of acceptance? Expressed or implied? Implied. You find the missing boy, it means what? You're doing some action. Not you're not saying I'll accept your offer by words. You're accepting it by what? Conduct. Expressed one or implied one? Implied. Next one. If a particular whether of acceptance is specified, the offer must be accepted in the one half, prescribed one and a half. That is the one more condition. What is the first condition? Acceptance may be expressed or implied. Should be in what mode? Prescribed. It must be unqualified and absolute, because if it is qualified, when it becomes a counter offer. If I say I will sell at 100 rupees, you must accept to buy at what price? 100 rupees. If I say cash, should be cash. If I say credit, should be credit. If you say something is it is considered as what offer? Counter offer. What offer? Counter offer. Counter offer or conditional offer acceptance operate as what? Rejection of what? Offer and causes its lapse. Next one, is acceptance required to be communicated? Yes. Case of communication is important. Remember, even in case of negotiation of negotiable instrument, what is important? Communication. Yes or no? So delivery is important there. What is communications or informations? If you accept the offer, but you don't communicate to the other person, is it valid or not valid? Not valid. Acceptance must be communicated either in the prescribed mode or in the usual or reasonable manner. What manner? Reasonable manner. Next one. Silence amounts to acceptance. Mere silence does not amount to what? Acceptance. If the offer is one, this is what most important. Look at everyone. If the offer is one, which is to be accepted, being acted upon it, then there is no requirement of communication of acceptance unless the offer itself specifies it. You can accept that offer by performing the conditions of the offer. For example, offer to give a reward of 1 lakh rupees to anyone who finds the missing boy. How can you accept this? By finding a what boy? Missing boy. You have to inform the same to the person saying that, sir, I accept your offer and find the missing point. No. Just for calm karo bas. That's some more in give reward sigate. But what if I have specified? I will give a 1 lakh rupees to anyone who drink this water, provided they should give an acceptance before they perform this condition. Then you should communicate the acceptance. Yes or no?
Yes.
Other than that exceptional situation, if an offer is required to be accepted by performing the conditions of the offer, it can be accepted by performing the what? Conditions of the offer. There is no communication required. Or the next one, acceptance must be given in what time? Reasonable time. What time? And what is reasonable time is a question of fact. If a person makes an offer, you should accept within how many years? Hence, it can be 1 day, 2 day, 3 years, 4 years, 5 years, depends upon the type of goods. For example, if I offer to sell tomatoes, what is reasonable time? Aparna, what is reasonable time? Not Aparna, Lakshmi, not Lakshmi, Annapurna. Yeah, we have Namulya. Saraswati, sorry, Saraswati. Yeah. Acceptance, I we have 50 pages, concept guys. Acceptance must be given within what time? Reasonable time. What time? And what is reasonable time is a question of fact. An offer becomes irrevocable by what? Acceptance. By what? Acceptance. ಅರ್ಥ ಆಯ್ತಾ? Based on this, they can ask questions in the examination. Roots of acceptance. One, roots of acceptance. Confident everybody. Roots of what? Acceptance. Next one. With these, we are done with acceptance. अब हम discuss करेंगे consideration. What is consideration, guys? You guys, I'll take rest for 1 minute. You guys read it. Read it fast. Can consideration be executed? Executed. Fast. Which one is present? Can it pass positive? Negative? Executory means that it makes the form of promise to be performed in what? Future. If it is promise, executory. If it is done, executed. It was done before, past. But all these things should happen at whose desire? You tell me. Consideration given before promise. What consideration? Consideration was given before promise. After promise. Execute future. While giving the promise. Rules of consideration. Now you guys tell me what are the rules of consideration? Tell me what is the consideration first of all? When by the desire of a promiser, we see or any other person done or abstain from doing, does or abstains from doing, promises to do or abstain from doing something, such an act or abstinence or a promise is called as what? If you know this, you know the essentials also. I will not explain, you guys only read it. No consideration, promises in none. Second one. It can be act or abstinence or a promise. What is abstinence? Negative or positive? Third one. It's consent. Yeah, mutuality means what? Consideration for a consideration. I make a promise, you should give a consideration, or somebody should give a consideration. You make a promise, to promise, I should give a consideration, or on behalf of me, someone else should give a consideration. But for every promise, there must be what consideration. And in a contract, there will be what promises? Reciprocal promises. What promises? Reciprocal promises. Next one, consideration must be. It should be real. Matlab, if I promise to discover a treasure by magic, real or unreal? Is it possible to discover a treasure by magic? Is the consideration valid or not valid? Should be real, possible to perform. Next one, virtual consent reversal. Next one, although consideration must be of some and it need not be adequate. Need not be. Let's say you have a phone worth of 1 lakh rupees. If CSR come and ask you guys, at what price you will sell it? ₹1 lakh phone. So I'm to buy at 2 lakh rupees. Wow, very good. Jemon, tell me, you guys tell. One say one. Very bad for your name, Saraswati. Live up to your name. What is this? 99,999 rupees 16. At what? One say. Let's say the price is 1 lakh rupees. At what price you'll give it to CSR? CSR. Say Himanshi, at what price you'll give it Himanshi? Don't say free, sir. I can't take anything at free because any agreement without consideration is void. I'm 50. Now okay, 50. In this contract, what are we married? So I'll give you an EMI, sir. So 1 lakh, you are selling at 50,000 rupees to CSR. Is this consideration valid or not valid? It can be 1 rupee also. There must be consideration. How much it is left to the parties, but there should be free consent. What consent? Free. Consideration must be lawful. I'll give an example. Let's say I give a check for you selling drugs to me. You go to the bank, present the check bounced. Can you file a case against me? Check bounce again. Can you file a complaint? Can you file a complaint under section number 138 of Negotiable Instrument Act? Even though check bounced, here the consideration is unlawful, invalid. Give one more example. I give you gift check. What check? आपका birthday है, your birthday is there. Or let's say you are getting married. To your marriage, I come with a check. I say, ma'am, no, sorry, I am very sorry. I can't get a gift, but I'm giving this check to you. They look 1 lakh rupees, not blank check. I give I give 1 lakh rupees worth of check. You take the check and the check is dishonored. Can you file a case against me? Why not? Any promise without consideration is void. No. Even if I give a steady, even if I give a check where there is no consideration, is that agreement valid or not valid? Not valid. Consideration must be something which the promisee is already bound to do. Furthermore, consideration must not be something, must not be, add not here. Yes, okay. Something other than, more than the promises already bound to do the promises. For this, I give an example of postman. Remember, if something is your already an obligation, if you promise to do the same thing, is it considered as valid consideration? No, should be something extra. For example, let's say you are a postman. As a postman, it's your obligation to deliver the letters on time. But if I say, uncle, you deliver the letters on time, I will pay you 1 lakh rupees. Uncle agreed. And you deliver the letters on time. If I don't pay 1 lakh, can you file a case against me? No. Why? Because for this promise to pay 1 lakh, there is no consideration for it. Yes. He's just performing what he's bound to perform. If something is already an obligation as per the existing contract, that is not considered as a valid consideration. Yes, or? So tell me, agreement without consideration, valid or void? Valid or void? What are there any exception? What is the first exception? Natural love and affection. Based on this, there can be practical questions in the examinations. Out of any of these examples, tell me, agreement without consideration, valid or void?
Generally,
Generally, what are there any exceptions? Section number 25 provides the exception. The first exception is agreement out of natural love and affection, subject to three conditions. The first condition is what? Between relatives, out of natural love and affections, should be in writing and must be registered. Must be what? So if it is in writing and if it is registered and if it is made out of natural love and affection between the relatives, what relatives? Near relatives, is the agreement valid or not valid? Valid. Enforceable or not enforceable? Enforceable. Everybody enforceable? Only if it is out of what love and affection? Must be in what the HR form. It must be registered. Are you clear with this? First exception. Second exception is past voluntary services. You know what services? If someone gives services voluntarily, is it a valid consideration? No. But however, if you make a promise to pay for it in a written form, what form? Enforceable or enforceable? Enforceable. I saw no. For example, somebody drops you voluntarily. You didn't ask him. I didn't ask her. She only says, "Boy, boy, come, I'll drop you." And he agrees. Come, boy. You just say, "Boy, boy, come, I will drop you." You drop him. Okay, Akka, no. You drop the boy. I mean, listen, you drop the boy, and the boy he says bye bye. But the same boy, don't you come. Wait, give me money. And he says, okay. But he only says, Akka, you help me. I don't have money now. I promise to pay 1 lakh rupees after 2 months. Have you 1 month? After how many months? 2 months. Now tell me, here, how much you promised to pay? 1 lakh. After how many months? 2 months. For her, what she gets? 1 year. What is the consideration for you? Nothing. Because the dropping did not happen as per any desire. So it's a voluntary act. Even though there is no consideration for your promise, the promise is valid. Why you use a promise to pay for what services? Past voluntary services. What services? Must be in what form? Written form. What form? Are you clear with this, everybody? Next one, time bar debt. What debt? Only when a debt becomes time bar after how many years? What's time bar debt? Uh, a debt which cannot be recovered by filing a suit in the court of law, it is considered as what then? Time bar. The recovery of which is barred by the Limitation Act, it is called as what? Time bar. After how many years it becomes time bar, Adi? After how many years? 3 years. There is no but however, if a person makes a promise to pay a time bar debt, if it is in written form, what form? And if it is registered, is it enforceable or unenforceable? Remember, everybody, listen, everybody. Now, I have taken a loan from you of 1 lakh rupees, and if I fail to repay it back, can you file a case against me? I have taken a loan, I failed to repay it back, can you file a case against me? After how many years? You did not file a case. It becomes what bar now? Time bar. Can you file a case against me? But however, I made a new contract with you, promising to pay the what? Content. Is this contract valid or not valid? Valid or not valid? What is the consideration for you? I'm paying the money. What is the consideration for me? Nothing. But is it valid? Because promise to pay time content. If it's in what form? Written form. Valid or not valid? Valid. Next one, agency contract. What contract? Agency and bailment can be with consideration or without consideration. Both are valid. Are we clear with this, everybody? Next one, completed gift. What gift? What's completed gift? Is a gift where the possession is transferred. What is transferred? Where the possession is already transferred, it is considered as what gift? Completed gift. Where the possession of the gift is transferred from donor to donor, it is considered as what gift? Completed gift. Everybody, what gift? Completed gift. In case of completed gift, what gift? What gift? It is valid even if there is no consideration. Remember blood donation example. You give a blood, once you give it, cannot take it back. You go and give a gift to somebody, you cannot take it back once it is handed out, especially in case of movable goods. Are we clear with this? Last exception is in case of charity. Based on this, there can be practical question in the examinations. What is charity? What is charity? A promise to give a donation, is it enforceable or not enforceable? Not enforceable. But however, if the promising has done something based on your promise, the contract becomes enforceable. I made a promise to somebody saying that I will give donation of 1 lakh rupees. Based on that, they did some operation to that kid. Is it enforceable or enforceable? Enforceable. I give a promise to 1 lakh rupees to Keshav, say that Keshav will construct a temple, you be the priest, I will pay you 1 lakh rupees to it. Based on this promise, he started building the temple. Now tell me, can you recover this 1 lakh rupees? I made a promise to give a donation of 1 lakh rupees to him to build a temple, and based on this, he started building the temple. He incurred some expenses. Can you recover this 1 lakh rupees donation from me? Yes or no? Yes, because you have done something based on my promise. What if he has not done something? Just I made a promise to give donation. No action has been taken from him. Enforceable or enforceable? Or enforced. These are the exceptional cases where an agreement is enforceable by law without consideration. There can be theory question or practical question. There are how many points, everybody? 6 points. What are the 6 points, everybody? What is the first one? Not that one. What is the first one? Natural love and affection. Second one, promise to pay for past voluntary services. Third one, environment. Fourth one, agency. Fifth one, completed gift. And sixth one, charity. Sixth one is what? Parvati, yes or no? Oh, yes. Next one, privacy of contract. What are contract? Privacy of contract. What are contract? Privacy of contract. Let's start with privacy of contract. Privacy. What is privacy? A contract is a private agreement. It creates rights and duties only between the parties to a contract. A stranger or a third party cannot enforce the rights available out of the contract. Agree with this, everybody? Yes or no? If Priya and Supriya makes a contract, not Supriya, Supriya and Ravya, I'm sorry, Ravya from Madurai. Ravya from, not Madurai, Vasura, Vasura. I am speaking continuously, it happens. You try speaking like this for 1 minute, you'll get to know. My brain is working continuously. So it gets stuck sometimes. I say, Saraswati has happened once. Well, Chandra, this some names, still she is doing something. Better concentrate, better. Not better, BT. When we include she includes he. Chilling. I have to complete this chapter. Listen. Pawan, listen, Pawan. Prajwal. Prajwal. I know Prajwal. Prajwal number one, Prajwal number two. And you are the new student. Yeah, you only. What's your name? Likit. So, yeah, I think you attended 1 or 2 classes of my last. Oh, you came in the last 2 classes. Wow, very good. मजा आएगा. Even he came only for 2 or 3 classes. You came late, right? You joined late, I guess. You as well as him. Yes. Huh? I can begin. I'm starting my present for JIGL classes. You sit. Why side? Why side? I don't even.
Beginning of starting of the class
Ah,
or today's marathon.
not today's marathon.
So no, sir. First one also happened.
JIGL classes from first day.
Only for JJL he came, sir.
Maybe I have not seen any.
Yeah.
Right, 20 days, 20 days. I was okay. Priya and Navya. Priya and Navya are like they have a contract marriage. Or you know. Ah, okay. They both have a contract. This contract creates rights and duties between whom? Priya and Navya. Navya can sue Priya, Priya can sue Navya. Can Varsha interfere in this contract? No, she's a stranger. Part she cannot interfere. Can she interfere? No, because she don't have any privity of contract. What are contract? Yes or no? Privity of contract is a principle which provides that a contract creates a rights and duties only between the parties to a contract. Only they can enforce the rights and obligations against each other. A third party or a stranger cannot enforce the rights available against two parties to a contract. Yes or no? That principle is called as what?
Previously on contract.
Into your what? Contract. Now, for example, let's say I supply the goods to a wholesaler, saying that, ma'am, you should make sure that you will not sell the goods below what price? 50 rupees. You supply to the retailer, saying that, sir, do not sell below what price? 50 rupees. The retailer sold goods below 50 rupees. Can the manufacturer sue the retailer?
Yes. You
I am the manufacturer, you are the wholesaler, and Annapurna is the reseller. Sorry, Saraswati is the retailer. Now, I made a contract with you saying that Keshav should not sell below 50. You made a contract with Saraswati that should not sell below 50. Now, Saraswati sold below 50. Now, tell me, can I sue Saraswati directly? Because she said there is no privity of contract. Can I sue Keshav? Yes. Can she sue her? Yes, because they have what privity of contract. We both have privity of contract. We both don't have any privity of contract. Yes, next come the exception to privity of contract. Where a stranger or a third party can file a case against the parties to a contract. Do we have any exceptions, guys? Yes. What are the exceptions? What is the first one? What is the first one? Beneficiary under the agreement to create a trust can sue upon the agreement, though not a party to the enforcement of trust, so has to get the trust executed for his benefit. Yes or no? In case of trust, who can file a case? Beneficiary can file a case. Who can file a case? Yes. So in case of trust, there will be two parties: author, trustee, beneficiary. The contract is between who? Author and trustee. But we can so enforce the benefits of that contract. Yes or no? Trust doesn't mean nambike here. Trust means institution. Public trust, private trust.
Yes.
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 Next one. Assigning under an assignment contract. You know what is assignment of contract? Transfer of rights by a contract. For example, I have given a loan to Pradyumna. Who can sue Pradyumna? I can sue Pradyumna. Can she file a case against Pradyumna? No, you cannot file a case against Pradyumna. Why? Because you are a stranger to the contract. What is the contract? Stranger to the contract. Only I can file a case. Yes or no? Can she file a case? If she comes and file a case, he will say, चले जाओ. Yes or no? But what if I transfer my right to her? I say, Madam, I am busy with my work. You go and recover the money from him. I am the assigner. She is the assigner. Can she file a case against him now? Yes or no? In case of assignment of right, who can file a case? Assignee can file a case. One more exception to the principle of privity of contract. What is the first one, guys?
In case
Trust. Who can enforce the contract? Beneficiary. They can have again theory question based on this if they want to make examination complicated. Are you guys getting the provisions? Privity of contract, exception to privity of contract. What is the first exception? Beneficiary of a trust. What of a trust? Beneficiary of a trust. Second one, assignment, assignee of the contract. Third one, family arrangement. What arrangement? Listen, everybody. Any agreement between the family members, if it is made in written form, what form? Any member of the family, even though he is not a party, can enforce the terms of the contract if it is in written form. What form? एक agreement बनाया है in the family for any reasons. If it is in written form, can you enforce the terms of that contract even if you are not signed an agreement?
Yes.
Four brothers, three sisters. All brothers made an agreement to divide the property or for some other reasons. If it's in written form, can the sisters file a case against the brothers to enforce the terms of the contract? Yes. Family arrangement. Bolo.
Family arrangements.
Who can enforce the terms of the contract? Any member of the family, provided that the agreement should be in what form? Written form. What form? Let's say two brothers made a promise to each other that they will pay 1 lakh rupees each to the mother. They did not pay. Can mother file a case against the sons?
Yes.
Brother made a promise to each other that they will pay 1 lakh rupees to the mother. They did not pay. Can mother file a case against them? Why not?
Because she's party, third party.
Mother is not a family.
There's no arguments.
But is there a platform?
Yes. Yes. And you said comment only.
Why is it? It's agreement.
Then yeah.
The next one. Acknowledgement of liability. Listen, everybody. I listen, everybody. One more example. I'll finish it. I'll finish it. Don't worry. Listen. Hmm? Ah, ah. Acknowledgement of liability. Well, Acknowledgement of what? Liability. See, generally, let's say, Keshav, listen, Keshav, turn this side, Keshav. Let's say, let's say, I have taken money from you. I give it to her. Say that go pay it to her. So now tell me, if she don't pay it to you, can you file a case against her? Sure, ma'am, I'll repeat it. Let's say I have taken money from you. I have taken money from you. I should repay it back. I am busy with my work. I give money to you. He's only. Yuvraj. What is that? You don't know you? He's you. 20 days. I give money to you, but now I said, ma'am, you will come and give money to you. You will come and pay money to you, but he's not giving it to you. What? What's wrong? Like, why are you guys laughing? What doesn't make no sense? Yeah, I'm getting confused with you. Wait, I'll make it. I'll make it simple for you guys. Arey, exactly. My name is CSR. I have taken loan from, let's say, not you. I have taken money from Hamza. Hamza, Hamza, Hamza. We have what's your name? He used to sit next to Siri. Any issues between both of you? No, right? No? Oh, man. Broke up? Okay, no problem, but it happens. 20 days. Listen, I have taken money from Hamza. I said, I give money to Sampurna. I said, ma'am, Sampurna, take this money. I will see you are my agent. I'll pay 10% commission to you. Go give it to him. Hamza. Now Sampurna takes the money. Now Hamza is behind her saying that Sampurna, sir has given money to you. Please give it. But Sampurna is like, no, I will not give it to you. Can Hamza file a case against her? Why no? They don't have any NTR contract. But what if Sampurna goes and gives 10 rupees to Hamza, saying that Hamza, today is a bad day, but I'll give 10,000 rupees to you. Remaining 90K I'll pay day after tomorrow. In this situation, if she don't pay money, can she file a case against her? Yes. By paying part money, she made an acknowledgement of her liability. She becomes liable to pay. Yes or no? Next one. Next one in case of what? In case where a person makes a promise to an individual for the benefit of what party? Third party, or create a charge on certain immovable property for the purpose. The third party can enforce that promise though he is a stranger to the what? Contract. Means I make a contract with you and I create a charge on this asset saying that you give a loan to him. If you don't pay, then I will pay. Yes or no? Can he file a case against you for recovery of money? Yes, because this contract is made in favor of which party? Third party. Which party? As a trustee, you should make the payment to him. If you don't make the payment, can he file a case against you? Yes. Based on this, they can ask questions in the they ask questions in the previous examination. They can ask questions in the upcoming examinations as well. Next one, privity of consideration. See, Indian Contract Act does not recognizes privity of consideration. It only recognizes what? Privity of contract. Not of contract. There is no privity of consideration. Means what? Who can provide consideration? Anyone can provide consideration. Can I provide consideration? Can you give? Are everybody concentrate here? Look here, everybody. Can I give consideration? Yes. Can I give consideration? Can you give consideration? Anybody can give consideration at whose desire? Promisers desire. Whose desire? Who can give consideration? Promisee or any other person. But it's whose desire? Can there be a stranger to consideration? Stranger to a contract? Can there be a stranger to consideration? Stranger to a contract? Are we clear with this? That is what called as privity of contract. Is there any stranger to a can there be a stranger to consideration? Can there be a stranger to a contract? No. Because it's a privity of contract. Understood? There is no privity of consideration. They can ask question based on this minute points. This chapter has a weightage of 10 to 15 marks in the examinations. Concentrate everybody. Lengthy chapter. Both chapters are lengthy. Chapters are the material. If you observe. Correct, right? But both has good weightage in the examinations. Are we clear with this? Next one. Terms must be certain. What must be certain? If the terms are uncertain, is the agreement valid or void? Void. Enforceable or enforceable? Not enforceable. Next, we have flaws in the contract. What is the contract? Tell me, if the parties are incompetent and if there is no free consent, is the contract valid or not valid? Not valid. We will discuss that part now. We're done with offer, done with acceptance, done with consideration. Now we should discuss about what? Consent. And competent to contract. What to contract? Competent to contract. When you follow what to contract? Competent to contract. Then who are the parties competent to contract? Major, sound mind, and not disqualified by law. Who are incompetent to contract? Minors, unsound mind, and the persons who are disqualified by law. So section number 11 provides that general rules is that all natural persons have the full capacity to make binding contract, but Indian Contract Act provides that minor, lunatic, what do you mean by lunatic? Unsound and the persons who are disqualified from contracting by any law which they are subject to are incompetent to contract. This section number deals with parties who are incompetent to contract. Section number 11. Section number 11. Who is the first party? Who is a minor? As per Indian Majority Act 1875, the one who has not attained the age of how many years? 18 years is considered as what? Minor. However, there are special cases if the minor is not have doesn't have any natural guardian and is under the court appointed guardian. In that situation, he attains the majority at what age? 21 years of age. It's a no. Next one. Rules of minors contract. What is the first one, everybody? Minors contract. Altogether what? Void. Is it void contract or void agreement? Void from the beginning or void after some time? Void from the beginning itself. Are yes or no? No. Can it be ratified? Ratification means correction. Can you approve whatever he has done when he was a minor once he becomes a major? No. Once void, always one. He can make a new contract, a new law, new obligation. Not he cannot ratify whatever happened when he was a minor. When he was a third one is important. Principle of estoppel not applicable to minor. Based on this, they can ask practical question in the examination. What is estoppel?
Stop from
Stop from denying. आप कुछ बोला है?
A minor can seek your agency to avoid contract.
See, even the book is catching the speed of seeds, sir. How do I know? I'm going in Rajinikanth's speed and it is able to catch it and answer the questions. Very good. How many days, Madhya? 200 days. Let's concentrate. Principle of estoppel applicable to minor, not applicable to minor? Not applicable to minor. Is a principle of estoppel. Principle of what? Once you make a statement, you should stick to it. Let's say a minor says he is a major and borrows a loan. Is that agreement valid or not valid? Listen. Have you heard about partner by estoppel? You partner by estoppel means a person you Principle of estoppel applicable to minor, not applicable to minor, not applicable to minor. Even if minor misrepresent his age and borrows a loan from an innocent party, still the agreement is void. You cannot make minor responsible personally. Yes or no? Let's say she's a minor. She go to the shop and say, Uncle, I'm a major. Please give me loan. Uncle gives the loan. When uncle demands it back, she says, I'm a minor. Can uncle file a case against her? No, because minor can always plead what? Minority. Uncle cannot say, ನೀನೇ ಅಲ್ವಮ್ಮ ಹೇಳಿದ್ದೆ, you are a major ಅಂತ. Uncle ಹೇಳಿದ್ದೆ. ನಾನು ಇವಾಗ change ಮಾಡ್ಕೊಂತೀನಿ ನನ್ನ statement. Can you see that? Yes, because a minor can change his or her statement. Principle of estoppel not applicable to minor. ಅರೆ ಸರ್, ಅರ್ಥమైందా? Is the principle of specific relief available to minor? No. Agreement with minor is always one. But however, if minor has taken loan by doing misrepresentation of age, and if the money is still with him, court can order him to restore it. If you already spent, no remedy. But if it is not spent, court may ask him to restore it. Clear with this? Next one. A minor estate, bolo,
Minor estate.
is liable to pay for what necessary item based on quasi contract. What contract?
Quasi contract.
Minor is not liable. His assets are liable. If a major supply necessary items to a minor, and if he has any asset, out of that asset you can recover the money back. You can recover the what? Money back. For example, you give education to a minor, who is not having education. You can recover out of his what? Assets. If he's not having assets, you cannot recover it back. Let's say you give a food to a minor. There is a kid going on in the street. He's already full. ಚೆನ್ನಾಗಿ ಊಟ ಮಾಡಿದ್ದಾನೆ. But he still say, ಮಗು ಬಾ, ಊಟ ಕೊಡಿಸ್ತಾರೆ. You take that kid. I'm not saying anything wrong. I said, ಮಗು ಬಾ, ಊಟ ಕೊಡಿಸ್ತೇನೆ. You take that kid to the nearest shop, Domino's or somewhere. You buying pizza or something. He's saying, Uncle Beda. He's saying, Auntie Beda. But still, you don't think I'm like your mother. Consider me like consider me like your mother and the yearly check things in Krasthira. Next day you want to recover money out of his assets. Can you recover it? No. Because you're already having sufficient supply. What items are necessary item? What items? Necessary. If he's not having necessary supply of necessary items, sufficient supply of necessary item, and if you supply what item? Necessary item. Can you recover from him? No. Out of his assets, yes. No assets, no recovery. Are you clear with this, everybody? They can ask practical question based on this quasi contract. Next one, an agreement by minor, another void.
Void.
There is no specific performance. Can minor be an agent?
Yes.
Can minor be an agent? Yes. Ultimately, who is responsible? Principal. But minor cannot be a principal. Since minor is never personally liable, he can't be adjudged as what? Insolvent. First you become major, take loan, don't repay it, but then you become insolvent. Clear with this, everybody? Next one, agreement by parent or guardian entered into on behalf of a minor. Is it valid or not valid? Valid. If it is for whose benefit? And whose benefit? Minor's benefit. But any agreement for sale of immovable property requires consent of the court. Consent of a court. Lunatic agreement. Tell me any agreement with unsound mind. Agreement is valid or void? Enforceable or enforceable? It's lunatic.
What's it?
It's unsound mind.
Cannot take decision by being opposed.
A person who cannot, no proper mind, very good. A person who cannot understand the terms of the contract and cannot make a rational judgment. What judgment? Consider as what mind? Any agreement by unsound mind. Agreement is valid or void? Enforceable or enforceable? Now, what if a person is sound mind, makes an agreement, becomes unsound mind? Is the agreement valid?
Yes, sir.
It's enforceable or enforceable? Because when the agreement was what? When the agreement was made, he was a what mind? Sound mind. But what if he was unsound mind? Makes an agreement. Valid or void? Enforceable or enforceable? Not enforceable. Other persons who are disqualified by law, there are few parties who are disqualified by law from entering into a contract. If these parties makes an agreement is void. Who is the first person? who are disqualified by law. Foreign sovereigns, because they're not subject to the jurisdiction of the local courts, it is not enforceable by law. Professional persons, what persons? In England, professional persons cannot enforce the right to recover the fees. They cannot enter into a contract. But in India, they can enter into a contract. Allowed. Company, can a company enter into a contract? Company is a what person? Can you make contract within the powers? Beyond the powers? That is what the law says. A company cannot enter into a contract beyond its powers. Yes or no? Last one, married woman. What woman? Can a married woman make a contract? Yes or no? And in India, anybody can make contract. No restrictions, except he is a major. Sorry, only if he is a major, soundman and not disqualified by law. Always clear the flaws in the consent. Who are the parties incompetent to contract? First, minor and soundman disqualified by law. What everybody? Lots of minor agreement is clear with this. Agreement with minor, void contract or void ab initio. Can it be ratified? Cannot be ratified. Can minor be a beneficiary? Any necessary supplying to a minor? Is a minor personally liable? Assets are liable. Uh, can minor be an agent? Principal. Can minor be held responsible for supply necessary items? Assets are liable. Yes or no? Can minor be can is a minor responsible for misrepresentations of his age? If you take loan by misrepresenting his age, is the agreement valid or void? Is the principle of estoppel applicable to minor or not applicable? Who's on? Very good, guys. And answer it. Let's start. Let's start. Let's complete it, guys. Hey, consent. What consent? One most important topic. There can be a chances of practical question based on this. I anticipate them to ask questions out of pre-consent. See, there are four concepts. If these four elements are there, not four elements, five elements are there, the consent is not free. What is not free? No, what is not free? If consent is obtained by using CUFM square, बोलो. On what date? August 15. I'll make a reel on this. Okay, what is CUFM square? On what date? You texted Nirmala Sitaraman saying that Nirmala Sitaraman ji, I want to see you because she's FM, right? Is she FM? What is FM? You were texting finance minister saying that C short form CUFM square. On what date? August 15th. She's coming to Bangalore on August 15th. Independence Day. What day? No, already Independence Day. But what is C? What is C? What is M? What is M? What is M? Send them again. Super extended. I'll use certain keywords, use these keywords and write the answers. Stick everybody, listen. 15 is what? Question. 15 is what? Simple. Committing or threatening to commit. An act forbidden by BNS. Either if I commit or threatens to commit. An act which is forbidden or prohibited by BNS. What is BNS? Civil law, criminal law. Is it commercial law, civil law, criminal law? For what law? Criminal law. What if someone said commercial law? I committed suicide. It's commercial law. Oh my god. Is it a criminal law? If I commit or threatens to commit any act forbidden by BNS, or if I detain any property of somebody unlawfully, to induce him to give a consent to enter into a contract with me, it is called as coercion. I say, if you don't give a consent, I will kill your baby. But inside which baby? Is this consent free or not free?
Not.
Did I make any threat here?
Yes.
Forbidden by BNS?
Yes.
Coercion or a coercion? And it's or no?
Yes.
I made a threat to commit an act which is forbidden by BNS. It is called as what? Coercion. Called as what? Punishable or not punishable? By which act? BNS. I used it to get consent. Consent is not free. I am your agent. I should give your books of accounts. You are my principal. Now you are asking for the books of accounts. I say, in principal, I will give this books of accounts only if you pay me what? Extra 10,000. I'm detaining these books lawfully or unlawfully? Lawfully or unlawfully? And I took your consent to pay extra how much?
10,000.
Is this consent free or not free? It's a coercion, undue influence, fraud, misrepresentation. Why it is coercion? Because I detained something lawfully or unlawfully. But I took your consent. Simple. 2 points are there. Threat to commit act forbidden by BNS or detaining something unlawfully and taking consent. It is considered as what? Coercion. Called as what? Understand? Yes or no? Tell me what is coercion? Any act forbidden by BNS or detaining or unlawfully detaining any property with the intention to induce the other persons to enter into a contract is called as what? Coercion. Called as what? Threat to commit suicide. Coercion or a coercion? Threat to file a suit? Not. Threat to file a false case? Coercion. Threat to go on a strike?
It's not.
All threats are not coercion. Only threats which are threats. No. No. Very bad. She influenced me in a quick 1 minute within 1 minute. No. All threats are not coercion. Only the threats which are forbidden by BNS is called as what? Coercion. Is strike forbidden by BNS? No. If I say I will go on a strike, you make a promise to pay. Is it a coercion? No. Consent is free. Are we clear with this? Coercion can happen in India, Keshav, or it can happen outside India as well. Coercion is coercion. Coercion is what? Coercion. Are we clear with this, everybody? Yes or no? Oh. A wife, I'm sorry, her husband said, wife, if you don't give a consent to sell the property, I will commit suicide. Because of this, her wife gave a consent to sell the property. Is the consent free or not free? Is it a coercion? Yes or no? Next one, undue influence. Listen, to be undue influence, there are three conditions to be satisfied. How many conditions? Three conditions. What are the three conditions? First one, relationship. Second one, dominant position. Third one, unfair advantage. What are the first conditions? There must be a relationship between the parties. Second one party in one position, dominant position over the other party, and the one who is in dominant position takes the unfair advantage of it. It is considered as what influence? Unfair, undue influence. If there is an undue influence, is the consent free or not free? Contract is valid or voidable? But the option of how many party? One party whose consent is not free. What influence? What is undue influence? Where the relationship between the parties is such that one person in a position to dominate the will of which person, other person, and the one who is in dominant position takes the unfair advantage of it. It is considered as what? Undue influence. What influence? In case of undue influence, consent is free and not free. Contract is valid or voidable. At the option of how many party? One party. Are we clear with this, everybody? So, can we transaction with Pardanashi woman? She is no more there. Pardanashi woman means she's not talk to anybody in her company. She don't talk to the public. She's considered as what woman? Pardanashi woman. What woman? Pardanashi woman. Any contract with Pardanashi woman, is it valid or void? Void. Enforceable or enforceable? Not enforceable. Have you heard about unconsignable transaction? What is unconsignable? Unreasonable transaction. What transaction? See, in case of unconsensual transaction, the law presumes that there is an undue influence. In that situation, what court can do? Either court can declare the entire contract as void, or it can enforce the contract subject to modification. For example, let's say because I am in dire need of money. Let's say I am in urgent need of money. I come and ask you give me money. You say 60% interest. I am agreeing for it. Did I agree for it?
Yes.
I have agreed for the 60% interest. Now later I want to cancel it. Can I cancel it? Yes, I can go to the court. Either in this situation, see, whenever I want, I say I can cancel the contract, I have to go to the court. If I go to the court, either court can cancel the contract in entirety. But what if I have taken the benefit of it loan? In that situation, court enforce the contract subject to what? Modification. Instead of 60%, court say you pay how much? 10%. Or it can say pay 5% or 6%. Court thinks it is fit. Yes or no?
Yes.
That is what called as what influence? Can you guys write in the examination? Next one is what? Fraud. What is fraud? Uh-huh.
Misrepresentation.
Okay, we can finish this. Listen, everybody. What is fraud, guys? Everybody, what is fraud? Suggestion as a fact. Guru? If you say something as a fact which is not true, and you know that it is not true, it is considered as what? Fraud. Listen, everybody. There are 5 points. How many points? I want everyone to focus. There are 5 points in the fraud. First one, if a person says something as true, something as what? Which is not true. And you know that is not true, it is called as what? Fraud. Second one, if it conceals a fact, active concealment of a fact which a person is aware of it, it is also considered as what? Fraud. Third one, any promise made without any intention of performing it. It is also considered as what? Fraud. Next one, any other act fitted to deceive. Fitted to what? Deceive. Or any other act which a specific law declares to be what? Fraudulent is all considered as what? Fraud. Are you clear with this, everybody? What is the first situation it is considered as fraud? What is the first situation it is considered as fraud? Active concealment of a fact. Yes or no? No, no, no. You say something as a fact which is not true, and you know it is not true. It is considered as what? Considered as what? You conceal something actively. ಬೇಕಂತ hide ಮಾಡ್ತೀರಾ. Is it a fraud?
Yes.
And the third one, any act fitted to, sorry, any promise made without any intention to perform it. Without any intention to what? Perform it. Is it a fraud?
Yes.
Yes or no?
Yes.
Any other act fitted to deceive. And the last one, any act which a specific law declares to be fraudulent. Now listen, I will give an example. You guys will tell me whether it is a fraud or not. Okay. Now what happens? Adi makes a promise to some uncle, saying that uncle, I will grow potatoes in my farmland. Only, no, no. Uncle says, Adi, I will give what you want only if you grow potatoes within 6 months. Adi approached uncle for something, not the for some person. Uncle said, Adi, I will give that person only if you grow what? Potatoes. Adi said, Uncle, I will do whatever it wants. Uncle says, Ella in Beda, just grow up 1,000 kg of potatoes. He says, Uncle, not 1,000 kg, I'll grow 2,000 kg. So let me promise. He made a promise to grow 2,000 kg of potatoes and sell it to the uncle. One day over, he has not taken any action. 1 month over, no action is taken. Uncle comes and asks, Adi, are you sure you are selling potatoes? Uncle, not really. I will grow potatoes. Uncle is worried now. How is Pala will going to grow potatoes when he is not even flowing the land, not even showing the seeds? 2 months over, 3 months over. Adi broke the contract. Now tell me, in this case, did Adi do any fraud? Why it is fraud? Fraud. How do you say he didn't have intention to perform when he made a contract? Because he did not take any action. That is no. That clearly shows that he did not have intention to perform it. Hi, you take a loan, don't repay even one installment. It's considered as what? Fraud.
Yes, sir.
Contract becomes valid or voidable. Next one. Tell me, silence is the fraud or not a fraud? Mere silence is not a fraud, but there are few cases where silence is a fraud, where you have a duty to speak. Want to speak? There are few contracts which are considered as contract of good faith. What of good faith? In those contracts, you must speak out the truth. If you don't speak the truth, it is considered as what? Fraud. In case of fraud, the contract is valid or voidable. Void or voidable? Voidable. At the option of how many party? One party. Silence is fraud or not a fraud? Are there any exceptions? When you have a duty to speak, tell me in which contract you have a duty to speak. Contracts are what faith? Good faith. That is insurance contract. What contract? Share market, share enrollment contracts. Then sale of land, family agreement. What agreements? These are considered as contract of what faith? Good faith. In these contracts, if you are silent, even silence also amounts to what? Fraud. Amounts to what? Are yes or no? Are yes or no? Companies, no. Listen, companies prospectus says company has declared dividend, but company has not specified out of what they have declared dividend. In reality, company made loss in the last year and they declared dividend out of reserves. By fulfilling those three conditions, there are three conditions to be fulfilled for declaration of dividend out of reserves. Remember, the average rate of dividend should not exceed the what? There are three preceding years rate of dividend, and the amount to be withdrawn shall not exceed 10% of the paid up capital and free reserves.
Yes.
Correct, right? And the amount to be left after withdrawal should not exceed, in the reserve should be minimum 15%. 3, 10, and 15 rule is there, right? So they are declared out of reserve. Declared out of what? Reserve. That is not specified. Then it's considered as a fraud. Company has not given the details, not given the what? Details. Out of which they have declared dividend. Then is it considered as fraud? Because prospectus is a conduct of what faith? Good faith. You should disclose everything. If you don't disclose, is it called as fraud? Yes or no? Next one, next one. Are you guys clear with fraud? Then what is fraud? How many points are? Only 5 points. Which is not true. By one knows it was not true. Second one, concealment of a fact. Third one, I will continue with Adi. I'll give one more example for this fraud example. Okay. Now, Adi, you not mind it, right? I know Adi. Now, Adi goes and asks uncle, uncle, please say yes. Uncle says, did you have okay? Well, he says, uncle, I am a devotee of Rama, devoted to your daughter. What is this? Saraswati, well, Keshav, he purposefully hides the details of his past relationships. Is it a fraud? Yes. Fraud. Is it a fraud? Yes or no? Yes. Because he's actively concealed the fact. Misrepresentation. What is misrepresentation, guys? You are saying something as true, which is not true, but you believe it to be what? Yuvraj, you believe it to be what? True. You believe it is of good quality. It is not of good quality. It is considered as what? Misrepresentation. Consider as what? What is different? Misrepresentation is different. When a person is innocent, when he is doing intentionally, fraud. Which one is in intentional? Fraud. Which one is innocent? Misrepresentation. Yes or no? If I make a statement of a fact which is not true, but I believe it to be true, it is considered as fraud or misrepresentation. Energy, guys. Fraud or misrepresentation. Time is now 4:41. We started at 8 o'clock. Are you guys having the same energy? We have exam in how many days? 20 days. Our 20 days is equal to how many months? 6 months. We will give everything it takes to clear the examination in this June itself. Yes or no? Let's go, let's go, let's go. Let's start. Next one. If I make a statement of opinion, you know, are statement and opinion both are same or not same? Statement is a fact. Opinions are not facts. If I make any opinions, if I give opinions, and if you give consent based on opinion, it is not considered as a fraud. Correct, right? Only it should be a statement. Should be what? Statement. See, for example, advertisement saying white washes whiter than the whitest. It is considered as what? Opinion. Our communication. The same. Opinion. Washes whiter than the whitest. It's a opinion. Damages for innocent misrepresentation. Can you claim compensation? No, you cannot claim compensation for misrepresentation, but there are exceptions. What are the exceptions? From a promoter or a director who makes an innocent misrepresentation in a company prospectus. Remember picture number 34 and 35? Criminal liability and civil liability in case of misstatement in the prospectus. Is the promoter liable to compensate the investor? Yes. Even if he is innocent, still he is liable to pay the compensation under section number 35. Yes or no? One exception. Second exception against the agent who commits a breach of warranty or authority. Now, if they invest in Reliance company shares, that fellow invest in which company shares? Tata company shares. Which company shares are? He does it innocently, but still, is he liable or not liable? Liable. Next one, next one. And in case of statement, estoppel, is liable to pay compensation or liable to pay compensation? Liable to pay. Negligent representation made by one person to another, between whom confidential relationship like solicitor and client exist. Now, for example, let's say um, our Rakesh. Sorry, our Jitendra. Our Jitendra. And I will forget the example. Our Jitendra makes a false. Jitendra gives a wrong advice to his client negligently. Papa innocent, but still gave a wrong advice. Is Jitendra liable or not liable? Liable to pay compensation? Others are not. Yes, because it is based on the confidential relationship. Client trusted you. Even if you're negligent and give advice, are responsible or not responsible? Responsible. In these cases, even though you are doing misrepresentation, you are liable. Market most important. Based on these 4 points, there can be practical questions in the examinations. Are we clear with this, everybody? Yes or no? Difference between fraud and innocent misrepresentation. Tell me where there is intent to deceive. Where there is no, which one, if there is a means to discover the truth, the contract is valid. Misrepresentation. Fraud, it's always wideable at the option of who? Agreed party. Damages, when you can claim damages? Fraud. Misrepresentation, generally no. But are there any exceptions? How many exceptions? What are the 4 exceptions? Prospectus. Second one, agent. Third one, confidential relationship. And fourth one is one more is another fourth one. Uh, from a person who is stopped from denying a statement he has made. Yes or no? Next one, next one. OPC. Which one is also punishable? Fraud is also punishable. Can you write in the examination if they ask difference between fraud and misrepresentation, everybody? Yes or no? Now we should start with mistake. Coming to class today, my mistakes are. A erroneous belief of something or someone is called as what? Mistake. If you think like that, that is your mistake. That is your biggest mistake of life. Listen, what is mistake? Erroneous belief, a wrong belief about something or someone, it is called as what? Mistake. You believe that you have texted X, but in reality, you have sent it to Y. Is it a mistake? Yes or no? A wrong belief about Prajwal. A wrong belief about somebody or something is called as what? Mistake. Mistake can be of how many types? Two types. Mistake of love, mistake of fact. Mistake of fact is how many types? Pradyumna? Mistake of fact is of two types. Unilateral mistake, bilateral mistake. If only one party under mistake, unilateral mistake. Contract is valid. Your mistake is your mistake. It is not my mistake. The contract is valid. What is bilateral mistake? Both the party under mistake. Contract is valid or void. Enforceable or unenforceable? I believe dog is alive. You believe dog is alive. Dog is dead. Agreement is what? Void. You go to a shop. You go to a shop. You buy something, believing that it is suitable to you, but it turns out to be not suitable to you. Can you cancel the contract? Is the contract valid or not valid? Because your mistake is your mistake. If only one party under mistake, the contract is valid. Contract is valid. If mistake of law, what of law? What of law? Is the contract valid or not valid? Foreign law, void. Indian law, valid. Because ignorance of law is no excuse. A debt is time bound. If it is time bound, am I liable to pay? Not liable to pay. You cannot recover it in the court of law by filing a suit. Correct, right? Then one thing wrong again. I have a new contract to pay. Is this contract valid or not valid? Am I liable to pay? Not liable to pay. Liable to pay. I can't say I was not aware about limitation act. Ignorance of law is no excuse. Are we clear with this? Yes, I know. I believe there are 1,000 kg of rice in Kuda. You believe there are 1,000 kg of rice in Kuda. But the rice is already destroyed by fire. Agreement is valid or void? It's what mistake? Amulya? Bilateral mistake. What mistake? I agree to sell dry fruits, which are in Godown. You agree to buy dry fruits. But without my knowledge, the dry fruit has become wet fruits. Because flood happened. Because of heavy rain, the water flooded to the Godown and dry fruits have become what fruits? Dry fruits. Tell me, is the contract valid or void? Uh, Go to the party. You can buy what fruits? What I need to sell? But it is what fruits? Then that is one mistake. Document is what? Enforceable, not enforceable? Not enforceable. Are you guys clear with this, everybody? And section number 20, section number what? 23. Lawful object and consideration. You know what object and consideration? If object is lawful, agreement is valid or void. Very good, valid. If it is unlawful, void or voidable? Void. If the purpose of agreement is lawful, agreement is void. There are five situations. Is there everybody five situations? What is the first one? Formal and minor. What minor? I made an agreement to sell alcohol to a person who is 18 years old. Agreement is valid or void? Void. Hurry, tell me fast. Valid or void? Why it is void? Common by what? Law. I gave a loan to child marriage. Valid or void? I gave a loan to buy drugs. They made an agreement to do smuggling activities forbidden by law. Second one, it is of such nature if it is permitted to defeat the provisions of the law. We are lifting of corporate will, you are lifting of corporate will based on this concept itself. A person not allowed to do something indirectly, which he can't do what? Directly. You apply for a license in your name, could not get it. If a subsidiary company applied subsidiary's name, allowed or not allowed? Not allowed. Because a person is not allowed to do something indirectly, which he can't do what? Directly. Listen. There is a law which says if you don't pay taxes, government can confiscate your property, sell it in auction. And in that auction, the defaulting party should not take part in the auction. That is the rule. She defaults. I confiscate. I'm BBMP persons. I'm selling it in auction. Can she take part in the auction?
No.
Because she can't take part in the auction, what she does, she appoints her friend as an agent. She says, friend, you go to the auction, take part in the auction, purchase it and give it back to me. They make this contract. Friend purchase the property. She's not giving it back to her. Can she go to the court? No. Is it enforceable or not enforceable? Because both of them are doing something indirectly which they can't do what? Directly to unlawful object. Yes or no?
Yes.
Third one, fraudulent. Object itself fraud hai. You make an agreement to sell bogus flat, and whatever the profit comes, you agree to share it equally. Agreement is valid or void.
Right.
Because your purpose is what? Fraud. Fourth one is what? Involves or imply injury to a person or property of whom? Another. Even a contract has injury to somebody else's property. For example, let's say you are agreeing to copy somebody's patent rights or copyrights. Agreement is valid or void.
Void.
Why it is void? Unlawful. Why it is unlawful? It is implying injury to somebody's property. Are sir, no. If I say I will pay compensation to if you hit her, agreement is valid or void? Because it is implying injury to no other person. Next one, if it is immoral, if it is what? Immoral. Are sir, no. What if Imanshi give a loan to Mimanshi to get a divorce from her husband so that she can get married to ಏನಂದ್ರು ಹೇಳ್ತಾರೆ ಇನ್ನೊಂದ್ಸರಿ ಕೇಳೋಣ. If you listen to the concepts with this curiosity, you will never forget the concept. She's so curious about this Himakshi and Mimakshi example. She's asking her friend also, I'm shouting about contract act, agreement, fraud, misrepresentation, partner contract act. She's really interested about Himakshi and Mimakshi. Uh, uh, yeah, you tell me what is the answer for this. Himanshi gave a loan to Mimanshi,
Dimanshi.
somebody, with the condition that she should get a divorce from her, whatever it is. He or she, whatever it is, you can confirm. And in return, after she get a divorce, she should get married to Himanshi. Like, she's okay. Himanshi is a boy. Himanshi gave a loan to Himanshu that he should get a divorce from his wife with this money. After he get divorced, he should get married to her. Is this agreement valid or void? Lawful or unlawful? Moral or immoral? How can you give a loan to somebody's husband so that he can get a divorce from her wife and get married to you? This is not my example, it is there in the material. Agreement is allowed. Are Keshav, Keshav, why? Who is that? Kesavananda Bharati versus State. Who is that? Are we clear? Are you guys clear with this? Is it object lawful or unlawful? Because it was immoral. Are you guys clear with unlawful object? What is the first one? Forbidden by law. Second one is what? Permitted defeat the provision of the law. Fraudulent implies injury to the person or property of another. Courts regard it as immoral or opposed to the public policy. What policy? Public policy. Are yes or no? These are the agreement which are considered to be void because the object is unlawful. Object is examples. You guys can go through it later. Next one, void and illegal agreement. What agreement? A loan to a minor. Is it void or illegal? Why? It is not illegal. Agreement to sell drugs. Punishable, not punishable. So tell me between void agreement, illegal agreement, which one is punishable? Illegal agreements are punishable. I take loan from a major. We give it to a minor. She is major. I am major. She is minor. I take a loan from her at 10% interest. I'll give it to her at 12% interest. She is a minor. Agreement is valid or void. Can I recover it from her? Can she recover it from me? In case if the main agreement is void, collateral agreements have validity. What is collateral? Support. But if the main agreement is illegal, I say, ma'am, I need loan. She says, for what purpose? I say, I want to find drugs. Lelo, sir. So come to class. Have it. A job. How do you know all these things? Okay. I make agreement with her to buy it. She runs away with this money. Is this agreement legal or illegal? Can she recover money from me? In case of illegal agreement, even the collateral agreements are also tainted with illegality. Well, enforceable, not enforceable. Understood, everybody? Arey, sir, no. They can ask questions are based on illegal agreement. Illegal agreements are valid or void. Enforceable, punishable, not punishable. Collateral agreements are valid or void. In case of illegal agreements, collateral agreements are valid or illegal. They are also punishable by law. Alexa, no. What if there is a contract? One part illegal, one part legal, possible to separate. Which part is enforceable? Legal part is enforceable. Alexa, no. Next one. Um, see, what if he was not aware about the fraud? See, she gave a loan to me for unlawful purpose because she was not aware about it. Can she recover it? Whereas, let us call it as pari delicto. Bro, pari delicto. What's pari delicto? Equally guilty. If a person is not equally guilty, can you recover the money?
Yes.
Whereas, no. Because she's not aware about it. Are we clear with this, everybody? Next one, agreement being void as the opposed to what policy? Public policy. And this one, section number 27, is most important, based on which they generally ask questions in the examinations. Questions in the what? Examinations. Important concept. We will take a small break. What break? And then we will continue. Before we go for a break, please, everybody, shall we quickly go to the question and answers, please? I want everyone to focus. Let's see whether we are on the right track or not. Still, I will solve the questions. Don't worry. Well, okay, read the questions. Okay, ready?
Yes, sir.
Uh, can you guys read this question, please? Ram employed in Mumbai promised to pay 8,000 per month to his wife Sunita. Sunita, Balper versus Balper. Is agreement valid or void? Why it is void? There is no intention to create one relationship. When she succeeds, she will not succeed. She will not succeed. Yes or no? Next one. When a contract becomes void under the contract of 1870, when it becomes void? When it ceases to be enforceable by law. Yes or no? Void agreement is different. Void contract is different. Yes or no? Next one, offer. In a pandemic of COVID-19, a drug company made an offer for advertisement, a reward 10,000 to anyone suffering from COVID after using the drug. This is what offer. Specific offer, general offer. You can accept it. Anybody can accept it. But following the conditions, can they request? Can they recover it? They cannot recover it. They can recover it. But also, no. State the various ways in which offer lapses. By not accepting within the prescribed time, by not accepting the prescribed move, offer and offer it as a debt, remember, I know. Full negative. Next one. Very good. Positive. In case of what number? Counter offer. And by not accepting the condition precedent, precondition. Yes or no? Can you guys read this question, please? A invite B to stay with him during winter with A. Winter freeze. Vacation, guys. Vacation stay. A invite B to stay with him during the winter vacation at his residence. B accepts the invitation and informs A accordingly. When B reaches A's house, he finds it locked. He has to stay in hotel. Can B claim damages? No. Acceptance of invitation to offer cannot be an obligation. Legal obligation. Invitation to offer. Yes or no? And there is the intention to create what relationship? Legal relationship. Amit's son absconded. He sent Suresh, his servant, to search the boy. When Suresh had left, Amit by handbills offered to pay 5,001 rupees to anyone finding his son. Suresh found the son. After coming to know about the offer, claimed the amount. Can he claim the amount? No, because he was not aware about the offer when he found the kid. We discussed this right now. Flaws in contract. Mention the main flaws in the contract. Incapacity, mistake, fraud. Srajan, a minor, fraudulently overstates his age and takes delivery of motor car after executing a promissory note in favor of trader for the price. Is the agreement valid or void? He's a minor. Principle of estoppel not applicable to minor. Minor cannot be speed what? Minority. Assets, if he has received the money or asset, if it is still with him, that can be recovered. But you cannot file a case against minor because minor is always a minor. Any agreement with minor is what? Void. Enforceable or not enforceable? Not enforceable. Can you guys read this question, please? Fraud question, question number 1. Then we'll take a break. Done?
Yes, sir.
Alright, so no. Solve it, guys. As I said, hardly 20 days time left for your examination. Every question you solve, every concept you understand, it means you're taking one step closer to your dream of becoming CS. Yes or no? Read the questions, everybody. Read it. Not Raju.
Would you? Reference from comments had by
Did you do any fraud here?
Yes.
Did Raju did any fraud? ऐसा नो ये बंदा बोल रहा है मेरा पास लाइसेंस है और है ना लाइसेंस ಇದೆ लाइसेंस ಇಂತ ಫ್ರಾಡ್ ಮಾಡಿದ ಕನ್ಸೆಂಟ್ ಇಸ್ ಫ್ರೀ ಆರ್ ನಾಟ್ ಫ್ರೀ ಎನ್ಫೋರ್ಸ್ ವೈಡ್ ಆರ್ ವೈಡಬಲ್ Who can cancel the contract? I'm suing for what? Compensation. Is it a fraud? First one, second one, third one, fourth one, or fifth one? First one. This is a fact which is not true by a person who believes, person who is on it. Are you guys able to answer the question based on whatever we discussed today's class? Yes. So we will complete the remaining topics after the small break. Take a break of 5 minutes and come back. We'll continue. No, no, not 10 minutes. Fast, guys. Let's not waste time. Fine. Next one. Void and illegal agreements. What agreements? Void and illegal agreements. I think we are already done with this. Next one. Agreements void being opposed to what policy? Public policy. See, what is public policy, sir? Public policy is not defined anywhere else. It just says anything which is in favor of public, it is considered as what? In favor of public policy. Anything which is opposed to public policy, anything which is against the public good or welfare, it is considered as opposed to public policy. Now tell me, if husband and a wife make an agreement saying that wife will not have an access to the kid, in return, husband will pay some amount of money. Is this agreement valid or void? Tell me, is this agreement in favor of public policy or opposed to public policy? Why it is opposed to public policy? Why it is opposed to public policy? Because it is against the society, right? Norms of the society, right? How can you deprive a person of parental rights? Both of them are the parents of the kid. They have the right over that kid. Correct now? Any agreement to deprive the parental rights is considered as what agreement? Void agreement. Because it is opposed to what policy? What policy? Public policy. Next one, agreement in restraint of marriage. Valid or void? Agreement with a major to restrain him from getting married. Agreement is valid or void? Valid or void? Enforceable or non-enforceable? Not enforceable. Any agreement which restrict a person's right to get married, valid or void? Void. Enforceable or enforceable? But if it is with minor, is it valid? Yes, because anyway, minor cannot get married. Now listen, everybody. I make an agreement with, let's say, with our Prajwal, saying that Prajwal, you should not marry anyone till you become 50 years old. I will pay him 50 lakh rupees. This fellow took this 50 lakh rupees, immediately got married. Can I sue him for breach of contract? Agreement is what? Void. Yes or no? Because any agreement to restrain a person from getting married to a particular person or to any person is considered as what? Void, not enforceable by law. Which one? Agreement. Marriage brokerage agreement. Are marriage brokerage agreements valid or void? Because an agreement to procure a boy for a girl or a girl for a boy for a consideration is considered as marriage brokerage agreement. Agreement is void. One who mediates a marriage. And what about matrimonial sites, sir? They sell information. They don't act as a mediator. No, they don't. If they do, it is void agreement. The local brokers who are there who negotiate marriage for a consideration, that is void. But marriage bureaus, what they do, they only sell the information. Vadu idare, vara idare. They just sell the information. They don't act like a mediator. Correct, right? An agreement to procure a boy for a girl or a girl for a boy for a consideration is the agreement valid or void? Void. Enforceable or not enforceable? Not enforceable. Next one, agreement in restraint of personal freedom. What freedom? Is it valid or void? It's against what right? Fundamental right. What right? If I say I will not do any business, if I say I will not do CS, if I say I will not do CA, if you pay me 1 lakh rupees, is the agreement valid or void? Void, not enforceable by law. Most important, agreement in restraint of trade. If an agreement restrict a person from carrying a lawful business or trade, is the agreement valid or void? Void, because every person has a right to carry a lawful business or trade. Are you guys getting it? Yes or no? Is it your fundamental right to carry a business or trade? If I restricted that right by entering into an agreement with you, is the agreement valid or void? If I say, Yuvraj, you should not do a business of selling tomatoes, I will pay you 1 lakh rupees. Is the agreement valid or void? Void. Because he has an absolute right to do whatever the lawful business he wants. Are you guys clear with this? Based on this, they can ask question in the examination. Section number 27. Concentrate everybody. As per section number 27, every agreement by which any person is restrained from carrying a lawful profession or a trade or a business of any kind is it valid or void? Void. But are there any exception? Yes. What is the first one? Reasonable restriction is valid. What is valid? Reasonable restriction. If there is a reasonable restriction, is that agreement valid? Yes. For example, sale of goodwill, sale of patent rights or copyright, where the buyer partnership agreement, where the buyer restrict the seller from carrying the what business, same business for a particular period of time. Is it agreement valid? Yes, it is valid if it is a reasonable condition. Next one, personal covenant between the employer and employee. Can employer restrict the employee from carrying the any employment when he's employed with him? Can employer restrict the employee from being employed anywhere else when he's being employed with him? Is it valid or not valid? Valid. That is when you join Infosys, they put a condition that cannot work for TCS. Is it valid or not valid? Valid. But yes or no? Yes. Restriction beyond service period would be what? If I say you should not work during the period of employment, valid. If I say you should not work even after retirement, it is void. Next one, only the restriction is void, not the whole agreement. Correct, right? Yes or no? Only the restriction which restrict a person from carrying a lawful trade or a business is void, but not the entire agreement. Correct, right? If I hire you as an employee, I put a condition saying that you should not work even after your retirement. Is the employment agreement void? No. Only what is void? That restriction is void. What is void? Restriction is void. When contract in restrictions of trade are valid, what is the first one? Sale of goodwill. What is the first one?
Sale of goodwill.
In case of sale of goodwill, it means business. Who can restrict whom? Buyer can restrict the seller from carrying a what business? Same business for a particular period of time. For example, if I sell the business of, let's say, I'm running Rameshwaram Cafe. I sell that business to you. You can stop me from doing the one more Rameshwaram Cafe for a particular period of time. Is it valid or not valid? Valid. In case of partnership agreement, what agreement? There can be a mutual agreement that partners should not do any business when they are partners in the partnership firm. Is it valid or not valid? Valid. Next one, partnership act. Which act? See, in case of partnership act, the outgoing partner can be restricted from carrying the competing business after his retirement. Is that condition valid or not valid? Valid. Partnership agreements are an exception. Next one is trade combinations. What combination? An agreement by which the parties regulate their trade activities. Is it valid? Yes, unless it is not anti-competitive. Last one, negative stipulations in service agreement which restrict an employee from being employed anywhere else during his employment. Is it valid? Yes. Now, what if, let's say, you promised to work with me for 2 years? How many years? You left job within 1 year. Can I stop you from working anywhere else for remaining 1 year? Yes. Yes. Because you promised to work for how many years? 2 years. Understood? It's called as negative stipulation. I can recover compensation for. Then next one. These are the wide agreements. What agreements? Because they're opposed to what policy? Public policy. Have you heard about wagering agreement? What is wagering agreement? Betting or gambling. Are they valid or void? Enforceable or not enforceable? Are they illegal? In state, Mumbai it is illegal. Mumbai it is what? Illegal. Therefore, because it is illegal, it is void in every state. It is illegal in Mumbai. अरे मुझे पता है. हाँ, it is because it's a state subject. Betting agreements are void, but it is illegal in what state of Maharashtra? That is Mumbai. Understood, everybody? Yes or no? If agreement is illegal, even the collateral agreements are also tainted with what? Illegality. Tainted with what? Illegality. Are they valid or void? Void. Now see this one. Commercial transactions are wagering agreement where there is no intention of buying and selling. See example. If I make a contract with you with the intent to speculate the price, I believe online price will go up. You believe onion price will come down. We don't have intention of buying and selling of onions. In FM, I think you would have learned this concept. Forward contract,
Yes, yes. Enough.
futures and options. We don't have intention of buying, you don't have intention of selling. We just have an intention of settling the price.
Price is-
It is speculative transaction. If it happens in share market, it is valid. But if it is in commercial transaction, is it valid or not valid? Not valid. It is considered as wagering, gambling.
So, but in commercial transactions, they do not, sir. Commodities.
That is illegal. See, it's speculative. Even in commodity market, it is speculative transactions. But if it happens in commodity market, it is valid. What if I and you make a separate contract outside the market? Is it valid or not valid? Not valid. Are we clear with this, everybody? So, what is? Can you guys read this entire para? Please read.
But when having contract, he will cause and to create. I will be very
In a wagering contract, there must be mutuality in the sense that gain of one party should be the loss to the other, and the happening of an uncertain event, which is the subject matter of the contract. Yes or no? The main element in wagering agreement is that one person loss is the other person's gain. One person win is the other person's loss. Next one, wide agreements. I have already discussed all these wide agreements. We'll quickly go through it. What is the first one? Agreement with what party? Incompetent party. Valid or void? Void. Next one, agreement with a bilateral mistake. Next one, agreement, the consideration on object is unlawful. Void. Where part of the consideration is unlawful, not possible to separate, entire agreement is void. Next one, agreement without consideration, void. Agreement in restraint of marriage, void. Trade, void. Restraint of legal proceedings, void. Then meaning is uncertain, void. Wagering agreements, void. Agreement which is contingent upon impossible event, void. Agreement to the impossible act, void. And it's all wrong. When contract becomes void,
when it is not enforceable.
not enforceable by law, void of an issue. Second one, when it ceases to be enforceable by law, becomes void when it ceases to be enforceable. The contract becomes void by reason of what impossibility, subsequent illegality. Next one, a contingent contract to do or not to do something upon a certain uncertain future. If event happens, becomes void. If the event becomes impossible. Correct, right? Last one, when the contract is voidable at the option of one of the party, and if he cancels it, it becomes what contract? Void contract. They may ask this question when the contract becomes void. What is restitution?
Restore
Restore it back. Got back? See, whenever a contract becomes void, or if it is discovered to be void, the benefit received by the party should be restored back. Or where a contract is viable at the option of one of the party, and if he cancels it, and if he has received any benefit, he must restore it back. 65 and 66. 65 deals with 64 and 65. It is 64 and what? 65. If a contract is discovered to be void, 65 is voidable. 65 is what? Void. If an agreement is discovered to be void or becomes void, the benefit received by the party must be restored back. Must be what? Restored back. Now listen everybody. Let's say I have taken money of 5 lakh rupees to teach law. I taught three chapters. After 3 chapters, I died. Am I bound to restore the remaining amount? Uh, well, I am not the corrector. Are my legal representative bound to restore the remaining amount? Yes or no?
Yes.
Now the contract becomes void because of impossibility, and whatever the benefit which should be what? Restored back. Yes or no? I know. Next one, quasi contract. What contract? Have you heard about quasi contract?
Yes. So,
Huh?
like half of the contract is done, then an amount to be deducted.
Yes. And I will restore the remaining part of money to you. Done. Next one. Listen, everybody. Guys, few more topics are left. I want everyone to focus now. Listen. See, till starting of the class, you guys were not having any of this concept. But now at least remember the few concepts of contract act, right? Yes or no? Hmm. Revision, guys, revision. And if you study on your own, estimate will take 3 to 4 days of your time.
Yes.
Listen. Quasi contract. What contract?
Quasi contract.
The actual contract. Are they made by parties? I will ask question you guys should answer. Are they actual contract? Made by parties? Imposed by law to provide justice? And yes or no?
Yeah.
That's what called as what contract? Quasi contract. It is based on the principle of equity. Principle of what? Justice. That is, no one should be rich at the cost of which person? Other person. No one should get rich at the cost of which person? Other person. Nemo dat quad non having. No, other law.
Unprecedented.
Nudum factum non oritur action. Allah. Nemo debtet locum latari ex liena gesta is the principle. Means no one can get rich at the cost of which person? Other person. Yes or no? Types of quasi what is the first one? Necessaries. Who is liable necessaries? Minor or unsound mind. A state is liable for supply of necessary items to the minor or the unsound mind or the person whom they are legally bound to support. If you supply necessary items to a minor or to minor's parents whom he is legally bound to support, can you recover the money out of his assets? Yes or no?
Yes.
Quasi contract. What contract?
Quasi contract.
You supply medicines to the grandmother of minor. Can you recover the money out of his assets of minor?
Yes.
Yes or no?
Yes.
Can you personally sue the minor?
No.
Can you recover out of his assets? What if he's not having any assets? You cannot recover anything. Yes or no? Next one. Suit for money. Suit for what? Money. Had and received. Had and what? Received. If a person has received any by money by mistake, money by what? Is he bound to return it back? Yes or no? Yes. Where the plaintiff paid money to the defendant under a mistake or in pursuance of a contract, the consideration for which has failed under coercion, oppression, extortion, such other means, is he bound to return it back? And yes or no? Any money paid by mistake or under coercion, can you recover it back? Yes, quasi contract. Next one, payment to third party of money, which another is what? Bound to pay. You are bound to pay, but I paid it because I have some interest in it. Can I recover it from you? You are supposed to pay property tax, but because you did not pay, I paid as a tenant. Can I recover it from the landlord? What contract? Quasi contract. What contract? Next one, money obtained by defendant from which party? Third party. What party? I get some commission secretly. I'm an agent. You are the principal. I'm selling some goods on behalf of you. From the third party, I receive some commission secretly. Am I bound to give this money to the principal?
Yes.
This money belongs to whom? Principal only, right?
This secret.
I am your agent. I am selling your property. I received some secret money, like secretly I received some commission from the third party. You discovered it later. Am I bound to pay it back? Not bound to pay it back. Bound to pay it back. Because it's a what contract? Quasi contract. I cannot be rich at your cost. Are we clear with this, everybody? Yes or no? Artha aita, everybody. Next one, quantum merit. What merit?
Quantum merit.
If you have done some work, but the work is not fully done, and there is a breach of contract because of the fault of other party, can you recover the money for the work done? That is considered as what? Quantum merit. What merit? I promised to supply goods worth of 1 lakh rupees, 100 kg. I supplied 500 kg, and you refuse to accept the remaining 500 kg. Are you bound to pay for 500 kg? Yes or no? Because I performed the part of the contract. That is called as what? Quantum merit. What merit? Quantum merit. Next one, obligation of finder of lost goods. If you find someone else's goods, are you bound to pay for it? So, are you bound to return it back? Is it finder keeper or finder should return it back? What owner? True owner. Because of what contract? Quasi contract. What contract? What if there is a reward announced? Can you keep the goods unless until reward is given? That is called as lien. Called as what? Lien. You have a particular lien. What lien? Particular lien. Last one, obligation of a person enjoying the benefit of what act? Non-plagiarious act. If somebody is giving services and if you enjoy it, and the person who is giving service does not have the intention of doing it free of cost, are you bound to pay for it? Arisa, no. A person comes and start cleaning your car window and you don't have intention of paying doing it free of cost. Are you liable to pay? Not liable to pay. Liable to pay because you enjoyed it. These are what contract? Quasi contract. What contract? Now we have the last concept, not last concept, the last second concept, discharge of contract. What is discharge of contract? End of contract. A contract comes to an end. What is the pathway? The pathway by performance. Second one, mutual agreement. Third one, lapse of time. Fourth one, operation of law. Fifth one, breach of contract. Breach of what? Now, if there is a contract, who should perform the contract? Both the parties should perform the respective promises unless the performance of the promise is excused by the law. When both the parties perform the contract, what comes to an end? I promised to deliver the goods, I delivered it. You promised to make the payment, you made the payment. Contract comes to an end. First one. Second one is what? Tender of performance. What of performance? What is tender of performance? When one of the promiser offers to perform, but the promisee refuses to accept it. Now, who is not responsible? Promiser is not responsible. Then who is only responsible? Promisee. Correct, right? However, this tender of performance must satisfy few conditions. What are the conditions to satisfy? What is the first one? It must be unconditional. Bolo. It must be made at a what time? Proper time and place. It must be made under the what circumstances, enabling the other party to ascertain that the party by whom it was made able and willing, then there is to be a whole of what he has bound to do by his promise. Means he should offer to perform the whole of the promise. And the next one, if it tender relates to the goods, you should give an opportunity to whom? To the promisee to inspect the goods. Yuvraj, inspect the what? Goods. And tender made to one of the joint promises has the same effect of what? Tender to all of them. I made a promise to three of you. I am the promiser. I offer to perform to one of the party. Is it valid offer to perform? Yes. Understood? Yes or no? Contract comes in and by performance. Who can demand performance? Promising. Who can demand performance? Promising. Or is assigning. Effect of refusal of a party to perform wholly. If the promiser refuses to perform the promise in its entirety or disable himself from performing the promise, what promisee can do? Promisee can repudiate the contract unless by his conduct or by words he signified his acquiescence in the continuation of the contract. I promise to sing in your theater every Friday for 2 months. Every Friday for up to how many months? 2 months. Second Friday, I'm absent. First week, Friday, I was present. I performed. Second Friday, I was absent. Did promiser refuse to perform here? Yes. As a promise, what I can do? Can you repudiate the contract? But you did not repudiate the contract. The third Friday, I appear and I perform the promise, and you remain silent. By remaining silent, it means you are agreeing to continue the contract. Can you cancel the contract after third Friday? The contract is valid. But however, can you claim compensation for the absence of the second day? You can deduct the money for the second day and you can pay for it. It is the consequences of failing to perform the promise by the promiser. Yes or no? Can we read the provision, please? Section number 39 provides that when a party to the contract, has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he had signified by his word or conduct his acquiescence in its continuation. By whom contract must be performed? Obviously, promiser. If there is something in the contract to show that the contract must be performed by the promisor himself, then who should perform the promise? Promisor himself. Where the personal consideration is not the foundation of the contract, then the contract will be performed by whom? By the promisor, or the promisor can employ whom? A competent person. What person? To perform the promise. See, if personal consideration is the foundation of contract. For example, teaching is the personal consideration. Correct, right? And I said, no, if I promise to teach JHL, I should not teach JHL. Can I send someone else? Possible, not possible. Because here the personal consideration is the foundation of the contract. But if I promise to sell water bottle, can I send water bottle to someone else? Yes or no?
Yes.
Is it valid or not valid? Valid. By whom the contract must be performed? Who should perform the contract? Promisor. Where there is something in the contract to show that the contract should be performed by the promisor himself. If personal consideration is not the foundation of the contract, even promisor can employ which person? Competent person to perform the contract. Nothing but is agent. Excuse me. Are you guys clear with this? Next one. Uh, Evolution of joint liabilities. What liabilities? What do you mean by joint liabilities?
Performing.
If two or more persons have made a promise, who should perform the promise during their joint lives? All the promisers should perform the promise jointly. In case of death of any one of the joint promisers, the surviving promisers, along with the legal representative of the deceased promiser, shall perform the promise. In case of death of all the promisers, the legal representative of the all the joint promises should perform the promise. Yes or no? Next one,
Release of one.
if there is a release of one of the joint promises, does it come release of all the joint promises? In case of, listen everybody, where a contract consists of, where a contract consists of joint promises, release of one of the joint promiser does not release the other joint promiser. Neither it releases the release promiser from his obligation towards the other joint promises. You three made a promise to me to repay 3 lakh rupees. If I release one person, does it mean other persons also release? No. And if she pays entire 3 lakh rupees to me, can she recover from the remaining parties?
Yes.
And I said, no. Just because one of the promiser is released, it doesn't mean she is released towards the other joint promises. Are you clear with this? Next one. Devolution of joint rights. What rights? What is joint rights? It is like promises. Is there everybody here? Is there concentrated? This concept is important. There are chances of asking practical question based on this. Listen, see, I'll give an example. The example I'll explain this section number 42, 43, 44, and 45. Listen. Let's say uh, I have taken loan from Adi, Spidey, and next to Spidey, what's his name? Vinay. I have taken loan from all three of them. I made a promise to, how much loan I have taken? 3 lakh. How much? Everybody must answer. Can't hear you guys. George, guys. How many days left? How many are they considered joint promises? No, 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 no. I have given loan to them. And they promise to repay it back jointly. How much are liable to pay? Now tell me who should repay this money back to me? All three. If any one of them is not there, remaining along with the legal representative. If all of them are not there, your legal representative. Section number 42. 43 says, can promising demand the performance from any one of the promises? Can I ask Adi to pay entire 3 lakh? The answer is yes. If agreement is silent, the liability of the joint promises is joint as well as several. Means I can recover it from any one of the promiser or all the promises. Correct, right? Now, if I demand entire 3 lakh from Adi, can I demand entire 3 lakh from Adi? If I demand entire 3 lakh from Adi, can Adi compel other promises to perform the remaining promise? So that promiser compelled can also compel the other promisers to contribute to the jointly. And so the section number 44 says release of one of the joint promiser does not release one other joint promiser. I say, Vinay, you are an innocent boy, you don't pay money to me. Now Vinay is happy. Does it mean Adi is also not liable? No. For me, who is liable now? Adi and Spine. Now, if Adi pay entire 3 lakh, can I recover 1 lakh from Vinay? Yes. Why? Because I released him from obligation towards me. Did Adi release him from his obligation towards him? No. Because as per section number 43, if any one of the promiser is compelled to perform the whole of the promise, he can demand performance from one other promiser. Arey, sir, no. I will give up my right. Who gave up my right? Promisee gave up right towards who? Promiser. But the other promisers did not give up their right towards the promiser, right? Is it liable or not liable? Liable. Section number what? 44. Then comes 45. Joint promises. It is otherwise. Now I have taken loan from these three of them. I am the promiser. These three are the promisee. Who can demand money from me? All of them during the joint line. If any one of them is not there, remaining along with the legal representative, all of them are not there. The legal representatives can demand the money from the promises. Are we clear with this, everybody? No. This is with respect to performance of the contract. Have you read about assignment? What is assignment? Transfer of right. My contract is called as what? Assignment. Only benefits can be assigned, not the liabilities. If you want to assign the liabilities, you need a consent of who? Other party. Consent of who? Discharge by mutual agreement. Based on this, there can be a theory question in the examination. Mark it important. Discharge by mutual agreement or consent. See, in this situation, is that everybody? What is the first mode of discharge of contract? No, no, no. Generally, discharge means what? End, guys. Tell me when the contract comes to an end. Either by mutual performance or by tender of performance. Correct? Correct. Now we're going to discuss where even without performance contract comes to an end. That happens only when there is a mutual agreement. What agreement? Mutual agreement. What is the first one? Novation. What is novation? Substitution of new contract. For which contract? Old contract. Is called as what? Called as what? Novation. In case of novation, which contract comes to an end? Old contract. Everybody, in case of novation, which contract comes to an end? Old contract. Next one, alteration. In case of alteration, what comes to an end? Contract comes to an end. In case of change in one or more of material terms of the contract, what comes to an end? Contract comes to an end. What rescission? Cancellation. Husband के wife बेटा, wife के husband बेटा, they mutually cancel the contract. What comes to an end? Contract comes to an end. Fourth one, remission. What is remission? Acceptance of lesser sum than what was contracted for, or lesser fulfillment of the promise when it is considered as what? Remission. See, if the promiser agrees to accept whatever less than what is due, or extend the time for the payment, or accept other than what is due, it is considered as remission. ನೀವು ನನಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕಿತ್ತು 1 lakh. I say pay 80K is sufficient. Is it called as remission? Now what comes to an end? Contract comes to an end. I'm supposed to pay money to you. I'll say, I'll give this watch to you. Please take this watch as a payment. You accept it. Is this performance valid? Yes. It is called as what? Remission. Called as what? Remission. And last one is what? Waiver. What is waiver? If you waive the loan, have you heard about waive? Yes. Yes. No. Write off is different from waiver. When the banks write off the debt from their books of account, it doesn't mean they are giving up the right. And still they can recover it. They're just making the alteration in the books of account. That's it. Waiver, legal waiver, that is done. They will not recover it from you. Waiver is different, write-off is different. Are you agree with this? Do you agree with this? What is writing up of bad loans? You just remove it from your balance sheet. It doesn't mean bank will not recover it from you. Bank will still pursue the case against you. But when they give the waiver, farmers loan waiver, means what? They give up that right against you. So waiver is different, write off is different. Agree with this, everybody? So in case of waiver, what comes to an end? Contract comes to an end. Next one, discharge by lapse of time, limitation and contract comes to an end. Next one, discharge by operation of law. Merger. What's merger? When a contract giving inferior right. Get which one? Contract giving a superior right. What comes to an end? Contract comes to an end. Next one, unauthorized alteration. What alteration? अरे बोलो what alteration? What comes to an end? Contract comes to an end. What comes to an end? Contract comes to an end. In case of unauthorized alteration, what alteration? Unauthorized alteration. What comes to an end? Contract comes to an end. Hmm? Who makes the alteration? Parties without consent of other persons. Contract comes to an end. Next one is insolvency. In case of insolvency, what comes to an end? Contract comes to an end. This one is most important. Based on this, they ask questions in the previous exams. What exams? Previous exam. I want everyone to focus hardly two more concepts of breach. That's it. The general principles of contract. What are contract? General principle. Based on this, they asked many questions in the previous examination, practical questions. I want everyone to focus on. Focus, guys. Are you guys ready?
Yes, sir.
What a performance? Impossibility of contract performance. If a contract becomes perpetual, if a contract becomes impossible to perform, the contract is void. If I make a promise which is impossible to perform, is the contract is valid or void? Valid or void? Void. This impossibility of performance can be of two types. Initial impossibility, supervening impossibility. Bolo?
Initial impossibility, supervening impossibility.
If the impossibility persists at the time of entering into a contract itself, it is called as initial impossibility. Agreement is void. For example, a person is already married. He makes an agreement to get married to one more girl. Agreement is valid or void?
Very good.
Possible to perform, impossible to perform. I make a promise to run 1,000 kilometers per hour. Possible or impossible? Is it initial impossibility, supervening impossibility? It is impossible from the beginning itself. Agreement is valid or void? Enforceable or not enforceable? Initial impossibility, agreement is void. So not concerned with that. We have section number 56. Section number what? 56. Remember? Section number 56. I gave this incident of 5 and 6 are friends. They fight. Then 5 takes 6 along with him and says, we both are greater number now. Remember? Okay. Section number 56 deals with subsequent impossibility or post contractual impossibility. Means if the impossibility arises after the contract is made, it is called as what impossibility? Supervening impossibility or subsequent impossibility. If subsequent impossibility happens, the contract is valid or void? Void. The contract becomes what? Void. Yes or no? See, because of some unexpected event or because of change of law after the contract is made, if the promise becomes impossible to perform, it is considered as what impossibility? Supervening impossibility. What impossibility? Both the cases, agreement is void. Supervening impossibility is also called as forced contractual impossibility or force majeure. What majeure? Force majeure or act of God. What are God? Act of God. Natural calamities, war, change of law. All these are considered as what? Supervening impossibility. What impossibility? In case of supervening impossibility, agreement is valid or void? Bolo, agreement is valid or void? Enforceable, not enforceable? Not enforceable by law. Are we clear with this, everybody? Yes or no? If temporary disability, what disability? Temporary disability or commercial difficulties or increase in the market prices, these are not considered supervening impossibility. Only if it is an act of God. Only if it is what? Act of God. It is considered as what impossibility? Supervening impossibility. Initial impossibility and what impossibility? Supervening impossibility. Supervening impossibility happens after contract or before contract? Agreement is valid or void? Void. Listen, everybody. Discharge by what impossibility? Supervening impossibility. What is the first one? Subject matter of the contract is destroyed when the contract is entered into on the basis of continued existence of a certain state of affairs and the contract is discharged if the state of things changes or ceases to exist, or when the personal qualification of a party is the basis of the contract and the contract is discharged by death or physical disablement of the party. And one more is that discharged by what illegality? Supervening illegality in case of change of law. What of law? See, I made a promise to teach, but I am dead. If I die, what happens to the contract? Possible or impossible? Is it supervening impossibility? Was it possible to perform? Was it possible to perform? Agreement becomes what? What? War, supervening impossibility. Change of law, act of God. These Kuwait and many other countries cancelled the contract to supply the gas and other liquid, these other petroleum product because of this war, right? And they claim supervening impossible. It means you cannot even sue them for recovery of compensation for the loss suffered. Is it initial impossibility or supervening impossibility? But however, this is the point based on which they can ask question in the examination. Difficulty of performance, commercial impossibilities, hard strike, lockout, civil disturbances are not considered as supervening impossibility. I made a promise to Jitender, saying that Jitender, I will produce 1,000 bachis in my factory and I will sell it to you for your marriage. Now what happened? I made a promise to manufacture 1 lakh bajis at my factory and supply to Chitendra's marriage. Marriage is due tomorrow, but in my factory there is a strike going on. What going on? Strike. Because of which I could not manufacture and supply the bajis to Jitendra. Now tell me, am I liable to compensation or liable to pay compensation? But there was a strike, right? Is it a supervening impossibility? Do you have a control over it? Yes. I was supposed to get a license, but I did not get license by the government. Am I liable to pay compensation to you? Yes. That is my fault. Teresa, let's say I made a promise to sell Reliance company shares. To buy it at a less price from the market, sell it to you at a higher price. But suddenly the market price of Reliance company increased. Now I have to buy at a loss of 1,000%. Am I bound to perform the contract? Not bound to perform the contract. Bound to perform the commercial impossibilities, strikes, lockouts are not considered as what impossibility? Supervening impossible. Are you guys clear with this, everybody? Section number 56, one of the important section number based on which they will ask practical questions in the examination. Supervening impossibility. The impossibility which happens after the contract is what is considered as what? Supervening impossibility. When the contract becomes impossible to perform in case of natural calamities, act of God, and war. But however, difficulty in performance, strikes, lockouts, civil disturbances are not considered as what impossibility, supervening impossibility. At that time, are you liable to perform or liable to perform? See, if it is supervening impossibility, law itself excuses you from performance of promise. Even if you don't perform, you're not supposed to pay any compensation because contract becomes what? You just have to refund whatever the money you have received. But if it is not a supervening impossibility and if you don't perform the contract, are you liable to pay compensation? Yes, you are liable to pay compensation. I made a promise to teach. Because of some issues of my throat, I could not teach. Am I liable to pay compensation to you? No. Am I liable to refund the fees? Yes. But what if I willfully default? Am I liable to pay compensation? Yes. Raisa, no. Let us discuss the breach of contract. What is breach of contract? Failing to fulfill the obligation, it is considered as what? Breach of contract. What is what? Where the promiser neither performs his contract nor tenders the performance, it is considered as breach of contract. Called as what? There are how many types of breach of contract? Two. There are two types of breach of contract: actual breach of contract and anticipatory breach of contract. If the promiser fails to perform or refuses to perform on the due date itself, it's considered as what breach? Actual breach. Before the due date, on the due date, before the due date. Array, so girl is missing on the date of marriage.
Actual. On date, actual.
Before the due date, before the marriage date. What breach of contract? ನಾಳೆ ಮದುವೆ ಇವತ್ತು ಹುಡುಗಿ ಮಿಸ್ಸಿಂಗ್. What boy can do? What boy can do? Can he cancel the contract? Or can he wait till the due date? If he has not cancelled and she comes back, is he allowed to marry her? Because the contract is still valid. Yes or no?
Yes, yes.
Understood? I'll give an example. You guys should know what will happen in this case. Listen. 20 days left. Listen. What I was discussing, guys, listen. I'll give an example. You guys tell me what happened in this case. Now, Anna, sorry, Saraswati made a contract with me to supply 1000 kg of rice. How many kg of rice? For what price of how much? 1 lakh rupees. How much, everybody? How much? Now, she made a promise to supply the 1000 kg of rice by 13th of May. 13th of what? May. What is the date today? 8th, she comes and says, sir, I will not supply rice. I say, Saraswati, how can you do this? She says, I can do this. So now tell me, is it an anticipatory breach of contract or actual breach of contract? Actual or anticipatory? Why it is anticipatory? Before the war date. You know what I can do in this case? Can I cancel it? I say, Saraswati, if you're not selling it, no problem. I will go and buy it from you. Someone else. I will buy it from Anushka. Can I cancel this contract? Yes. And I can sue her for tax. I can say, take this notice, pay me the compensation. On that day, she agreed to sell me at 100 rupees per kg. But in the market now it is 120 rupees. I should pay extra how much now to buy the 20 rupees? I can recover it from whom? From her, Saraswati. Now, what I did is about waiting till the due date. Till 13th. Now on 12th, she comes and says, sir, I will perform. Am I bound to accept?
Yes, yes.
Because the contract is still valid. But what if? But what happened? I was supposed to, she refused to perform the contract today. What is the due date? 13th. Now I'm supposed to cancel. I did not cancel. Is the contract valid?
Yes.
Yes or no? But what happened during this time, like on 10th, goods are destroyed by fire. Or there is a war between the two countries. She's from Pakistan, now there is a war. Tell me in this case, do I have a right to recover compensation from her? Because in case of supervening impossibility, contract becomes what? Void. Arey, contract becomes void. Contract becomes void. Enforceable, not enforceable? Non enforceable. Teresa, no. Means I will not recover compensation also. The advantage, sorry, the disadvantage for waiting till the due date is I will keep the contract open for benefit of all parties, one the part. If she performs the contract, I should accept it. And if there is supervening impossibility, the contract becomes void. In case of what breach of contract? Anticipatory breach of contract. Are we clear with anticipatory breach of contract?
Yes.
What is anticipatory breach of contract? Before the what date?
Due date.
Before the what date? Due date. Are we clear with this, everybody?
Yes.
Next one. Remedy for the breach of contract. What is the first one? Can you file a case for damages?
Yes.
Who can file a case for damages? Array, who can file a case for last topic of general principles of contract? For sure, you will get one or two questions out of general principles of contract. Ready? Yes, remedy for the breach of contract. Remedy for the what? Breach of contract. What is the first remedy in case of breach of contract? You can file a suit for what? Damages. What is damages? Compensation. Who can file a case for damages? The aggrieved party. Where, listen, in case of breach of contract, the party who suffered from the breach of contract can file a case against the party has broken the contract for recovery of damages. Recovery of what? Damages for all the loss which naturally arises out of the breach of contract. It is considered as ordinary damages. What damages? Ordinary damages. I want everyone to read these provisions. When the contract has been broken, what has been broken? A party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or a damage or caused to him thereby, which naturally arose in the usual course of thing from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such a compensation is not to be given for any remote or indirect losses. Correct, right? Yes or no? There are two types of damages: ordinary damages, special damages. What's ordinary damages? The losses which naturally arises out of breach of contract. What are special damages? Incidental losses. That you can recover it. That you can recover it only if both the parties were aware about those incidental losses. I give multiple examples for this. For example, let's say if I agree to sell a goods at 10 rupees, but if I break the contract, market price is 12 rupees. And I'm supposed to buy at what price? 12 rupees. At what price?
12 rupees.
At what price? How much money you can recover it from me? 2 rupees as a compensation. This is called as ordinary damages. And there's one more. What if you have a contract to sell it at some other price to somebody else and you would have made profit of extra 2 rupees? Now you can recover it only if it was informed to the promisor. I repeat. What? Incidental losses. What losses? Can be recovered from the promisor only if the promisor was aware about it. For example, I promised to construct a building for 1 lakh rupees. I constructed the building collapsed. Am I liable to pay compensation for this? Yes. Now, based on my promise of construction of building, you had made a promise to the other person to give it on rent basis. If you don't give it to him now, you should pay compensation to him. Correct, right? If this fact was informed to me, I should pay this normal damages as well as what damages? Special damages. Only if it was informed to promisor. Informed to who? And there are two types of damages: liquidated damages as well as what damages? Unliquidated damages. What's liquidated damages? If the parties have agreed the amount of compensation payable at the time of entering into a contract itself, it is called as what damages? Liquidated damages. If it is not agreed by the parties and fixed by the court, it is considered as what damages? Unliquidated damages. What damages? Array below what damages? Unliquidated damages. What is the first type of damage? Unliquidated damages. What damages? The compensation payable for the loss which naturally arises out of the breach of contract, it is considered as what damages? Ordinary damages. What damages? Next one is what damages? Special damage. What is special damages? The losses which are incidental to the contract and which were known to both the party. It is considered as what damages? Special damages. See, listen, everybody. ಹೇಳಿದ್ದೆ ನೋಡಪ್ಪ, I ordered some food from Swiggy to a pet or to a dog. That Swiggy boy did not deliver the food, because of which the dog did not eat the food for a few days, and dog suffered severe health issues. And I spent 1 lakh rupees for the treatment of the dog. Can I recover this 1 lakh rupees from the Swiggy boy? And the company can recover 1 lakh.
No.
No.
Yes, sir.
I ordered food. He did not deliver the food on time. Dog suffered some health issues. I have spent 1 lakh rupees for the treatment of the dog. Is the Swiggy company liable to pay me 1 lakh rupees?
Yes, sir.
Yes or no?
Yeah.
Why? Why? How they know that I'm ordering the food for the dog?
No, I'm feeling something.
You can, if I'm in,
For not getting it on time, but
how much you can claim? 100 rupees?
How it's good for the that.
Exactly. But can I claim compensation for the treatment of the dog? Did I inform them?
No.
What if it was informed? Can I claim the it is called as special damages. What damages? You can claim special damages only if it was informed to whom? To the promisor. But ordinary damages can be claimed even if it was not informed. Are we clear with this? Ordinary damages, special damages, exemplary damages. What damages? What's exemplary damages? Which are punishment in nature. The punitive in nature. The compensation which is given not for the to compensate a person, but to punish a person, it is called as what? Exemplary damages or punitive damages. This is given in case of disorder of check or in case of breach of promise to marry a girl or a boy. Even though there is no loss suffered, still some amount of money is given as a compensation to punish a person. It is called as what damages? Exemplary damages. What damages? Next one is what damages? Nominal damages. Below what damages? Namesake damages. Just to record the fact of breach of contract, if some amount of money is given as a compensation, it is called as what damages? Nominal damages. Is there any difference between penalty and liquidated damages? Yes, they can ask this theory question in the examination. See, penalty is unreasonable sum. What's sum?
Reasonable.
LD is a what sum? A reasonable sum. In the contract, if you fix a reasonable amount of money as a compensation in case of breach of contract, it is considered as what? Liquidated damages. If it is unreasonable sum of money, it is called as what? Penalty. And out of this, which one is recoverable? Which one is recoverable? Liquidated damages is recoverable. Penalties cannot be recovered. Essence, which one is to threaten a person? Penalty. Which one is to compensate a person?
liquid.
See, if it is a genuine free estimate of the loss, it is called as what? LD. If you fix a random amount just to force someone to perform the contract, it is called as what? Penalty. Tell me out of penalty and LD, which one is recoverable? Which one is the reasonable estimate of loss? Which one is random amount? Penalty. Which one is recoverable? Which one cannot be recoverable? Penalty. Are we clear with this? Next one. The next remedy available in case of breach of contract is specific performance. What performance? What is specific performance? When the promisor is compelled to perform what he has promised to perform, it is called as performance. Specific performance. Everybody, specific performance. Where compensation in terms of money is not sufficient or an adequate remedy, in that situation, the promisor may be compelled to perform what he has promised. That is called as what? Called as a specific performance. What performance? You promise to pay, sorry, promise to sell antique. Now you broke the contract. You are ready to pay the compensation. I don't want compensation. What I want, the goods itself. It is considered as what? Specific performance. They can ask this question in the examination. Specific performance will not be ordered where monetary compensation is an adequate remedy. If money consideration is adequate remedy, then there is no question about specific performance. Specific performance is available only when monetary compensation is not the what remedy, adequate remedy. Next one. Where court cannot supervise the work. Execution of contract means which is a long-term contract where the contract involves what skill? Person skill. What skill? Or where one of the party is a what? Minor. One of the parties is a what? Minor. In these cases, contract cannot be specifically performed. Specifically what? Performed. Last one is injunction. Last one is what? What is injunction? to restrain a person from doing something. Is it positive or negative? It is to compel a person to do something or to prevent him from doing something. That is what called as injunction. These are the remedies available in case of breach of contract. And with these, we are done with the general principles of contract. What of contract? General principles of contract. Then we have special contracts. What contract? What contract? Uh, So we have special contract, section number 124 to 238. So in this, we have contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and contract of agency. These are the five types of special contracts. And based on these, we can expect around 6 to 7 months or 5 to 10 months questions in the examinations. So let's start. See, indemnity means it's a contract where one person promises to save the other person from the loss caused by the conduct of promisor himself or by any other person. That is called as contract of indemnity. When the word indemnity comes to your mind, you should remember that indemnity is always about to compensate the loss of somebody else. Insurance contract is kind of indemnity contract. But in Indian law, insurance contracts are not considered as contract of indemnity. They are considered as contingent contract. But as per the England laws, as per the English jurisprudence, all insurance contracts are contracts of indemnity, except contract of life insurance. I repeat, in English law, in English jurisprudence, all insurance contracts are contracts of indemnity, except life insurance. Why? Because it cannot compensate the life death of a person. So fire insurance and marine insurance, all these are considered as contract of indemnity. Where in England, in India, contract of indemnity does not cover the insurance contracts. Yeah, because it covers only those losses which happens because of the act of a person. Insurance covers the losses because of accident. Correct, right? Unexpected event or untoward event. That's why insurance contracts are not contract of indemnity in India. So what is contract of indemnity, sir? It's a contract in which one person promises to save other person from the loss caused by the conduct of the promisor himself or by any other persons. We would have studied this in the dividend chapter. After 7 years, the unpaid dividend along with the shares should be transferred to IPF account. After 7 years, if anybody wants to claim those shares or the dividend amount, they should apply to the IEPF authority. When you apply to the IEPF authority, along with the application form, you should give an indemnity bond. What? Indemnity bond. To whom? To the IEPF authority, saying that I am the rightful owner of these shares, and if you suffer any loss, if I'm not the rightful owner, I am claiming that I'm the rightful owner. If I am not the rightful owner, and if you suffer any loss in the future because of you paying the money to me, I will compensate you. Who makes this promise? The one who claims the shares. From whom? From the IEPF authority. So here, person is making the promise to IEPF authority saying that he is the rightful owner. If he is not the rightful owner, and because of that, if the IEPF authority suffers any loss, who will compensate? Shareholder will compensate. And I will save the authority from loss. Correct? He is promising to save the IEPF authority from the loss caused by the conduct of himself. It's also considered as one contract of indemnity. So, contract of indemnity is a contract in which one person promises to save other person from the what? Loss. And the loss can be caused by the promisor himself or by any other person. Now, what if, let's say, you both have a joint venture agreement? You have an agreement to supply goods to her. Now, if you don't supply goods to her, what she will do? She will file a case against you for recovery of what? Compensation. Now, you're scared of this. So what you will do? You will take a contract from him. You'll say, sir, I will pay some amount of money to you today. You make a promise to me that in future, by default, if she files a case against me, you should save me from the losses. So now I make a promise to you saying that you go ahead with the contract with her. If she files a case against you in future, and if you suffer any losses, who will save you? I will save you from the losses. So I made a promise to you to save you from the losses caused by the conduct of who? Other party. Now who's other party here? She is the other. So indemnity can be to save the loss from the caused by the promisor himself or by any other person. The word is person. Person means what? Person, natural person or artificial person, but should not be by the accidents. Otherwise, getting it. Yes or no? So, what is contract of indemnity? It's a contract in which one person promises to save the other person from the loss caused by the promisor himself or by any other person. The one who makes the promise is called as what? Indemnifier, and the person to whom the promise is made is called as what? Indemnity holder or indemnified. Are we clear with this? Now, let's say Varsha filed a case against Priya. I made a promise to Priya that Priya, I will save you from the losses caused by the conduct of a third party. What party? Third party. Now, if she files a case against her, now if the court says Priya should pay compensation to Varsha, correct, right? And in this situation, compensation, she can recover it from whom? Recover it from me. I will pay the damages. Are you guys getting it? Whenever the court orders an indemnity holder to pay damages or the cost of the suit or any sum payable out of compromise, the amount will be paid by the indemnifier. Paid by whom? But this is subject to contract. Subject to what? Contract. These are the rights of whom? Indemnity holder. Indemnity holder. What holder? Indemnity holder. Indemnity holder and indemnified is both are same. Are we clear with this? In a contract of indemnity, there will be how many parties? Two parties. Who are the two parties? Indemnifier, indemnity holder. One who makes a promise to save the other person from the loss is called as what? Indemnifier. And the person to whom the promise is made is called as what? Indemnity holder. What holder? Indemnity holder. When third party file a case against the indemnity holder, the indemnity holder will be having how many rights?
Three.
Against to indemnifier. What are the three rights he will have? What are the three rights he will have? What is the first one? He can recover all the damages which he is compelled to pay in a suit filed by the third party. He can also recover cost. Recover what? Cost. Can also recover any sum payable by the compromise. DCS is the right of the indemnity holder against the indemnifier. Against the indemnifier. I hope you guys are clear with these concepts. Everybody, yes or no? Indemnifier, indemnity holder, then loss from the act of which party? I've given examples for both provisions. It can be expressed as well as implied. What is expressed by words? What is implied by the content and imposed by the law? For example, in case of contract of guarantee, contract of what? Let's say I'm the surety. She is the creditor. She is the debtor. I say creditor, you supply goods to her. If she don't pay, then I will pay. She supplied the goods to her. Clear. She has not done the payment. Who should make the payment? I should make the payment. I have done the payment. Did I suffer any loss here? Because of whose act? Debtors Act. Is she liable to compensate me now? This is an implied contract of indemnity. Even though she has not made any promise to compensate me, but still she is liable to compensate me. It is considered as what? Implied contract of indemnity. What contract of indemnity? Implied contract of indemnity. Are we clear with this, everybody? Reza, no. It can be expressed as well as implied. What is expressed by words? What is implied by conduct of the parties or from the circumstances of the case? From which it covers the loss caused by conduct of the promisor himself or by the conduct of any other person. Thus, loss occasioned by an accident is not considered as what? Contract of indemnity. Contract of what? See, this point number three is most important. Commencement of liability. Commencement of what? You guys tell me, मैंने बोला था, listen everybody, listen. I told Priya that Priya, you enter into a contract with her if she files a case against you. And if you suffer any loss, who will save her? I will save her. She broke the contract. She filed a case against her, and the court ordered Priya to pay a damages worth of 1 lakh rupees. No, sure. Now the question is Priya liable to pay the amount first, then recover it from CSR? Or is it like she can recover directly from CSR and give it to Varsha?
Yes.
Which one? First one or second one? Because the liability of the indemnifier commences as soon as the liability of the indemnity holder becomes absolute and certain. Indemnity holder post-mortem work. the liability of indemnifier, liability of becomes absolute, and the liability of indemnifier commences as and when, as soon as what happens? The liability of indemnity holder becomes absolute and certain. The moment the court ordered her to pay a compensation of 1 lakh rupees, whose liability will start? Indemnifier liability will start. She's not required to pay it first, then recover it from me. She can directly recover it from whom? From the indemnifier. ಅರ್ಥ ಆಯ್ತಾ? So the liability of indemnifier commences as soon as when the liability of indemnity holder becomes absolute and certain. Nothing but the court orders. Are we clear with this, everybody? Yes. Next one, section number 125, the rights of indemnity holder when sued. What are the rights of indemnity holder? He can recover damages, cost, as well as the sum, provided she should not contravene any of the orders of indemnify. If I say don't defend the case, but she still defends the case and she incurs some expenses, am I liable to compensate? Not liable to compensate. Not liable to compensate. She should not contravene my orders if I have given any order, or she should take my permission to do it, or she should do it as a man of what prudence? Ordinary prudence. Yes or no? Then only she can recover cost, damages, as well as the sum. What she can recover? Cost, damages, as well as the sum. Are we clear with this, everybody? Section number 124 and 125. With these, we are done with the contract of indemnity. What is contract of indemnity? It's a contract in which how many person? One person promises to save the other person from the loss caused by the death of the promisor himself or by any other person. How many parties? Two parties. Indemnifier, indemnity holder. When the liability of indemnifier commences, as and when liability of the indemnity holder becomes absolute and certain. And what are the rights of indemnity holder when he is sued? He can recover all the damages, cost, as well as the sum. From whom we can recover? Indemnifier. Can it be expressed?
Yeah.
Can it be implied? This is about contract of indemnity. Are we clear with this, everybody? 124 and 125. See, contract of guarantee concept is very simple. Listen, everybody. In this concept, you're going to study about. Listen, in the contract of guarantee, you study about what is contract of guarantee, about consideration to the surety, then you study about liability of surety, then there is concept of joint surety, then you study about rights of surety and discharge of surety. It's all about surety. All about what? Surety. Are you guys getting it? Now, first, just imagine what is contract of guarantee? What is contract? What is guarantee? If somebody, let's say I want to buy something, I go to a shop and you're standing next to me, I'm buying something and I say, Anna, I forgot my wallet at academy, I don't have the money. But person is not trusting me. And you're standing next to me. What you will do in that situation?
We'll give you the guarantee and pay him back later. Or
This is correct. She knew guaranteed say, wow. You can pay it, no, you can take it from me later. No, what if you don't have, you also don't have the money? It's a very big amount. Okay, let's say I'm buying something which is worth of 50,000 rupees and you don't have that amount of money. He is your relative. Or he missed you more than CSR. Now I'm standing next to you and I ask goods from him and he says, I'll not supply because you don't have the money. At that time, what you say, no, don't worry, he's a trustable person. You supply goods to him. If he don't pay, who will pay? I will pay. मैं वादा करता हूँ. I will make a promise. नाम इनके promise मारते हैं that if he don't perform, who will perform? I will perform. That is what called as guarantee. See, guarantee can be for two purposes. Either for the discharge of debt or the performance of a promise. ನೀನ್ ಮಾಡಿದ ಅಂದ್ರೆ ನಾನ್ ಮಾಡ್ತೇನೆ ಅವ್ನ್ ಬಿಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಾನ್ ಬಿಡ್ತೇನೆ ಎರಡು ಬರುತ್ತೆ for the two things here, discharge of liability or performance of a promise. Clear? What is contract of guarantee? It's a contract in which one person promises to perform or discharge the liability of which party? A third party. In case of his, it is called as contract of guarantee. Contract of what? Can you guys repeat what is contract of guarantee? It's a contract to perform the promise or discharge the liability in case of default. By which party? Third party. That is considered as contract of guarantee. Contract of what? You guys tell me, in a contract of guarantee, there will be how many parties? In a contract of guarantee, there will be how many parties? Three parties. What are the three parties? Principal debtor, creditor, and surety. Principal debtor and creditor at the surety. Are we clear with this, everybody? Can you guys read? I want, we should go sort of fast, okay? Concentrate, everybody. Let's start. A contract of, and once I finish this chapter, as I've already discussed, I will cover this chapter, then we will discuss BNS and BNSS, then we will try to cover a Negotiable Instrument Act. For remaining chapters, we will solve the question and answer with the help of question bank. And everybody should solve the question bank if you really want to pass in this paper in the upcoming examinations. I want to score good marks in the upcoming examinations. Make sure you do solve the questions of question bank. And along with that, make sure you do revise with the help of short notes. There are few chapters which are omitted from your short notes. For example, specific relief act. If you remove specific relief act, then if you remove these, one more chapter is there, which is removed. We have certain parts of Constitution of India which is not there. If you remove that, short notes is hardly of 85 pages. That's it. This short notes is of how many pages? It has around 114 pages, but it has three chapters which are of mentioned already short notes. Now you have short notes, right? So short notes is hardly of 80 pages, which you should refer 1 week before the examinations for the fourth time revisions. Third or fourth time revision, you should refer to what? Short notes. Maybe it will be possible to cover everything from the detailed notes. Are you guys getting it? But make sure question bank, you should solve it with 100% dedications. Done? Are we clear with this? Okay, let's start. Chalo. Contract of guarantee. Everybody concentrate now. What is contract of guarantee? It's a contract to perform the promise or discharge the liability of which person? Third person. In case of its default, it is considered as contract of guarantee. How many parties are there? Three parties. Surety, principal, debtor, and creditor. Everybody should participate and should answer my questions. Are we ready? Are we clear with this? Surety means what? One who gives the guarantee is called as surety. The one in respect of whose default the guarantee is given is called as what? Debtor. And the person to whom the guarantee is given is called as what? Creditor. Are we clear with this? Yes. Next one. Types of agreement. Agreement, there will be three agreements. Okay. How many agreement? Three agreement. Contract of guarantee is a tripartite agreement. One agreement between principal debtor and the creditor. One agreement between the surety and the creditor. And one implied contract between debtor and the surety. Principal contract between the principal debtor and the creditor. Second one between surety and the creditor, and one implied contract between whom? Debtor and the surety. Three types of contract. Next one, consideration. This is one more important topic based on which they can ask questions in the examination. You guys tell me, what do you mean by consideration? Consideration मतलब क्या होता है? When at the design of the person, promisee or any other person, then our promises abstain from doing, does abstain from doing, promise such an act or abstinence or promise is called as consideration. I will give an example. You guys should tell me. See, every promise must have consideration. If surety is giving a promise to perform the liability of third party, it should have a consideration, correct? Right? Because a promise without consideration, is it valid or not valid? Not valid. Agree with this, everybody? Every promise must have a consideration. Yes or no? A promise without consideration, valid or not valid? Not valid. Agree with this, everybody? Then you guys listen to me now. Listen. For example, I said, Adi, you supply goods to Spidey. If you don't pay, then I will pay. Correct, right now, who made a promise to Adi here?
You CSR.
Who am I? CSR, but I'm not you, Allah. I am CSR, not you. Who am I? CSR. I made a promise to whom? Adi. That Adi, you supply goods to him. If you don't pay, who will pay? I will pay. Are you guys clear with this, everybody? Now, for my promise, what is the consideration for me here? I made a promise to whom? For this promise, is there any consideration for me? No consideration, no contract. Any promise without consideration is invalid. What is consideration, you tell me? When at the desire of the promiser, promisee or any other person does are done. Now tell me, is Adi doing something as per my desire? What he is doing, he is applying goods to Spidey. Consideration need not be for the benefit of the promiser. The only requirement is that it should happen as per whose desire? Promiser desire. Is he doing something as per my desire? What he is doing? Anything done to the benefit of the debtor at the desire of the surety is considered as consideration for surety. Anything done or promise made for the benefit of whom? Debtor. As for whose desire? Surety desire is a consideration for no surety. Are you guys clear with this? Yes or no? I will give you more example. You guys should tell me what will happen in this case. Now, what if Adi already supplied goods to Spidey? Then I promise to become a surety for this. Is it valid? Not valid because he is not doing anything as per my desire. Now, what if Adi has already given a loan to the Spidey and it is due for repayment? He has not done the repayment. Now, I say, Adi, don't file a case against Spidey for 3 months. If you do not sue him for 3 months, if you don't pay, then I will pay. Is it valid contract? Do you have any consideration here? What are the consideration from Wali here? Not filing his suit against him, Spidey is the consideration for me because he's doing as per whose desire, promises desire. Anything done or promise made for the benefit of the debtor as per whose desire, surety's desire is the consideration for surety. It need not be for the benefit of surety, but should be as per whose desire, promises desire. Whose desire? Promises desire. Are we clear with this, everybody? Arizano, can you guys read anything done below? It's made for the benefit of the principal and for the study of giving a guarantee. Are we clear with this? Next one. A distinction between indemnity and guarantee. You guys have number of parties. How many parties are there in guarantee? Three parties. How many parties? Three parties. Got you. And in case of indemnity, parties. Primary liability. In case of indemnity, who has the primary liability? Indemnity, indemnifier. Uh, indemnifier. In case of guarantee, who has the primary liability? Debtor. I say if you don't pay, then I will pay. First you should pay, na. If you don't pay, then I'm only liable to pay, na. That is why principal debtor means इसका liability primary होता है, correct, right? Who has a primary liability in case of guarantee? Principal debtor. Indemnity? Indemnifier. Next one, request of debtor. Surety should always act as per whose request? Everybody, principal debtors, not principal debtors request. Whose request? Principal debtors request. But in case of indemnity, in case of what? Indemnifier need not act as per whose request? Indemnity holder request. Will you go and act as per the request of IP authority? No. You only give an indemnity bond. Saying that, sir, if something goes wrong in future, I will compensate you. And even when you apply for duplicate share certificate, what certificate? Duplicate share certificate, company can demand what? Indemnity bond. What bond? Indemnity bond is nothing but contract of indemnity, where you make a promise to the company that saying that if in future if something goes wrong, you will compensate that company. Yes or no? Next one. Existing debt or duty. Where there is an existing debt, guarantee. There is an existing debt. But in case of indemnity, there is no existing debt. Right to sue in his own name. Tell me who can file a case against third party in his own name? Surety. See, if debtor defaults, surety makes the payment. Can you sue the debtor directly for recovery of money? Yes or no? But that is not possible in case of what? Not possible in case of what? Indemnity. Indemnity, there is no privity of contract between indemnifier and the third parties. Which parties? That is why third party indemnifier cannot file a case against him, third party. In his what name? Own name. He has to sue in his whose name? Indemnity holder's name. For example, let's say because of her you suffered the loss. But I made a promise to compensate you. Now, can I sue her directly? No. Can you sue her? Yes. So indemnifier cannot sue the third party in his own name. Are you guys getting it? So surety can file a case against debtor. Debtor is a third party, right? Between creditor and surety, who's the third party? Debtor. Can surety sue the debtor in his own name directly? Yes or no? Yes. That is the difference between indemnity and guarantee. They can ask this question for question or they can ask this question as a theory question in the examinations. Next one, nature and extent of surety's liability. Important here. The surety's liability is always primary in nature, secondary in nature. Secondary in nature. Tell me to what extent surety is liable? To the extent who is liable? Debtor is liable. To the same extent who is liable? Surety is also liable. The surety is liable to the same extent that whom? Debtor. We call it as coextensive. To the word coextensive. The liability of the surety is coextensive with that of whom? Principal debtor. What debtor? If debtor is liable for 1 lakh, I am also liable for 1 lakh. But however, surety can restrict his liability by an agreement. By what? If it is agreed that I will be liable only for 1 lakh, so it is liable for how much? 1 lakh. If nothing is agreed, law provides the liability of surety, liability of is always coextensive with that of principal debtor. If debtor is liable for 1 lakh, surety is also liable for how much? 1 lakh. Let's say I made a promise to her that, ma'am, you take a bill of exchange from her. If she don't pay, then I will pay. You have accepted, you have received the bill of exchange. Now she has not done the payment. Because she has not done the payment of bill of exchange, you got it notarized by paying some 10,000 rupees of expenses. You incur some extra expenses. Plus there is a delay in repayment. So there is interest. So the total amount is 1 lakh 50. Bill amount is 1 lakh. Noting charges is 10,000. Interest is 25,000. Remaining 15,000 is something. Now, to what extent I am liable as a surety? Am I liable only for 1 lakh or 1 lakh 50? 1 lakh 50. If nothing is agreed, law says surety liability is always what? Coextensive with the which data? Principal data. What data? What if it is clearly agreed that I would be liable only for 1 lakh? Only how much? 1 lakh. If agreed, agreed amount. Not agreed? Hold the point. Are we clear with this? So the liability of surety is primary in nature, secondary in nature. Secondary in nature. Correct, right? If liability arises after default or before default? Now the question is it like can the creditor directly go against the surety instead of filing case against the debtor? Is it like surety first recover it from debtor, then go against the sorry? Can creditor on default by debtor directly go against the surety for recovery of money? Yes. There is no need to file a case against who? Debtor. Because the moment default happens, who becomes liable? Surety becomes liable. Are we clear with this, everybody? Types of guarantee. There are two types of guarantee. How many types of guarantee? What are two types of guarantee? Specific guarantee and continuing guarantee. If a guarantee is given for a single debt or a specific transaction, it is called as what guarantee? Specific guarantee. What is continuing guarantee? If a guarantee is given for a series of transactions. What transaction? Two keywords here: single debt, specific transaction, specific guarantee. Series of transaction is called as what? Continuing guarantee. What guarantee? Now I say, ma'am, you supply the goods to her time to time whenever she requires it. If she don't pay, then I will pay. It is what guarantee? Very good. What guarantee? Continuing guarantee. Wherever the word time to time is used, keep this in mind. It is a what guarantee? Continuing guarantee. If I say, ma'am, you supply goods of 1 lakh rupees to her. If she don't pay, then I will pay. It is what guarantee? Specific guarantee. What guarantee? Specific guarantee. Are we clear with this, everybody? Yes or no? Understood. Next one. Is it possible to revoke continuing guarantee?
Yes.
Having effect on what transaction? Future transaction. Before she supplied the goods, can I cancel it? Yes. If I cancel it, it will be effective only for what transaction? Future transaction. But whatever already happened, am I responsible or responsible? Whatever already happened, responsible. Whatever is yet to happen, am I responsible or responsible? Because it is cancelled. Are we clear with this? There are how many types of guarantee? Two. There are two types of guarantee: specific guarantee and continuing guarantee. Revocation of continuing guarantee. Is it possible to revoke continuing guarantee? What is revocation? Cancellation. What is revocation? Notice of revocation of surety. See, if it is a continuing guarantee, can I cancel my surety by giving a notice?
Yes.
And it will have effect on what transaction? Whatever happened, am I responsible or responsible? Next one, by death of surety. A continuing guarantee comes to an end by death of surety. If surety dies, what comes to an end? Guarantee comes to an end. But what about the existing contracts? Is my asset responsible? Assets continues to be responsible for the whatever happened before the death of the surety. Are we clear with this, everybody? Discharge of surety. Based on this, they can ask questions in the examination. Discharge means what? End of surety. You know? Termination of surety. Based on this, they can ask theory question in the examination. Concentrate, everybody. What is the first way of discharge of surety? Notice of what? Revocation. In case of continuing guarantee, you can revoke the guarantee by giving a notice. Second one is by death of what comes to an end? Contract comes to an end. It's only for future transactions or existing transaction? Future transaction. By death of surety, by notice of revocation. One is any variation in the what? Terms of the contract. See, if debtor and the creditor makes any changes in the terms of the contract without whose consent, and whose liability comes to an end? Surety. Alteration. Whatever happens after alteration, who is discharged? Surety is discharged. Variation. Understood, everybody? Next one is by what? Surety is discharged if the creditor releases the principal debtor. Who releases? If debtor is not liable, who is not liable? Surety is not liable. If creditor releases the debtor or makes an act or omission which results in the discharge of whom? Principal debtor. Or debtor? But if the creditor fails to sue the principal debtor within the limitation period, the surety is not discharged. Who is not discharged? Keep this in mind based on this they can ask question in the exam. Listen, everybody. Listen. If debtor is discharged, it's also discharged. Surety is also discharged because the liability of surety depends upon who? Debtor. If debtor is not liable, who's not liable? Surety is also not liable. For example, let's say we have this there in the contract act. I agree to be a surety for she constructing the house, provided you supply goods to her. You should supply raw materials to her. She will build the house. If she don't build the house, I would be the one who is responsible. You did not supply raw materials to her because of which she cannot construct the house. Now tell me, is she liable or not liable? For the breach of, is there any breach of contract here? There is a breach of contract. Means the contract could not be performed by her. Is it because of her or is it because of the promiser? Because you did not supply goods to her. She could not perform. Is she liable or not liable? Not liable. Is the contract valid or not valid? Is she debtor liable or not liable? Not liable. If debtor is not liable, who is not liable? Surety is not liable. So if a debtor is discharged or if a debtor is released from his obligation, who is also released? Surety is also released. We are discussing about discharge of surety. What is the first situation? By revocation. Everybody by what? Revocation. Participate everybody. What is the first way? Revocation. Second one? By death of surety. Third one? Variation in the terms of the contract between whom? Creditor and the principal debtor. Without whose consent? Surety is consent. Fourth one, where surety is discharged by release of the principal debtor or by omission of a debtor, which will result into what? Discharge of the principal debtor. Or debtor. But however, not filing a case within what period? Limitation period. Against the debtor will not discharge you. Surety. See, limitation period does not make the contract invalid. It just says that you cannot recover the debt by filing a case in the what? Court. That's it. Next one. Where the creditor without consent of surety makes an agreement with the principal debtor for composition. What's composition? Compromise or promise to give a time or not to sue him. In these cases also who is discharged? Surety is discharged. Who is discharged? When the creditor makes an agreement with who? Debtor to compromise or not to sue him or to give an extra time. In this case also who is discharged? If it happened without whose consent? Surety is consent. Whose consent? See, keep this in mind. If these two are debtor and creditor, she makes a contract with her to give a more time to her without my consent. Who am I? Surety. Am I discharged or not discharged? Discharged. But what if she makes a contract with some third party? Not with debtor. Now money is due for repayment. I'm the surety. Now she comes and say, ma'am, you don't file a case against for 3 months. If you don't file a case against her for 3 months, I will make a payment to you. So now she agreed to give a time with third party, not with the debtor. Is surety discharged or not discharged? Not discharged. Only when the creditor makes an agreement with whom? Principal debtor, either to give a time, either to give a time, or not to sue him, or to compromise without whose consent? Surety is consent. Who is discharged? Surety is discharged. Everybody who is discharged? Surety is discharged. Are we clear with this? Everybody, one more situation. What is the one more situation? Next situation. If the creditor does any act which is against rights of surety, rights of or omits to do any act which is the duty to the surety requires him to do, and the eventual remedy of the surety himself against the principal debtor is thereby implied, the surety is discharged. See, if creditor does anything which is against the rights of surety, rights of see, once surety makes the payment, whatever the goods given as security, goods given as what?
Security.
Creditor belongs to who? What if those goods are destroyed? Because of whose negligence? Creditor's negligence. Now, who is discharged? Surety is discharged. Who is discharged? Surety is discharged. Why surety is discharged now? Because my eventual remedy is impaired. What is impaired? Destroyed. Because of whose act here? Creditor's son. Whose act? Creditor's son. Otherwise, giving it. This is the one more situation who is where what is discharged? Surety is discharged. Next one. That's not. Section number 141 and 139 both are interrelated. If the creditor loses or part with any security, what is security here? Assets. At the time of contract, the debtor given in favor of the creditor, the surety is discharged. Who is discharged? Surety is discharged. These are the situations where who is discharged? Everybody. Surety is discharged. Can you guys tell me what are the situations where surety is discharged? What is the first one? By revocation. Second one, death. Variation in the terms of the contract. He does anything which releases the debtor or discharges the debtor. Next one, compromises. Compromises with what? Debtor or agrees to not to file a suit against, agrees not to file a case or agrees to give a time. And next one, does any act which impairs the eventual remedy of the surety. And last one, if he destroys the security given by the debtor. In these cases, who is discharged? Surety is discharged. 5 to 6.89 if they ask theory question in the examination. So are we clear with this, everybody? Yes or no? Next one. Discharge of surety is done. Now we shall discuss about rights of surety. Rights of what are the rights available to the surety? As I said, in guarantee contract, most important topic is what is contract of guarantee, parties, types of contract, differences. Then we have consideration to the surety, and then we have the discharge of surety. Then we have a rights of surety. That's it. Only these topics are there in the what? Contract of guarantee. Contract of what? Are we clear with this, everybody? Now, rights of surety. Rights of what? What is the first one? Rights of surety against the creditor. Against the he is entitled to the benefit of every security. Underline the word every security which the creditor has against the principal debtor at the time when the contract of surety is entered into, whether he knows of the existence of security or not. And if the creditor loses or without the consent of surety, part with the security, the surety is discharged to the extent of value of security. Simple. See, listen, everybody. The surety has a right to all the security which were given by debtor to whom? Creditor at the time of entering into a contract. Even if who is not aware about it, surety is not aware about it. For example, I have taken some gold loan. I am a debtor. She is a creditor. I have taken a gold loan by giving this gold as a security, and she is the surety. I default in the repayment of money. She makes the payment. Now, what happens is she has the right against creditor to recover that what? Gold jewelry. Now, what if she has lost it or she has sold it to somebody? Now, to that extent of sale or loss, who is discharged? See, liable or not liable? Not liable. Understood? This is the first right of who? Against whom? She will have a right to receive all the security given by whom? Debtor. To whom? At the time of entering into a contract of guarantee. Now, what if after that she becomes surety? Now, given some extra asset as security, on which she don't have any right. Only whatever security given at the time when the contract of guarantee was given, first she has a right against the creditor. Right against the creditor. Are we clear with this, everybody? Next one, right against principal debtor. Right against who? Who is principal debtor? I am the principal debtor. I am the debtor. She is the creditor. She is the surety. Now, if I default, who will make payment? Everybody should concentrate here. Concentrate, participate. If I am the surety, she is the creditor, she is the debtor. I'm the debtor, creditor, and surety. If I don't pay, who will pay? She will pay. On the payment of money, let's say I was supposed to pay 1 lakh rupees, but she paid the 1 lakh rupees. Now, once she makes the payment, she becomes a creditor. She will stand in the shoes of whom? इसको बोलते हैं subrogation. Means she will be vested with all the rights which creditor had against who? Against who? Now, can she file a case against me? Who can file a case? Against who? Recovery of what? Money. I'll give one more example. I have given the water bottle security with a condition saying that if I debtor defaults, she can sell it by giving a notice to me. Clear. Now I default in the repayment of money because I defaulted. Surety made the payment. Now can surety sell its water bottle by giving notice to her? Because she becomes the what? And she will be vested with all the right which she had. Who had? Creditor had against who? That is the one more right available to whom? Surety against who? Who will be vested with? Continue. Let's continue. Hello, listen. Okay. What is the first one? What is the first right? Rights against whom? Data. Second one is what? Right against the against what debtor? Principal debtor. I hope you guys are clear with right against principal debtor. He will be vested with what? All the right which creditor had against to principal debtor. Last one, sureties right against the co-sureties. What sureties? What sureties? So a surety has a right of contribution from the co-sureties who are equally bound to pay with him. Correct, right? Who has a right? Surety has the right to demand the equal contribution from whom? From the co-sureties. Correct, right? Because the liability of the sureties is always joint and several. Joint and what? If these three are co-sureties, what is co-surety? If there is more than one surety, is considered as what? Co-sureties, joint promises. If I compel them to pay 1 lakh rupees, even they are also liable to contribute equally, right? Yes or no? They can ask this question in the examination. Rights of surety. Rights of surety. Are you clear with this? With this, we are done with the contract of guarantee. Keep this in mind. In the guarantee concepts, you have only what? Concept of guarantee, parties to the guarantee, consideration, liability of the surety, then difference between indemnity and guarantee, rights of the not rights, discharge of surety, and the rights of the surety. Only these many concepts are there in the contract of guarantee. Are we clear with this, everybody? You tell me what is contract of guarantee? It's a contract to perform the promise or discharge the liability of a third party in case of its default. It is considered as what? Contract of? Yeah. How many parties are there? Three parties. What is the consideration for surety? Anything that our promise made for the benefit of data. At whose desire? It is a consideration for surety. Understood? There are how many contracts in guarantee? Two or three? Three. Expressed one and one implied. One implied contract between guarantee and data. Surety and data. Are we clear with this, everybody? Yes or no? Next one, we'll start with the bailment. What's bailment, guys? Simple concept. What is bailment? Just imagine you taking. Just imagine you taking a car on a rent basis or a bike on a rent basis. That is considered as what? Bailment.
Principal data.
What? Which one?
The continuous process schedule.
Difference topic or consideration topic? Consideration. At the desire of the surety. You are the creditor. He is the debtor. I am surety. I will say you supply goods to him. If you don't pay, then I will pay. Now, what is the consideration for me?
We apply.
And you're doing as per whose desire? Let us consider. That is only its consideration for me. If you do it as per your own wish or as per his wish, that is not considered as a consideration for me. You should supply only when I say you supply. If you already supplied, then if I become surety, it's not a surety. Clear? Yes or no? Yes. ಸರ್ ಬ್ಯಾಟ್ರಿ ಬೇಕಿತ್ತು ಸರ್ ಬ್ಯಾಟ್ರಿ ಖಾಲಿ ಆಗ್ಬಿಟ್ಟಿದೆ ಕಳಿಸಿ ಸರ್ Alright, don't waste time. Keep revising. Innocent misrepresentation. Have you heard about this? Difference can you write? Which one is intentional? Which one is innocent one? If a person had a means to discover truth in case of misrepresentation, contract cannot be cancelled. Fraud, it can always be cancelled. Which one is punishable? Which one is not punishable? Misrepresentation. Where the contract is always can Cancelled?
Fraud.
Fraud. In case of misrepresentation, there are few situations where the contract is not, it can be cancelled, but you cannot claim compensation. But are there any exceptional cases where you can claim compensation?
Yes.
Misrepresentation, remember,
Yes.
directors, in case of prospectus, agent breaching the duty, and one more. Which one? There are few cases where even in case of misrepresentation, you can claim compensation, right?
Yes.
What is the one more? Two we have discussed.
It's just
Professional negligence by one of the any professionals like advocate, RCA, RCS. These cases you can recover compensation. Agent, breach of duty by an agent. That is in case of prospectus. Correct. Ah. Next, agreement without consideration. Can you guys read question number 1? What is the answer? First case, void. Second case, valid. Exception है ना? Agreement made out of natural love and affection, subject to how many conditions? 4 conditions. Next one, Ram. We did this yesterday. Agreement is what? Void, not enforceable by law. Privity of contract. Can you guys read this? Will the Maldi succeed? One of the exception है ना? Family agreements. If it is in what form? Written form. Any family member can enforce the contract. She will succeed. Very good. Next one. Question number 2. Hmm. Why? Is whether B can sue C, but not because there is no privity of contract. Okay, next one. Question number 3. Read the full question. Here the contract is made between whom? Father-in-law and his father and father-in-law. Now, can he enforce the contract? Answer is yes. Marriage contract are enforceable, na? Privity of contract. Marriage agreement, family agreement, who can enforce it? Beneficiaries can enforce it. One of the exception. Huh? Is it not maintainable?
It was not the boy who was in the contract. He was father.
Okay. But as per, we'll go with this answer. Not enforceable by law. Okay. Next one. We cannot change the answer. But actually, the answer is different because one more case is there where if a family marriage agreement, marriage contract, the beneficiary can enforce the contract. Who can enforce it? Beneficiary. ಹೌದು hello hello Why agreements? They ask question based on this in the June 25 examinations. Can you guys read the question, please? This question was asked in June 25 examinations. Read.
Something like it says he would be eligible to pay that. Now there is is training and it should be right up. The father and died parents for that to face means that's how we made up his life.
Valid or not valid? Valid. But if he restrain him from working anywhere else after he leaves the job, it is not valid. But if there is an agreement to pay compensation, valid. Section number 27. We discussed the agreement in restraint of business or trade or profession is void. But are there any exception? Yes. What is the one of the exception? Service agreement. What agreement? Service agreement. We discussed this, right? Yes or no? Okay. Okay. Let's continue with the remaining topics. You will be able to solve the question. Don't worry. As I said, once I finish this class today, you spend 1 day for JIGL, solve all the question bank questions, you get a confidence in the exam. Okay, you need to know what type of questions will come in the examinations. Getting it? Okay. Next, let's start with the next topic. What is the next one? Bailment. What is bailment, guys? Bailment ಅಲ್ಲಿ ಏನು ಇನ್ವಾಲ್ವ್ ಆಗಿರುತ್ತೆ ಗೂಡ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆಗಿರುತ್ತೆ ವಾಟ್ ಇಸ್ bailment ಡೆಲಿವರಿ ಆಫ್ ಗೂಡ್ಸ್ by one person to another person upon a contract with condition that the goods should be returned or disposed of in accordance with whose instruction? Bailer instruction. Whose instruction? Delivery of goods by one person to whom? Another person for some purpose upon a contract that the goods shall be, when the purpose is accomplished, be returned, otherwise disposed of according to whose direction? Person who is delivering them. Nothing but bailer. There will be how many parties in agreement? What are the two parties? Bailer and bailey. Bailer and what? One who delivers the goods is called as what? Bailer. The person to whom the goods are delivered is called as what? Bailey. Types of bailment on the basis of benefit, on the basis of what? Reward. Bailment can be for whose benefit? Bailer benefit or bailey benefit or benefit of both the parties. Benefit of which parties? Tell me, if I deliver the goods, I'm going abroad, I want somebody to take care of my goods for 2 days. I give it to the neighboring person. It is for whose benefit? Bailer or bailey? Bailer's benefit. Correct, right? Yes or no? Now, what if you want some notes or some bike? I give the bike to you. I am the bailer, you are the bail. It is for whose benefit? Bailer's benefit. Now, when we both receive the benefit, for example, if you take a bike on a rent basis, it is considered as what? If you take bike on rent basis, who gets the benefit? I get the rent, you get the bike. Correct, right? It's the benefit of whom? Both the parties. Benefit of whom? So it can be for the benefit of bailer, benefit of bailey, or the benefit of what parties? Both the parties. Next one. On the basis of reward, it can be gratuitous as well as non-gratuitous. I'm not discussing here that any promise without consideration is void, but one of the exception is bailment. Bailment can be with consideration or without consideration. Well, next one. What is gratuitous bailment? Where there is no remuneration, where there is no what? Remuneration for the bailment, and it is considered as what bailment? Gratuitous bailment. What bailment? Such a bailment will be for the benefit of whom? Benefit of the bailer. Benefit of whom? Are you clear with this, everybody? Listen, everybody, listen. In case of gratuitous bailment, what bailment? What is gratuitous? With the consideration, without consideration. For example, let's say uh, I am giving a car for your benefit. Whose benefit? You want a car for 2 days. I give the car to you. To use it for how many days? 2 days. Without charging anything. It is for whose benefit? Bailey or bailer? It is gratuitous, non-gratuitous. Gratuitous. And keep this in mind, a gratuitous bailment comes to an end on the death of whom? Bailer. Death of whom? Automatically it is revoked. Clear with this, everybody? And one more thing is that bailer can terminate gratuitous bailment at any time by giving notice to whom? Bailey. Based on this, they can ask question in the examinations. Practical question. Let's say, listen everybody, Pradyumna, listen Pradyumna. Now Pradyumna wants to go out. So now he needs a car. He asked me for a car. I'll give my car. Saying that Pradyumna, use it for 1 week and then you give it back to me. Now I say, sir, am I supposed to pay anything? I say, no, no Pradyumna, you just take it. Who will charge money for it? You take it, use it, and give it back to me. He takes the car. He does a decoration to the car. Full flower. the full car, he filled the petrol to the car, he incurred some expenses. Same example I gave, no? You guys remember the example? So if I terminate the bailment, terminate the what? Bailment, and if he suffers any losses, am I liable to compensate him? Listen, everybody. A gratuitous bailment. What bailment? Can it be terminated?
Yeah.
By whom? At what time? Anytime. By giving notice to whom? Bailey. But because of premature termination, if the bailee suffers more loss than the benefit he receives, then who has to compensate? Bailer. To bailee. But if it's for a reward, can the bailer cancel the bailment before a specified time? No. You cannot do it. Are we clear with this, everybody? Now, only one more example. You guys tell me what will happen in this case. If the bailment is gratuitous and for the benefit of the bailer, who should incur all expenses? Bailer or bailee? It is a gratuitous bailment. For the benefit of bailer,
Okay.
I am going abroad. I want somebody to take care of my dog and keep my dog with you. It's for whose benefit? Bailer or bailee? Now, who should incur all necessary expenses? Ordinary as well as extraordinary expenses should be borne by whom? By the bailer himself. Other than that, in normal bailments, normal expenses are borne by whom? Bailee. Extraordinary expenses are borne by whom? By the bailer. Correct, right? No. Next one, next one. Are you guys clear the section number 159?
Yes.
What is section number 159? If the bailment is gratuitous, it can be terminated by whom? At what time? By giving notice to whom? But however, if the bailee suffers loss more than the benefit he has derived out of the gratuitous bailment, who has to compensate? Bailment. To whom? Bailee. Bailment for reward. What is bailment for reward? When there is a consideration for both, it is considered as what? Bailment for reward. Duties of bailee. Duties of what? Bailee. Keep this in mind. The first duty of a bailee should take a reasonable care. What care? What is reasonable care? As a man of what prudence? Ordinary prudence. Who take care of his what goods? All goods. ನಿಮ್ದೇ ಮಗು ಆಗಿದ್ರೆ ಹೇಗ್ ನೋಡ್ಕೊಂತಿದ್ರು ಆ ತರ ನೋಡ್ಕೊಬೇಕು. ನಿಮ್ದೇ ಗೂಡ್ಸ್ ಆಗಿದ್ರೆ ಹೇಗ್ ನೋಡ್ಕೊಂತಿದ್ರು ಆ ತರ ನೋಡ್ಕೊಂಡ್ರೆ ಇಟ್ ಇಸ್ ಕಾಲ್ಡ್ as what care? Reasonable care. What care? If somebody gives gold jewelry, so ನಿಮ್ದೇ gold jewelry ಆದ್ರೆ ಎಲ್ಲಿ ಇಡ್ತೀರಾ? Locker ಅಲ್ಲಿ. I give gold jewelry. You keep it outside. Somebody comes and happened. Who is responsible? Are you responsible or responsible? Will you take reasonable care?
No.
Why not? Because he did not act as a man of what prudence? Ordinary prudence. Or in his own case, under what circumstances? Similar circumstances. Keep this in mind. If a bailee takes reasonable care, what care? I will know what care. If something happens to the goods, who is not responsible? Bailee is not responsible. But then who is responsible? You kept the jewelry locked it. Some thief, extraordinary thief, expert thief. What he has done? He broke into your house. He entered your house. He did burglary. He stole everything. Tell me, are you responsible or responsible? Not responsible. Bailey has taken what care? Reasonable care. What care? Are you guys clear with this? So Bailey's duty is to take what care? Reasonable care. As a man of what prudence? What true in his what case? Case. Who take care of his own goods are the same one quality of value. Are you guys getting? Are you guys clear with this? Next one. Not to use in an unauthorized manner. What manner? You should not use the goods in what manner? Unauthorized manner. If you use the goods in an unauthorized manner, who is responsible? Bailey. To whom? Right, Bailey to whom? Because if you make an unauthorized use and if there is any loss to the goods, who should pay the compensation? Bailey. To whom? Are we clear with this? Everybody? मैंने बोला था you should ride this horse. Only you should ride this horse. But you make other person to sit along with you. Let's say four persons are riding the horse. Because of that, the horse got injured. Now, who is responsible? Very responsible or responsible? Because he made the what use of goods? Unauthorized use of goods. Next one, he must keep the goods built separate from his what? Own goods. Who should not mix the goods? Bailey should not mix the goods Of his own. With whose goods? Tailor's goods. If he mixes the goods, if it's possible to separate, who will incur all the expenses? Bailey should incur all the expenses. There are three scenarios with consent mixture. If he mixes the goods with the consent of the bailiff, then they will have the right in the mixture produced in the same proportion. What proportion? Same proportion. Next one, if it is without consent mixture and if it is possible to separate it, the bailiff should incur all the expenses of separation. If it is not possible to separate, in that situation, who should compensate? Bailiff. Are you guys getting it? If it is with consent mixture, both of them will have the same right in proportion of their share. If it is without consent mixture, possible to separate, then bailiff should separate it and should incur all the expenses and losses. And if it is not possible to separate, not possible to not, in that situation, what happens? Bailey should compensate to bailiff. Next one, he must not set up what title? Adverse title. What title? What's adverse title?
Like,
Means he cannot claim it as his own. Should not try to become the owner of the goods. Next one, return the goods. Return the what? Goods. Who must return the goods back? Without any demand from who? Bailiff. On the completion of bailment, who must return the goods back? Bailiff. To whom? If he doesn't return the goods back, and whatever happens after the expiry period of bailment, who is responsible? Even if he has taken what care? Reasonable. Clear with this? Last one. The accretion. What's accretion? Increase in the value of the goods or increase in the goods. Correct, right? For example, I gave a cow as a bailment. Cow gave birth to the what? Calf. Now, are you supposed to return the calf along with the cow? Yes or no? Because any accretion to the goods should return back to the home to the bailor. For example, I pledge my shares with you. To borrow loan from a bank, I pledge my shares. Is it a bailment? Pledge is also a what? A bailment. But the only purpose is for the security, as a security for the repayment of debt. Correct, right? Now, during this time, what happened? Company issued bonus shares. What shares? This bonus shares belongs to whom now? Bank or the bailiff? Should give them back.
Bank should be
So move to the bailiff on the repayment of debt. Are we clear with this, everybody? These are the rights of who? So the duties of who? The rights of who? Bailiff. Are we clear with this, everybody? What is the first duty? Second one?
Not turn over
One on the right way. Third one?
making
Thought about the fourth one? One of those things can learn not to mix them. So next one, fourth one, must not remember. Fifth one, return the goods. And sixth one, return the accretion. What is accretion? Increase in the value of the goods. Next one, very particularly based on the last questions in the examinations, I want everyone to concentrate. Important topic here. Based on this, they ask question in the examination. See, there are two types of lien. What Yes, how many types of liens are there? Two. What are the two types of lien? Particular lien and general lien. Isn't it? What is lien, first of all? A right to keep the goods of someone else is considered as what? Lien. It's a right to keep the goods of or possession of someone else is considered as what? Lien. Lien can be of how many types? Two types. Particular lien and general lien. Particular lien is available when a person has done some work or labor on the goods. General lien is available in special circumstances, not in all the cases. For example, if you give your watch for repair purpose and if you don't pay your repair charges, can you keep the goods until you pay repair charges? Yes or no? So, lien is a right to keep the possession of the goods for the amount due. What due? Amount due is considered as what? Lien. I repeat, lien is a right to keep possession of the goods of someone else until what is satisfied? Claim due is satisfied. What is satisfied? Claim due is satisfied. The amount due is satisfied. That's considered as what? Lien. That's considered as what? Lien. Yes or no? Okay. Right is a right to retain the goods which belongs to another person until his claim is satisfied or the debt due to him is paid. Is considered as what? Lien. Lien can be of how many types? Two types. What are the two types? What's particular lien, sir? The right to keep the goods on which the claim is due. What is due? It's considered as what? Particularly, where you have a right to keep the goods for the general balance of account. What balance of account? Not for the amount due on the goods. Even for some other dues also, if you have a right to keep this goods, it is considered as what? General. What? Let's say I give a watch for repair purpose. You do the repair to the watch. I also kept my bag. I come back and I say, no, watch office going. He says, give me the money. I say, I'll not pay. Can you keep the watch?
Yes.
Can you keep the bag? Can you keep the bag? No. Particularly means what? The lien which is available for the amount due on the goods. That is considered as what? Particular lien. What lien? General lien is available only to a banker, agent. Are you guys getting it? Only they have a what lien? General lien. What lien?
Sure, you will take what happens. You take.
Yeah, correct. If loan is due, but if you don't pay, until unless you pay, you can keep it. That is called as lien. A lien can be of how many types? If you can keep the goods for the amount due on the goods, it is considered as what? Particular lien. If you can keep the goods for any balance due, it is considered as what? General lien. What lien? You guys get clear with this, everybody? Bailey has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of contract to the contrary, a right to retain such goods until he receives a what? Due remuneration. Until what remuneration? Only when it is due, you can keep it. If it is not, you cannot keep it. He has rendered in respect of debt. Correct, right? Now, what if I have agreed to give 1 month credit? How many months credit?
1 month.
Work is done. Am I supposed to return the goods back to you? I will do the work today. I will do the work today, but you will get pay after 1 month. This is what we have agreed. Now work is done. Can I keep the goods unless until you make the payment here? No. Why? Because I have agreed to give it on what basis? Credit basis. Claim is not due now. It will be due after how many months? 1 month. The lien is available. What is the right to keep the possession of the goods?
All day.
For the claim due. What do you claim due? That is considered as what? Lien. Aresa, no. The right of a person to retain the goods which belongs to whom? Another person until the claim is satisfied. Not satisfied? Claim is satisfied. That is considered as lien. What is generally?
When
Retain the good not only for the demands arising out of the goods and also for the what balance of account? General balance of account. That is considered as what lien? General lien. General is available to bankers, factors, nothing but agents, fingers, policy brokers, and attorneys of law, advocates of law. Only these person has what lien? What lien? General lien. Are we clear with this, everybody? Next, duties of bailor. What are bailor? What are duties of bailor? First one, in case of what bail? What bailment? Gratuitous bailment. What bailment? The bailor should disclose all the known faults. What faults? In case of gratuitous bailment, he must disclose known faults. But in case of non-gratuitous bailment, he must disclose what? All the faults. Is he responsible or responsible? Even if he is not aware about it, is he responsible or not responsible? Responsible. The bailor is bound to disclose all the faults in the court's bail which he is aware of and which materially interfere with the what? Use of them or expose the bailee to the extraordinary risk. What risk? If he does not make such disclosure, he is responsible for what? Damage arising to the bailee directly from such fault. Understand? No. Are we clear with this, everybody? In case of non-gratuitous bailment, what bailment? If the goods are bailed for a hire, the bailiff is responsible for the damage, whether he was or not aware about the existence of such fault. For example, to take a bike on rent basis, if there is any failure in the bike and if he suffers a loss, who is responsible? Bailiff is responsible. Correct? Sir? Next one. Who should pay necessary expenses in case of gratuitous bailment? Where a bailment is done. What is done? For the benefit of the bailiff, and bailiff is to receive no remuneration for that. I repeat, where the payment is done for the benefit of the bailiff, and bailiff is to receive no remuneration for that. Who should bear all necessary expenses? Bailiff should only pay the all necessary as well as the extraordinary expenses to the bailiff. That's the one more duty. Defective title of bailiff. If because of defective title of the bailiff, if bailiff suffers a loss, who's liable to compensate? Bailiff. To bailiff. For example, let's say you took bike from me on a bailment. There is no valid RC book for the bike. There is no insurance policy on the bike. Because of that, police caught you and you are supposed to pay 1 lakh rupees, sorry, some amount of money as a fine. Can you recover it from the bailer?
Yes.
Yes or no? Yes or no?
Yes.
Because you suffered the loss. Because of whose fault? Bailer's fault. Whose fault? Bailer's fault. Or bailer's defective title. Are we clear with this? Next one. Termination of bailment. What are bailment? Last two topics of the contract of bailment. Concentrate everybody. Termination of bailment. When the bailment comes to an end. Bailment comes to an end. What is the first one? 3 months. 3 months over. Bailment comes to an end. Second one. I gave this tent house for a marriage purpose. Marriage got over. Return the goods back. Next one. Tell me which bailment can be cancelled by giving a notice. Gratuitous bailment. Non-gratuitous bailment cannot be terminated. Yes or no? Next one. Next one. Which bailment comes to an end by death? Gratuitous bailment. Discuss किया था ना हम लोग? Next one. Destruction of what matter? If the bailment court itself is destroyed, what comes to an end? Bailment comes to an end. These are the cases in which bailment comes to an end. There can be possibility of theory question out of this. Are you clear with this, everybody? Finder of lost goods. What are lost goods? Tell me if you find goods of somebody, you are considered as one bailey. Are you bound to return it back? Yes or no? Now tell me, if you incur some expenses voluntarily to protect the goods and to find the true owner, can you file a suit against the bailiff for recovery of those expenses? No, you cannot file a case. You have a right to keep the goods, but not a right to file a case against it. For any expenses voluntarily incurred by you, protect the goods or to find the true owner.
What if the goods are important?
You can keep it. You should pay the money. Now, there is a justice, right? See, you own the goods. You should try to find the true owner, return the goods back. If you incur any expenses voluntarily to protect the goods and you find the true owner, who can recover it? He can recover it, but not by filing a suit. The only right available to you is what? Right to exercise the lien. Right to exercise the what? Lien. You can keep the goods unless until what is done? Payment is done. What is done? If there is any reward announced, what announced? For the recovery of reward, you can file a case. But for any recovery of voluntarily, any recovery of expenses incurred voluntarily, can you file a case? Can you retain the goods? Can you retain the goods? Can you file a case? Can you file a case? Can you retain the goods? For recovery of reward?
Yes.
Can you retain the goods?
Yes.
Can you file a suit? They can ask question based on this. And one more. Can you sell the goods?
No.
Generally, you cannot sell the goods, but there are exceptions where the goods are of when the goods are generally of commercial goods, like which are bought and sold, and if the goods are of perishable nature, what nature? Are the lawful expenses incurred by the bailee to protect the goods amounts to how much? 2/3 of the value of goods. How much? 2/3. If it exceeds 2/3 of the value of the goods, in that situation, who can sell it? Bailee can sell it. Who can sell it? When dairy can sell it, it should be commerce generally bought and sold. Second thing is the perishable goods. Or the expenses incurred to protect the goods amounts to how much? 2/3 of the value of the goods. If the value of the goods is 1 lakh rupees, you already incurred more than 67,000 rupees of expenses. Can you sell it now?
Yes.
Yes or no? Yes. This is the only exceptional cases where you can sell the goods which you have found it. Are we clear with this, everybody? Next one. Carrier as a bailee. What is a bailee? Common carriers. Are they considered as bailee? Common carriers means whom? The one who carries the goods of other person. Are they considered as bailee? Yes. They're considered as what? Bailee. Considered as what? Correct, right? Because they're carrying the goods from one place to another place. And they will deliver the goods as per your instructions, right? It's a next one. Innkeepers. Who's innkeeper?
Because
Hotel. The liability of the hotel keeper is governed by section number 151 and 152 of the Indian Contract Act and is that of an ordinary bailee with regard to the what? Property of the guest. What of the guest? Are you below what of the guest?
Yes.
If they have taken reasonable care and if something happens, to the goods, they are not responsible. If they not taken any reasonable care, are they responsible? Responsible. Responsible. I keep my goods, valuable goods in the room. I lock the room and I give a key to the receptionist. Something like monkey came inside and it stole everything. Is the hotel responsible or not responsible? Responsible. Because they don't take what care? Reasonable care. What care? But what if I'm not delivered the key? The key is with me only. There is no payment only. Should payment should be what? Delivery. Total goods. Not, you must give. See, car parking. When I do wallet parking, it is considered as payment. If you don't do wallet parking, is it considered as payment? Why no? Because the possession is still with you only, right? Because you have the key of the car. So no. But tell me, is depositing cash to a bank, is it a payment?
Yes.
Is cash is a goods?
Yes.
Cash is not a goods. But first of all, in case of payment, goods must be returned back. Will return the goods in the same form, sorry, cash in the same form. It is not, it's not, it's in fungible form, right? Depositing cash is not a bailment. Keeping goods in a locker is not a bailment. What is not a bailment?
His
The key is with you.
position is not in.
Given to the bank. Key is still with you only. Are you clear with this? These are the concepts of what? Bailment. Concepts of what? Are you clear with bailment? Next one, pledge. What's pledge?
Right.
Pledge is a bailment. But the purpose is to secure the what? Repayment of debt. Repayment of what? What is pledge?
Security of the paying the
Pledge is a bailment. Pledge is a what? As a security for the repayment of debt and the performance of a promise. Performance of what? See, I'm giving these goods and the security for the repayment of debt and the performance of a promise. It is considered as what? Pledge. Is it a bailment? Why it is called as bailment? Because it's a delivery of what? Goods by one person to all pledges are bailment, but all bailments are not pledge. Which one is wider term? Which one is wider term? Bailment is a wider term. Bailment is a what term? Wider term. Are you clear with this, everybody? How many parties are there in case of pledge? Two parties, pledger and pledgee. Pledger and what? One who does the pledge is called as what? Pledger or pawnee. The one who what is done is called as what? Pawnee or the pledgee. Essentials of pledge. By essentials of pledge, what is the first one? Read everybody. Property should be delivered to pawnee. Delivery should be in the work as per the contract. Delivery should be for the purpose of security. And delivery should be upon the what? Condition to return it back. Condition to some job. Rights of the pawnee. Can pawnee return the goods pledge? Can Pawnee retain the goods pledge? He can retain the goods pledge not only for the amount, he can also retain it for what purpose? Amount due, interest as well as necessary expense. What expenses? And then below what expenses? But not for extraordinary expenses. I repeat, Pawnee can keep the possession of the goods for the payment of what? Debt as well as interest as well as the necessary expense. What expenses? Not for the what expenses? Extraordinary expenses. Next one, pawn is right where pawner makes default. What pawnee can do? Can he sell them? What banks does if a pawner defaults in the repayment of the debt? Do they sell them? By giving notice to who? Pawner. Pawnee is the one who gives the money. Who can sell it? By giving notice to who? If there's a default in the repayment of what? Debt. By whom? Order. Now, after giving notice, if you sell them at a lesser than the amount due to him, can you recover an interest order?
Yes.
Can you recover the loss from the pawnee? Now, if he makes any surplus, let's say value of the goods is 1 lakh, net amount is 50K, and is sold at 1 lakh. What is the extra amount he recovered?
50.
Is he bound to give it back to the pawnee?
Yes.
Yes or no?
Yes.
If you sell at excess price, recover it. Loss, you can recover it from who? Pawnee. Recover it from who? Are you clear with the rights of the pawnee? What is the first right? So what? Amount due, interest due, necessary expenses. Can you sell them
Yes.
on default by who? They give you notice to who? If you make loss, can you recover from the pawnee? If you make any surplus,
Return it.
right of pawnee. Next one, rights of pawnee. Rights of, can you redeem the goods back?
Yes.
When you paying the what? Money due. What due? Money due. Can he claim the damages if there is an exchange of goods by the pawnee? If the pawnee uses the goods pledged to him, or if it destroys the goods, who can release it? Regular compensation from for the foreigners. Are we clear with this, everybody? Now you guys tell me, generally who can pledge the goods? If I am the owner, who can pledge the goods? Owner can pledge the goods. Can a person who is not a owner pledge the goods? If I am the owner, only who can pledge it? Owner can pledge it. Can a non-owner pledge the goods? Possible or impossible? Not possible. But there are few exceptional cases where a non-owner can pledge the goods. Who can pledge the goods? Who can pledge the goods? To save the interest of innocent person, there are cases where a non-owner can pledge the goods. Let us discuss those cases. What is the first one? Mercantile agent. What agent? Who is mercantile agent? Business agent. Any agent who has the right to sell the goods or to pledge the goods or to consign the goods in the ordinary course of business is considered as what agent? Mercantile agent. What agent? A mercantile agent can pledge the goods to an innocent person. If he pledges the goods without having a right to an innocent person, is the pledge is already not valid. Valid. I repeat, a mercantile agent who is acting in the ordinary course of business without authority, if he pledges the goods to somebody who's acting in what faith? Good faith. Is the pledge valid or not valid? See, she is the mercantile agent. I'm asked not to pledge it, but she pledges it. So, the person is acting in what faith? Good faith. Is the pledge valid or not valid? Because she's a what agent? She did the pledge in the one course of business. I'm ready to start business. To a person acting in what faith? Good faith. They can ask this question as a theory question in the examination. What is the first exception where a non-owner can pledge the goods? What is the first one? Mercantile agent. Everybody, what agent? Next one, pledged by a seller or a buyer in possession after sale. Tell me, after the goods are sold, who is own? I have sold the goods to you, but I'm in possession only. Who is the owner? Seller or buyer? After selling, who is the owner? Not who has possession of the goods. Did I pledge this goods to a person starting in what way? Is the pledge one balance sheet? How many do you know that?
Yes. No, 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 no.
After selling, who is the owner? But who's pledging it?
Seller.
Person acting in what phase?
Good faith.
Is the pledge valid or valid? Valid. Second situation. Now let's say I gave the goods to you with a condition that ownership is transferred on payment of price. Payment is not done. Now who said what you who said it? Buyer. I gave the goods to you with a condition that ownership is transferred on the payment of what? Price. Payment is not done. Who has the goods? And he pledges the goods to a person acting in what faith? Good faith. Is the pledge valid or not valid? Who is the owner? Personality in what way? He's in or arguing about this earlier transaction. Is the pledge valid or not valid? Valid. One more exception. Third exception. Pledge will follow having a limited interest. What interest? Like what interest? Now tell me, listen everybody, I gave a goods worth of 5 lakh rupees to you for a loan of 1 lakh. Loan of how much? 1 lakh. To what extent you have the right over this goods? 1 lakh. 1 lakh. Can you re-pledge it to somebody else? For 1 lakh rupees loan?
No, you can't.
Why?
Because
See, I pledge it to you. For a worth of how much? You have an interest over this bottom for how much? Extent can you pledge it? For 1 lakh. Can you pledge it for what for 1 lakh? That is what one more situation. Who is the buyer? I am the owner. Now he is pledging it, so other person is pledging it. To the extent of his limited interest. Is the owner not valid? Valid. Otherwise, clear with this? One more exception. Which may a co-owner. What owner? If we are co-owners, when we are in possession of the goods, I will pledge it without her consent. Is the pledge valid? Valid. And the last one, pledged by a person in possession under a voidable contract. What contract? What's voidable contract? It's a contract which is enforceable at the option of which party? One party. But not a option of other party. Yes or no? I have taken her consent by force. Is the consent free or not free? Contract is irrevocable. If she has the right to cancel it, before she cancel it, I pledge the goods to a person taking one pay, bill friendly. So she gets the one possession. And she is a pledge only not valid. Valid. Because it was pledged by a person who was having the possession of the goods, acting under a what contract? Voidable contract. What contract? Yes or no? Are they clear with this? These are the exceptional cases where who can pledge it? Non-owner can pledge it. Who can pledge it? Non-owners can pledge it. They can ask this question in the examination. They can ask you to write the exceptional cases where who can pledge it? Non-owner can pledge it. This is the concept of pledge. And the last concept we have is the contract of agency. Correct, right? Chances are more that they will ask question based on this in the examination. Contract of agency. Contract of what? Agency. Listen, everybody. Shall we start contract of agency? Everybody, who would like to know what is agency? What is agency? Who is an agent? A person employed to do an act on behalf of the other, or to represent another in a dealing with which party? Third party. CS representing his client before the NCLT is an agent of his client. So, a person employed to do an act for another or to represent another in a dealing with third party is considered as what? Agent. Considered as what? Creation of agency. Agency is created by what? Delegating authority. Delegating what? Where one person delegate the authority to which person? Another person. That is considered as what? Agency. Considered as what? Agency can be expressed. It can also be what? Implied. That can be what? Expressed or implied. When it is given by words, it is called as what? Expressed. Other than words, generally, a person is appointed by executing power of attorney. What's the document called as? A person is appointed as an agent by executing a document called as what? Power of attorney. There are two types of power of attorney: specific power of attorney, general power of attorney. To do a single act, specific power of, a special power of attorney. To do multiple act, general power of attorney. Specific act, single, special power of attorney. Multiple activities, general power of attorney. What power of attorney? General power of attorney. Clear with this? Next one. Implied agency includes what? Agency by estoppel. Agency by what? What's estoppel? I allow somebody to represent herself as my agent. Or I represent her as an agent to third party who is innocent. And if he incurs any liability based on that, can I deny it later? No. She becomes an agent by estoppel. She is telling in the presence of me that she is my agent. I remain silent. She believes upon it and she does something. Will she become my agent? Agency by what? Stop from denying. Because I only allowed her to represent herself as my agent. Agency by stop. Next one. Wife as a what? Who is the agent of whom? Wife is the agent of husband. And what items? Necessary item. What item? If the husband has not supplied necessary items to the wife, wife can pledge whose credit? Husband credit. And she acts as an agent. And for whatever the goods she buys, who is responsible? Husband is responsible. Who is responsible? But husband is not liable if he has warned the tradesman not to supply the goods, or if he has forbidden the wife to not to pledge his credit, or wife has already sufficient supply of one items, necessary item, or she was supplied with one allowance, sufficient allowance. In this case, who is not responsible? Husband is not responsible. Next one is important. Agency by necessity. Agency by what? What necessity? Emergency. Where a person act as an agent of other person in case of emergency to save the other persons from the loss as a man of what prudence? Ordinary prudence would do in his own cases under similar circumstances. What circumstances? Similar circumstances. Then it is considered as what? Agency by necessity. Agency by what? Are we clear with this? Agency by necessity? See, simple. You're not my agent. Just to save me from the loss, as a man of ordinary prudence would do in his own case. If you do something, you'll be considered as what? Agency by necessity. Agency by what? There's a concept called as partner in case, authority in case of emergency. In emergency, you can do all such activity as a man of ordinary prudence would do in his own case. Under what circumstances? Similar circumstances. Yes or no? That is called as agency by what? Necessity. Agency by what? Clear with this, everybody? Next one, agency by ratification. What is ratification? This is also called as ex post facto agency. Bro. मतलब क्या होता है जनरली आई अपॉइंटेड यू डू समथिंग बट देयर आर केसेस वेयर यू डू समथिंग विद माय परमिशन देन आई विल अपॉइंट my agent. That is considered as an ex post facto agency where a person does something on behalf of other person without authority or going beyond authority. The principal may elect to ratify it or disown it. If he ratifies it, he becomes his agent. If he disowns it, then he is not responsible. Who is not responsible? Principal is not responsible. Are you guys clear with this? It's called as what? Agency by? It is also called as what? Ex post facto agency. Bravo. Arezzo, where an agent, where acts are done by one person on behalf of another person, but without his knowledge or authority, he may elect to ratify or disown. If he ratifies, he becomes agent. If he disowns, he does not become the agent. Or else, no. Conditions for ratification. They may ask this question in the examination. Agency by ratification, market importance. There can be a question in the upcoming examination, pages 20, about the contract of agency. Ratification is effective only if the following conditions are satisfied. What is the first one? The agent must expressly contract as an agent for the principal who is in existence and what if I do something on behalf of a minor? Can minor ratify me as his agent? Once he becomes an agent?
You cannot enter into a contract.
Yeah, he cannot ratify. That is why ratification is possible only when you do something for a person who is in existence, competent contract. Second one, the principal must be competent to contract. Not only at the time of entering into a contract, but also at the time of what? Ratification. Third one, principal at the time of ratification has a full knowledge. What knowledge? Full knowledge. From the material facts. Who should disclose it? Who should disclose it? Rajwal has done something. Any Prajwal. Prajwal has done something without my permission. Can I ratify it? Can I ratify it? Has he done something?
Yes.
The person who was in existence when the act was done, is that person for whom he has done the act competent to contract?
Yes.
Am I competent to contract? And you should disclose what fact? All the material facts about the transaction. What if you hide some information and take my consent to ratification? Is the ratification valid? Ratification is not valid. Ratification must cannot be made so as to subject a third party to the damages or terminate any right or interest of which person? Third person. The ratification should not injure whose rights? Third party rights. Whose rights? Third party rights. Only one can be ratified.
Lawful acts.
Only what can be ratified? Lawful acts can be ratified. Unlawful acts cannot be ratified, cannot be ratified, cannot be ratified. Are we clear with this? Mark this concept as important agency by ratification. There are chances that they will ask question based on this in the examination. Types of agent. What are types of agent? What is the first one?
Special.
What special agent? An agent appointed to a particular act is considered as what? Special agent. He is appointed by a document called as special power of attorney. Power of attorney, special power of attorney. Second one is what? An agent, a general agent is appointed to do anything within the authority given to him by the principal in all transaction with respect to the what? Specified trade or matter. A third party may assume that such an agent has the power to do all the that is usual for the general agent to do in the business involved. Correct, right? No. What is sub-agent?
When the
Agent appointed by the agent is called as what? Sub-agent. Generally, an agent cannot appoint sub-agent because it is based on the principle a delegate cannot further delegate. But with the permission of principal, who can appoint agent? Agent. Now the agent appointed by the agent is called as what agent? Is he the agent of principal or agent of agent? Sub-agent is responsible to agent or principal? Agent, not the principal. He can claim remuneration from who? Principal or agent? Agent.
So here the sub-agent is doing the work as per the agent, right?
Correct.
Is it like separate from what the principal is telling the agent? Or is it
Same.
the same line of
I have given the work to you and you are giving that work to her.
okay.
You are my agent, she is your agent. Now I am not responsible for whatever she does. For me, who is responsible? You are only responsible. But what if I have authorized you to appoint her as an agent? Then I will be responsible to third party. She is responsible to you, but you are responsible to me. Then that is called a what agent? Sub-agent. And what agent? A person who is appointed by an agent and to whom the principal work is delegated, known as what agent? Sub-agent. Yes or no? A sub-agent is bound by all the duties of which agent? Original agent. Sub-agent is not directly responsible to the principal except for the what? Fraud or willful wrong. Fraud or what? Willful wrong. Next one, mercantile agent. What agent? Market important theory question. They can ask types of mercantile agents. Who is mercantile agent? Second one, business agent. What agents? Who is the first one? Factors. Who is the first one? He is the agent employed to sell the goods which have been placed in his possession. He will be handling the possession of the goods and he will sell them on behalf of the principal. Then he is called as what agent? Factors. Consider as what? He is the apparent owner of the goods in his custody and can sell them in his own name and receive the payment for the goods. These car dealers are considered as what agent? Factors. Because they sell the goods, cars on behalf of the manufacturers, right? Will they have possession of the car? Yes, they're considered as a factor. Next one is what? Our share market brokers are considered as agent. Yes or no? Will they receive any commission for the activities?
Yes.
That is called as commission. Next one, debt credit agent. What is it? Who is debt credit agent? He is a mercantile agent who is in consideration for extra remuneration, guarantees to his principal that purchasers who buy credit will pay for the goods they take. Because if they don't pay, who should pay? Agent should pay. You are selling my goods on a credit basis to third parties, customers. And you are making a promise to me saying that if I pay you extra commission, you will make sure that you recover the entire money and you pay it to me.
Okay.
That is why you are called as what agent? And radar agent, who for extra remuneration or extra commission assumes the liability of recovery of money. Is considered as what agent? Radar agent. What agent? Next we have what? Auctioneers. Who is auctioneers? I want to conduct the auction is called as what? Auctioneer. He sells the goods on behalf of the owner. Behalf of owner. Next we have partners. His partner is an agent of other partner.
Yes.
Last one, bankers. Other bankers are our agent. They receive money on behalf of us. At that time, they are considered as what? Agent. Are we clear with this, everybody? Next, we have duties of agent. What are agent? Who should work within its scope? Can you go beyond its scope? Second one. If there is no instruction, you should follow what? Customs prevailing in a particular business. First, you should follow instructions about principle. You know specific instructions about what? Customs. What is customs? Practices. How it is usually done. Third one, should have what skill and diligence? What skill and diligence? Reasonable skill and diligence. If you don't have the reasonable skill and diligence, who is responsible? Agent. Principal. Disclose what information? Information disclose is principal. Next one, you should not disclose what information? Which part is third party. Should not enter into what situation? Conflict of duty. Seventh one, keep what accounts? And what account? Should not make what profit? Out of what? The transaction of the principal. If he makes secret, should give it back to who? Principal. Losses? Principal is not liable. If you make profit, you should give it back to who? Principal. But if you make any losses, who's not responsible? Principal is not responsible. Can an agent appoint sub-agent?
Yes.
Generally, no. Because it is based upon the principle called as a delegatee cannot further delegate us. Delegate us non-protest delegate. A delegate cannot further delegate. Are there any exceptional cases?
Yes.
Yes or no? What are the first exception cases? Where the delegation is allowed by the principal, where a trade custom or usage sanctions the delegation, where delegation is essential for the what? Proper performance, where an emergency renders it imperative, where nature of the work is purely what? Ministerial. What's ministerial? Clerical in nature. What in nature? Anybody can do that. There is no personal skill involved. That can, in that situation, can appoint one agent, sub agent, or where the principal knows that agent intends to delegate and it does not deny it. In this situation, who can appoint sub agent? Agent. They can ask this question in the examination. Who is sub agent and when agent can appoint the sub agent? Market important, everybody. Market important, everybody. Are you clear with the duties of agent? Next one, rights of agent. Can agent receive remuneration? Yes or no? So agents have lien.
Yes.
Just now we discussed the factor. They have what lien? Particularly or general lien? General lien. Means unless until the principal makes payment of your remuneration, can you keep whatever you have which belongs to the principal?
Yes.
You can keep the books of accounts, you can keep the goods, you can keep everything, whatever you have. That's why it is called as what lien? General lien. Next one, right to be indemnified. Right to be what? Because of principal, if agent suffers any loss, he can recover it from whom? Recover it from whom? Principal. Next one, extent of agent authority. What authority? Agent can do all such activities which are required to carry out the work assigned to him. But in case of emergency, in case of what? He can go beyond his authority with the intent to save whom? Principal. From the what? Loss. As a man of what prudence? Ordinary prudence. To in his what case? Own case. What case? Own case. Column 2. Responsibility of principal to which parties? What parties? Third parties. And which parties? Tell me. Listen, everybody. Listen, 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 listen. This concept is important. If you understand this concept, that means you understood the entire concept of agency. Listen, everybody. Listen, listen, listen. Tell me. I'll explain with an example. Listen. I am the principal. She is the agent. She is a third party. Okay. She, without disclosing my name, without disclosing whose name, and without even mentioning that she's somebody's agent, enters into a contract with her. She believes that she's entering into a contract with Priya itself. But actually, in reality, Priya is selling goods, CSRs. Now tell me, in this scenario, can principal demand the performance from third party?
No, from the agent.
Can I demand performance from her? Can I recover money from her? Why no? Because she did not have intention to enter into contract with whom? Principal. Here the principal name was never disclosed. Yes or no? That is why law says if principal wants to recover performance from the third party, he should allow whatever the right the third party had against whom? Against the agent. Let's say Priya was liable to pay 1 lakh rupees to him. Because she is liable to pay 1 lakh rupees to her, she made a plan saying that I will buy 1 lakh rupees goods worth or 1 lakh 50 rupees worth of goods from Priya and I will set off how much? 1 lakh and the remaining how much? 50,000 rupees. With that intent, she made a contract with whom? Priya. But in reality, what Priya is doing, she is selling goods of whom? CSR. Did she disclose that fact that she is agent of CSR? What is the belief she has? She has a belief that she's entering into contract with whom? Priya. In this scenario, if the principal wants to demand the performance from whom? Third party. Which party? He can do so. Subject to whatever the right who had, third party had against who? Priya. Means I should allow her to set off how much? 1 lakh. Are you guys clear with this? Now, what if in the same example, Priya did not disclose my name, but she has disclosed the fact that she is somebody's agent. Now she knows that she's not entering into contract with whom? Priya. Because she knows that she's what?
An agent was
Agent of somebody. Only name is not disclosed. In this situation, can the principal demand the performance from third party? Yes. And that time you don't have any rights. Yes or no? These are the concept here. What is the first one? Disclose principle. What principle? If the principle is disclosed, the contract actually happened between who? Principal and which party? Third party. Third party can sue principal. Principal can sue. Third party cannot sue agent. Because there is a privity of contract between the agent and the third party. Next comes undisclosed principle. Below what principle? Where the agent discloses that he is merely an agent, but conceals the identity of the principal, he is not personally liable. Who is not personally liable? Who is not personally liable? Agent. As he drops out in the normal way, the principal on being discovered will be responsible for the contract made by the agent. This is in case of undisclosed principle. What principle? Last one, concealed principle. There are three situations, guys. First situation, Priya says she's the agent of whom? CSR. Makes contact with whom? With her. Now for her, who is responsible? Principal responsible. Second situation, undisclosed principal. What principal? Means what? She is disclosing that she is agent of somebody. Only the principal's identity is not disclosed. In this case, still who is responsible? Principal only responsible. Because she knows that she's not entering into contract with Priya because she's an agent of somebody. But last one, concealed principal. What principal? Name of the principal, not only the name. Principal himself is concealed. Third party is not aware about the fact that Priya is somebody's agent. In this situation, who is personally liable? Agent personally liable. And if the principal want to require the performance from the third party, he can also only subject to the right whatever who had third party had against the previous. That is agent. That is in case of what? Concealed principle. What principle? Arey, sir, no. Can you guys read the concealed principle concept? You'll understand now. Just read it once. If I conclude the contract, if I disclose the identity, and if she want to cancel, can she cancel it? Yes or no? Because she did not have intention to enter into contract with me. She had intention to enter into contract with Priya. Are we clear with this? What are three situations? Disclosed agent, undisclosed agent, concealed principal. One principal liable for whose tort? Agent's tort. Whose tort? If an agent does any tort, what is tort? Vicarious liability. Remember vicarious liability for the wrongs of agent. Sorry, nah. At the same time, if an agent, while carrying the business of the principal within his authority, commits any tort, for such tort, who is responsible? Principal is responsible. Everybody who is responsible. Are we clear with this, everybody? Next one. This question they asked in the previous examination. Underline important. Personal liability of agent to third party. आप लोग बोलो. You guys tell me. Need ಹೇಳಿನಂತೆ. If agent does something on behalf of principal, who is responsible to the third party? Agent or principal? You are my agent. You do something on behalf of me. You borrow loan on behalf of me. For the repayment of debt, who is responsible? Principal or agent? But there are exceptional cases where agent personally have responsible. What are they? First one is what? The situation. Second one. Why will I go to abroad to bring the principals? I will make you only responsible. Second situation. Third one. If you don't make that, you send it as an agent. If you send it on your own, then you are only responsible. Third situation. Fourth situation.
When an agent class issue facing the first
Example, if you're acting for a minor, I cannot sue minor, right? Then who is responsible? Agent only responsible. Next one. Means if you go beyond authority, whatever happens beyond authority, who's only responsible? Agent only responsible. Last one. What is agent agency coupled with interest means you work for your own benefit as well. Generally, agent work for whose benefit? When you work for your own benefit as well, to that extent, who's responsible? Agent responsible. Last one. Principal is liable, he is also liable. These are both are liable. So the cases in which who becomes liable? Agent becomes liable. Based on this, they asked questions in the previous examinations. The cases in which agent is personally liable. Who is liable? Personally liable. Next one, agency coupled with interest. What's agency coupled with interest? Where the agent act for the benefit of the principal as well as for his own interest. It is considered as what? Agency coupled with interest. Now, for example, let's say I am liable to pay 1 lakh rupees to you, and she is liable to pay 1 lakh rupees to me. I say I will appoint you as my agent. You go and recover how much? And keep it for yourself. This is considered as what? Agency coupled with interest. Called as what? Called as what? Agency coupled with interest. Where the agent work for his own benefit along with the benefit of the principal, it is considered as what? Agency coupled with interest. An agency coupled with interest cannot be cancelled. Unlike there is a contrary agreement, an agency coupled with interest. Is it revocable or irrevocable? Irrevocable. Revocable or irrevocable? Irrevocable. Are we agreeing with this, everybody? Yes or no? So, an agency coupled with interest cannot be terminated in the absence of contract to the contrary to the prejudice of what? Such interest. Such what? That's what considered as the agency coupled interest. Coupled with what? Interest. Next one, termination of agency. What's termination of agency?
cancel
When the agency comes to an end. Can you guys know what's the first one? I asked you to do something, you have done it. Comes to an end. Next one. Between principal and the agent. Next one. I appointed as agent for 2 years. 2 years over, agency comes to an end. Next one. Agency comes to an end. Next one. Board of directors. You are my company board of directors. When company is not there, how where is the question of you being director of a company? I appointed you to sell my house. House itself is destroyed. What you will sell? Renunciation. Not remuneration. Renunciation. Renunciation. Give up. Give up. When you give up your right of agency, what comes to an end? Agency comes to an end. Transferring your right to someone else, right to ship of shares. Next one. Revocation. Next one is what? Revocation. Correct. Renunciation. We have the concept of renunciation. In case of right issue, it always carries a right of renunciation. But private placement cannot. There cannot be a renunciation. Next one. Revocation. What is revocation? Cancellation. I can take it back. Pretty simple. I appointed you as my agent, I can cancel it. These are the cases in which what comes to an end? Agency comes to an end. Is agency coupled with interest revocable or irrevocable? Irrevocable. Where the principal, where the agent has incurred any personal liability. What liability? Agency becomes irrevocable. And the last one, when the authority has been partly exercised. What exercise? Can you cancel the agency? No. They can ask question based on this as well. When termination take effect? What effect? Takes effect. Okay, when the termination take effect? See, listen. Principal want to cancel agency. Want to cancel agency? I send letter. Before agent receives letter, he has done something. For that act, am I responsible? Not responsible. Who is responsible? Principal. Because a termination of agency takes place only when it comes to whose knowledge? Agent's knowledge. Now, what is the informed agent? Well, before the information goes to the third party, agent told us,
Oh,
am I responsible to third party?
Yes.
The answer is yes. Because he's innocent, right?
Yes.
But I can recover it from who? Agent. So revocation takes effect towards agent when it comes to whose knowledge? Agent knowledge. Revocation takes effect towards third party when it comes to whose knowledge? Third party's knowledge. And whose knowledge? Understood, everybody? These are the concept with respect to termination of agencies.
then what it's turning, but after told rules are ratified.
Yes, you can ratify. Principal can ratify. Principal can ratify anything and everything. But the only thing should be lawful thing, should be lawful activity. Second one, he should disclose. The agent must disclose all the information to the principal. Okay. Joint venture agreement. What agreement? Joint venture agreement. Now, terms again. Following factors must be kept in mind while doing the what agreement? Joint agreement. What agreement? I want everyone to read the point by point. 3 points. What is the capability of both the parties should be clearly indicated in the joint venture. For example, Tata, Docomo. Then we have many other joint ventures, right? Maruti, Suzuki. Continue. Next one. Next one. Next one. Provisions for making available the engineers, skilled workers with the collaborative on the payment of expenses with respect to the state fund are to be given. Details regarding the specification and quality of the product to be manufactured also to be given. Next one. Responsibility of collaborator in establishing or maintaining the assembly plan should be clearly determined and provided for. If subcontracting of the work is involved, clarify if there will be any restriction. The rate of the use of information, all this must be disclosed. Chances are less that you'll have a question. If they have a question, that you can few points about it. C contract, contracts which are made from electronic communication, media are considered as what contract? E contract. What contract? Are we clear with the e contracts, everybody? Yes or no? When you buy goods in the Amazon, it is what contract? E contract. When you send mail, e contract. We discussed this now in case of arbitration agreement. Even exchange of emails is considered as what? Agreement. Considered as what? Agreement. Are we clear with this? Necessary ingredients for e contract? Offer needs to be made, offer needs to be acknowledged, there should be lawful consideration, intention to create lawful relationship, parties must be competent in the contract, free and genuine consent, object of the contract must be lawful. Types of e-contract. The moment you think about it, wrapper, it means you entered into a contract with them. Second one, creation of email ID or opening a agreeing to terms and conditions. Next one, when you say I agree to browse, you agree you are bound by the terms and conditions of the website. Next one, by scrolling down, it enters into an agreement. Last one, by signing into the particular website. Clear? And these are the provisions of our Indian Contract Act 1872. Now listen, everybody.
If you write sign, your right sign, analysis,
How much they were liable to pay? Means they were liable to pay 200, 200, 200. Out of that, Z paid amount. Can Z be compelled to pay entire amount?
Yes.
If he pay entire amount, can you request from other person? How much he can recover? 200 and 200. But out of that, one of the person is insolvent. And he can only pay how much? One half. Which only how much he can pay? 100. How much he cannot pay? What is the loss here? Shared by what? Remaining. In what ratio? Equal ratio. Now how much X should pay? 250. And how much Y should, sorry, X was declared insolvent now. So Y and Z should pay how much now? 250 and 250. Now tell me Z can recover how much from Mr. Y? 250. Teresa, no. Because you already paid how much? 600. He will take 250 from Y. He will pay 250 plus how much X will pay? 100. It becomes how much? 600. We discussed this joint promises. Teresa, no. Yes. Next one. Question number 3. Can it be recovered? Cannot be recovered. Has he paid his consideration? Can it be recovered? Cannot be recovered. Cannot be recovered. First you pay the premium. Next one. Is it valid or not valid? What? Are there any exception? Sale of goodwill, partnership agreement, service agreement. Correct, right? Next one. This question was asked in June 25. Can you recover the compensation? Can you recover the compensation for the loss suffered? Yes, you can recover the compensation for the loss suffered. Damages provision you should write. Can you write this? Can you read this question, please? Is this over any thing? Let's continue. Uh, Same thing, na? Yes or no? Was the war temporary purpose or was there any time specified over there for performance of the contract? So it is possible to perform. See, if time was specified and in that time what happens, contract becomes void. If time was not specified, and if war is only for what period? Temporary period. Is the contract still valid? Yes. Is it bound to perform? Yes, bound to perform. हमने discuss किया था ना temporary disabilities or considers what impossibility? Supervening impossibility. Question number 2. Question number 3. Question 24. This question was asked in June 24 examination. So please, if you guys solve this question well and goes, there are chances of repetition of questions in the examinations. Which one? Breach of contract. Breach of what? Contract. Solve question number 1. Can you sue the B under the Indian Contract Act? Why no? A tended to supply goods up to how much? For a period of 1 year. B ordered the goods up to only how much? A want to sue the B for the breach of contract. Can he file a case? No. What was ordered for him? 30,000. Question number two. How much he promised to pay? How much he was liable to pay? Is it reasonable, sir, or unreasonable, sir? What is the loss he will suffer if you don't pay the money? 5,000. But how much he agreed to pay? Is it reasonable estimate of loss or unreasonable amount? Is it a penalty or liquidated damages? If they have fixed reasonable sum or unreasonable sum as a compensation for the breach of contract, is it a penalty or any penalty? Is it recoverable? Recoverable. Irrecoverable. Court will give only how much? 5,000 rupees. Yes or no? Next one. Discharge of contract distinct between novation and alteration. What is novation? Substitution of our contract, new contract. Which contract? Old contract. Alteration means change the terms of the contract. Distinguish between quantum merit and anticipatory breach. What is quantum merit? As much as merited or earned. If you have done some work but not completely done, the work you have done, you can recover the money. It's called as quantum merit. If what is FOB contract? These are not that they are removed from your topic. What is FOB? Clear book. What is CAF? Cost, insurance, and fine. Distinguish between void and illegal agreements. Which one is punishable? In which case, even collateral agreements are tainted with illegality. Guarantee, can you guys solve these questions? Fast. Should solve it fast, guys. Is surety discharged here? Because it's variation of the what? Terms of the contract. Without which consent, surety is concerned. Discuss किया था. Question number 2. If it is specific guarantee, continuing guarantee. Can it be approved? When you notice or by 10,000, surety. Next one. Bailment. Who should pay compensation? No. Take reasonable step to find the true owner. Can he keep the goods till he receives necessary expenses? Can he sell them? Only when two-thirds are perishable goods. Lien. This question was asked in December 25, 5 marks. What Manish can do? Can he keep the goods? What is the difference between particular lien and general lien? If you have the right to keep the possession of the goods and for the general balance of account, in case of specific lien, you can keep the goods only on which what is done? Skill or labor is employed. It's considered as what lien? Specific lien. Agency, can you guys read Rishi case law, please? insurance agents have a right to collect the premium? Yes. No. They sell only insurance policy. That's it.
Premium free.
You should pay directly to the insurance company. And if you pay the money to that insurance agent, is the principal responsible or responsible? Not responsible. Because it is beyond the authority of an agent. The insurance company responsible or responsible? Not responsible. Next one. Once make up the cash, pay the cash. But creditor did not do it. Is the surety responsible or not responsible? Not responsible. Because of creditor's act, who will discharge here? Debtor. Then who's also discharged? Surety is also discharged. Next one. What type of agency it is? You sell the goods. See, I'm liable to you pay money to me. Then you sell the goods and you recover the whatever the money you have paid it to me. Is it agency coupled with interest? I told you guys, right? What is agency coupled with interest when the agent act for himself as well as for the benefit of whom? Principal. That is considered as what? Agency coupled with interest. Now you are selling the goods on behalf of me and also for your benefit. That is considered as what? Agency coupled with interest. Can it be cancelled?
Yes, we do.
Can agency be cancelled? Agency can be cancelled, but not agency coupled with what? Interest. Can it be cancelled? Cannot be cancelled. Cannot be cancelled. Just discussed I told you guys important also. Agency coupled with what? Interest. Case study question. They asked this question in December 25 for 10 marks. And there is June 25 for 10 marks. And there is also December 24 for 5 marks. So not 5 marks, 10 marks. Means one question for 10 marks for sure will come out of concept practical questions. Because in the last 3-4 attempts, from the date they have introduced the new syllabus, they're asking questions based on this in the case study questions for 10 marks. Then, can you guys see this question and answer the question? Read everybody, read. Section 10 of the Indian Constitution. But come to the question and solve the questions. With the question number 1. Will he succeed or he will succeed? Why will not succeed? Why there was no agreement? Who made an offer here? At what price? What rejects you? The offer to buy at what price? Is the counter offer? Counter offer, which offer will lapse? There is the question of contract itself. And this one to someone else. So can he claim compensation? No. Should write about counter offer. Number? Question number 2. Acceptance must be communicated. Acceptance must be absolute and unqualified. Should be given as prescribed more. One more? Before the lapse of offer. We discussed the rules of acceptance. Next one. Can offer be removed? Lapse of offer. When the offer comes to an end. When it comes to an end. By notice of revocation. When not accepting the condition specified by counter. And also by not fulfilling the condition precedent. In all these cases, what comes to an end? Offer comes to an end. Next one, last question. Was he available to the offer when he found the money? Then he cannot recover it. So now what we can do is, because there is already a question based on offer and acceptance, we can focus more on the consideration part onwards. I'm not saying you should do this. That is your work. I'm not a person suggest guesswork. If you want to, you can do the same thing based on this. And there is one more question. Based on this, there is a December also they ask, oh, sorry, last question in the what? June exam. What exam? In the June exam, they ask questions based on special contract. And special contract. You read the question. Read the question number first one. What is the liability of the guarantor? Primary or secondary? Secondary. Is it coextensive with the of principal? Data. Principal one. Data. Next one. Rights of pawning, furniture and pawning. Can you sell the pledged goods and recover the money?
By notice.
After giving a notice. On resale, if you suffer the loss, you can recover it from whom? Honor. If you make any profit, suppose you give it back to the what? Just read the question and understand the question. Read the question, everybody. One small question is read.
Yeah, on my electronic what specializes like I have a it might be actually images start planning seven events. But I actually I'm already I go ahead because I did steps to be like the board that's played for 100. We got for some years under the and the HPA when I get it.
But now we have sale on good side, so you are supposed to sell the sale on good side. Under what circumstances an agent can be held personally liable? Under what circumstances an agent can be held personally liable? When he agrees to be personally liable, but the principal is in abroad,
When the agent
exceeds the authority, signs the check in his own name, so specify that he's acting on the agent. We discussed this all these things, right? And there is one more question.
Wow.
Based on consideration, there are this question in the December 24. Can you guys, you want to read out? Read this once. Last question. So they see, get an idea. Read it. It's last.
Extending the name.
So you guys,
So but this is like only the part एक the law
hmm,
yeah I
read it.
consideration is one of the essential ingredients of the contract whether it's on policy and it's a process. If it's not to get the fine.
It's not for influence size increase or nothing we prepare. If that's not a competition, of course, by employment. There's not something in the consideration.
Once, this. Okay, read the question number one.
It's so hard. Just like all of this. You know that easy to no, it's a
So can Mira, is the contention of Mira correct? Is there any consideration for Mira? Is there any consideration for Mira? Who gave consideration to Mira?
wrong.
On behalf of whom? Raj, is the consideration valid? Consideration will move forward. Promisee or any other person. Chinnaya versus Ramaya case law. Can a third party provide consideration? Yes, third party gave consideration here. Correct, right? Next one, question number 2.
The selection of Indian contract against certain exceptions that makes the problem consideration valid.
Exception. Natural love and affection. Promise to pay for. No. Promise to pay for past. That is in case of privity of contract. Promise to pay for warranty services. Completed gift. Time bound debt. Then agency. Then guarantee. And to promise to give donations. If the promise he has done something based on whose promise? Promise has promised. Question number 3.
It's like 10,000 to another actually
Yes, yes,
And they can. I give this example being preached. Question number 4.
these are different affection.
it's like
Entity of contract. We discussed same example I have discussed. And the last one, there are normal types of consideration 3. England only 2. Past consideration is not valid in England. Correct, right? 10 marks. And see the covered this in detail. You do one more time of revision, like you solve the questions of question bank, and you guys are ready for the examination. Done. With these, we are done with the contract act. Clear with this? Next, we'll start with the lesson 7. Law with respect to crime and procedure. This one covers BNS as well as BNSS. What is BNS? Bharatiya Nyaya Sanhita. What is BNSS? Bharatiya Nagarik Suraksha Sanhita. First concept, the difference between criminal offense and civil wrong. Nature, which one is offense against the society? Criminal wrong. Which one is offense against individual? Reason, it's a serious crime threaten the public order and social security, whereas civil wrong affects a private right, correct, right? Individual's right. That is why it is not so serious in nature. Parties, in case of criminal wrong, the parties involved are considered as what? Accused versus, sorry, state versus accused. In case of civil wrong, plaintiff versus defendant, aggrieved person versus the wrongdoer. Person committing the wrong is called as offender or a criminal. In case of this, he is called as the tortfeasor. Tort, right, right? Governing law, criminal wrongs are governed by which law? Criminal law. Whereas civil wrongs are governed by which laws? Civil law. Objective, uh, the objective of criminal laws is to punish a person. The objective of civil law is to give compensate the person who has suffered the loss. Standard of proof means evidence required. In case of criminal wrong, as it involves a punishment to a person, the state should prove the guilt of a person beyond reasonable doubt. Beyond what doubt? Even if the uh,
accused can create slightest of the slight doubt in the minds of the judge. The judge cannot convict him. There is a requirement of evidences beyond reasonable doubt. But in case of civil cases, it's always probability. The one who can provide higher accuracy of evidences will win the case. It's like more than 50%. So if a person can show that the case is in favor of him more than the other person proves it, then he can win the case. Correct, right? So in case of civil cases, it is always what? Preponderance of probabilities. If you have a probable case in your favor, then the court will decide in your favor. There is no requirement of providing the evidence beyond what doubt? Reasonable doubt. In case of what cases? Civil cases. Which one is compoundable? Civil cases compoundable, criminal cases non-compoundable. Punishment, there is a imprisonment, fine, or both. In case of civil cases, damages, compensation, injunction, and specific performance. Difference between BNS and BNSS. You guys should tell me what is the difference between BSS, BNSS. Everyone look here, concentrate, participate, answer so that learn. You are revising it in the class itself. Getting it? Listen everybody. Nature. Which one is substantive law? Which one is procedural law? Very good. This should be the ideal class, correct? Right? Everybody should answer. Everybody should participate because you guys are writing examination in the what? June. Clear it off, guys. Just clear it off. Go to the next level. Queue up this indagi. Don't be stuck at one station or one level. Yes or no? Give your 100%. See, don't worry about external factors. Don't worry about what is not in your hand. Just keep doing what is within your reach. What you can do, you can give your best efforts for the next 20 days, forgetting about rest of the things. And good things always happens eventually. Getting it? So give your 100%. 20 days. Work hard. I believe you guys can do it. Yes or no? Let's do it. Let's go. Purpose. Which one defines the offense? Which one provides the procedures to be followed to punish a person? Which one deals with the crimes and punishment? Which one deals with the arrest, investigation, trial, bail, evidence, procedures? BNSS. Rights and liabilities. Which one creates rights and liabilities? Substantive law creates rights and liabilities, whereas BNSS regulates the what? Criminal process as well as the safeguards. Earlier we had IPC, now it is called as what? BNS. And in case of BNSS, we had the CRPC. Structure, there are 22 chapters, 358 sections. In this case, there are how many chapters? And 531 sections. And this jurisdiction of DNS is important. DNS has what jurisdiction? Intra-territorial jurisdiction as well as the extraterritorial jurisdiction. First of all, what is jurisdiction? The geographical area or the subject to which the law is applicable is called as what? Jurisdiction. It can be either geographical area or the person to whom the law is applicable is called as what? Jurisdiction. Called as what? Jurisdiction. It is also called as territorial jurisdiction or subject matter jurisdiction. Correct, right? Yes or no? BNS has what jurisdiction? Intra-territorial jurisdiction as well as the extraterritorial jurisdiction. What is intra-territorial jurisdiction? Where a crime under any provisions of the BNS is committed within the territory of India, what is applicable? BNS is applicable, and the court can try and punish such person, irrespective of the fact that the person who has committed the crime is an Indian national or foreigner. This is called as what territory? Intra-territorial jurisdiction. Are we clear with this? So, what is the provision you will write when a crime has been committed? What has been committed? Under the provisions of BNS within the territory of India, the court can try such persons and punish this person irrespective of the fact that the person is a citizen of India or not. That is what called as what jurisdiction? Intra-territorial jurisdiction. Are we clear with this? When we have next one, there are exceptions to intra-territorial jurisdictions. Correct, right? What are the exceptions? President and governor. During the time they hold the office of president or a governor, they cannot be tried under what? BNS. After they resign, you can try them. Second one, international, foreign sovereigns. What sovereign? Foreign sovereigns. And last one, ambassadors and the diplomats. I hope you guys you can write the exceptions from what jurisdiction? Intra-territorial jurisdiction. Then we have a concept called as extraterritorial jurisdiction. Yes or no? Where the crime is committed where? Outside India, but the person is liable to be tried where? India. punished, it is considered as what jurisdiction? Extraterritorial jurisdiction. BNS has both intraterritorial jurisdiction as well as the extraterritorial jurisdiction. There are two provisions here. Section number 1, subsection 4. Section number 1, subsection what? 5. If any person commits, who commits? Any offense beyond India which is punishable in our country under any Indian law, he is liable to be convicted and punished. For example, USA arrested Maduro for an offense happened where? Outside USA. But that was punishable as per which law? USA law. What law? That is why they have arrested him. As per USA law, if anybody doing trafficking to the USA and he's involved in USA, even though he's sitting where? Outside US and he has done the offense where? And still he is punishable as per what? USA criminal law. That's why they have arrested him. And he's tried in which court? USA court. He's a citizen of which country? Venezuela. That's right. How can he be tried in the US court for an offense done outside India? Is it possible? Not possible. Possible because a law can also have what jurisdiction? Extraterritorial jurisdiction. In the same way, if a person commits an offense where beyond India, but is punishable as per which law? Indian law. Can he be tried? Can that person be convicted? Yes, and punished in the same manner as if the crime was committed where? In India. Are we clear with this? And the second one, the provision of the BNS will also apply to any offense committed by whom? Indian citizens. What citizen? If you are an Indian citizen and if you commit an offense, even where? Outside India. Commits where? Are you? Can you be tried under the BNS? Punishable under the BNS? You are an Indian. You go to the foreign. You get married to a minor. You come back to India. Punishable, not punishable? Because you are a what citizen? Indian citizen. Extraterritorial jurisdiction. Offense happened where? In India or outside India? Punishable, not punishable? Second one, any person on any ship or a aircraft registered in what? India, wherever it may be, because it is considered as a India itself. Correct, right? And the last one, any person in any place without and beyond India committing what? Offense targeting a computer resources located in India. These are the provision with respect to jurisdiction. I know you guys will write the answer if they ask question about what? Jurisdiction. Are you guys clear with jurisdiction, guys? What is jurisdiction? The geographical area or the person to whom the law is applicable. It is considered as what? Jurisdiction. Intra-territorial jurisdiction, extraterritorial jurisdiction. If any person commits any offense as per the provisions of BNS, he can be tried and punished as per the what? BNS, irrespective of whether he is a national of India or not. It is called as what jurisdiction? Intra-territorial jurisdiction. The moment you come to India, you're bound by which laws? Indian laws. Even if you're not aware about the provisions of Indian law, punishable, not punishable? Punishable. Arey, sir, no. Next one, case laws and other topics. We will not discuss this. You know this. What is the case law? If you once you arrive to India, you are bound by the what laws? Indian law. Stages of crime. What is the first stage of crime? Preparation, attempt, and commission of the crime. These are the four stages of a crime. What is the first one? Criminal intent, preparation, attempt, and commission of a crime. What is criminal intention? First stage. What is intention? Conscious exercise of what faculties? Mental faculties of a person to do an act for the purpose of accomplishing or satisfying a purpose. The court cannot punish a man for a mere guilty of what? Intention. Why? It is difficult to prove. Exactly. Intention means doing any act with whose will? Own's will. Intention can also be imputed. What is imputed? Implied. For example, recklessness, negligence. It can be nothing but mens rea. Nothing but what? Mens rea. Next one is preparations. What is preparations? Arranging necessary measures for the commission of what? Intended criminal act. If preparation itself is punishable, are there any exceptions? Where there is preparation itself is punishable by law. What are the cases? Waging a war against the government, preparation for counterfeiting the coins and Hamza, 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 Hamza Ali Hazari. He buys not his print the cash. Uh, correct. Next up. Possessing counterfeit coins, false weights and measurement and forged document is itself is considered as what? Punishable. Making preparations for what? Committing dacoity. What is dacoity? More than fire or more person? Fire or more person commits what? Robbery. It's considered as what? Dacoity. Yes or no? Very good. Attempt. What is attempt? Is it a preliminary crime? So it's a direct movement. What movement? towards the commission of a crime after you make necessary arrangement or a preparation is called as what Tejaswini is called as attempt. Called as what? Is attempt punishable? Not punishable. Punishable. In a crime, first he forms the intention, then he makes a preparation, then he moves towards the what? Commission of an offense. So first one is intention, second one is preparations, third one is attempt. Attempt can be classified into how many categories? Three categories. What are the four categories? What is the first one? Completed offense and attempt. Built in what section? Same provision, same section, same punishment. Yes or no? Example, offense against the state. Assaulting or attempting to assault whom? President or governor. Sedition. Public servant accepting or attempting to accept what? Gratification. Truth of evidence knowing to be false. And dacoity. These are punishment is same for what? Both attempt as well as the completed offense. Next one is what? Separate punishment, separate section number. For example, attempt to murder, and murder. Same section number or different section number? Different section number. Different section number and different punishment. Correct, right? Third one, attempt to commit suicide. Separate because you cannot punish a person once he commits a suicide. Attempt to commit suicide, is it punishable? Earlier it was punishable, but now he will be considered as person who is suffering from severe stress under the Mental Health Act, and it will be sent to the Nimans. Okay. Okay. Next one. No specific punishment. What punishment? If there is no specific punishment for the attempt, this is what most important. In that situation, what is the punishment given to him? As per section number 62, whoever commits an offense punishable by BNS with imprisonment for a life or imprisonment, and where no express provision has been made for the punishment of such offense, he shall be punished with the imprisonment as any description given for the offense for a term which may extend to how much? One half of the imprisonment for life, or one half of the longest term of imprisonment, or with some such sum of fine as given in the offense, or with the both half of the imprisonment. What is the maximum? If no punishment is given for attempt, then he would be punishable with the what? Half of the imprisonment. Half of the what? Yes or no? Are we clear with the types of punishment for attempt? What is the last stage? Commission of crime or accomplish. Is it the first stage or last stage? If he succeeds, he will result into what? Commission of the offense. If attempt is successful, he is guilty of an attempt only. If he is unsuccessful, attempt. Successful, completed offense. Are we clear with this? This is the crime. What is the first stage? Intention, preparation, attempt, and accomplishment. Done. Types of punishment. We have first one is what? Death punishment. Is it the harshest punishment? It is also considered as what? Judicial killing or taking of a life. It is given in what cases? Rarest of the rare cases. What are the case law you write for this? Bachchan Singh versus State of Punjab. In for what cases death penalty is given? Example: murder, dacoity with murder, waging war against government of India, awaiting mutiny actually committed, giving or fabricating false evidence upon which innocent person suffers the what? Death, abatement of suicide to whom? Minor or insane. What is abatement? Inducing a person to commit that suicide. Attempt to murder by a life convict, mob lynching. Mob lynching. What is mob lynching? Group of people kills a person, right? Punishable with what penalty? Death penalty. And terrorism or organized crime. What crime? What is organized crime? Group of people continuously doing that offense with a proper plan and profit motive. It considered as what? Organized crime. Business. It can be considered as what? Organized crime. Correct, right? They may ask this question in the examinations. For what offenses there can be what punishment? Death punishment. It's given for, it can be considered as organized crime if the intention is to what? Earn the profit, and because of that people got cheated, and there is a people have suffered the losses. Cartel is also an organized crime. Group of people are there, right? And they're doing it continuously with a proper plan to make a profit. Considered as an organized crime. And next one, life imprisonment. What is life imprisonment? Rigorous imprisonment till the last breath of the convict is considered as what? Life imprisonment. Recently, one person has been granted with life imprisonment. Who? Vinay Kulkarni. This Congress MLA has been sentenced to the life imprisonment. Why he was crying? Next one, imprisonment can be of how many types? Two types. What are two types? Rigorous imprisonment, simple imprisonment. Forfeiture of property. What is forfeiture of property? Deprivation of specific property without any what? Compensation. For the default or act forbidden by law. What is the last one? Fine. Fine is the forfeiture of what? Money by way of penalty, punishment. It should be imposed individually and not what? Collectively. Have you heard about default sentence? If the person fails to pay the amount of fine, then he can be sentenced to how much? He would have suffer imprisonment for a further period as mentioned by the court, which is generally referred to as what? Default sentence. Community service is what most important. Based on this, they can ask fraud offences, minor offences. It is introduced to create a what? Balanced and rehabilitative criminal justice. Underline the word balanced and rehabilitative criminal justice, and to reduce the burden on the prison system. What system? What happened recently? One of the person was doing wheeling and all, and that person was asked to serve as a traffic controller. Wheeling means he was disturbing the traffic, or he was doing the driving on something rash driving, and that person was asked to do what? Serve as a traffic controller. Community service, correct? Right? Is it a rehabilitative justice? Yes. Can you guys write about community services? For which kind of offences community services is given as punishment? Involvement of public servant in what trade? Illegal trade. Non-appearance of a person to a what? Proclamation. We have discussed this, right? Proclamation of offender. Next one, attempt to commit what? Suicide to influence legal authority. You will say, if you don't give permission, I will commit suicide by lighting. Like I will set myself on fire and I will die. People do this, right? Or you will say, I'll consume poison if you don't give the permission. Resha, no. First conviction of petty theft, not petty theft. Petty theft, small theft involving value of how much? 5,000, and property must have been recovered. Public misconduct by a what person? A drunken person, and defamation. In these cases, there can be what service? Community service. Can you guys write about community service? It is a what type of justice? Rehabilitative and balanced system of justice. Are you guys clear? Types of punishment, everybody? Yes. And that is a serious offense. Minor cases, then it is given. So a public servant can be asked to do the community service. Which one? Which one? Criminal offense. This is also crime. Huh? Minor is not punishable. He'll be under the this one juvenile system. Exactly. Still, minor is a minor. He will not be punished under the normal system. He'll be under the juvenile system. No, no, no. He will be sent to the juvenile system, rehabilitative homes. Okay, next one, next one. Everybody, next one. Difference between what? Which one is monetary punishment imposed by the court? Which one is imposed as a punishment for violation of law? Penalty. Always in what in nature? Penalty can be monetary as well as non-monetary. Fine is imposed by whom? After adjudication. But there is no requirement of adjudication for what? Levy of penalty. See, in case of Companies Act, many places you find the word penalty and fine. Correct, right? For example, for not holding the AGM, it is a fine, not penalty. But for not filing the forms, it will be a penalty. Means if you want to file that form, you should pay the penalty, then only you can file it. Correct, right? But for levy of fine, what government is supposed to do? They should initiate a prosecution against you. Means they should file a case in the court. Then you should go and pay the fine in what? Court. For example, if you don't file form number INC 22 within 30 days of incorporation of company, supposed to pay the what? Penalty. And if you don't file AOC, for there is a what? Penalty of how much? 100 rupees per day. Yes or no? It is penalty. If you don't pay penalty, you cannot file the form. And for levy of penalty, there is no requirement of adjudication. There is no case. But for levy of fine, government should file a what? Case against you. Be an adjudication. What is adjudication? Judicial determination of dispute is called as what? Adjudication. For levy of fine requires what? Adjudication. For levy of penalty, there is no requirement of what? Adjudication. Yes or no? Yes or no? Next one. In case of fine, the default is the nature of what? Offense. Right, criminal offense. And the provisions provide for fine as a punishment. In case of penalty, the default will be in the nature of what? Non-compliance. What compliance? Next one, fine and imprisonment are mostly provided what? Together, whereas monetary penalty, sorry, fine and imprisonment are generally given what? Together, where monetary penalty is provided for any default, generally no punishment by way of imprisonment is given. Correct, right? For example, section number 447 deals with what? Fraud. In case of fraud, what is the punishment? Is it a fine or penalty? Fine or penalty? Fine. That court, the government can levy fine only after what? Adjudication. Only after what? Fine is always what in nature? Monetary in nature. Penalty can be what? Monetary as well as non-monetary. So we can say penalty includes even the fine. Yes or no? Next one. Are we clear with this, everybody? Fundamental elements of crime. I don't think I need to explain fundamental elements of crime, but I'll just discuss. What is the first one? Human being. Can company commit a crime? Ah, yes, it can commit a crime. Alter ego, mens rea. Next one, next one. First requirement of commission of a crime is that act must be committed by whom? Human being. Human being must render the what? Legal obligation, physically and what? Mentally fit, and not acted in accordance with the what obligation? Legal obligation. Yes or no? What if you are unsound minded if you commit a crime? Are you punishable? Not punishable. Because there is a what rea? Mens rea. Next one, what is mens rea? Guilty mind. The mental element necessary to constitute a crime is called as what? Mens rea. Actus non ficitium nis mens rea means what? Act alone does not amount to guilt. The act must be accompanied by what? Guilty mind. What mind, Prajwal? Guilty mind. Right, right. Intention and the act both constitute the what? Crime. The act is judged. This is most one of the most important. This is one of the most famous sentence. You don't judge mind of a person by sorry, you don't judge the action of a person based on his mind, but you judge the mind of a person by his action. Resado, Resano. How do you feel? Like, how do you say I'm serious about you guys passing the examination by your action? How can you judge my intention based on your action? What is my action? Like how? Okay, slogans. Like how do you guys? No, no. How do you guys judge that I have an intention? Like I really want you guys to pass. हाँ see मेरा क्वेश्चन बैंक है मेरा शॉर्ट नोट्स है मेरा मटेरियल है that shows that I want you guys to pass. You judge the mind of a person based on action, not by his words. Yuvraj, Yuvraj, are you guys clear with this? Everybody, yes or no? This is what called as mens rea. What rea? What rea? Mens rea, guys. Guilty mind. Actus non facitria, nisi mensitria means what? An act itself does not make a person guilt unless it is accompanied with what? My guilty mind. Yes or no? Act is judged not from the mind of the wrongdoer, but the mind of the wrongdoer is judged from the what? Act. Substance speaks more than the word. And we say that in the form of what? We judge the mind of a person. Sorry, we don't judge the act of a person by his mind, but we judge the mind of a person by his act. He may say 100 things. He may say, I do this, but you judge a person by his what? Action. What he really does. That is what matters the most. Next one. This is not sincere word. This is law. These are no next one. Types of menstruation. Types of what? There are four types of menstruation. Not four types. Three types or four types? Three types. Intention, negligence, recklessness. What is intention? When a person can foresee the consequences of his act and he consciously desires those acts, it is considered as what? Intention. You know what is going to happen and you want that to happen. It is considered as what? Doing it intentionally. You know that if you stab somebody, he will die and you stab him. because you want him to die. It is considered as what? Intention. Arey sir, no, I want everyone to concentrate now. Intention is the what? Purpose or design with which act is done. Intention indicates what? Position of a mind, condition of someone at the time of commission of the offense, will of the accused to see the effect of his unlawful conduct. Yes or no? The person can foresee the consequences of his act and he voluntarily desires those act. It is called as what ria? Mens ria. Bolo what ria? Criminal intention does not mean only the specific intention, but also includes what intention? General intention. I don't have intention to kill you, but I have intention to kill somebody, but you die. Am I punishable? Not punishable. Yes or no? Because intention also include what intention? General intent. Remember mixing the poison. For example, let's say you mix a poison to a food, a laddu, and you want someone else to eat, but I eat it and I die. Are you punishable? Not punishable. Keshav, am I punishable? Not punishable. Punishable. Because intention includes specific intention as well as the general intention. Negligence, you guys know what is negligence? Not taking care when you are required to take the what? When you have a duty to take the care. Right, right. When you neither foresee the consequences nor desire those consequences, but you fail to take the what? Required care. What care? Is called as what? Negligence. If negligence is a menstrual, arey son. Next one, recklessness. What is recklessness? Correct. You foresee the consequences, but you don't desire those consequences. But you consciously take the risk. That is considered as what? Recklessness. आपको पता है if you drink and drive, you will commit an accident. But nobody likes to commit accident, right? That is called as what? Recklessness, carelessness. Are you guys clear with this? Three forms of what ria? Mens ria. Next one. Exceptions to mens ria. Are there any situation where a person is punishable without mens ria? Yes. What is the first one? Statutory imposition, where law itself does not require the mens rea. Difficulty in proving what ria? Petty cases, there is no requirement of mens rea. For example, fine. Traffic rules violation. Next one, you interest of what safety? Public safety. There is no requirement of what ria? Mens rea. Next one, offense without any what? Knowledge. Ignorance of law is no excuse. There is no. Next one. Corporate body and mens rea. Can a company be held responsible for crime? Because person includes what? Company, association, body or person, whether company incorporated or not. Can company be prosecuted for criminal offenses same like natural person? Yes. And the criminal intention. What intention? The mens rea of alter ego. Who is the alter ego of company? Board of directors and shareholder. This MD, KMP and professionals. The alter ego of the criminal intention of the alter ego is imputed to whom? To the company. And company is punishable for what offenses? Criminal offenses. What offenses? And this was held in which case law? Maharashtra versus syndicate transport. What transport? What is the last element of crimes? What is actus rea? Guilty act. Unlawful commission of done. Carrying out a what? Plan with a guilty intention. It is the result of voluntary human conduct which law prohibits. Which law what? Prohibits. These are the basic concepts of crimes. What are the concepts we discussed now? Jurisdiction. Second one. Status of crime. Third one. Types of punishment. And the fourth one. Fundamentals of crime. Everybody, what is the first concept we discussed? Jurisdiction. Second one. Third one. Types of punishment. Fourth one. Fundamental elements of crime. Let us discuss the offense against the what? Property. What is the first one? Theft. See, to write this answer, आपको 5 वर्ड ರಿಮೆಂಬರ್ करना पड़ेगा. You need to remember 5 words. ನಿಮ್ಗೆ 5 ವರ್ಡ್ಗಳು ಜ್ಞಾಪಕ ಇರಬೇಕು. ಯಾವ್ದಾವುದು? Dishonest intention. What intention? What property? Movable property. Out of whose possession? Someone's possession. Without what? Consent. And he moves the property. What of the property? Moves the property. What the property? Move the property. इतना अच्छा है. I feel good. Seriously. Um, tell me if you anyways. Step any very simple. If any person with a dishonest intent take what property out of whose possession? Without his what? He moves the property. Just moving is sufficient. It is considered as what? Theft. Panch word yaad rakh lena. What are the panch words? A dishonest intention, movable property out of someone's possession without consent, moves the property. Like opening the tap, just pushing that wallet aside. All these are considered as what? Theft. Arey sir, no. There is a wallet which is lying down. Okay. You just move it aside. You can take it later. Is it considered as theft? Is it called as theft? Yes. Just moving is important, not taking the possession of the goods. Yes or no? Yes or no? Next one. Next one. Explanations, you guys go through it. Illustrations, can you guys do the illustrations, please, everybody? Getting a tree from the what? Zed's land. Is it a theft? Inducing Zed's dog to what? Follow. Is it a theft? Arey, sir, no. To throw biscuit the dog and the dog follow me. Is it a theft? Yes or no? Next one. Driving bullocks, carrying the what? Treasure. Theft. Next one. Because there is no what? Possession. Finding. No, why finding ring on the public road is not a theft? Nobody is having possession now. So what is theft? What is theft? Anyone with a dishonest intent take what? Movable property out of the what? Possession of other person without his consent and moves the property. Uh, when you are a finder of lost goods, it is not considered as a theft. If you take it, listen, if you take it and if you try to use it, it is considered criminal. No, criminal misappropriation of property. And you are absent for this class. I know. If you are present, you would have asked this question at that time itself. I would have answered. Ah, है ಯಾರೋ ಒಬ್ರು ಕೇಳಿದ್ರೆ ಬಿಡಮ್ಮ ಹೋಗ್ಲಿ ನೆಕ್ಸ್ಟ್ ಒನ್ Honor takes watch without paying what? Loan. Is it a theft? Reza, no. I gave this water bottle as a pledge. I did not repay the money. You have the water bottle. I just come and take it away. Is it a theft? Why yes? Even though I am the owner, if I take it from your possession without any what consent, it is considered as a theft. Yes. Next one takes debts goods, believing them to be what own. Is it considered as a theft? Reza, no, no. All these examples are there in your ICSM material also, but मैंने different तरीका से present किया है. That's it. Are we clear with this, everybody? Next one. Punishment for theft. You guys go through it. I will not make you guys remember the punishment for theft. How many years? 3 years. Next one, snatching. What is snatching? Sudden or quick act. Possible seizure of what property? Movable property from a person or his possession. Purpose is what? Theft. Reza, no. In order to commit a theft, to commit theft, order to commit a theft, the offender what he does suddenly, quickly, or forcibly. Next to keep the in order to commit theft, in order to commit what? Theft. That is with the intent to dishonestly take the movable property from the possession of another person. What do you do? Suddenly, you know, or quickly, or forcible, seizes, or secures, or grabs, or takes away from a person his possession. Any what property? Obviously, snatching can happen only for what property? Movable property. Quickly, forcibly, or suddenly, you take away the movable goods. It is considered as what? Snatching. Snatching is also a theft. But in this case, what happens? Suddenly, quickly, or forcibly. Now tell me, listen everyone. You are carrying a bag. In that bag, there is a mobile phone. I come next to you. Slowly, I take the mobile phone. I run away. Is it called as what? Is it a theft? You are going with the bag. You are singing and going and you are enjoying your evening time walk. Suddenly come and I'll snatch it and I run away. Oh, sorry, I always said to snatch. Are we clear with this, everybody? Arey, no. Snatching, what is required? Snatching is the theft. And what is the extra element here? Suddenly, quickly, forcibly. You know? somebody is trying to snatch your chain and you say, get up, still fix it away. Is it considered as snatching? Yes or no? Next one. Extortion. What is extortion? Simple. You put somebody into a fear of what? Injury. Fear of what? अरे बोलो fear of what? Injury. And thereby you induce the person. What do you mean by induce? You make that person to deliver what? Any property, valuable security, or anything convertible into valuable security. See, extortion can be for movable property as well as what property? Immovable property. Snatching and theft only for what property? Movable property. Are we clear with this, everybody? What is extortion? When one person intentionally puts whom? Another person into a fear of what? Injury. And thereby dishonestly induces him to what? Deliver any property or valuable security or anything convertible into, that is called as what? Extortion. Called as what? Yes or no? Now the no, girlfriend of Yuvraj says, Yuvraj, if you don't transfer your property, I will disclose all the information about us to your parents. Next one. Is it extortion? Why? He put him into a fear of what? Injury. Injury to what? Reputation. And made him deliver what? Gain deliver agide, property deliver agide. Or convertible into valuable security. He gave a contract, now that contract is convertible into what security? Valuable security, right? Yes or no? Or next one. Are we clear with this, everybody? Can you guys read illustrations, please? Let's start. Next one. Punishment beta. Just today illustration. Threat to publish what? Defamatory libel. Unless paid. Is it extortion? Next one. Threat to detain child. Unless promissory notice signed. Is it a threat to fulfill unless check is signed? Next one. Is it a extortion? Because it is convertible into what security? Valuable security. Threat to electronic message to kill child unless ransom is paid. Cyber crimes. Extortion. Yes or no? Next one. Difference between theft and extortion. Tell me which one involves consent. In extortion and see, listen everybody. Theft and snatching, you don't take consent. Will you say, Anna, I'm stealing money from you? Will you take consent? No. But in case of extortion, you take consent, but not a free consent. That is what. But there is a consent. Yes or no? Next one, next one. Method. Which one involves secret taking? But extortion, threat as well as the inducement. Yes or no? Offense. Which one is passive? Which one is passive? Which one is active use of fear? Which one is why he is blushing? He got to know who is blushing here. Active use of fear. What use of fear? Active use of fear. Which one is active use of fear? Extortion. Is that no? He only. Huh? Are you guys clear with theft and extortion? Yes or no? We can ask this question in the examination. What is the first one? Consent. Where there is consent? Which one is secret taking? Offense type? Theft, passive, extortion, active use of fear. Are we clear with this, everybody? Next comes robbery. Next comes what? What is robbery, guys? It's an agreed form of what? Theft or extortion involving violence, of violence or wrongful restraint. Only three things here. Either it involves violence or threat of violence or wrongful restraint. In that situation, both extortion and theft will be considered as what? Robbery. Considered as what? When theft is robbery, when in order to commit theft ಮಾಡ್ಲಿಕ್ಕೆ ಅಥವಾ in committing a theft, that is while committing a theft or while carrying away or attempting to carry away whatever obtained by theft, the offender causes or to any person that hurt, wrongful restraint or fear of instant death, instant hurt, instant wrongful restraint. It is considered as what? Considered as what? Considered as what? So when theft is robbery? While committing the theft. Sorry, first one, commit a theft. Or while committing a theft. Or while taking away whatever obtained by way of what? Theft. You put a person into what? You cause a death, hurt, wrongful restraint, or fear of instant death, instant hurt, instant wrongful restraint. It is considered as what? Either you put him into fear, or you cause the death, or a hurt, or wrongful restraint. It is considered as robbery. When extortion is robbery, if the offender at the time of committing the what? Extortion is in the presence of the person commits the extortion by putting that person into the fear of what? Instant death. Bolo? Second one, instant hurt, instant wrongful restraint, instant wrongful, the same thing. And to person or any other person induces the person there to deliver up the what? Things extorted. It is considered as what? Extortion is considered as the robbery. Why? Because you put that person into an instant fear of death, instant fear of hurt, or instant fear of wrongful restraint. Now tell me, if I hold you at a gunpoint and say, give your gold chain, if not, I will kill you. Is it a extortion or robbery? It's a extortion, but it is a robbery. Why it is robbery? Is it a instant fear of death? Is it a robbery? It's extortion. Is it extortion? Yes. But is it a robbery? Because extortion becomes robbery while committing that extortion if you put person into what? Instant fear of death, instant fear of hurt, or instant fear of what? Restraint, wrongful restraint. Now, what if you send a message saying that I have your photos? If you don't send money, I will leak these photos. Why only extortion? There is no instant fear of death, instant fear of wrongful restraint. Are you guys clear with this, everybody? Yes or no? I want to steal something from your house. I taken every valuable things while I was leaving. You saw me. Suddenly woke up and you came and you got surprised. Wait. Is it a theft? Yes or no? Because you saw me, I was like, if I leave you, you may give a complaint to whom? Police officer. So what I will do, I'll take out the gun and I will fire the bullet and you are dead. Now it becomes what? First of all, is it a robbery? It is also murder, correct? But is it a robbery? Why it is robbery? Because while taking away whatever obtained by theft, what I did, committed the death. Caused the what? Death. Is it a robbery? Robbery can be either what? Theft or extortion. Or what? Are you guys clear with this, everybody? Yes or no? Difference between theft, extortion, robbery. Which where there is a consent? Robbery, robbery there is a fear as well as force or threat. Physical presence, where physical presence is not required. Huh? Extortion, physical presence is what? Not required. Uh, must be present and threatening in case of what? Robbery. Theft also it is not. Uh, for example, what if I take away the cash from your account? Theft. Correct. Use of force, where there is no force. Theft. Extortion, no. Robbery, yes. Today we have the type of offense we discussed. Theft. Second one, next one, dacoity. What is dacoity? Committing, attempting to commit, or aiding in the commission or of attempt is considered as what? Dacoity. Robbery must be involved. Yes or no? Means there is a death. or a harm or a wrongful restraint. Correct, right? By how many persons? Joint liability, even the aider present at the scene guilty of what? Dakaiti. Yes or no? What is the punishment for Dakaiti? Committing Dakaiti, how many years? 10 years plus fine. Murder committed during Dakaiti, 10 years of rigorous imprisonment plus fine. Operation of Dakaiti, 10 years plus fine. Assembly of 5 or more persons, 7 years plus fine. Belongs to a gang habitually committing Dakaiti, 10 years plus fine. Are you guys clear with this, everybody? These are the offenses with respect to property, that is theft, snatching, robbery, sorry, extortion, then robbery, then dacoit. Clear with this, everybody? अब आएगा dishonest misappropriation of property. Whatever you ask this question, if you find someone else's goods and if you use it or you convert it for your own purpose, it is considered as what? Misappropriation of property. Punishable, not punishable? Can you guys read the question, please? Whoever. Honestly or dishonestly? Misappropriate or convert to his own use. Any what property? Punishable, not punishable? Not less than how many months? Maximum how many years? What are the essential element of criminal misappropriation of property? Dishonest intent. What property? What property, Tejaswini? Movable property. What is Tejaswini? Okay. Dishonest intent. Second one, movable property. What property? Obviously, they cannot criminally misappropriate immovable property. Correct, right? Third one, perversion to what use? Own use. Dishonest misappropriation for time only is also considered as what? Criminal misappropriation of property. Next one, finder of goods. What of goods? If you find someone else's good, can you use it? If you try to find the which owner? True owner. And give it back to him. Correct, right? Now, what if, let's say, um, you find the watch of somebody and you use it for only one day for a function? Is it a criminal misappropriation of property? Yes or no? Even using it for a time being only is also considered as what? Criminal misappropriation of property. Are we clear with this, everybody? Next one. Illustrations, you guys go through it. Dishonest misappropriation of property of whom? Deceased person. What person? Whoever misappropriates or converts its own use property in possession of which person? Deceased person, knowing that property belonged to whom? Deceased at the time of their death, and the property has not yet come into possession of the someone legally entitled to do it. Is he punishable, not punishable? Very good. Clerk or servant? 7 years plus fine. पता है था? Next one is criminal breach of trust. ये बहुत ही serious offense है. This is this is related to us. It is we come across with these offenses generally. For example, let's say I give money to you to buy shares on behalf of me, but use it for your own purpose. Punishable, not punishable? Which offense? Is it dishonest misappropriation of property or criminal breach of trust? See, the main difference between criminal misappropriation of property and criminal breach of trust is possession. In case of criminal misappropriation of property, you come in possession of the goods involuntarily. Nobody is giving it to you. You only finds it. But in case of criminal breach of trust, someone else is giving it to you. They are trusting you and they're giving it for specific purpose. But use it for what purpose? Some other purpose. It is considered as what? Criminal breach of trust. What breach of trust? Arey no. Whoever interest with the property or dominant over the property commits a criminal breach of trust if they dishonestly misappropriate or convert a property to their own use or dishonestly use or dispose of property in violation of legal directions expressed or implied contract relating to such trust or willfully allows another to what? Do it. In these cases, it is considered as what? Criminal breach of trust. See, simple. First essential element for criminal breach of trust is entrustment of property. Somebody is entrusting a property to you and you misappropriate that property, or you use that property in violation of what? Directions given by the one who is entrusting it to you. That is considered as what? Criminal breach of trust. What breach of trust? मैंने बोला था invest in Reliance company shares, but you invest in Tata company shares. Are you liable for criminal breach of trust? Yes or no? Because I entrusted you with what? Money for a specific purpose. And you using that money in violation of directions given by whom? By the person who entrusted that money to you. Is it a criminal breach of trust? Yes or no? Yes, it is a criminal breach of trust. Example, can you guys get the illustrations, please? Can you tell it? It was given for what purpose? Safekeeping purpose. You just should safekeep it. But if you sell it, is it punishable or not punishable? Or criminal breach of trust. Next one. Next one. Good faith, no. Dishonest intention होना चाहिए. ठीक है? Next one. Next one. Board of directors misappropriate the funds of company. Is it a criminal breach of trust? Is he a trustee of assets of the company? If he misappropriate them, is it punishable or not punishable? For the criminal breach of trust. Yes or no? Next one. Receiving stolen property. What property? If you receives or retains the stolen property, are you punishable, not punishable? Punishable. How many years? 3 years. Are a fine or all with what? Both. Yes or no? What are the explanations? Dishonesty receives or retains or assist in concealing a what? Stolen property. Then also is the punishable with how many years? 3 years. How many years? Are you guys clear with this? Next one is cheating. What is cheating? Cheating and cheating by personation is what most important section numbers. What is cheating? अब बोलता है ना cheating करता है तू. What is cheating? Right, listen. What is the first ingredient? Deception. क्या होना चाहिए? One person deceiving the other person. And by the deception, he is inducing you to do something. What is inducement? If that deception is not there, he will not do something. Or he will do something. It can be positive as well as what? Negative. For example, let's say Keshav made a promise to a girl that he will marry her. Because he made a promise to marry that girl, she don't get married to that other boy whom the family is okay with. Then he comes and say, I will not marry you. Is it a cheating? Resa, no. What Keshav did he do any deception here? Because of that, what she did? Is she doing something or not doing something? And because of that, did she suffer any loss? What loss? Right? Mental loss. Like physically or emotionally. Or yes or no? Mind or reputation or what? Property. Yes or no? Now what if Keshav made a promise to that? Okay, not that one. Next one. Where is Himansh? Next one. I hope you guys are clear with this concept of cheating. बस क्या होना चाहिए? Deception. अरे बोलो भाई क्या होना चाहिए? Second one, inducement. Dishonestly or with a fraudulent intent. Modified intention from the what? Beginning itself. Damage or likely to what? Harm a person's body, mind, reputation or property. A boy made a promise to marry a girl. Because of that, she gave a consent. Is it a cheating? She did not have the intention to marry her. Punishable, not punishable. Presa, no. Understood everybody. Can you guys read illustrations, please? A person, goods on what? There is deception here. Because of that, he induced the person to what? Sell the goods. On what basis? The one who sold the goods on credit basis suffer any loss here? Yes. Is it a cheating? Next one. Sell the what? Goods. Cheating? Yes. Next one. Next one. Cheating. Next one. Is it cheating? Because it should be what? Dishonest intent. Now, when the boy made a promise, at that time he had an intention to marry her. After some time, circumstances changed and he is not willing to marry her. After cheating, when they were in relationship, oh yeah, yeah, right. I'll change the example. Next one. See, when these are all common example, criminal cases. When the boy and girl were in relationship, at that time they were in no, he was having intention to carry it for a longer period of. He had an intention to marry, but after a few years of relationship, now he is not willing to marry her. Now the girl want to file a case against him for what? Cheating. Will she succeed? Because he had an intention to marry her. Now he's not having intention to marry her. It's not considered as cheating. Why? Because he had intention to marry when he had made the promise. Like when he took the consent. Every false promise is not cheating. By that false promise or by the deception, you would have taken her consent. And because of that consent, she would have suffered loss to her body or a mind or a reputation or a property. That is when it is called as what? Cheating. Understood, everybody? Next one. Cheating by personation. What is cheating by personation? Remember that story is different, that lady is different. Yeah. A person is said to cheat by personation if he cheats by what? Pretending to be someone else, knowingly substituting one person to whom another, or representing that he or someone else is different person that they really are. Then it is considered as what? Cheating by personation. If you pretend it to be someone else, which you are not, or knowingly substitute one person to whom another person, or representing that he or someone else is different than they actually are, then it is considered as what? Cheating by personation. Cheating by what? These are the types of offenses. Types of what? Offenses. Next one, 320, 321, 322, 323. I've already discussed, but I'll discuss one more time. Let's read section number 320. What are the points required in this? If a person dishonestly or fraudulently hides, removes, gives away, or transfers property without adequate consideration, underlined without adequate consideration, with the intention of avoiding the what? Payment to creditors. Either he is transferring, or he is hiding, or he is giving away any property without consideration or with consideration. Adequate consideration. And what is the reason for that? Avoiding the payment to creditors. Payment to whom? What is the punishment? Minimum 6 months, maximum 2 years, or a fine, or both. 320 here, not 420. Earlier it used to be 420. Now it is what? 20? 320. What is 320? Dishonest or fraudulent concealment or removal of property. With consideration, without consideration. Without adequate consideration, with the intent of avoiding the what? Payment. Next one, 321. Fraudulently preventing the debt from being available to whom? Creditors. If a person dishonestly or fraudulently stops money that is due to him from being used to pay what? Creditors. If you don't recover the money because you have to pay to someone else, it is also punishable. Section number what? 321. Section number what? Next one, 322 is all about this fraudulent sale deed. What deed? If a person dishonestly or fraudulently signs or execute a document to transfers the property or creates a charge, and that document mentions a false details about what? Consideration or the person for whose benefit it is transferred. Benami transactions. Are they punishable or not punishable? Section number 322. I'm selling a property. Actual price is 5 lakh. In the stamp paper, we mention, sorry, in the sale it we mention only 1 lakh to avoid stamp duty. Punishable, not punishable? Arey, bolo, punishable, not punishable? How many years? Now I am selling it to you, but I mentioned the Rakesh name. Next to Prajwal. Pratik, Pratik. Is it punishable, not punishable? How many years? Arey, how many years? Next one, 323. What is 323? Dishonest or fraudulent removal or concealment of property. General provisions. Can you guys read? Whoever dishonestly or fraudulently conceals or remove any property of himself or any other person, assist in the concealment or removal of such property, or dishonestly releases any demand or claim to which he is entitled, shall be punished with imprisonment up to how many years? Or fine, or with both. This can be even to government also. That is for only creditors. This one is for what? Any person. For example, government is planning to confiscate my property for commission of any fraud. To avoid that, I transfer it to somebody. Come under which one? 323. Because don't want to make a payment to creditors. I transfer it to somebody with insufficient consider. That come under which section number? 320. Reza, no. Difference between 320 and 323. Can you guys read? Second one. To hide the property or give up claim not necessarily linked to the creditors. Not compulsory linked to the creditors. Types of act cover removing, cancelling, without any adequate consequence. This one, removing, concealing property, assisting in such act, or releasing any lawful claim. Example, you guys can go through it. Offenses with respect to document and property marks. What marks? Section number 336, forgery. Can you guys read forgery? What is forgery? Simple. If you create a false document or a false electronic record with the intention to what? Cause a damage or injury to the public or any person, support a false claim or title, make someone to part with the property, make someone to enter into what? Contract or commits fraud or enables the fraud. That is considered as what? Forgery. Considered as what? Can it be electronic record? Can it be a document? Creating a false document itself is not a forgery. By that way, if you induce a person, if you cause a loss to somebody or to the public or to support a false claim or a title, make someone to sell the property, make someone to enter into a contract or commit a fraud or enable the fraud, and it's considered as what? Forgery. You create a fake certificate. By that way, you induce a girlfriend to enter into a contract with you. Is it a forgery? You create a fake CS pass certificate and you keep it with yourself. Is it a forgery? Uh, but by that document, you induce a girl to enter into a contract of marriage with you. Is it a forgery? Are you punishable? Is it a cheating also? Is it cheating? What is cheating? There should be a deception, dishonest, fraudulently inducing a person to do something or to deliver a property which will cause harm to the body, mind, reputation, or to the property. If it has not caused any loss to her, not a cheating. If it has caused loss to her, then it is cheating. Cheating by way of forgery. Yes or no? Can you guys read these illustrations, please? मैंने इतना examples दिया है. If you read this example, you will never forget the concept of cheating. Read everybody. Understood, everybody? Offenses with respect to property mark. What mark? What is property mark? A mark used for denoting that a movable property belongs to what person? Particular person. Trademarks होता है ना? It is called as what mark? Property mark. Punishable, not punishable? Punishable. Defamation is important. Based on this, they can ask questions in the exam. What is defamation, guys? If any person make or publish any imputation, remember this word. What word? Imputation. What is imputation? Statement, allegations, or accusation about any person. What person? By words, signs, visible representation, with the intent to harm, with the knowledge or belief that it will harm the reputation of such person. It is called as what? Defamation. Yes or no? Yes or no? What is defamation? If any person make or publish any imputation about any person, words or signs or visible representation with the intent to harm, it will harm the reputation of such person. और आपने किसी और का इज्जत खराब करना चाहता है, इसीलिए आप कुछ बोलता है, वो बोलना is called as what? Defamation. Are we clear with this, everybody? Are yes or no? Types of victim covered. Which is power person? Is it covered? If you defame a deceased person and if it hurts the family members' emotions, is it defamation? Yes. Next one. Company or a group, are they considered? Can company file a case against you for defamation? For example, if you say uh, biscuit of some company is full of sugar, not good for health, something, some false statements you made with the intent to damage their reputation, can they file a case against you? Yes or no, Kitty? Yes. Next one. Kitty, stop using your mobile phone. Otherwise, I'll take your mobile phone and I'll never return it back. Punishment. And you guys, one. Punishment. What are the types of punishment? Prajwal, punishment. 2 years, 2 years, 2 years. Exceptions. Based on exception, they can ask question in the examinations for defamation. Can you guys read the exceptions, please? If you say truth, in what? Public good. What good? Well, is good faith opinion on the public servant's conduct, not considered as defamation. Third one, good faith opinion on the what? Plea questions. Next one, substantially true court proceedings. What proceedings? Is it considered as defamation? No. If you report whatever happened in the court, is it considered as defamation? No. Next one, and the court decisions are participate in the conduct, not considered as defamation. Criticism of what performance? Next one, lawful authority giving what? Censor, not defamation. Accusation of to what authority? Lawful authority. Filing complaint is not considered as defamation. Good faith imputation for what? Protection. Protection of others, like giving information about thieves. If you go to Tirupati, they mention the pictures of uh, dongas. Donga. They don't దొంగలు ఉన్నారు జాగ్రత్త అండి జాగ్రత్తగా ఉండండి జాగ్రత్తగా నేను బిడమ్మా ఓకే నాకు తెలుగు రాదు మేనేజ్ చేస్తా అంతే ఓకే ఐ సీన్ దట్ బోర్డ్ వేర్ సమ్ ఆంటీస్ అండ్ ఆల్ వర్ దేర్ ఆంటీస్ వర్ ఆల్ వర్ దేర్ బీ కేర్ఫుల్ దొంగలు ఉన్నారు ఇస్ ఇట్ ఎ డిఫమేషన్ నో public safety what safety public safety can they go and file a complaint the defamation case no who actually do the theft Next one. Caution in what faith? Good faith. But a caution in what faith? Arey, aisa no. Now, what if Keshav? Oh, next one. Are we clear with defamation, everybody? Last topic of what? Our BN. I don't know. Still, we have two more topics. That's it. Let's start. Let's start, everybody. Can we discuss this one? General exception. What is the first one? Bound or mistakenly believing himself bound by the law. Is it a crime if a person done if a person does something, if he is bound or mistakenly believing himself to be bound by the law, is it considered as a crime? No. For example, if a person fires at the mob and he is protesting, is it considered as a crime? No. Next one, when acting judicial, is it a crime? Next one, act done under the judgment or order of the court, is it a crime? No. Act justified or mistakenly believing to be what? Justified. Remember, I'm going to discuss the mistake of fact. Water, girl, he was trying to swim, but you think thought she was trying to commit suicide. He mistaken the fact in a good faith. अरे ऐसा नो. Next one, accident in doing what act? Lawful act. You are doing some lawful act, but accident happened and some person is dead. Punishable, not punishable? Not punishable. अरे ऐसा no. You are driving a car with every precautions, but still accident happened. Other person is dead. Punishable, not punishable? Not punishable. Next one, were done without criminal intent to prevent which harm? Greater harm with his consent. Operation Mardibekal Sutokpita. It's not considered as a crime. Next one, act of a child. Under how many years? Act of a child, 7 to 12 years with immature understanding, not a crime. Act of a person of what mind? Unsound mind. Act of intoxicated person against his will. If he consumes it voluntarily, crime. But if the intoxication happened against his will, it's a crime, not a crime. Next one, offense requiring intent or knowledge by voluntary intoxicated person, punishable, not punishable? Punishable. Next one, act intended to cause death or grievous harm. Alter. Is it punishable, not punishable? Punishable. An act not intended to cause death, done in good faith with a consent for the benefit. With a crime? No. You have done it with a consent and in what faith? Good faith. And what faith? Surgery. Next one, 27. Act done in what faith? Good faith. Benefit of whom? Child or unsound mind person with the whose consent? Guardian's consent. 28. Consent under the fear or misconception is not valid. Exclusion of facts that are offenses by their what? Very nature. Causing miscarriage, even if it is done with the consent of the mother, is it considered as a crime or not a crime? That act itself is a crime, even if there is no even if there is a consent. Where consent doesn't play importance. Miscarriage itself is a what? Crime. Understood? I'll give one more example. For example, girl is 16 years old, boy is a major. They get married. Is it a rape? Even though the girl has given the consent, still it is considered as a rape. Why? Because she is how many years old? Their consent doesn't play any importance. Are we clear with this, everybody? Huh? POSCO Act. POSCO Act. Shantam Papa. Nobody should get into that POSCO Act. POSCO में गया, जिंदगी बर्बाद हो गया. POXO. It is not POXO. POSCO. POSCO. EO. Prevention of sexual harassment and abuse. Act done in good faith for the benefit of whom? Without consent. Is it an offense? Act done in good faith without the consent. अरे ऐसा we did CPR, but still she's not breathing. So Ma- Now you guys tell me, is he punishable? Later the girl is like, she was like, how dare you? He was like, I never allowed even my husband to. Is Adi punishable, not punishable? Because he done it in good faith. Without consent or with consent. At that time, how can he? Huh? It's in good faith. Papa to help. What? Huh? No, it is good. Next one, next one. Communication, but in what faith? Like, for example, that lady goes to the hospital and doctor say, ma'am, you are conceived. And she died. Is the doctor punishable? Because she got a shock. She got. Is the doctor punishable? Why? He disclosed some information in what way? Good faith. Now he knows that whatever the incident happened earlier, like, let's say if a doctor says you have a disease, after hearing that the person is dead, is the doctor punishable, not punishable? Communication made in what faith? Good faith, not punishable. Next one, threat of instant death. What death? What death means you are held under a gunpoint. Holding you under a gunpoint, the person asks you to hit somebody. Are you punishable, not punishable? Good faith. Correct, right? Now, what if I'm holding you at a stick point, not a gunpoint, and I ask you to steal the cash, and you steal the cash, and to kill somebody? Are you punishable, not punishable? Because there is no instant what? Death. Correct, right? Only if there is a fear of instant death, sorry, if there is a threat of instant death, and if you do something, you are not punishable. But the person who is keeping you under instant death will be punishable. Are you guys getting it? Last one. Accused at causing what harm? Slight harm. Punishable, not punishable? Not punishable. Section number 34 to 44. Right to what defense? Private defense. What defense? Do you have any private defense? Arey, so no. What is private defense? If a person act to protect. No, what happened, Pradyumna? No, say, what happened? Okay, let's. If a person act, who act, person act, protect themselves or their body or the property or the body property of someone else against imminent unlawful aggression or a threat. It is considered as what defense? Self defense. When the act, even if it causes the harm or death, is not punishable under the criminal law within the legal limits. What limit? See, if a person does something, whether to protect himself or their body or a property or the body or property of whom? Someone else against the imminent lawful aggression or a threat, then it they're not punishable, even if it causes a harm or death to whom? Other person. It is called as what defense? Self defense. Or what defense? Section number 37 of the provides that act against which there is no what defense? Right of private defense. They can ask this question in the examinations. When the right of private defense is not available. What is the first one? Public servant acting in what way? Police officer. Against police officer, you don't have any private defense. Person following the directions of whom? Public servant. Acting in what way? What if they're acting in bad faith? Do you have private defense? Yes. Next one. If there is a time to seek help from whom? Public authority. There is a question of private defense. Last one. Shouldn't use what force? Excessive force. The right to private defense is also available against whom? Against the unsound mind. Are you guys clear with this, everybody? Arey, sir, no. What's private defense, first of all? An act done to protect themselves or their body or a property or a property of someone else is not punishable even if it causes an harm or death of the other person, provided if it's within the what limit? Legal limit. Private defense is not available against whom? Public officer acting within this what? Good faith, or any person acting under the directions of the public authority in what faith? Good faith. Or if there's a time to seek what help? Public authorities help. Or shouldn't use what force? Excessive force. What force? Yes or no? This one, these two topics are most important. I predict them to ask questions out of it. When private defense of body extend to causing the death, and when private defense to the property extend to causing the what? Death. Generally should not cause death, right? Resa, no. I will give an example. You guys should tell me whether it is punishable or not punishable. Okay. Now let's say, listen. Now Pradyumna is at a restaurant, not restaurant, coffee shop. He is having coffee with his fiancée. But these are all imaginations, not real things. He's having he's having cold coffee and his fiancée is having hot coffee. So that place, three gundas comes and they start teasing fiancée of Pradyumna. Now Pradyumna got angry. He threw the coffee, the coffee. To whom? To the gundas. Is Pradyumna punishable for this? Because he has thrown wait, because he has thrown a cold coffee. The person immediately goes inside the coffee shop. There is a boiling water. He brings that boiling water and he is about to throw that boiling water against his fiance. He saw this. Suddenly, somewhere he get that superpower. He suddenly kicked that person. And that person is dead. It's because of one kick that person is dead. Now tell me, will in this case is Pradyumna punishable for death? Yes or no? Is it a private defense? Did he cause death? Is he punishable or not punishable? Because that person was causing a grievous hurt to whom? Pradyumna or any other person. Private defense is available even if the harm is against you or to any other person. Or what person? Any other person. Are yes or no? Can also cause death of a person. However, it should be a grievous hurt. Like we'll discuss when a private defense extend even to causing a what? Death of a person. Not of a person. Let us discuss. Based on this, they can ask practical question in the examination. Let's see what is the first one. Assault that reasonably causes the fear of what? Death. Fear of what? Can he cause death in the situation? Reza, no. No, what if that incident happened? Now all three of them are hitting Pradyumna. Now Pradyumna is like almost about not dead. Wait, he is badly injured. Suddenly, some background music comes and he wakes up and he takes a weapon and he kills all three of them. Is Pradyumna punishable? Not punishable. Why not punishable? Because they are doing assault that reasonable because of the fear of what? Death. You can also cause a death. Second one, assault that reasonably causes the fear of what? Grievous harm, serious injury. Third one, assault with the intention to commit what? Rape. Then that girl can cause the death of a person. ऐसा no, ऐसा no. अब murder कर सकता है if that incident is happening. Next one, assault intended to gratify what? Unnatural lust. That can be the punishment. Self defense. Assault with the intent to kidnap or abduct. If somebody is trying to kidnap you, that time you can cause a death of a person. There should be imminent danger. What if he's like kid is trying to kidnap you? Can you cause a death? Huh? Kid. How can you kidnap? Small kid. Next one. It should be what if he's a big fellow and he's trying to kidnap you? Then you can cause a death of a person. Keep this in mind every point. Last one. Assault intended to wrongfully confine someone in a manner that would prevent them from what? Seeking the help. You can cause the death. Last one. Throwing or attempting to throw acid causing the what? Fear of grievous hurt. In these cases, private defense extends to even causing a what? Death of a person. There are two types of private defense. Private defense of body, private defense of what? Property. Yes or no? Last one is what? When private defense to the property extend to causing the death. What is the first one? Committing the what? When you cause a death. Yes or no? Second one, house breaking after sunset before what? Serious offense, you can kill the one who is doing the robbery. Next one, mischief by fire or explosive on human dwelling or a property storage. Somebody is trying to set your house on fire. Can you kill that person? Is it a crime? Punishable, not punishable, not punishable. Theft or mischief or house trespass only if the situation create a reasonable fear of death or a grievous hurt may happen if the defense is not used. Right. In these cases, you can cause a, and with these we are done with what? BNS Bharatiya Nyaya Sanhita. One of the interesting and easy chapter. Next we have BNSS. This is also easy chapter, easy concepts. Yes or no? If you go with these preparations, you can aram se answer any of the question they ask. Especially they ask question based on defamation. Be careful with the defamation and exception to the crime. When an act is not considered as the crime. Clear with this, everybody? Yes or no? Let's read BNSS. What is BNSS, guys? Bharatiya Nagarik Suraksha Sanhita. And BNSS. Is it a substantive law or procedural law? Does it define the rights and duties? No. Only provide the what? Procedures to enforce the law. Plus, substantive law defines the rights and wrongs. This one provides the legal process. Focus. Substantive law focuses on the offences, remedies, and punishment. Procedural law for trials, evidence, and enforcement. Substantive law is which law? BNS, contract. BNSS is a what law? Procedural law. Criminal courts in India, what is the highest court? Supreme Court, High Court, Lower Court, metro cities, we have Metropolitan Court, Session Court, Chief Metropolitan Magistrate, First Class Metropolitan Magistrate. District level, what do we have? Session Court, First Class, Second Class Judicial Magistrate, Executive Magistrate. Executive Magistrate does not have the adjudication power. Correct, right? For example, police officer are considered as what? Tahsildar is an executive magistrate. BSP is a what? Executive magistrate. Commissioner is a what? Executive magistrate. Resa, no? Next one. Tell me the hierarchy of criminal courts in India. In that district level, like तुमको लेने नहीं रहता है, session court रहता है, then first class judicial magistrate, second class judicial. All these are criminal court only, but they will have different power. Power of session judge is different. Power of First class judicial magistrate JMFC is different. Second JMFC is different. What is JMFC? Judicial magistrate first class, judicial magistrate second class. Are we clear with this, everybody? Let's start. Sentence. Power of the court to pass sentences. High Court can pass what sentence? Uh, Judge, High Court judge, what he can pass? Authorized by the law. What by the law? Should be authorized by the law. Cannot pass any. Can he pass beyond what is authorized by law? If Companies Act says for fraud, the imprisonment is 10 years. How many years? Can High Court give 11 years? Only how many years? 10 years. Whatever authorized by the law. Done. Next one. Session judge. What judge? Session judge as well as what judge? Additional session judge. Additional? ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ ನೋಡೋಣ. Additional? ಮತ್ತೊಂದು ವೆರಿ ಗುಡ್ ಇತ್ತೊಂದು ಸೇರಿಸಿ ಹೆಚ್ಚುವರಿ हाँ, हेलो हिंदी में क्या बोलता है एडिशन को हिंदी में क्या बोलता है may also pass any sentence authorized by what law. However, death sentence must be confirmed by which court? High Court for execution. You know this, right? Now darshan case is going on in which court? Ah, session court. Trial always happens in which court? Session court. High Court is appellate court. No trial happens in High Court. High Court, trial always happen in which court? Session court. JMFC first class, JMFC second class are the trial court. First trial happens. Appeal court to High Court, then to Supreme Court. Are we clear with this, everybody? Next one. Sentence which magistrate can pass. First one is what? Judicial magistrate. What magistrate? Chief judicial magistrate. How many years he can pass? Death sentence, imprisonment for life, imprisonment exceeding how many years? Can he pass all these things? No. He can pass any sentence except what? Death sentence, imprisonment for life, imprisonment exceeding how many years? Means up to how many years he can pass? 7 years. More than 7 years, it goes to where? Session judge. More than 7 years, it goes to where? Or additional session judge. Death penalty, session judge. But it has to be confirmed by whom? High Court. Getting it? Next one. Judicial magistrate first class. What class? We can impose imprisonment up to how many years? 3 years. When up to how much? Both imprisonment and fine or community service. Judicial magistrate first class to how many year? 1 year. Or fine up to how much? 10,000. Or both and fine and also what service? Community service. Can you guys write the answer if they ask question about power of the judges to pass sentence? High Court, any sentence authorized by the law. Session judge, additional session judge, any sentence authorized by the law. Chief judicial, that sentence require confirmation of whom? High Court. Chief judicial magistrate. Why? Because why death sentence requires confirmation by the High Court? Because it is a violation of fundamental right, deprivation of life right. That has to be confirmed by which court? High Court. Chief judicial magistrate. To how many years? 7 years. Not more than 7 years. You cannot pass death sentence. You cannot pass life imprisonment. Only how many years? 7. Chief judicial magistrate first class or both. Magistrate second class. Next one is important. Section number 24 is important. Sentence of imprisonment in default of fine. We discuss किया था ना हम लोग sentence, default sentence. What sentence? A magistrate can order imprisonment if the accused fails to pay the what? Fine. But it must within the what? Sentencing limit. If imprisonment is already part of substantive sentence, then the additional imprisonment cannot exceed how many months? How much? One fourth of the maximum imprisonment the magistrate is authorized to impose. The imprisonment for default can be in addition to the maximum substantive sentence that the magistrate can impose under section number what? Section number what? 23. For example, a magistrate awards how many years? How many years? Plus how much fine? 20,000 fine. On non-payment of fine, up to how many months he can pass? 6 months. Default imprisonment may be added, making the total of how many years? 2.5 years, which is legally valid. One fourth of 2 years? 2 years. How many months here they're given? 6 months. Right, right. Valid or not valid? Valid. If any default is made in payment of fine, the default sentence should not exceed the what? One fourth of the actual imprisonment. What imprisonment? The maximum imprisonment. What imprisonment? Maximum imprisonment. Aresa no. Aresa no. Can you guys read this please? If imprisonment is already part of substantive sentence, then the additional imprisonment cannot exceed one fourth of the maximum imprisonment the magistrate is authorized to impose. Authorized to what? For that offense, magistrate is authorized to impose imprisonment of how many years? 2 years. For non-payment of fine, you can add extra how many months? 6 months. How many months? If it is 6 years, what is one fourth of 6 years? For 2 years, if it is for 6 months, for 6 years, it is how many months? 18 months. Means 1.5 year. Are no. Are we clear with sentence for default in the payment of fine? We can ask practical question based on this. What they can ask? Practical question. Next one. Sentence in case of conviction for several offences at one trial. I have discussed order that punishment either they can run concurrently or one after the other. But at any time, should not go beyond how many years? 20 years. How many years? Somebody gave this answer in the yesterday's class. Somebody said 20 years is the maximum imprisonment. Yes or no? When you guys read this, please, I want everyone to read. मेरे लिए आप लोग पढ़ाई करो. I will take some break for 2 minutes. Read. If a person is convicted for two or more offences in one trial, the court may. If it is concurrently, it is the advantage for whom? Criminal. If it is consecutively, it means what? Disadvantage for him because he has to serve more number of years of imprisonment. Yes or no? आपने क्या किया? You kidnapped a kid and you killed a kid. There are two offences. One is what? Kidnap. Other one is what? Murder. You can be convicted for both the offences and you can be granted imprisonment for both the offences. Either it can run concurrently or consecutively. If it is concurrently, if it is 5 plus 5 years of imprisonment. But I say it run concurrently means what? Maximum how many years to serve? 5 years. If it is consecutively, 10 years. But maximum how many years? Continue. And limit on what? Punishment. If sentence runs, if a person is convicted for multiple offences and if the court decides that punishment to run consecutively, the maximum imprisonment should be how many years? How many years? Next one. Cannot exceed twice the maximum punishment the court can impose. Should not go beyond the maximum imprisonment. Appeal rights of the convicted person. If multiple consecutive offences are sentenced, the total sentence will be considered as what? Single sentence for the purpose of an. The purpose of what? Yes or no? Can I show the example, please? I want everyone to read the example. Based on this, there can be question in the examination. Read. Okay, 20 years or maximum twice the maximum imprisonment. What is twice the maximum imprisonment here? 24 years. 24 or 20, whichever is less. Which one is less? 20 years. Are we clear with this, everybody? Inherent powers of the High Court. Do High Court have inherent powers? What is inherent powers? Deemed power or implied power in the interest of justice. Interest of what? Justice. See, even though something is not mentioned in the BNSS, still High Court can act upon it in the interest of justice. Interest of what? Justice. Let's start section number 528, everybody. Resolve the inherent powers of the High Court to pass orders to give effect to BNS provisions or to misuse the court process and secure the justice. See, section number 528 provides the inherent powers to the High Court, either to implementation of BNSS provisions or to secure the justice or to prevent the misuse of what process? Court process. The power of the High Court are partly administrative and partly what? Judicial. Inherent powers under section number 528 includes power to quash FIR. Quash means what? Cancel FIR, investigation, or any criminal proceedings pending before the High Court or any court subordinate to it and are of wide magnitude and ramification. Court can always take note of any miscarriage of justice. What carriage of justice? And can prevent the same by exercising its power under section number what? 528. Keep this in mind. If there is a specific provision, what provision? In BNSS, you cannot use section number 528. Only when there is no provision and in the interest of justice or to prevent the abuse of court process, the High Court can use the what? Inherent powers. What powers? Are you guys clear with this? Based on this, you can ask questions in the examination. Next one, arrest of a person. What of a person? Have I discussed how the arrest is done? Proclamation of offender, cognizable offense, non-cognizable offense, when arrest can be made, what are the protection for arrest of a woman? Resano. Mm, hmm, That's it. This one. Yeah. Ah, let's quickly go through this, everybody. Huh? Case law, crime. Cheating by personation. That's it. Arrest of a person. What is the one more? Let's finish this, guys. Let's please finish this. Everybody start. Let's start. Arrest. What is arrest? Custody of another person under the authority empowered by law. It is considered as what? Arrest. Can there be arrest without warrant? Cognizable offences? Yes. Non cognizable offences? No. Let's read. A police officer may arrest a person without the order from the magistrate, without a warrant, in the following cases. What is the first one? In the presence of who? Police. Second one, cognizable offense with the condition if a reasonable complaint or credible information or suspicion exists that person committed a cognizable offense, he is punishable with imprisonment of up to how many years? 7 years. And the police officer believes the person has committed the what? Offense. And the arrest is what? Necessary to prevent a further offense, ensure proper investigation, prevent tampering with evidences, prevent threat or inducement to the witness, or ensure accused appears before the what? Court, or the police officer must record the reasons for arrest in writing. If no arrest is made, reasons for not arresting must also be recorded. This is for up to 7 years. Up to how many years? If he is accused of a cognizable offense, which is punishable with more than how many years? Or how many years? Only what is important? Credible information. If there is a credible information exists that the person is committed a what? Offense punishable with more than how many years? 7 years. Is it more than 7 years or 7 years or more? More than 7 years. In that situation, police can arrest without any what? Warrant. See, up to 7 years, you should record the reasons for arrest. And you can arrest for what reasons? These reasons. You cannot arrest directly. Correct, right? You should have a reasons to arrest. But if the offense is punishable with more than 7 years, when you arrest a person, you have received what information? Credible information. Next one. What is the next one? Proclaimed offender. What offender? Fifth one. Person in possession of what property? Stolen property. Obstruct the whom? Police are escaping the custody. A deserter of what forces? Armed forces. He can be arrested wherever he is found. Next one. Offense is committed where? Outside India. And if he is subjected to extradition, means to be sent outside India. A trial. Correct, right? You can arrest that person. Foreign is citizen of India, a citizen of some other country, has done a fraud where or crime where outside India and is hiding in India. If you find him, can you arrest him immediately? Yes. Next one, release convict, violating the what? Rules, arrest immediately. Requisition from whom? Another police officer. In that situation, a police can arrest without any warrant or the permission from the magistrate. They can ask this question in the examination when police can arrest a person without warrant. What is the first situation? If he commits the offense in whose presence? Police officer present. If it is up to 7 years, cognizable offense, and he has the reasons to believe that what is necessary, arrest is necessary. More than 7 years, credible information, arrest. Next one, proclaimed offender. Next one, possession of stolen property. Next one, obst- Next one, deserter from the armed forces. Next one, offences committed outside India. Next one, released convict for the violating rules, acquisition from another police officers. Are we clear with this, everybody? Notice instead of arrest for what offences? What offences? Police officer, in all cases, continue. Credible information, a reasonable suspicion exists that he has committed a what offense? If you notice to the whom? Accused to appear before them. Person must comply with the what? Notice. If the person complies, they cannot be arrested unless the police record the reasons for doing so. If the person fails to comply or refuses to identify themselves, the police may what? Police may what? Right, right. Next one. Special protection for what person? Elderly and infirm person. You need a permission of whom? DSP. Permission of whom? to arrest a person who is of how many years of age, and the offense is punishable with imprisonment of less than how many years. Therefore, arrest and duties officer making the what? Arrest. What is the first one? He has to identify himself. He has to wear the badge with a clear, he's showing his name. Preparation of what? Arrest of memorandum should be signed by whom? Member of the family or respectable person from the locality where the arrest was made. Should be countersigned by the arrested person to acknowledge the arrest. Right to inform who? Relative or the friends if they were not present. Right to meet the advocate of his what? Choice during the interrogation. But he cannot be present throughout the interrogations. But he can meet before the interrogation. Next one. This is in case of non-cognizable offense. If any person commits a non-cognizable offense, huh, and if they refuses to provide their what? Name and address or provides false identity details, then the police officer may arrest the person to ascertain their what? True name and residence. Once the identity of the person is confirmed, they shall be released on a bond or a bail bond with a condition to appear before whom? Magistrate, if required. Because it is a non-cognizable offense. If the person is not resident in India, then the bail bond must be secured by what? Indian surety or surety. If the person's true name and residence are not ascertained within how many years of arrest, or if the person fails to furnish a bail bond or sureties as required, police must immediately present the person before the what? Nearest magistrate with the jurisdiction. Can a private person arrest a person when a person commits a non-bailable and non-cognizable offense in their presence, and the person is a what? Proclaimed offender. In these two cases, a private person can arrest. What if I commit a murder in classroom? I kill somebody in the classroom. Is it bailable, non-bailable? Cognizable, non-cognizable? Can you arrest me? Will you guys hold me and take me to the police station? Or will you hit me? Can you hit and cause death to the person? Can you arrest me? ಕೈ ಕಾಲ್ ಕಟ್ ತಗೊಂಡೋಗಿ where he will give police station. Can you do that? Procedure of what if I have done some, I slapped somebody. Can you arrest me? Is it cognizable, non-cognizable? Slapping somebody, cognizable, non-cognizable? Non-cognizable. It is not a serious offense, na? Aisa, no. Once arrest is made, what is supposed to do? Hand it over to whom? Police officer within how many years of arrest? If no police officer is available, the nearest police station. Role of the police after a private arrest. What they're supposed to do? Should take them into custody and should produce him to the what? Magistrate. Aisa, no. Can a magistrate arrest a person? When if an offence occurs in the presence of a magistrate within his what? Jurisdiction, magistrate may arrest the offender himself or order the person to arrest the offender. After arrest, magistrate may commit the offender to custody or subject to provisions with respect to the what? Bail. Arrest by magistrate at any time within the what? Jurisdiction. Magistrate may arrest any person himself or direct someone to make an arrest if a person is within the what? His jurisdiction, and if the magistrate has the authority to issue the warrant for the person's arrest under the given circumstances. How arrest is made? Can you guys write about how arrest is made? Important. Make it important. They can ask in the examination. When a police person confine a person, when they use the force, can they use the handcuffs? Only if he is a what? If he has a criminal history. What history? Reza, no. Or it includes organized crime, terrorist, drug offences, murder, rape, human trafficking. For small offences, you cannot use the handcuffs. Next one. Restrictions on use of what force? Deadly force. They cannot use a deadly force. Is there any special rules for women? Yes or no? Oral submission is sufficient. You cannot touch and confine the woman. In case of woman, a male officer should not touch woman's body unless it is absolutely necessary. It should be a female police officer. Women cannot be arrested after what? Sunset and before the sunrise. In such a exceptional cases, women police officer must obtain the what permission? Return permission of the magistrate of first class. If you want to arrest after sunset and before the sunrise. Other relevant provisions similar to these constitutional provisions, once you arrest should produce before whom? Magistrate. Within how many hours? Magistrate can give accused to the police custody only for how many days? 15 days. Or how many days? Not more than 15 days. Have I discussed about summons and warrant? What is summons? It's a legal document calling a person to attend before whom? Judge or an officer of the court. It is considered as what? Summons. Are sir, no. Is it required to be in writing? Required to be issued in duplicate? Signed by which officer? Presiding officer. Must be the seal of what? Court. In case of e-summons, it can be signed by the digital signature certificate. Service of summons. Who can service the summons? Police officer, any officer of the what? Court or any other public servant authorized by the state government. Methods of serving summons, personal or physical delivery or as by what? Electronic service. Service on body corporate. What corporate? We can ask this question. In case of body corporate or the partnership of societies, how it is served? It is served by delivering it to whom? Director, manager, secretary, or any other officer of the company. Alternatively, a registered post addressed to any officer is considered as what? Valid service. Service of summons on the firms and associations on whom it is served? Any partner. Service when person summons cannot be found. Important here. If the person cannot be found at a particular place, how it is served? Leaving the copy with whom? Adult family member who resides with the person, or the adult family member may be required to sign the receipt on the back of the other duplicate. Next one. Adult female member, adult male member. Earlier it was only male, but the girls and the feminists started saying that it is a discrimination. Why not female? That is why they introduced the word any person. Adult person. Next one. It is most important. Based on this, they ask questions in the examination. Where a person is escaping, avoid the summons. How it is served? How it is served? Affix the duplicate of the summons to the what? Conspicuous spot of the house or homestead where the person usually resides, and the court may then require that declare the summons has been duly served. Order a fresh attempt. Next one, service on the government service, government servant where it is sent the head of the department. What of the department? Then he will serve it to the employees. Service of summons outside the local limits in that situation, it can take the help of other magistrate. Correct, right? One court can send it to the other court will serve the summons to the person who is accused. Proclamation and attachment. Have I discussed about proclamation and attachment? What is proclamation? If a warrant is issued against a person and the person has what? Absconded or concealing themselves to avoid the what? Arrest. The proclamation requires the person to appear at a specified place and time, not less than how many days? 30 days. If the person fails to appear within the what time? Specified time, and the offense they are accused of punishable with how many years? 10 years or more. Or life imprisonment or death, the court may, after inquiry, declare them as what offender? Proclaimed offender. If a person is a proclaimed offender, can police officer, sorry, any person arrest him? Can police arrest him without warrant? Yes or no? Proclaimed offender. Next one. What is attachment of property? Taking the like it restraining a person from transferring the property. Correct, right? So once a proclamation has been made, section number what? 84. The court may order the what? Attachment of their property. Should be they should mention the reasons in writing. Immediate attachment may be ordered simultaneously with the what? Proclamation if the court is satisfied that the person is about to dispose their property or is about to remove the what? Property from the court's jurisdiction. When he is about to sell the property, the court can order for what? Attachment of property. What are property? Attachment of property. Have you heard about search warrant? When the court can issue search warrant, the court believes that person will not comply with what? Summons, or the document, parcel, or a thing is not known to be in anyone's possession, or a general search or inspection is necessary for the purpose of what? Inquiry, trial, or other proceedings. Warrant allows search or inspection in accordance with the what? Court directions. The court may specify the exact place or area where the search or inspection shall be conducted. If the place is specified, the executing officer must limit the search to that particular area only. Correct, right? Only the district magistrate, judicial magistrate can issue search warrant for what? Postal records. Search of place suspected to contain what property? Stolen property or court document. Who can issue warrant? PM, HDM or magistrate of first class. When if they have reasons to believe that a person is having the what? Stolen property or stealing or selling, producing what items? Objectionable articles. They can ask question in the examination. What are objectionable articles? What are objectionable articles? Counterfeit coins, metal pieces violating the what act? Coinage act, counterfeit currency notes and counterfeit stamps, forged document, false seals, obscene object. What object? What is obscene object? There are items which are prohibited, and if you keep those obscene objects, they can be what warrant? They are considered as objectionable item. What items? Are instrument or materials used to produce the what? Above items. These are considered as objectionable items. If a person is having the objectionable item, court can issue what warrant? Search warrant. What warrant? And a search warrant gives the power to the police officer to enter and search the premises, seize and suspected the stolen property are objectionable items. Present the seized item before whom? Magistrate. Arrest a person found in the premises who are suspected of knowingly dealing with such illegal items. All these things can be done by whom? By the police officer. Remember these objectionable articles. What articles? Objectionable article. Next one. Can there be a search warrant for an person wrongfully confined? Yes or no? Next one, recording of search and seizure through what means? Audio, video, electronic means. All these things to be done to protect the um, evidence. Next one, summary trial. What trial? What is summary trial? Disposal of the cases is called as what? Summary trial. Offences that can be tried summarily. They can ask this question in the examination. What offences can be tried summarily? What is the first one? Theft where the value does not exceed so much? 20,000. Receiving what property? Stolen property. Assisting in the concealment or disposal of what property? Stolen property. Respect to mischief or causing loss or injury. Insult with intent to provoke breach of peace or criminal intimidation. Abatement of any offences listed above. Attempt to commit any of the above offences. Offences with respect to what? Trespass. Cattle trespass. These are considered as what? A triable what? Summarily. In case of summary trial, what is the maximum imprisonment be given? 3 years, 3 months. Not exceeding how many months? 3 months. How many months? 3 months. Um, Maximum imprisonment for summary trial should not go beyond how many months? 3 months. The magistrate may, at their discretion, also try in a summary way any other offences not punishable with what? Death for life and not exceeding how many years? 3 years. Along with those offences, specific offences, magistrate can try even some other offences which are punishable with less than how many years? 3 years. But the imprisonment ordered should not go beyond how many months? 3 months. How many months? Compounding of offenses. Compounding of what? Offenses. What is compounding? Settlement of the offenses. Generally, criminal offenses are non-compoundable, but there are exceptions. What are those exceptions? What is the first one? Second one, wrongfully restraining or confining any person. Third one, assault or use of criminal force. Fourth one, theft. Fifth one, sixth one, assault or criminal force in attempting to wrongfully to confine a person. Seventh one, a criminal breach of. These are compoundable offenses. One more important topics based on which they can ask questions in the examination. They can ask what are the compoundable offenses. Last one, bail. What is bail? Release of temporary release of accused from the custody of the police officer to the custody of a private individual is called as what? Bail. There are how many types of bail? There are three types of bail. Regular bail, and only High Court can give what bail? Anticipatory bail. Hmm. Bail puriyallappa, bail. Anticipatory bail is only given by whom? High Court or the Court of Session. Court of what? Session. A person who reasonably believes that they may be arrested for committing a non-bailable offense can apply to which court? High Court or the Court of Session for anticipatory bail. Conditions for availability of anticipatory bail. What is the first condition? No threat or promises or inducement to witness any familiar with the case details, not leaving India without whose permission? Court permissions. Any other suitable condition. Next one, 514 to 516 period of what? Limitations or cognizance of offences. Generally, there is no limitation period for criminal offences, but there is a limitation period for petty offences. If an offence is punishable with fine only, not only, what is the limitation period? 6 months. If it is not exceeding 1 year, if the offence is punishable with the imprisonment for a term not exceeding 1 year, what is the limitation period? 1 year. If the offence is punishable with the imprisonment for more than 1 year, but not exceeding how many years? 3 years. Next one. When the limitation period commences, when the offence is not known immediately, the date when it comes to whose knowledge? Offender's knowledge. When the identity is not known, identity is ascertained. Last one, exclusion of what date? Starting date. We know that starting date should be excluded. Exclusion of time in what cases? Certain cases. This also we have discussed in the which act? Limitation Act. Can you guys read the first point, please? Should be excluded. Next one, High Court can issue stay order, right? That should be excluded. Next one, if you are supposed to give notice to any authorities, that should be excluded. Next one, next one. The period when the accused was absconding or concealing what? Himself. Next one, continuing offense. What is continuing offense? If an offense is done by a group of people over a period of time, it is considered as what offense? Continuing offense. Is it a single act or a continuous offense? In case of continuing offense, a fresh period of limitation begins to run at every moment during which offense continues. For example, uh, unlawful dumping of waste. Mm, right. Yes, it continues to run, right? In case of continuing default, with a further fine of 5,000 rupees per day. If you fails to hold AGM within 6 months of end of financial year, you are liable to a punishment of up to 1 lakh rupees of fine, and with a further fine of 5,000 rupees per day in case of continuing default, subject to maximum of 1 lakh rupees. So it is 1 lakh plus 1 lakh, maximum only. With these, we are done with what? BNS and BNSS. I want everyone to now focus. Let's start. What is the first one? Can you write the answer? Next one. Separation. The the counterfeiting the coin. Hmm. Elements of crime. State the exceptional cases where what is not required. Means temporary exclusions, petty offences, where it is difficult to prove. Yes, I know. Third one, because there are exceptional cases where even there is no mens rea, still it is what? Punishable as a crime. Next one, conscious exercise of mental faculty. Next one, for every question, write the same answer. Clear with this? Next one, distinguish between motive and next one, mens rea and for difference, you guys go through the material. Next one, question number 6. Is it true or false? False. Can a company be prosecuted for criminal offences? Because even company can have what we are might alter ego. Types of punishment. This question was asked in December 25 for 5 marks. Read. Next question. A person community service. First time offender, property is recovered. Less than how much? 5,000 rupees. What is applicable? Community service. If you know, balanced and rehabilitative justice. Illy then already community service. What is the first one? First conviction. Petty theft. Not pretty. So not pretty. Petty theft involving what? Property valued below how much? 5,000. And the property must have the recovered. So the reason I am telling you guys to read. Next one. कलर भी किया है देखो कलर भी किया है मैंने फाइन एंड व्हाट पेनाल्टी डिस्टिंक्ट बिटवीन व्हाट फाइन एंड पेनाल्टी लिख सकते हैं क्या आप लोग theft robbery and extortion wait I could not do coloring for this topic sorry can you guys read the question December 24 they asked for 5 marks read क्या क्या होना चाहिए dishonest intention without consent what property movable property possession of the other person moves the property yes or no question number 2 is it a theft question number is it extortion yes it is called as what extortion now why did I include it in the theft sorry next one when a person is put into the fear of what death when he causes a death hurt or wrongful restraint or instant fear of death hurt or wrongful restraint then it is considered as a robbery become robbery yes or no Gayatri, can you guys read this which means reward yeah they shot down one of the villager Daikaiti, robbery, five or more person, it is considered as what? The guy. Question number 2. Is it a dacoity? How many persons are there? This question was asked in which examination? December 20. Last exam. only ಕೇಳಿದೆ. How many marks? 5. Extortion. Can you guys read extortion, please? December 25. Is it a extortion? Priya forced Neha to sign a check of how much? Else she will publish a false and damaging information about Neha's family in the local newspaper. Neha, afraid of the damage to her and her family's reputation, did according and signed a check. Is it a extortion? She delivered anything valuable, convertible into valuables. Set. Right, right. Is it considered as extortion? Discuss. Question number 1. Misappropriation. Next one. Huh? It is not. Read once, then we will do something after the break. What is become blur in this? Should I close it? Who is ready to go for lunch? Lunch fellow. Who is that lunch fellow? Are you guys able to answer the questions of previous examination? That is what matters the most. Everybody read, everybody. If you don't read, astray. Read. Now is it clear? This one, question number 315. Is he punishable for misappropriation of property? Yes. Next question number 123. This question was asked in December 25 for how many marks? 5 marks. So minimum 10 marks questions will come out of what? BNS and BNSS. Yes or no? Read question. Is it a criminal breach of trust? Yes, because he asked him to invest in what? Government securities. But he bought which company share? XY Limited share. ಹೇಳಿದ ಕೆಲಸ ಮಾಡಬೇಕು. Next one. Question number 2. Criminal breach of trust क्या? मैंने आपको ट्रस्ट करके दिया था, आपने मिस अप्रोप्रिएट कर लिया. Is it considered as a criminal breach of trust? Yes. Question number 3. This question was asked in December 25. Ambuj. Next one. Ingredient of what? Cheating. Ah, no. Because he was acting in what faith? Good faith. A bona fide belief that certain property belongs to him. Purchaser also under the same belief purchased a property. Same. This question was asked in each examination. Remember 25. Oh, it means already 15 marks questions were asked. Whether A is liable or not liable. A is liable or not liable. Are A is liable or not liable? Not liable. Yes or no? Breaking promise without any what? Dishonest intent. It is not considered as what? Cheating. Yes or no? Next one. Read exam. One more question. Anand could not clear his civil service interview. Is it cheating? Yes, she is punishable. Cheating. Next one. Cheating by personation at a short note. At a short note on the fraud connected with a insolvency, forgery, defamation, exceptional defamation, libel and slander. And this lengthy question was asked in the previous examination for 10 marks. You guys can go through it. This question was asked in December 2023, I guess, out of this question. General exceptions, private defense, BNSS, power of the court to pass what? Sentence. When police may arrest without any what? Warrant. Arrest by private person. How arrest is made? Summons and warrant. Based on this, there is one more question. 20 marks ho gaya na? But there will be a choice, right? Like 6A1. Can you guys read this question? What is meant by what? Summons under the BNSS. Discuss the provision with respect to service of what? Summons. On what bodies? Corporate bodies, partnership firms, and societies. Did I discuss this concept? Proclamation, search warrant, summary trial, compounding of offences. And if you see the question bank here, it covers most of the topics. So what you should do once revision is done, one time revision is done, stick to the question bank and short. That is why I said don't without solving the question. And it is like arranged topic wise so that it becomes easy for you guys to know what type of questions will come based on which topic and how to prepare for it. Any question on the topic, you write the same answer. Understood? With these, we are done with BNS and BNSF. Clear? Next instrument. So, Negotiable Instrument Act 1881, as the name itself suggests, it is a law to deal with negotiable instrument. There are three negotiable instruments. What are the three negotiable instruments we have? Promissory note, bills of exchange, check. That's right. Promissory note, bills of exchange, check. These are considered as what instrument? Negotiable instrument. Correct, right? Next one. See, the definition of negotiable instrument is negotiable instrument means promissory note, bill of exchange, check, which are payable either to order or bearer. When it is payable to order, expressed to be payable, or when it is payable to specific person and does not prohibit the further transfer. When it is payable to bearer, when it is expressed to be payable to bearer, or if it is where the only endorsement or the last endorsement is the endorsement in blank, then it is considered as what? Payable to bearer. Payable to whom? What is payable to bearer? Whoever has it can get the payment. It is called as what? Payable to bearer and payable to order. Are you guys clear with this? Now, if I make a promise to pay to Jitender, it is what? Payable to order or payable to bearer? Payable to order. Jitender, order is order. Now, what if I say I promise to pay to Mr. X? Order is order, 1 lakh rupees. It is what instrument? Order instrument or bearer instrument? Order. Payable to is order. This is expressly mentioned. Now, what if I say I promise to pay the bearer 1 lakh rupees? Payable to whom? Bearer. Expressed to be payable. Now, what if it was payable to Jitender? He do endorsement by signing at the back of the instrument without mentioning whose name? Endorsee name. That is considered what endorsement? Blank endorsement. If it is a blank endorsement, it becomes what instrument? Bearer instrument. What instrument? Are you guys clear with this? So, promissory note, bill of exchange, or a check may be payable to bearer or to the order. And we discussed when it is payable to bearer or when it is payable to order. Directly come to classification of negotiable instrument. There are chances of asking question based on the classification of negotiable instrument. Yes or no? What is the first one? इसको हम लोग already discuss किया promissory note, bill of exchange, check payable to bearer when it is expressed to be so payable. Our only endorsement or the last endorsement is what? Endorsement in blank. What is order instrument? A promissory note, bills of exchange, check is payable to order when it is expressed to be so payable or it is expressed to be payable to particular person and does not contain any word prohibiting the transfer or indicating an intention that it shall not be transferable. That is considered as what instrument? Order instrument. Next one is inland instrument. Tell me what is inland instrument? Next to Kirti will tell what is inland instrument. What's her name? Preetu. You remember your name. Next to you. Ritu. Ritu, what is inland instrument, Miss Ritu? The instrument which is drawn on the land is called as inland instrument. What is inland instrument? Instrument which is drawn on the land is considered as what instrument? Inland instrument. An instrument is considered as inland instrument if it is drawn or made in India. Drawn or made in India and drawn upon a person who is resident in India or payable in where? India. Any one condition satisfied out of the remaining two, it is considered as what instrument? Inland instrument. What is the first condition? Which is the must condition? Be drawn or made in India. Condition must be satisfied. Along with that, out of remaining two, any one condition to be satisfied. What are the remaining two conditions? Drawn upon a person resident in India or payable in India. Any one condition must be satisfied. Now, what if I make an instrument in Bengaluru, drawn upon a person who is in USA, payable in India? What instrument? First condition, out of remaining two, any one condition to be satisfied. Now, what if instrument is drawn in USA, drawn upon a person who is in Chennai, payable in Bengaluru? Foreign instrument, because first condition is must. Should be drawn in India. Drawn where? India. A promissory note, bill of exchange, check is considered as inland instrument if it is made in India and made payable in or drawn upon a person who is resident in India shall be considered as what instrument? Inland instrument. What is foreign instrument? Which is not a inland instrument. Exactly. If it is drawn outside India or even if it is drawn in India, if it is drawn upon a person who is resident outside India and payable where? Outside India. दोनों कंडीशन सेटिस्फाई नहीं हो रहा है ना इट इज कंसिडर्स व्हाट इंस्ट्रूमेंट फॉरेन इंस्ट्रूमेंट व्हाट इंस्ट्रूमेंट are you guys clear with this everybody yes or no what is the first type of instrument order instrument bearer instrument third one inland instrument fourth one foreign instruments are we clear with this everybody and next one demand instrument what instrument what is demand instrument the instrument which are payable on demand there is no grace period what period grace period yes or no it is considered as let's start inland china guy concentrate. Inland instrument. What instrument? Inland. Partner. Now, what is inland instrument? Instrument, promissory note, bill of exchange, check which is drawn or made in India and drawn upon a person resident in India or payable in India. It is called as what instrument? Inland instrument. What is foreign instrument? Or drawn upon a person resident outside India or payable. What is demand instrument? A promissory note, bills of exchange, where no time for payment is specified. It is considered as what? Demand instrument. What instrument? Demand instrument. See, wherever the word on comes, on presentation, on site, or on acceptance, it is considered as what instrument? Demand instrument. Demand instrument, there is no grace period of how many days? 3 days. But if it is payable after site, after acceptance, after specific period of time, it is considered as what instrument? Time instrument. After it is time instrument. On demand instrument. If it is payable at site, on site, after site, time instrument. And in case of time instrument, there is a grace period of how many days? 3 days. Everybody, how many days? 3 days. So can you guys tell me what is demand instrument? Promissory note, bill of exchange, in which no time for payment is specified, and a check are always payable on what? Demand. Keep this in mind. Check is always payable on demand. Instrument payable on presentation, on site, or a check is always considered as what instrument? Demand instrument. Then comes time instrument. What instrument? A bill or a note which is payable after a fixed period. What period? Or after site or on a specified day or on the opening of an event which is certain to happen is known as what? Time instrument. Correct? Right? After there will be grace period of how many days? How many days? 3 days. Next one, ambiguous instrument. What is ambiguous? Sir? What is ambiguity? Confusion. Where an instrument can be considered either as a bill of exchange or as a promissory note at the option of the holder, it is considered as what instrument? Ambiguous instrument. If I try a bill of exchange where I am the drawer, I am the drawee, you are the payee. Who is liable to make the payment here? I am only liable to make the payment. It is same like what note? Promissory note. What note? Now, the holder of the instrument can treat this instrument either as a bill of exchange or as a what note? Promissory note. From that date, it is considered as whatever he chooses to treat it as. Correct, right? If I am the drawer, I am only the drawee, you are the payee. Ultimately, I'm only liable to make the payment, right? It is same like what note? Promissory note. Even though I mentioned this as a bill of exchange, you can take this as what? Promissory note. It is why it is considered as what instrument? Ambiguous instrument. Are we clear with this, everybody? Next one, eighth one, inchoate instrument or incomplete instrument. What is inchoate instrument? Which is incomplete in the negotiable instrument. When a person signs and delivers an instrument, whether it is wholly blank or partially incomplete, he gives a right to the holder of the instrument to make it complete by specifying the what? Any amount. Specifying the what? Specified by the holder, but not exceeding the amount covered by what duty? Stamp duty. What duty? Are you guys getting it? Yes or no? For example, let's say I'm liable to pay 1 lakh rupees to you. What I will do, I will give a blank instrument. I will just sign it. It is stamped. I will sign it and I will deliver it to you. It is considered as what instrument now? Incoherent. Is it complete or incomplete? Can you make it complete by writing the any amount? What amount? But not exceeding the what duty? Every transaction covers every stamp duty covers certain transaction. If up to 1 lakh, 100 rupees stamp paper, more than 1 lakh, this is the amount of stamp paper. Correct, right? Even in case of memorandum of association, depending upon your authorized capital, what will change? Stamp duty will change. What will change? Correct, right? So, no. So, if let's say stamp duty, there is a stamp paper worth of 5,000 rupees that covers transactions worth of 1 lakh. How much? I give a stamp paper to you, signed, and I'll deliver it to you, which is incomplete. This is considered as what instrument? Incoherent instrument. Can you make it complete? Specifying what amount? Any amount. To how much? Can you mention more than 1 lakh? Whatever covered by the stamp. What is covered by the stamp duty? 1 lakh. Can you mention 1 lakh? But what if I'm liable to pay only 50,000 rupees to you? Can it still fill 1 lakh? But how much I'm liable to pay you? How much you can recover? 50,000 rupees. But if you transfer it to a person who is acting in good faith, what faith? For a valuable consideration, who is considered as holder in due course. What in due course? That fellow can recover how much from me? 1 lakh. That is considered as inchoate instrument. What instrument? Inchoate instrument. Can you guys read inchoate instrument, please, everybody? I want everyone to read these provisions. Fatafat, 2 minutes. You guys read this provision. If you want any explanations, I'll give the explanations to you guys. Go through it fast, everybody. जोर से पढ़ाई करो. Are incomplete in some respect. Paper must be properly stamped as per the law. As per section 20, when a person signs and delivers a stamp paper, either blank or incomplete, by doing so, he gives prima facie authority to the holder to fill in the blanks or to complete the instrument. The instrument can be completed for any amount specified by the holder, but not exceeding the amount covered by the liability of the signer. For holder, how much is liable? How much I intended to pay to you? 50,000. I'm liable only for 50,000 rupees, even if you fill 1 lakh rupees. But to a holder in due course, what in due course? Who is holder in due course? Any person who receives the instrument for a valuable consideration. What consideration? Before maturity. Before what? Maturity. Acting in what faith? Good faith. Is considered as what in due course? Holder in due course. What in due course? That person can recover how much from me? 1 lakh. The full amount, which is covered by the stamp duty. They can ask practical question based on this. Are we clear with the types of instrument? Yes or no? What are types of instrument? Order instrument, bearer instrument, demand instrument, foreign instrument, demand instrument, time instrument, ambiguous instrument, incoherent instrument. Okay, with this, everybody. Now, section number 13 defines negotiable instrument. What instruments? What are negotiable instrument? Negotiable instrument means promissory note, bills of exchange, check. 1 plus 3 is how much? 1 plus 3 is how much? Section number 4 deals with promissory note. After 4, what comes? 5. Then bill of exchange. Covered under section number what? 5. After 5, what comes? 6. 4, 5, 6 deals with a promissory note, bills of exchange. 10. Which section number defines a negotiable instrument? Section number 13. Section number what? There are how many negotiable instruments? What are the 3 negotiable instruments? Promissory note, bills of exchange. Check. Math on the next one. Are you guys clear with this, everybody? Resa, no. Let us discuss promise. What is promissory note? Is it required to be in written form? Every note should be in what form? Written form. It's a what? Instrument in writing. Containing what? Unconditional order undertaking. Under unconditional undertaking. Promising to pay what? Certain sum of money. Signed by whom? Promising to pay what? Certain sum of money. To whom? Specific person, or to his order, or to the bearer. But as per RBI Act, promissory note cannot be made payable to whom? Bearer. Simple say simple. The moment I say negotiable instrument, the first thing is it should always be in what form? Written form. What form? With the instrument. Because it always create a right. As a what? Instrument. What is the instrument? Or is the promissory note is the instrument? What instrument? Negotiable instrument. What instrument? Negotiable instrument. Is bill of exchange is the instrument? Check is the instrument. So every time if they ask question about what is promise note, what you first you write? Instrument. In what form? Because instrument must be in what form? It's an instrument in containing what? Signed by whom? Signed by the maker. Signed by whom? Maker. Promising to pay what? To whom? Certain person. Or to his order. Or to the bearer. It is considered as what note? Promissory note. The one who makes the promissory note is called as what? Maker. The person to whom it is payable is called as what? Payee. Called as what? Payee. Who am I? Who are you? If you transfer it to somebody else, you are called as what? Endorser. Another person is called as what? Now, who is holding the instrument? You are holding the instrument. You are called as what? Holder. Holder. Now you transfer it to whom? Endorsee. Now, this person is called as what? Holder. Holder in due course only when you have a defective title and you transfer it to somebody who's acting in what faith? Good faith. That person becomes holder in due course. Are we clear with this, everybody? Yes or no? Who makes the promissory note? To whom it is payable? Can pay it, transfer it? Then he is called as what? Other person is called as what? Yes or no? And who is holder? One who is having the possession of the instrument in his own name. What name? And is entitled to receive the benefit of the instrument. Then he is called as what? Holder. Having possession is not sufficient. I should be entitled to the what? Benefit of the instrument. What of the instrument? Benefit of the instrument. Yes or no? Are we clear with this? Can you guys set the features of promissory note? Everybody, there will be how many parties, guys? Maker, payee, holder, endorser, endorsee. Can you guys go to the essentials of promissory note? Is it required to be in written form? Promise to pay, order to pay, or promise to pay? Is it required to be conditional or unconditional? See, if it is depends upon the uncertain event, what event? It is considered as conditional one. If it depends upon the happening of certain event, what event? Like that. Is it valid? Yes, it is valid. But if it depends upon the happening of an uncertain event, what event? Uncertain event. Is it valid or not valid? Not valid. Are you guys getting it? For example, if I make a promise to pay 1 lakh rupees on death of X, is it valid? Valid because death is certain to happen. What is certain to happen? Death. Now, what if I make a promise to pay 1 lakh on the marriage of somebody? Not valid because marriage is not certain to happen. You may get married, you may not get married. Reza, no. It's your choice. Next one. It will be signed by whom? Maker must be what? Sir, that. If we pay only what? Money and not money only. What if you make a promise to give a donkey? Is it valid or not valid? Not valid. Promissory note should only contain the word money. Next one. Promise must be the what? Legal money of the country. It must be on what paper? Stamp paper. It must contain the what? Name, place, number, and date on which the instrument was made. Are we clear with this, everybody? Next one is bill of exchange. Next one is what? Again, what is bill of exchange, everybody? It's an instrument in containing order undertaking. Signed by whom? Promising to pay, directing whom? Certain person. To pay what? Certain sum of money. Only to or to his order or to the bearer. That is considered as what? Bills of exchange. There will be how many parties in bill of exchange? How many parties? कितना है? One, two, three. How many parties? Three parties. What are three parties? Drawer, drawee, pay. Can drawer and pay be same? Can drawer and pay be same? Can drawee and pay be same? Because who is liable to pay the money? Drawee to whom? Pay. Drawee is liable to pay whom? Pay. Arey ऐसा no. Can drawer and pay be same? Can drawer and payee be same? Yes. Can drawee and payee be same? Because who is liable to pay? Who is liable to pay? Drawee. To whom? Payee. Payee is the one who receives the money. Can drawee and payee be the same? You change the question and you only answer. Drawer and payee, right? What, Annapurna? You're saying something, huh? Drawee and payee? Huh? I am the drawer. You are the drawee. It means who is liable to pay? I am ordering you to pay. Means you should pay. Can you make a promise to yourself to pay? So who should be different? Drawee and payee must be different. But can drawer and payee be same? How? I can order you to pay the money to understood. Same like a check, self check. Check is the bill of exchange. Check is a what? Bill of exchange. Arey, ऐसा no. What is bill of exchange, guys? What is bill of exchange? Containing unconditional order. Directing whom? Certain person to pay certain sum of money only to his order or to the bearer. ऐसा no. There will be how many parties in bill of exchange? Drawer, drawee, pay. बोलो. Generally, who accepts the bill? Drawee only accepts the bill. What if you don't accept it? Someone else will also accept it. Then person is called as what? Acceptor. Called as what? Acceptor. Who will drawee in case of need? Drawee in case of need. See, along with the original drawee, if a drawer mentions any other person who can be resorted to, if the original drawee refuses to accept the instrument, is called as what? Drawee in case of need. Now you are the original drawee, but I have a fear that you may not accept the bill. Along with your name, I mentioned some other person's name. Then now that other person is called as what? Drawee in case of need. ಬೇಕಿದ್ದಾಗ ಮಾತ್ರ ಅವನು ಬರ್ತಾನೆ. ಅವನು ಯಾವಾಗ ಬೇಕಾಗ್ತಾನೆ? ಯಾವಾಗ ಒರಿಜಿನಲ್ ಡ್ರಾಯಿ ಬೇಡ ಅಂತಾನೋ ಅವಾಗ ಯಾರು ಬೇಕಾಗ್ತಾನೆ? ಡ್ರಾಯಿ ಇನ್ ಕೇಸ್ ಆಫ್ ನೀಡ್ ಬೇಕಾಗ್ತಾನೆ. ಅವನು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಾನೆ. ದಟ್ಸ್ ವೈ ಇಸ್ ಕಾಲ್ಡ್ as what? ಡ್ರಾಯಿ ಇನ್ ಕೇಸ್ ಆಫ್ ನೀಡ್. Alternative. ಅರೆ ಸೊ no. Next one. Holder. Who is holder? Any person who is having the possession of the instrument in his what name? Own name. And is entitled to what? Receive the benefit of the instrument. It can be any person. It can be payee also. ಯಾರ ಹತ್ರ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಇರುತ್ತೆ ಅವ್ನು ಯಾರು ಈಸ್ ಕಾಲ್ಡ್ as what? Holder. ಅರೆ ऐसा no. Who is endorser? Who is endorsing? Person to whom it is instrument is endorsed. Now, who is acceptor for honor? Accept for honor means, for example, you are supposed to accept the instrument. You do not accept it. To save the honor of the drawer, the drawee, if someone else accepts the instrument, he is called as what? Acceptor for honor. Acceptor for what? We clear with this, everybody? Essentials of bill of exchange. Can you guys go to the essentials of bill of exchange? Should be in what form? Should be unconditional order to pay. Signed by whom? Drawer. Must be certain. Should be stamped. Promising note and bill of exchange both must be stamped. Types of bill. What is the first one? What is inland bill? Instrument which is drawn in where? India. Or and payable in India or drawn upon a person who is resident in India. It's called as what instrument? What is foreign bill? Not a inland bill. What is trade bill? If a bill is drawn for a genuine trade, that is buying and selling of goods, is considered as what bill? Trade bill. What bill? Next one is accommodation bill. What bill? Accommodation bill. What is accommodation bill? What is accommodation bill? To accommodate a person, if a bill is drawn, it is considered as what bill? Accommodation bill. Just to give a financial assistance to somebody, if a bill is drawn, it is considered as what bill? Accommodation bill. It is also called as bill without any consideration. Arey, sir, no. I have explained these concepts, right? What is accommodation bill? It's a bill where a person lends his what? Name to help or oblige the another person. What person? See, I am not liable to pay any money to you. But you say, sir, मुझे पैसा चाहिए, sir. I will say, I will not give पैसा. You do one thing, you draw a bill on me. I'll accept the bill. You go to the bank with this bill, get it discounted. Before maturity, what you do? You give the money to me. I will pay it to whom? Bank. I'll explain. Listen. Listen, see, for example, let's say, को पैसा चाहिए, क्या चाहिए? पैसा. You come and ask me, sir, give me money. I'll say I cannot give money because मेरे पास cash नहीं है. What I will do? What you will do? Sir, you do one thing, sir. You're anyway a reputed person. Everybody trust your credit worthiness. I'll do one thing. I'll draw a bill on you. I will say, why will you draw a bill on me? Am I liable to pay any money to you? No. Still, you'll say I will draw a bill on you. I'll say, okay, fine. You draw a bill on me. So you draw a bill on me. You are a drawer. I'm the drawee. I accept the bill payable to you. After how many months? 3 months. After how many months? Is it for a genuine trade or just to give financial assistance to you? I'm just giving my name, correct, right, as a drawee. Now you go with this bill to whom? Bank. Get it discounted. Get the money. Use this money. Do business. Earn money. And before maturity, what you will do? Give it to whom? Drawee. And I will pay it to whom? Bank. Reza, no. Yes, I am the drawee. I am the one who is giving assistance to her because she need money immediately. Reza, no. Now you are called as what party? Accommodated party. What party? I am called as what party? The one who lends his name is called as what party? Accommodating party. Reza, no. Now tell me, if she holds the instrument, non head they go discount it. But what you did, you held the instrument for 3 months. How many months? On 3 months. Am I liable to pay? Not liable to pay. Because there is no consideration for me. Correct, right? But what if you endorse it to the bank? Am I liable to pay to the bank? Am I liable to bank? For me, who is liable? You are liable. Arey, sir, no, that is called as what bill? Accommodation bill. What bill? Read accommodation bill, everybody. Where a person lends his name to help or oblige another person. It is a bill drawn, accepted, endorsed without consideration. It is executed only to provide financial assistance to another. Accommodation party, accommodated party. Correct, right? Reza, no. Am I liable to third parties? Is the accommodating party liable to third parties? Third party means your bank. Am I liable to the banks? Am I liable to the accommodated party? No, because there is no what consideration. Arey, aisa no. Bill in set. What is bill in set? When a bill is drawn in set to avoid the loss of bill, it is considered as what? Not bill. It is called as what? Bill drawn in set. Arey, aisa no. Each part is called as what? Via. And there will be how many set? Three set. How many set? What is bank draw? A bill drawn by one bank over the other bank. It is called as what? Bill drawn in, sorry, bank draft. What draft? Nothing but demand draft. What draft? Where one bank draws the bill on the other banks to make a payment to some specific person. It is called as a demand draft. Yes or no? In that case, who is the drawer? Who is the drawee? Who is the payee? No, some other person. Earlier, when I did my CS, at that time we used to pay the money by DD only because check can be bounced, but not the DD. DD ಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಏನ್ ಮಾಡಬೇಕು? ನಿಮ್ಮ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಬ್ಯಾಲೆನ್ಸ್ ಇರಬೇಕು. Yes or no? So amount is blocked. You cannot cancel the demand draft. Correct, right? That is why what is to happen. See, I go to the bank. I go to the what? Bank. Karnataka Bank of Bangalore. I'll ask them to draw a DD on Mumbai Bank of ICSI. Mumbai Bank of what? Payable to whom? ICSI. Payable to whom? Now, Karnataka Bank of Bangalore is drawing a DD on the ICICI Bank of Mumbai. Payable to whom? Payable to whom? So what ICICI will do? They present this DD to whom? To the ICICI Bank. What bank? I want to make payment to whom? Who is the payee? One who receives the payment is called as payee. I want to pay fees to whom? By what? DD. I go to my bank. I ask my bank to draw a DD on whom? ICICI Bank. I give a bank details. What details? And it is payable to whom? ICSI. Payable to whom? Now ICSI has the DD. My bank is the drawer. Who is the drawee? Other bank is the drawee. Yes or no? And who is the payee? ICSI. So here bill is drawn by one bank. Over which bank? Other bank. That is considered as what? Demand draft. What draft? Arey, no. Are you guys clear with this? Can you guys tell me the difference between bill of exchange and promissory note, everybody? What is the first one? Parties. How many parties are there? Bolo bhai. Bill of exchange. Which one is payable to maker? Promissory note cannot be made payable to whom? Are aisa no. Bill of exchange can be made payable to the drawer himself. Can the drawer and pay be same? Can maker and pay be the same? Aisa no. Everybody answer aisa no. Nature of liability. Which one contains unconditional promise to pay? Which one contains unconditional order to pay? Where acceptance is not required? Which one must be accepted before payment? Where who has primary liability? The liability of the maker is what? Primary and absolute. Bill of exchange? Because first who is liable? In bill of exchange, first who is liable? Drawee. If you default, then who is responsible? Drawer. No. I order you to pay money to her. First she will come to you. If you don't pay, then who will pay liable to pay? Drawer. Yes, no. Which one required to be protested? Promissory note not required to be protested. Bill of exchange should be protested for the non-payment. Next one, notice of dishonor. Notice of what? Where notice of dishonor is required? Because some other person should make the payment. In case of promissory note, if I don't pay, I'll know the right. Are you supposed to inform this to me? No. Last one, payable to bearer. Payable to whom? Can promissory note be made payable to bearer? No. Bill of exchange? Yes. Only if it is payable after certain time. What time? After certain time. Are we clear with this, everybody? Yes or no? What is the first one? What is the first one? Promissory note. Second one. Third one. Section number what? What is section number 6? Yeah. What is check? Check is also bill of exchange. Also what? There will be how many parties? How many parties? What are the parties? Drawer, drawee, pay. It is always drawn on whom? Specified banker. What banker? Always payable on what? Demand. These are the additional features of bill of check. What is the first feature of what is check? Drawn on what banker? Always payable on what? Demand. And also include truncated check. What check? What is check truncation? The scanned image of a check which is used to the purpose of what? Clearing cycle. It is considered as what? Check truncation. To avoid the physical movement of the check for clearing purpose. It is considered as what check? Truncated check. Yes or no? What are the parties involved in case of check? What is the first party? Drawer. Second one, drawing. Third one, pay. Arre हाँ, you know. Essential subject, it is always drawn on whom? Banker. Payable on what? Does it requires acceptance? No. Huh? Which does not require acceptance? Yes. Does bill requires acceptance? Yes. Can it be drawn on a bank, which whatever the bank you want? Can you draw a check on any bank? You should draw a check only on a bank where you have the what? Account. Next one. Banker is liable only to whom? Drawer. Even for non-payment, the banker is liable only to whom? Drawer. Next one. A check is usually valid for how many months? After 3 months, it becomes what check? Stale check. Stamping is required or not required? But bill of exchange, promissory note, difference between check and bill of exchange. What is the first one? On whom it is drawn? Check. Bill of exchange, any person. Payable on demand. Which one is always payable on demand? Bill of exchange, specified period. Acceptance. Which one required to be accepted? Where no acceptance is required. Grace period. Where there is a grace period. Where there is no grace period. Next one, discharge of drawer. Drawer is discharged only if he suffers the what? Damage due to delay in drawer is discharged if not duly presented for the payment within a specified period of time. Notice of dishonor. Where it is not necessary. Check is necessary. Let me give a notice of dishonor. But in case of bill of exchange, both the cases it is required. Next one, revocation of authority. Only wrong is change ಮಾಡ್ಕೊಳ್ಳಿ. Revocation of authority. Can you countermand the check? Can you countermandate the check? Can you cancel the check? Yes or no? But bill of exchange cannot be countermandated. Crossing. Which one can be crossed? Which one cannot be crossed? Bill of exchange. Yes or no? These are the three negotiable instruments. What are the three negotiable instruments? Banking and other provisions. Some general provisions of the bank are there. I want everyone to focus. Let's start, everybody. Let's start. Yeah, we are wasting time. Let's start. Banking provisions. Are this obligation of the banker? He should honor the what? Check. Collect the check and drops on behalf of whom? Customer. Well, listen, everybody. If I give a check, with this check, what he will do? Go to the bank. Which bank? Your bank. Drop it so that they will collect on behalf of you. Yes or no? That is the obligation of banker. Third one, keep proper record of transaction. Fourth one, comply with the express standing instruction. If you are given instruction to make payment every month, you should make payment every month. Next one, not disclose the state of customer's account. Give reasonable notice to the customer if the banker wishes to close the account. Rights of the banker. What of the banker? Can you have a lien over any goods for a general balance of what? Account. Next one, right of what? Appropriation. Claim incidental charges as well as the interest as per the rules and regulations of the bank as communicated to the customer at the time of opening the account. Opening the what? Account. When banker must refuse the payment, they can ask this question. When banker may refuse the payment, when banker must refuse the payment, they can ask any one question based on this in the examinations. What is the first one? When the customer countermands the what? Payment. Second one, when the banker receives notice of whose death? Customer's death. Next one, the customer adjudged as a insolvent, insanity, or when an order of the court prohibits the what? Payment. When the customer has given notice of what? Assignment of the credit balance to somebody, or title is defective, or notice of closing the account. In these cases, who should refuse the payment? Banker must refuse the payment. They can ask this question in the examinations. Next one, when banker may refuse the payment, not mandatory, but he may refuse the payment. When Prajwal, when banker may refuse the payment, what is the first one? He may make payment, may not make the payment. Next one, no sufficient funds of the drawer. Doubtful legality. Check is not duly presented. That is, if it is presented after what hours? Banking hours. You should go within banking hours. But what if you go after banking hours? Can they refuse? Can they make payment? It is left to the bank discretion. They may make payment. It is not must. It is may. Next one, when the check on the face of it is what? Irregular or ambiguous. Irregular what? Ambiguous. When the check is presented at a branch where the customer has no account. What account? Possible to make payment? ಇವಾಗ ನಾನು ಓಪನ್ ಚೆಕ್ ಕೊಟ್ರೆ ನನ್ನ ಅಕೌಂಟ್ ಇದೆ ಬಸವನಗುಡಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಕ್ಯಾನ್ ಯು ಗೋ ಅಂಡ್ ಟೇಕ್ ಮನಿ ಫ್ರಮ್ ಜಯನಗರ್ ಬ್ರಾಂಚ್ ಎಸ್ ಸೇಮ್ ಬ್ಯಾಂಕ್ ಹೋಗ್ಬೇಕು ಇಲ್ಲ ಇಲ್ಲ ಆತರ ಏನಿಲ್ಲಪ್ಪ ಕಮಿಷನ್ ಚಾರ್ಜ್ ಮಾಡ್ಕೊಬೋದು ಅಷ್ಟೇ ಅವರು ಹಂಗೆಲ್ಲ ಮಾಡೋಂಗಿಲ್ಲ ಟೆಲ್ ಸಿ ಎಸ್ ಆರ್ then they will tell both they will scold both of us at that time. You should tell CS taught this to us and they will scold both of us. ನಿಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೆಲಸ ಇಲ್ಲ next one, joint account, a check is not signed by whom? Jointly. In all this case, banker may refuse the payment. Discharge of banker payment in what course? Due course. See, generally, if a banker make a payment to a wrong person, is the banker responsible? Not responsible? Responsible. But however, if a banker makes the payment as per the apparent tenor of the instrument, acting in good faith, without negligence, even if it is paid to what person? Wrong person. What person? Is the banker responsible? Not responsible? Not responsible. If it is due course, banker is not responsible. If it is not in due course, who is responsible? Banker is responsible. Now, what if banker, without verifying the signature of the drawer, makes the payment? Is the banker responsible? Not responsible? Responsible. Next one, what is payment in due course? A payment is considered as payment in due course if it satisfies how many conditions? What is the first condition? Second one, third one, fourth one, fifth one. When it is considered as what in due course? If payment is in due course, who is not responsible? Even if it is made to what person? Wrong person. Arey, no. Next one. Protection to what banker? If you collect a money, if a banker collects the monies to a wrong person, acting in what faith? Who is not responsible? Banker is not responsible. What is overdue check after how many years? 3 years. It is considered as what check? Three. Array, no, no. Overdue means 3 years. Stale means 3 months. Next one. Right half holder against the what? Banker. Against whom? Holder doesn't have any right against the banker. Only who has the right against the banker? Customer. Array, sir, no. What is crossing up check? Crossing is a direction to whom? Paying banker. Direction to whom? अरे बोलो direction to whom? Paying banker. To pay the check only to whom? Banker and not otherwise. ನೀವು ಬ್ಯಾಂಕ್ಗೆ ಹೇಳ್ಬೇಕು ಏನಂತ ಹೇಳ್ಬೇಕು ಬ್ಯಾಂಕರ್ ಡೋಂಟ್ ಮೇಕ್ ಎ ಪೇಮೆಂಟ್ ಟು ದ ಪರ್ಸನ್ ಮೇಕ್ ಎ ಪೇಮೆಂಟ್ ಓನ್ಲಿ ಟು ಹೂಮ್ ಬ್ಯಾಂಕ್ ಅಂತ ಹೇಳ್ಬೇಕು ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ಯು ನಾಟ್ ಯೂಸ್ ದ ವರ್ಡ್ ಯು ಜಸ್ಟ್ ಪುಟ್ ದಿಸ್ ಲೈನ್ ಎರಡು ಲೈನ್ ಹಾಕಿದ್ರೆ ಏನಂತ ಅರ್ಥ ಅದು ಬ್ಯಾಂಕ್ ಶುಡ್ ಮೇಕ್ ಪೇಮೆಂಟ್ ಟು ಹೂಮ್ ಬ್ಯಾಂಕ್ ದಿಟ್ ಇಸ್ ವಾಟ್ ಕಾಲ್ಡ್ as crossing. What is crossing is a direction. It's a what the whom paying banker. What banker? The check only to whom? Banker and not otherwise. Arey sir, no. The object of the crossing is to ensure that payment is made to whom? Banker. So it can be traced to the person receiving the amount. The cross check is one on which two parallel transverse lines are drawn across its face. That is considered as what? Cross check. What check? This cross. What is crossing up check? It's a direction given to the paying banker to make payment only to whom? Banker. It is called as what? Crossing. How the crossing is done? By drawing two transverse parallel line. What lines? Transverse parallel line. What are the types of crossing? General cross. Only lines? General crossing. Special crossing. Along with that, you mention what name? Bank name. What name? Third one, account pay crossing. It is mentioned along with that account pay, it should be payable only to the account. Last one, not negotiable crossing, which is not transferable. If it is transferred, the holder will not be getting the good title. What title? They will be having the same title of whom? Transfer. These are the various types of crossing. This question might come in the theory examination as a theory question. Crossing and types of crossing. What is crossing? We want to which banker? To make payment only to whom? How we give direction? Types of crossing: general crossing, special crossing, account pay crossing, not negotiable crossing. Yes or no? Next one, maturity. What is maturity? The date on which what is become payable, instrument becomes payable. Are yes or no? If it is a time instrument, there is a grace period of how many months? 3 days. How many days? If it is demand instrument, no grace period. Yes or no? Tell me if an instrument is payable on demand. Payable on what? Is the instrument become when it is payable on the same date? What date? The promissory note or a bill payable at a site or on presentment is payable on what? Demand. It becomes due immediately upon the issue. The concept of maturity applies only to the instrument payable after the date, after site, or after the certain event which is bound to happen. Yes or no? Demand instrument, there is no question of maturity. It is applicable only for what? Time instrument. What instrument? Yes or no? Third one, fourth one, fifth one is most important, based on which they can ask practical questions in the examination, because the concept of maturity is applicable only for which instrument? Time instrument. What instrument? Right, examinations in June. Results comes in the month of August. Pass. At 2 o'clock. Correct, I know. At 2 p.m. Results. If you pass, freedom. Achadi. 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 If something goes wrong, God forbid, touch wood. If something goes wrong, आज नहीं तो कल. So give your 100%. ठीक है? Done. Let's start. Which one? Table is not good. Why? Good. I'm standing on the wood. Okay, listen, everybody. Now, maturity. The concept of maturity is applicable only in case of what instrument? Time instrument. Now, if the instrument is payable after a number of months, listen everybody. If an instrument is payable after 3 months, after how many months? The instrument becomes payable on the corresponding month. What month? Corresponding day of the month. For example, let's say if I make an instrument today, payable after how many months? 3 months. What is the date today? 9th of. So when it is payable, May, June, July, August. 9th of August plus how many days of grace period? So plus 3 days becomes how much? 12. 12 is the maturity date. Are we clear with this, everybody? Now, payable after a certain number of months. After what? Size. The period calculated from the what? Date of acceptance, presentment. What if there is no corresponding day? It will end on the last day. Now, for example, if I make an instrument on 31st of December, payable after 2 months. Now, what is 2 months? Do we have 31st of February? No, it is 28th itself is the what date? Last day. That's how many days of grace period? 3 days. So it is what? 3rd of March. Are we clear with this? And the last one is most important. What is the last one? If the maturity falls on the what day? The instrument becomes due on the what date? Preceding business day. And the preceding day is also a holiday. It moves further back to the what? Previous working day. What working day? ಅರ್ಥ ಆಯ್ತಾ? ನಾನು next one. Difference between holder and holder in due course. I hope you guys remember what is holder and who is holder in due course. Who is holder? Any person who is entitled to what? Possession. In his what name? And is entitled to recover or receive the what? Amount from the party. What from the parties? Then he is considered as what? Holder. To be a holder, the person must be what? Be named in the instrument or the endorsee or the bearer of the instrument. Who is holder in due course? Who for a valuable consideration become the what? Possessor of the bearer instrument or any payable to the person before the amount becomes payable without what? Sufficient cause to believe that the defect exists in the title of the transferor. See, this is like uh, even though transferor title is defective, if the transferee acts in what faith? Good faith. He becomes the absolute owner. What owner? That is why he is called as what? Holder in due course. What in due course? Are we clear with the definition of holder and holder in due course? Yes or no? Holder is different. Holder in due course is different. समझ में आ गया? Who is holder in due course? Any person who receives the instrument before what? Maturity, acting in what faith? Good faith. For a valuable consideration, gets the instrument free from all the defects. मैंने fraud करके instrument लिया था. I give it to her who is acting in good faith. She gets the better type. I can't recover it, but she can recover it. Once she recovers it, she can recover it from me because she's innocent. Are we clear with this, everybody? Yes or no? Now, capacity of the parties. Who can become a party to the negotiable instrument? Any person. Can minor be a party to the negotiable instrument? Yes, but he can't incur any liabilities. Can minor be a drawer? Yes. Can he be a drawee? No. Can he be a promiser? No. Can he be a payee? Yes. Are we clear with this, everybody? Yes or no? Next one, liability of drawer of a check, liability of maker of note and acceptor of bill, liability of endorser, liability of prior parties, liability inter se, liability of acceptor of forged endorsement, liability of acceptor of bill. On what name? Fictitious name. What name? Who is the first person? Liability of whom? Primarily, who is responsible in case of bill of exchange? Drawer or drawee? Primarily, who is responsible? Drawer or drawee? Primary liability is always drawee. मैं आपको बोलती हूँ आप पेमेंट करो इसको. मैं कौन हूँ? आप लोग बोलिए मैं कौन हूँ? ये कौन है? आप लोग कौन है? कौन पेमेंट करना पड़ेगा? तो पेमेंट नहीं किया तो आप किसके पास आ जाओगे? मेरा लायबिलिटी प्राइमरी होगा सेकेंडरी होगा? Who am I? Who is she? Whose liability is primary? Whose liability is secondary? Are you guys clear with this? In case of dishonor of bill, who is responsible? Primarily, who is responsible? If she don't pay it is dishonor, then who is responsible? Lawyer. Yes or no? In case of accommodation bill, what bill? Only who is is the notice of dishonor required or not required? Not required. Other bill, is it required? Yes, it is required. Yes or no? Yes or no? Tell me, if bill is dishonored, what is dishonored? Can you make drawer responsible? As a holder, can you make drawer responsible? Are you supposed to give a notice to whom? Because primarily, who is responsible? If you don't pay, then who is responsible? Yes or no? Next one is drawee of a check. Who is drawee of a check? Always. Bank is the drawee. Yes or no? Continue. If there is sufficient balance, are the bank liable to pay? Not liable to pay? Liable to pay? Not liable to pay? Liable to pay. Yes or no? Next one. Liability of maker of a note or acceptor of a bill. Are they primary liable? Secondary liable? In case of promissory note, who is liable? Maker or drawee? There is no question of drawee in case of promissory. There will be how many parties? Two parties. Who is liable to pay? Maker. Is the liability is primary or secondary? In case of bill of exchange, who is primarily liable? Acceptor or drawee? It is one who accepts the bill. Who is liable? Acceptor or drawee? Primary is liability is primary or secondary? Primary or secondary? Primary. Arey, yes or no? If they don't pay, then who is responsible? Drawee. Arey, yes or no? Now tell me, is endorser liable to the endorsee? Who is endorser? Transfers the instrument is called as what? Endorser. Who is endorsee? Person to whom the instrument is endorsed is called as what? Endorsee. Endorsee, who is responsible? Endorser. He is like a surety. He is like what? Press simple, say simple. Listen, everybody. Madam, like madam. Every endorser who endorses and delivers a negotiable instrument before maturity is liable to whom? All the subsequent holders. What holders? Listen. Now, listen. He is the Troyan. Sorry, promiser. I am to pay. Who am I? Pay. Who am I? See. मेरा पास promissory note है. Can I transfer this? Is it possible to transfer? Now if I transfer it to her, who am I? Who is she? Wait. Can she transfer it to her? No, who is she? Who is she? Give it to her. Who is she? Who is she? Now she is the holder. Correct, right? On the due date, she will give to whom? Maker. To whom? If she don't make payment, who is responsible? She'll go to whom? Endorser. This endorser goes to whom? So and the endorser is responsible to all the subsequent holders. What holders? Subsequent holder. Are yes or no? Now what if she is insolvent? Can she directly come to her? Yes or no? What if she is also insolvent? Can she come to me directly? We will directly go to the negotiation and assignment. Important topic based on which they can ask questions in the examination. What is negotiation, guys? What is negotiation? Transfer of instrument by one person to no only. Let's start. What is negotiation? Transfer of instrument from one person to another person. Convey the what? Title. Constitute the transferee as what? Holder of the instrument. There are how many types of negotiation? What are two types? Negotiation by delivery, negotiation by what? Endorsement and delivery. Endorsement and what? Which instrument can be negotiated by delivery? What type of instrument can be negotiated by delivery? Bearer instrument. What instrument can be negotiated by endorsement and delivery? Order instrument. What instrument? In all these things, what is common? Delivery is common. What is common? Delivery. Without delivery, you cannot negotiate an instrument. Yes or no? Next one, difference between negotiation and assignment. Assignment requires a separate contract. What contract? Separate contract. Negotiation is done on the what instrument? Same instrument. What instrument? You are alone in this journey of you becoming a CS. You meet good people, you meet bad people. Some people becomes part of your journey for some time. Some people teach us some lessons to you guys. Learn from those lessons. Take that as a motivation. Keep walking towards your goal of becoming a CS. And only thing which is constant in your journey of becoming CS is CS. Nobody else. If somebody says, I'm gonna be there for you guys all the time, it was it's a difference between negotiation and assignment. Examination as early as possible and go to the corporate. There are a lot of things to do after you become a CS. This is just one part of your life right now. So uh, you should do it with honesty, and if you give your honest efforts, for sure you guys will pass. In fact, if somebody comes say I'm not studying, don't believe them. Mhm. Don't trust anybody. Okay, you best. Uh, if yeah, you know you I would. Uh, you should nothing. Next one. Let's start. Difference between what? Negotiation and assignment. Transfer is affected by what? Mere delivery or by endorsement and delivery. In case of assignment, what is required? Separate document is required. Notice of transfer is not required in case of negotiation. Assignment, what is required? Notice of transfer is required. SDC, what is SDC? Do we have concept of holder in due course in case of negotiation? Yes. Do we have the concept in case of assignment? No. Types of negotiation. How many types of negotiations are there? What are two types? Negotiation by delivery, negotiation by endorsement and delivery. What are types of endorsement? A important. They can ask practical or theory question based on this. Very important. Yeah, correct, ma'am. Correct. When the maker or holder of a negotiable instrument signs it for the purpose of negotiation, either on the blank or face or on the slip attached to the instrument, it is called as what? Endorsement. The one who transfer the instrument is called as what? Endorser. And the person to whom it is endorsed is called as what? Endorsee. What are types of endorsement? Blank or general endorsement. Means without mentioning whose name? Endorsee name. Once you make a blank endorsement, the instrument becomes what instrument? Bearer instrument. What instrument? Bearer instrument. What is special endorsement? Along with the signature, you mention whose name? Endorsee name. Whose name? That is considered as what endorsement? Special endorsement. Below what endorsement? What is restrictive endorsement? Which prohibits further negotiation of instrument. It is called as the restrictive endorsement. What is partial endorsement? When you transfer part of the amount. It is valid or not valid? Not valid. Next one, conditional endorsement. What endorsement? What is sans recourse endorsement without any recourse? See, if instrument is dishonored, the holder can go back to whom? Endorser. Go back to whom? But if endorser excludes that liability, it is called as what? Sans recourse endorsement. For example, in our case, I have endorsed it to her, she endorsed it to her, she endorsed it to her. Now, what if she do sans recourse endorsement? Means what? If instrument is dishonored, she can't go against her. She should directly come to whom? Previous endorser. What endorser? Because she has done what endorsement? Sans recourse endorsement. Means without any remedy against her. Resa, no. What is sans recourse? Without any remedy against that particular endorser if the instrument is dishonored. Next one is what? Liability depends upon what? Contingency. If I endorse the instrument to her, subject to fulfillment of some condition. If I say I am endorsing this instrument to you, subject to you getting married to somebody. Is this instrument endorsed or not endorsed? Not endorsed. Until unless what is fulfilled? Condition is fulfilled. Reza, no. What's negotiation back? Where the endorser becomes the holder of the instrument. So the further negotiation, it is considered as what? And negotiation back. Endorser himself becomes the endorsee. That is called as what? Negotiation back. What back? In case of negotiation back, who is discharged? All the previous intermediaries are discharged. Yes or no? Next one, negotiation of lost instrument that was obtained by what means? Unlawful means. What means? Is it valid or not valid? Not valid. But if it is transferred to holder in due course, is it valid? Yes, valid. Fourth endorsement. What endorsement? Is the acceptor liable or not liable? Liable. But forgery does not convey what title? Any title. What title? Uh, then come to the concept of acceptance of bills of exchange. We discussed what are types of acceptance. What are types of acceptance? General and qualified. Which one is not valid? Qualified acceptance is not valid. And we also discuss acceptor for honor. One who accepts the instrument to save the honor of whom? Other person is called as what? Acceptor for honor. Presentation for acceptance should be presented before what? Maturity. Before what? During what hours? Business hours. What hours? Business hours. See, this concept is important. Presentment for acceptance when excused, when it is not mandatory. Based on this, they can ask question in the examination. When it is not mandatory, when drawee cannot be found. After what search? Reasonable search. When the drawee is a what person? Fictitious person. When presentment is irregular but acceptance has been refused on some other grounds. In these cases, what is not mandatory? Presentation is not mandatory. Next, payment. Next one is what? Payment. Next one is what? Presentment for payment, promissory note, bills of exchange, check must be presented for the payment by or on behalf of the holder. Presentment must be made during the usual business hours. What hours? If it is a check during what hours? Banking hours. What hours? It is promissory note and bill of exchange during business hours. If it is check during what hours? Banking hours. If there is suspicion of fraud, forgery, tampering, destruction, the drawee bank may demand production of what? Original truncated check for verification purpose. When presentment for payment is excused, it is important. Based on this, we can ask question in the examination. See, if I present the instrument for payment and if the payment is not done, what is not done? If payment is not done, can I make the drawee responsible? If I present, if I present for payment and if the payment is not done, can I make the drawee responsible? Yes. Without presentation, can I make him responsible? No. So what is mandatory? Presentation. But however, there are exceptional cases where what is not mandatory? Presentation is not mandated to make whom responsible? Drawee are responsible. What are those cases? What is the first one? Presentation. I want to present, but they're not allowing me to present. Then you are not responsible. Second one is closed on the what date? Due date. Third one, the payment to make the no place of payment to make the payment. Correct. When after due search, the maker, drawer, or acceptor cannot be found. Next one, when there is a promise to pay, notwithstanding the non-presentment, when the presentation is expressly or impliedly waived by the party entitled to do it. When the drawer could not possibly have suffered any what? Damage due to the non-presentment. And the drawer is a what person? Or is incompetent to contract. When the drawer and the drawee are the what person? Same person. When the bill has already been what? Dishonored by, if it is not accepted, where is the question of presenting it for payment? When the presentment has become what? Impossible. When the presentment is irregular, but acceptance has been refused on some other ground. Okay. Now we will go to the concept of dishonor of check. What of check? Dishonor of check. Important concept. है. We will discuss dishonor of check. Hmm. Listen. Based on dishonor of check, there can be questions in the examination. What is the first one? Why do we draw checks? Is simple. Keep this in mind. A check is always drawn on a bank where a person has maintained the account. It is drawn either for discharge of payment of debt or discharge of liability. And if that check is returned without payment because of insufficient fund, what fund? And the person who has given that check will be liable for what? Dishonor of check. When a person is liable for dishonor of check, when a check is drawn by a person on an account maintained by him with a bank must be issued for the payment of any amount of money to whom? Another person. It must be for the discharge in whole or in part of any debt or liability, and the check is returned unpaid by the bank. Unpaid by whom? Bank. Because of the amount standing to the credit of the account is insufficient or it exceeds the amount arranged to be paid from that account under an agreement. He shall be deemed to have committed a what? Offense. In case of check bounce case, what is the punishment applicable? Up to how many years? 2 years. Or a fine which may extend to what? Twice the amount of the check or with the both. Understood? That is the punishment for check bounce case. What are the conditions for applicable to section number 138? The first condition is that the holder of the check should present the check within how many months of drawing it? 3 months. How many months? 3 months. Second one, the payee or the holder in due course must issue a written demand notice within how many days? 30 days. Remember, I explained with the chart. You present the instrument, dishonored, give a notice, demand the payment. You don't make payment within how many days? 15 days. Then you can go to the uh, magistrate court. You can file a complaint. It's a criminal case, right? What case? Criminal case. Arey, what case? Criminal case. Yes or no? Yes or no? Can you guys read the case law? Can we refer this? Can we refer check bound case for mediation? Is the check bound case compoundable, non-compoundable? Compoundable. Compoundable, non-compoundable? Compoundable. Who can refer the parties to compounding of offences? Court. In case of offence by company, offence by whom? Who will be responsible? Company, and every person at the time of offence is in charge of and responsible to the company for the conduct of business. Such person shall be liable to be prosecuted and punished accordingly. A person shall not be liable if he proves that without his knowledge or he had exercised the what diligence or diligence. Are government nominees, directors responsible, not responsible? Not responsible. Cognizance of offense, I have already discussed this. Which court has a jurisdiction? Magistrate court. Correct, right? Judicial magistrate, which class? First class. Case must be filed within how many months? 1 month. See, simple, listen. First, holder present the instrument for payment within how many months? How many months? 3 months. Check bound. You should give a notice demanding the payment within how many days? 30 days. Then the drawer should make payment within how many days? 15 days. If not paid, from that date, you can file a complaint in the what court? Magistrate court. Within how many months? 1 month. Are we getting it? Within how many months? 1 month. Resano. Resano. Where you file a case? Which magistrate court? Ah, correct. Where? Like, for example, let's say I am the drawer. I have a bank in Bengaluru. You have a bank in Tumkur. You presented the check through Tumkur Bank. Where the cause of action arises? Tumkur. Wherever the payee has account. Who has account? Payee. I've explained this with a chart, remember? Okay, next one. Can this case be tried summarily? What is summarily? In a brief manner, a speedy trial. Only if the amount of punishment does not exceed how many year? 1 year, and the fine payable does not exceed how much? 5,000 rupees. Yes or no? Next one. This one is important. 43A and 148 is important. Can court order a person to pay interim compensation? In case of check bounce cases, can there be interim compensation? Court trying the offense, section number 138, may direct the drawer to pay what compensation? Interim compensation. That should be paid within how many days of order? 60 days of order. Uh, Court may extend the period by further how many days? 3 days on sufficient cause shown by the what? Drawer. Yes or no? Can court order a person to pay the what? Interim compensation? That should be paid within how many days? 60. If it is not paid within 60 days, next how many days? 30 days. Yes or no? If the drawer is acquitted, means what? If he is not found guilty, then the court shall direct the complainant to repay the what? Interim compensation. What compensation? Interim compensation. Repayment shall include the what? Interest at the bank rate. What rate? वापस करना पड़ेगा ना with the bank rate. Yes or no? Within how many days? Will it be extended by how many days? 30 days. Next one. What if we go for an appeal, let's say, at the lower court, the holder of a check one, I received the compensation. Court ordered the drawer to pay the compensation. Now the drawer is going for an appeal. Going for what? Against the lower court order. When you go for an appeal, what appellate court can do? It can ask the person to deposit the what? Amount of compensation. To whom? To the other person. How much it can order to pay? Minimum 20%. Minimum how much? And that should be deposited within how many days? 60. What if he is acquitted? Then the holder should refund it within how many days? 30 days. Along with what? 30 days or 60 days? 60 days. Extendable by what date? 30 days. Along with what? Prescribed by the RBI. Understood? What is the minimum amount payable? 20% of the fine or the compensation awarded. What awarded? Compensation awarded. Yes or no? And it is not fixed in always. It's always fixed in nature. It is discretion of the court. What of the court? Discretion of the court. What of the court? Discretion of the court. What is discretion? Option of the court. Court may give interim compensation, may not give the interim compensation. Yes or no? Next one. NEFT, RTGS, I will not explain. You guys know what is NEFT and RTGS. Which one is more convenient? Where there is a limit, where there is no limit, which is quick transfer, which one is done batch wise, which one is real time transfer, which one is near to real time transfer. NEFT. Yes or no? But both works 24 into 7. Yes or no? With this, we are done with what? Negotiable Instrument Act. Let's go to the question bank. I want everyone to be honest. As I said, next few minutes of time is the only time we're gonna study JIGL. So, how many of you can answer this question? Ready? Everybody? Ready? Start. Not valid. There should be a clear promise to pay. Is there any promise to pay here? No. Continue. Not certain. Payment time is not certain. Continue. However, Ravi Enterprises contended that this is a mere acknowledgement of the debt and condition, therefore not enforceable as a promissory note. Based on the above facts, explain the essential requirements of a is it a valid promissory note? No. Next one. Check. This question was asked in December 25. 10 marks question for sure will come out of Negotiable Instrument Act. So 10 marks, 10 marks, 10 marks. So we have covered around how many marks questions? We covered 4 chapters, is it? Ah, Four chapters, 40 marks questions we have already. This is fourth one. BNSS don't know one chapter. Continue. Check. Meena's contention correct or wrong? Wrong. Because check includes what check? Truncated. Should write what is check and also truncated check. Enumerate the distinction between check and bills of exchange. Can I write number of parties which can be drawn? All these things. Next one. Explain the meaning of holder. Whether a person who has obtained the possession of an instrument by theft. No, forgery does not confers what title? Any title. If you receive it by forgery, will not become the holder of the instrument. Next one, which can be considered either as a bill or a promissory note. Next one, continue. Is it valid? X is a major. Minor is the payee. Can minor be a payee? Can he be a promisor? Can he be a promisor? No. Can he be a payee? In this case, is he a payee? Is he a payee? Is the instrument valid? No. A minor can be a party to the negotiable instrument without incurring any what? Liability. Yes or no? It's valid. Next one. Exam question number two. Is minor responsible? Not responsible. There is no remedy against whom? Minor. Next one. He can recover the amount from whom? D as well as the C. All the previous endorsers are responsible to him. Yes or no? इसके ऊपर discuss किया था. Discharge of endorsers liability. What liability? Right. Right. This question. Remember, discharge of instrument by cancelling the remedy available to the previous endorsers. For example, what happens? She is the promiser. I am the hold promisee, the payee. I am the endorser. She is the endorsee. She is the endorser. She is the endorsee. She is the endorser. She is the endorsee. She's having the hold. She's the having the instrument. Now, what she does while playing, uh, she's playing with that instrument. ಆಟ ಆಡ್ತಾ ಇದ್ದಾರೆ ಆಟ ಆಡ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ she cancel whose name? What's your name? Krishma's name. My name. She cancels whose name? Now who is discharged? And also who is discharged? He is also discharged. Why? Because she cancelled whose remedy? Correct, na? Who cancelled whose remedy? Shirisha cancelled Kirti's subsequent remedy. Because of this, who is discharged? Both of them. Am I liable now? Now you read this question and answer. No. Hmm. Who transfer it without consideration? X. Transfer it to whom? Y. Without consideration. But can he recover from the previous party? Aresa, no. However, what parties? If you receive instrument without consideration, can you recover the money? No. But if it is transferred to somebody who receives the instrument for what? Consideration. Can you recover from previous parties? Yes. Aresa, no. Next one. Explain the types of endorsement. Types of endorsement. Blank endorsement, full endorsement, partial endorsement, sans recourse endorsement, conditional endorsement, not negotiable endorsement. We discussed two. What is sans recourse? Without any recourse. If it is sans recourse, all the intermediaries becomes what? Liable. See, in case of negotiation back, what back? All the intermediaries are discharged. If it is normal endorsement, because it becomes circuit, right? Listen, I make endorsement to her, she endorses to her, endorsement to her. She again endorses it to me. It means who is discharged now? These two are discharged. Because if I go against her, she'll go against her, she'll come back to me only, right? But what if the sans recourse endorsement? What is sans recourse? Without any recourse. Means she cannot come to me, right? So I will give it to her, she give it to her, she give it to her, she will give it back to me. Now tell me for me, are they responsible, not responsible? Responsible. Because it is what endorsement? Sans recourse. Because if I go against her, she'll go against, she cannot come back to me, right? She'll go against her, right? Reza, no. Liable or not liable? Liable. That is what we already discussed all these things. Next one, question number five. If an instrument is obtained by unlawful means, what means? Valid or not valid? Not valid. Distinguish between negotiability and assignment. Negotiation and assignment we discussed just now, right? Which one requires separate contract? Which one requires notice? Assignment. Which one requires to be stamped? Assignment, but not the negotiation. Correct, sir, no. Where there is a question of holder in due course? Where there is a question of holder in due course? Negotiation. But there is no question of holder in due course in case of what? Assignment. Next one is for your answer. Um, in case of forced endorsement, is the party responsible or not responsible? Not responsible. Forgery does not confer what? Any title. Presentment for payment. Tell me within what time you're supposed to present the instrument. Maturity date we discussed now. Calculate the maturity date in this case. When it was dated. Payable after how many days? So what is 10 days? 11. Plus how many days? So what is the last date? 14th April, huh? 14th February, right? Arey, yes or no? Arey, it is payable after 2 months. After 2 months means what date? After 2 months means what? March, April. April 1st. Plus how many days? What is the maturity date? 4. Arey, yes or no? But he presented the instrument after how many days? 10 days. Now who is discharged? The holder is discharged. What is the interest payable in case of dishonor of negotiable instrument? 18% per annum. Discharge from liability. When the parties are discharged from the liability. Effect of material alteration we discussed now. In the previous class, in the detailed classes, we discussed what is material alteration, what is not considered as material alterations. Next, dishonor by non-acceptance. When notice of dishonor is what? Unnecessary. Crossing of check. How many types are there? This order of check is what important. Based on this, they generally ask questions in the examinations. Can you guys read this question number 1, please? Agree with this? Agree with this statement? You should write when it is considered as an offense under section number 138. When the instrument, when a check is drawn and a bank where he has maintained the account for the payment of debt at discharge of liability, and if it is returned without payment due to insufficient balance, he has committed an offense under section number what? 138, and is punishable with the imprisonment of how many years? 2 years. Not 2 years. 2 years only, na? Or twice the amount of the check. Okay, fine. Yes or no? Minimum 6 months, maximum how many years? 2 years. Question number 2. Don't say yes. Repeat question asked in December 2023. Yes, it seems. Before even I ask question, she is saying yes. तेईस नहीं है फयाज तेईस है फाइज फाइज फयाज फाइज फाइज ओके ओके कंटिन्यू राइज एंड फाइज ओके कंटिन्यू बेटा कंटिन्यू the above matter can be referred for amicable settlement through mediation. Can it be referred for mediation? Court can refer this to mediation, right? Can you guys read question number 3? Can he file a complaint? Can he file a complaint? In what court? Magistrate court. Within how many months? Of the cause of action. Before that, he has to satisfy the condition. He should have presented the check within how many months? 3 months. On default, he should have given a demand notice within how many days? 30 days. Should have made payment within how many days? 15 days. If he has not done the payment, then we can file a complaint in the magistrate court, first class, or chief judicial magistrate. Yes or no? Next one. Banker. When must banker refuse the payment of check? When banker may refuse the payment, when the banker must refuse the payment. This also we have covered in the previous class. Yes or no? Next one. Case study question. They asked this question in the which year? December 24. December what? 24. Minimum 10 marks questions will come out of what? Negotiable instrument. What instrument? Negotiable instrument. I want everyone to read the question and answer. Read. Purana, but still read. Read, read. No, I'll not. Read. On a serious note, solve question number 1, 2, 3, 4. पागल है क्या? Go within how many months? 3 months. He will not be in a position to claim the compensation. Should go within how many months? Yes, who has a director of R&D company issued a check. The rest is liable or not liable? Liable. Are there any exceptional cases where he is not liable? Yes. If it was issued without his consent, ಇದೆಯಲ್ಲ ಅದು concept. In case of company when he is responsible. Next one. Summons can be served directly or through electronic mode and all those things are there. Next one. Interim compensation. Maximum how much it can be paid? 20%. Sorry, minimum or maximum? 20% of amount of fine or the compensation should be deposited within how many days? 60 days. Extension how many days? 30 days. If acquittal happens, it should be refunded within how many days? 60 days. Extension how many days? 30 days. With interest at the rate of RBI rate. Yes or no? Are you guys able to solve this question? These are the questions which were asked in the previous examinations out of Negotiable Instrument Act. Which act? Negotiable Instrument Act. Now let's go to the TPC. We'll discuss question and answer. Sar mat bolo. Concentrate. Even for IT Act, what you guys will do, you will solve these questions. Huh? ನಾಳೆ ಇಲ್ಲ Monday. Let's start, everybody. Question and answers. CPC. Let's start. Everybody, let's start. First question. Explain the cause of action under the what? CPC. Differentiate between whom? Decree and order. For the defendant, when the ex party decree has been passed. What is ex party decree? A decree passed without hearing which party? Other party. Is called as what party decree? Ex party decree. Have you heard about res sub judice? Res judicata? There are practical questions also in this. Difference between what? Res sub judice and res judicata. I have this question in which year? June 2023. Jurisdiction of the court. They ask question based on this in the which year? December 2023. For how many marks? 5 marks. And they also ask this questions. I have mentioned the year of question. I mentioned the year of questions for each questions. Okay, topic wise, you guys can go through it. Distinguish between the set off and counterclaim. They can ask. They ask this question of difference between set off and equitable set off. In which year they ask this question? December 2023. For how many marks? 5 marks. And in December 2025, they asked question about injunction. Asked a question about what? Injunction. One of the ICSI favorite topic. They generally ask questions out of injunction. Uh, and they also ask question about this service of summons, modes of service of summons. That's right. Next one. They also ask question about this decree passed in against a minor without appointing whom? Guardian. Remember, in case of minor, there should be appointment of guardian, right? Minor or unsound mind. They ask question based on this in which exam? Last exam. So this also has 10 marks weightage. CPC has how much weightage? 10 marks. These are the important chapters. Reading it. Constitution of India, BNS and BNSS, then law with respect to civil procedure, Contract Act and Negotiable Instrument Act and arbitration. These are the chain killers, not chain killer. The important chapters. Chain killers are killer. Other topics. Aste. Each question to solve ಮಾಡಿ ಹೋಗಿ. For which chapter? CPC. Administrative law easy there. Administrative law, you just refer to this question bank. Trust me, you refer this to this question bank, you are thorough with this. Okay? But I'm not sharing the question bank. You will receive it after. Anyways, also will go through it. First read administrative law. Need for administrative law. Why it is required? Read this. Sources of administrative law. The sources of administrative law. Constitution of India. Act or statutes. Ordinances. Judicial decision. Write a short note on Constitution as a sources of what law? Administrative law. Rule of law. Ah, that one. Rule of law developed by whom? British. A.V. Rising. This question was asked in December 2024 for how many marks? 5 marks. Administrative discretion. What is the use of administrative discretion? Judicial review. Hello, what review? Judicial review. Um, under what circumstances decision of an exercise by administrative authorities are considered as what? Abuse of discretion. Abuse of what? Discretion. Non-application of mind we discussed now. Abuse of discretion. Then this is what important. Rule against bias. Nemo judex in causa sua. Rule of fair hearing. Audio altrum partem. They ask this exception to the principles of natural justice. They ask this question for 5 marks. Next one. Are there any exceptional cases where principles of natural justice is not applicable? Yes. Government contract, tortious liability. Is government liable for tortious liability? Resano. Yes. So make sure you guys solve the questions. Uh-huh. Ah. ಅದು ಹಳೇದಮ್ಮ ರಿಮೂವ್ ಮಾಡಿಲ್ಲ ಲಾಲ್ ಲಗ್ಗಯ್ಯ ಯಾ I will share it to you guys soon.